Thank you. I appreciate you.
Good morning, everybody. We have a long day in front of us, so I just want to really quickly lay down some ground rules because I know last time there was a little noise from the crowd. So just make sure that there's no clapping, there's no booing, there's no groaning when somebody makes their statements. These are things that many of us here on this committee have worked many hours on. So we have stake in it as well. But we understand that when people come here and speak, they don't want to hear their opinions either being heckled or people on the other end seeing somebody get a little too excited. So just make sure that we keep it down. Any other comments from my co-chair?
Yep. Hi, everybody. Welcome. Senator Martha Marks. This is my favorite part, public hearings of the process where we get to hear from the public. And this is what democracy looks like, right? So welcome, everybody. And I'm ready for a fun, long day.
Long is the operative word. Any remarks from our rankings? Seeing none, we'll get right into it. First, we have our commissioner of our Department of Housing, Salem Mascara Bruno, and Michael Santoro from Department of Housing.
Good morning, Senator Marks, Representative Felipe, Senator Sampson, Representative Scott, and distinguished members of the Housing Committee. Thank you for having me here today. I'm Salem Mosqueda Bruno, Commissioner for the Department of Housing. And I'm here to support three proposals that we submitted. We submitted written testimony. I'll quickly go over them. In Act 6891, that limits security deposit to 1 month. This act allows accessibility to housing for those that are looking for apartments, not having to pay 3 months, which includes 2 months of security deposit at this time and 1 month of rent. So we're looking for to keep those costs affordable. So accessibility to housing is very important. And Act 6892, limiting the increase of rental charges upon transfer of residential property to a new owner. Under this proposal, an increase greater than 10% will automatically be considered excessive unless a new owner completes major renovations. These proposals balances landlords and tenants' interests, allowing landlords in a reasonable return on investment while protecting existing residents from excessive rent increases, protects vulnerable populations such as low-income families, seniors, and individuals with disabilities on fixed income, and that may not be able to afford an excess in rents. Provides stability to tenants and also prevents people from being evicted. By limiting excessive rent increases, landlords cannot easily evict a tenant for non-payment of rent due to unaffordable increases. And the Act 1306 is a technical change to this act because it's not needed at this time. So if you have any questions, I'm here to answer, and Michael Santoro from my staff will be here to help me out.
Thank you, Madam Commissioner. Any questions from members? Senator Sampson.
Thank you very much, Mr. Chairman. Madam Commissioner, thank you for being here this morning. Nice to see you. I'm just curious, on 6891 and 6892, in particular, 6891 is the limit to 1 month security deposits, and 6892 would cap a rent increase to 10%. I'm just curious, where these proposals are coming from. Do you have some data to suggest that these are necessary policies in the state of Connecticut for some reason? What's the compelling interest the state has?
Sure.
Mr. Chairman.
Sure. 6891. Right now we have in the state of Connecticut, you're 62 and older, you only pay 1 month security deposit. Well, through the pandemic and through this past 4 years, we have been providing rental assistance to many of our families. And one of the big barriers that they have is actually to come up with security deposits. When a monthly rent is $2,000, you will have to come out with $6,000 in order to be able to afford an apartment. So that's in excess of what they can afford. In the past, 1 month security deposit for families and 1 month rent was common, and we wanted to make sure that residents have access to housing in a more affordable way. That answered your question, Senator Sampson?
Senator Sampson?
Through you, Mr. Chairman. Yeah, I appreciate the answer, though I'd be curious to know exactly when it was common for 1 month security deposits. I've been in the real estate business for 30 years, working with property owners, primarily, people that own multifamily housing in the cities of Waterbury, New Haven. I mean, that's how I started in real estate. And I don't know that security deposits have actually increased at all. In fact, I think they've decreased over time. And we do already have a maximum of 2 months in the state. You mentioned that the reason is that you want to make it easier for tenants to be able to get into an apartment by having a reduced security deposit. I don't know if that's a compelling state interest, and it's clear that that's a very one-sided interest. It's protecting the tenant. As the landlord's concerns been addressed? I mean, have you pondered, what the impact to the property owner might be in a situation like that? Through you, Mr. Chairman.
Actually, I was a landlord before I was the commissioner. I ran a nonprofit affordable housing developer in New Haven for about 20 years. And we, at that particular organization, managed about 500 units in the New Haven area, charge only 1 month security deposit. And it made a difference to many of the families that have very limited resources. So that through my experience, yes, a 1 month security deposit will help a family, especially with the rents, how expensive they are right now. And if a single mom with 2 kids paying $2,000 for a month, and then they have to come out with another $4,000. So it's pretty dramatic economically for those families.
Thank you, Mr. Chairman. Through you. Yeah, again, you repeated more or less the same thing, which is you have a concern over lower income families being able to afford a rent. And certainly we all have that concern, but that doesn't address a lot of other issues. I mean, what about, more expensive rents in more affluent communities where the, value of the property is significant, and especially compared to the amount of rent. And it doesn't take much to do that. I mean, I sometimes to put a countertop in a house might cost $2,000. I mean, that's a month's rent right there. Somebody damages a countertop. The cost of repairs and contractors has gone up exponentially also. So, when you consider a security deposit, what's it for? It's to allow the property owner to be able to have money put aside in case there is damage to the unit so that it can be repaired afterwards. 1 month security deposit doesn't go very far. I mean, if we got some contractors in here and we ask them, what they would be able to repair for, a $1,500 security deposit, it's probably not going to go very far. I really would like an answer to what, if you've thought about the issue with the landlord and what they're going to how they're going to handle this situation. I mean, there are landlords that I suspect are going to be averse to renting in the market, and maybe even more averse to renting to different candidates. They're going to be even more selective about the candidates because they know that they can't charge enough security deposit. So I guess let me ask you this question. I would predict that property owners, in lieu of being able to charge a larger security deposit, would probably try and make it up in other places, like the cost of rent. Do you think that's a possibility? Through you, Mr. Chairman.
So to address whether I have thought about a landlord or not, as I mentioned before, I was a landlord, and as you have businesses, right? So the security deposit is just in case there are damages at the end of the lease. Well, you will, as a landlord in the business, you collect rent every month, where you have your replacement reserve, you reserve resources for operations to pay all the bills. And then you get your revenue on the properties. But you're assuming that a tenant will destroy a property or will damage the property to the landlord, so the landlord can use those 2 months security deposit to fix an apartment. But that's not the case. Not many people are destroying the units or make expensive damages to an apartment.
Representative, Senator Sampson.
Thank you, Mr. Chairman. Yeah, no, I don't disagree. I don't think most tenants are doing any damage. I suspect most tenant landlord relationships are actually quite positive. I've had the same tenants in my properties. One of them 10 years, another one 4. So I mean, you can certainly build a relationship over time, but to suggest it doesn't happen, that's not fair either. I mean, I can list a number of times just in my own short experience where the tenant has done significantly more damage than 1 month security deposit. And we're going to have landlords testifying today. And if any of them are watching, I'd strongly suggest that, in addition to your testimony, you bring up, one of those stories to point out that 1 month security deposit is certainly inadequate. I mean, do you have any concern over what we're doing here, which is to effectively say that it's no longer up to the landlord and tenant to decide the terms of their agreement on their own? I mean, it's a private contract, it's negotiated by the parties. I'll pay you a certain amount. This is our expectation. Now, instead of letting those folks work it out, we're going to jump in there and we're going to say that there's these rules that they have to follow, whether or not that fits a situation. And the reason why I ask that is because, I put a bill in every year actually to get rid of the limitations on advance rental payments, for one, and for security deposits. And I'll explain why. And it's because very often you'll have a tenant applicant that has some negative thing in their history. They have poor credit, or they have an eviction, or they have something that happened, but they are in a good place now and they want to rent, and they actually have the money in their pocket. So they say to the landlord, look, I know you have other applicants, but I really want to get this apartment, and if I know I have an eviction, but you know what, if I gave you 3 months security deposit as extra protection, could I get the rent? A lot of times a landlord might go for that. And my concern is by suggesting that you're going to say, oh, no, 1 month security deposit, you're not hurting the landlord. The landlord's going to just rent the apartment to someone else, especially now when there's incredible competition for rents. But what you're going to do is you're going to tell that person that is in that situation where they have poor credit or something, that they're going to have a harder time finding a rent because they cannot make an additional negotiation. They can't sweeten the pot, to the landlord. Have you considered that? Through you, Mr. Chairman.
Of course. And Senator Sampson, you are a good landlord, right? And you care about the people that you provide an apartment. But there are many landlords that don't. The same way that we have tenants, we have good actors everywhere, as landlords and as tenants. So what we're trying to protect is from those landlords that are speculating and try to take advantage of the residents that do not have that much resources to be able to be in a place.
Senator Sampson.
Thank you very much, Mr. Chairman. I appreciate that. Although, I mean, when referring to tenants, you made it clear that you felt that the vast majority of tenants were good tenants, and so do I. But I would say the vast majority of landlords are good landlords too. I mean, the fact of the matter is, to be in any kind of business, It doesn't matter whether you're selling pizza. I mean, if you sell terrible pizza, you're going to go out of business, right?
Yeah.
You know, I mean, if you're a terrible landlord and, you know, you're not going to have luck keeping your tenants or having repeat tenants or managing your property. So we all know that there are certainly bad landlords. There's some of the, we hear this horror stories all the time, particularly in the city of New Haven, some of the large landlords that are out of state. We know all about that. But this bill doesn't address just them. This bill addresses the, you know, the people that have an extra, you know, they own a 2-family house. Maybe they're buying that as their first purchase. A lot of first-time buyers I've worked with over the years, that's something they do. They buy a 2-family house, and that allows them to rent out one of the units so that they can help offset the mortgage. You're lumping those people in this category also. Now, if I'm a young family and I just barely managed to get a first-time home buyer mortgage to buy a small 2-family house, and I'm going to rent out one of the units to someone, and those people do significant damage to the house beyond, maybe they cause, you know, the rent is $1,500 a month, but they cause $5,000 worth of damage, which is not hard to do. I mean, $5,000 does not go very far. I really wish we had some contractors in the room. So what do you get for 5,000? You know, the thing is, then what? Though that family doesn't have the means to fix it. You know, so how are they going to put that rent back into service and offer it to another tenant? You know, Madam Commissioner, I mean, the reason why I'm having this dialogue with you is because I think that there's a major disconnect between the policies that are coming from the state of Connecticut and the real issues that need to be addressed to fix the problem of having too few affordable and available apartments. I believe that the reason why there's too few affordable and available apartments is because of the difficulty in being a housing provider. You know, for example, let's talk about the other bill. The other bill creates a 10% cap on rents, which is actually pretty substantial. But what if the property taxes go up 20% and the cost of the repairs? I had to get a quote on a roof for one of my houses just recently. And I remember I put a roof on a similar house like 10 years ago and it cost $4,500. This time, the lowest price I got was $15,000. So over that period of time, it's gone up 3 times. So, and this is something that the property owner has to factor in when they're charging their rent. As you mentioned, the landlord is setting aside money over time so that they can make repairs. It's not that the security deposit is not for that. The security deposit is for damages. But the landlord is supposed to be, you know, for planning for the future to make their repairs, right? And I agree with that, but those repairs are way more. The taxes are way more. The insurance is way more.
Mhm.
Everything has gone up. So I guess, you know, when you say you're going to put a limit on the amount of rent, are there any factors that you would think might make an exception for that if the costs to the property owner also went up, maybe much more than that? Through you, Mr. Chairman.
Thank you, Senator Sampson, for that question. As I said before, this bill is, this bill is to help to protect tenants, but and it also considers landlords, because 10%, an increase in 10% when somebody buys a property can be managed, but an increase in excess of that, it put many residents in unstable place where they will have to find other places or be evicted because they cannot afford those rents. And that is, if a landlord buys a property and they have major repairs, then that doesn't count, the 10%. They can use a different approach because they're gonna make major repairs into that property. But we have had many investors, and again, I'm not talking about our landlords. We have a very good relationship with the landlords in Connecticut. I'm talking about those hedge funds, those private investors that are buying property and they charge in excess to it. We have people that call us on 20%. A senior person that is on fixed income, they cannot afford to pay those rents.
Senator Sampson.
Thank you, Mr. Chairman. I just want to make it clear, we're not talking about somebody changing the rent in the middle of a rental agreement. Is that correct?
Within the 12 months, if somebody is an investor buys a property within the last 12 months, and they suddenly want to charge more than 10%, that is considered excess, and that can go to the Fair Rent Commission.
Senator Sampson.
Thank you, Mr. Chairman. No, what I'm getting at is that, there's a lot of language I hear in this room, typically from the majority. They refer to anytime the lease ends as an eviction. They talk about an offer for another additional lease term as increasing the rent. Those terms are misleading, because the fact of the matter is, if you have a lease for a certain period of time, the price is locked in. It cannot change. So what we're talking about is the end of that term when a new term is being offered. You're suggesting that the increase can't be more than 10%.
Once the landlord, within 12 months that the landlord have bought a property.
Right. You're talking about the exception,
Yes.
which is, for somebody who makes major renovations. I wait to see what the bill looks like at the end to decide what were you calling major renovations, because I think that there might be something lost in that language also when the time comes. But I'm more concerned about the situation where there's no major renovations, and the fact that sometimes the costs go up. I've had situations where I didn't raise someone's rent for 10 years, but then something happens, I got a new tenant, or the market changes dramatically, or the town raises my property taxes through an assessment dramatically, or I have a condo unit where the condo fee goes up, an extra $200 a month. I mean, at some point, the landlord has to have a mechanism to be able to keep up with their expenses. And you're not putting a cap on condominium association fees, are you?
No.
Oh, yeah.
Forgive me, I was trying to go through the chair, but we're going a little fast. And are you putting a cap on property taxes, Madam Commissioner?
No. And we're not putting a cap. This still goes to the Fair Rent Commission. So this gives them an opportunity. If you're a landlord and have a reasonable cost, you still go to the Fair Commission. We're not putting a cap.
Would you consider the market value in a particular area to be reasonable cause? Through you, Mr.
Help me.
Morning, Mike Santoro. I'm the Director of Policy Research at the Department of Housing. Through you, Representative Philippe, Senator Sampson, this bill does not establish a rent cap. All it really does is it takes some of the burden off local fair rent commissions on new property owners who, within the first 12 months of ownership, try to slap an excessive rent increase on existing tenants. It does not deal with existing landlords. It does not affect them in any way. It does not establish a rent cap in any way. It simply establishes a threshold for fair rent commissions to determine automatically a rent increase in excess of 10% on by a new owner is automatically deemed to be excessive. They don't need further justification to claim it as excessive, unless that new landlord also does major renovations. Then that automatic excessive declaration would not apply. Okay, so all the examples you're putting out really don't apply.
Senator Sampson.
Thank you, Mr. Chairman. I appreciate the commentary, Mr. Santorum. But I have to tell you, honestly, hearing your words are very concerning to me. I mean, to slap a rent increase. I mean, the terminology to say it's automatically excessive. When the price of eggs went up recently, which has all been in the news like crazy, it's like 10 times. I mean, are the cost of eggs excessive? But do the people selling the eggs have a good reason for the price? The answer is yes. Thousands and thousands and millions of birds were killed because the USDA said that avian flu is a threat. Now, I don't know if that's 100% true or what the story is or whether they got it right or not. But at the end of the day, there was a reason. And, sometimes prices change dramatically, and towns very often raise their property taxes substantially. You're suggesting with this bill that if someone buys a property, they automatically cannot change an existing tenant's rent more than 10%. And that is indeed a cap. And what if
Pardon me, Senator, but that is exactly not what this bill does. This bill simply establishes a threshold for what is deemed to be excessive by a Fair Rent Commission. Still has to go to Fair Rent Commission. Fair Rent Commission still has to hear what the landlord has to say, as the commissioner indicated. There may be justification for that new owner to have and ask for a greater increase. All it simply says is if it is without any renovation, it is automatically deemed excessive by the Fair Rent Commission. Still goes to them. Decision is still theirs based on their local rules, their evaluation. It is not in any way a cap on rent.
Senator Sampson.
Thank you, Mr. Chairman. And going forward, let's try and go through the chair so that we're not debating one another directly.
My apologies.
And I was in the middle of a sentence, and I will give you all the time in the world to respond, but I'd like to finish my thoughts also. And I would disagree with you about whether this is a cap or not, because I think it's quite clear it's a cap, because what we're doing is saying to the Fair Rent Commission in this bill what the law considers to be excessive. And yes, it does give some wiggle room for them to make exceptions and to hear out the landlord's position, but it also makes it very easy for them to say, oh, you raised it 10% and that's it. And I think that that's extremely dangerous. I also think that, in other places where they've had rent caps, landlords, because they never know what their future costs are. They never know whether their costs are going to jump 50% in 3 years. So if you set up a limitation on them, whether it's 2% or 5% or 10% or 20%, my experience is they will increase the rent that threshold right then and there every time. It will become a new minimum because they can't take the chance that they go, oh, well, I'll do 0, and then maybe 10% if the costs go up. If the costs go up in 3 years, 30%, and they didn't collect the rent increase in advance, they're going to be in a big disadvantage. Can I just ask, this bill comes from the Department of Housing. I want to understand what the thought is at the Department of Housing and for you, Madam Commissioner, that you believe that it is the right and role of your agency to make policy that interferes with private commerce, private contracts, and the determination of what someone wants to charge for their product.
Thank you for that question, Senator Sampson. For the past almost 6 years that I have been commissioner, I get at least one email every day from individuals or seniors that cannot afford the rent. I have one of the mainest cleaning lady at the department came to me and said, my rent went up almost 30%. And I can't afford it. I'm still working and I cannot afford it. So we do need to have some limitations. And as I mentioned before, not to the landlords. I mean, a landlord that can increase rents 10% because of increases on taxes or operation is a different thing that we have investors buying properties and increasing their rents. That's it. They just hedge funds investing. Not only one, we have many investors coming to the state and having people out because the excess in rent. So that gives me an opportunity, not an opportunity, but we have an issue and we have to alleviate some of that with the rent increases and with investors that they're not from saying they don't care.
Senator Sampson.
Thank you, Mr. Chairman. So it's nothing more than you feel that rents are too high and you want to help people.
It's not a feeling, it's a reality.
I understand that, but it's your opinion that rents are too high and you want to help people.
It's a reality that people are paying a lot of rents and they cannot afford it.
I understand. Yeah, Madam Commissioner, I'm just looking to see if there's anything else there. Because, look, I'm hearing the people in the room, and I'm with you 100%. I don't like paying high bills either. My parents are senior citizens. They have difficulty with their bills. I'm helping them out and things like that. I mean, the fact of the matter is, the things are costing a lot of money these days. A lot of things have happened in our world. There's been so many changes in a federal level, on a state level, that are impacting prices and everything else. But you're picking out one group of people and saying, we're going to tell this one group of people they can't charge what they need to for their product, even though everything that they have to pay for costs more. And we're going to do that to help this other group of people. And I'm with you. Let's find a way to help people with their rents. But to harm landlords in the process seems counterproductive to me. The landlords are going to come today, Madam Commissioner. They're going to come before us today, and they're going to say that I can do business in 50 different states. I can do whatever I want. I could change my business and go into retail. I could do a lot of different other things. And the fact of the matter is that if you start proposing these requirements, I'm not going to offer housing in the state anymore. And what that will do is end up increasing rents more. I wish the people who are in this room are looking this in the most simplest way would take a moment to contemplate what I'm saying. I am as concerned about anyone about folks having to pay too much for anything. I want people to be able to afford to live and prosper in our country. And I want things to be inexpensive, and I want opportunity to be everywhere. That's what I want. And you know how you get rid of opportunity? You start to have government that interferes in private contracts and telling people what they can do with their own property and how much they can sell things for and what they can rent it for. When you tell somebody that they can't sell their property to a hedge fund, although this bill doesn't actually mention hedge funds, it could be anyone. You're telling them that they no longer can actually sell their property for its full value also. Are you aware of that?
I'm not telling them. This
Very,
bill-
very quickly before we get into this, there have been a few outbursts from members of the crowd. Can we please just make sure that we keep it down? I understand. And even if you don't agree with some of the things that are being said, that doesn't give the opportunity to speak out of turn. You will get your turn in the public hearing. Sorry, Madam Commissioner.
I just lost my train of thought. Senator Sampson.
I will ask again, which is that in my view, when you tell a property owner that or a future buyer that if they decide to come purchase a particular property in Connecticut, that they do not have the ability to charge what they want for it, that there will be limitations on the rent. Like, what if they wanted to come in? If there was a property that somebody rented to their family owners for far below market value for many, many years, and then suddenly they decide they want to sell the property and retire to Florida or something. Sounds like a good idea. The person that's buying it is now looking at it and saying, I can't buy it because you were charging too low a rent. And if I buy the building, I can't do what I need to do if I only charge a maximum of 10% more than what you were charging, because you were charging only your family members, half the usual rent. I'm just suggesting, and that's just one example, but I think anytime you put a limitation on like that, you're telling a potential buyer there are going to be concerns with, your ability to be able to prosper and make money. I mean, we don't set the rent or set the price of many goods. I mean, we don't set the price of food. We don't set the price of cars. We don't set the price of other things, including things that we all need. Eggs, there's no government mandate that you can't raise the price of eggs more than 10% or anything like that. And that's because we recognize that there's market forces. And that's what I've been driving at in this conversation. And respectfully, I mean, and to find out what your reasons are for this bill. And all I've got is, well, people are hurting, we need to do something. Well, I agree. But there's a lot of things you could do. You could come up with more housing subsidies. You could try and find ways to make it easier for landlords so there's more of them, so that there's more competition in the marketplace, so that there's more available housing. That will drive down the price. But simply coming along and putting more barriers for housing providers means you'll have less housing providers. I fear these policies, as much as people seem to like them and they're wearing shirts saying we ought to do things that are going to make it harder on landlords. What they're doing is they're going to cause a problem that makes it so there's less landlords. And when you have less landlords, you're going to have even more problems and less rents and higher rents. And I think that's apparent to anyone who puts a little thought into it. And that's what concerns me about this whole conversation. So I will just ask one more time. And I know that the chairman's been very patient with me asking you a lot of questions, but we don't get the commissioner in front of us maybe once a year. So I appreciate you being here. Is there anything else to these policy decisions? The rent cap, respectfully, I see it that way, and the 1 month security deposit, other than the fact that it will, in the very short term, help folks by limiting the amount of their security deposit. Do you have any other evidence to suggest that this is going to create more rental opportunities or drive down rents going forward? Because I'd say it would do the opposite. Through you, Mr. Chairman.
Thank you. There are other states that have done that. In California, Oregon, to protect residents and to keep rents more stable. And as I said before, this is not a cap and it's not mandating. Is a place where a landlord that comes into, or a landlord that just buy a new property doesn't exceed the increase in rents for somebody with fixed income be able to pay and be in eviction. So 10% is reasonable. We don't get 10% on income. A person had the minimum wages keeps steady, right? And a person every year doesn't get a 10% increase in their salaries. So all this, what it does is to allow these individuals to be if the landlord is not gonna do any more repairs or anything, they shouldn't charge 10%. And we're not putting a cap. It still have to go through the Fair Rent Commission.
Thank you, Mr. Chairman. The only thing I would say is, I mean, certainly some people do get more of than a 10% raise. You know, some people, their rents, their pay is stagnant, you know, for long periods of time. Other people get, you know, large bonuses. Sometimes people change jobs. The thing about that is that, you know, the prices of goods are changing now. I mentioned that the change in the cost of a roof, for example, for a modest single family house is basically tripled in the last 10, 12 years. You know, these things are changing out in the world. And is there anything in this proposed legislation that would accommodate a big change like that? Like, you know, if property taxes doubled, for example, would a landlord still be required to abide by the requirements that you are putting forth in these two bills?
The landlord will have the opportunity to go to the Fair Rent Commission and present their case.
Right. But the one thing I would say through you, Mr. Chairman, is that the bill basically says that the Fair Rent Commission will consider a increase over 10% to be excessive. So you're telling them what is excessive so that they can actually start to enforce that. You know, I think it's been framed by you and the other gentleman. I forgot his name. I'm so sorry.
Michael
Santoro. That's right. I appreciate you guys coming to me, but you've kind of laid this thing out that, like, well, it's going to be up to the Fair Rent Commission now. If you're telling the Fair Rent Commission what the parameters are, I think that's how they're going to start making rulings. So anyway, this conversation could go on for a long time. I think we have difference of opinion on a number of things on the definition of an eviction. I mean, I believe that, you know, when a rent is established for a period of time, we could maybe put some requirements in that say that, you know, if a landlord's going to change the amount they want for rent for a new term, they have to provide, you know, a certain period of time worth of notice, something like that. So someone will have an opportunity to make a decision. But that's not an increase. That's like, you know, I bought one car and I've come back to the dealer and I want to trade it in. Well, the price of the new car is going to be different, you know, and you can negotiate a lease for more than 1 year. You know, it happens. And people don't do it very often because sometimes, you know, the tenant often is the one that is unsure. They say, well, I'm going to sign a 1 year lease because, you know, I might be in a position to buy a house down the road, or I don't know how long I'm going to be living in New Haven. I plan to be living someplace else after a certain period of time. But that's all part of the negotiation. And I'm afraid when you take away rules for the negotiation, or take away opportunities, the negotiation itself by putting rules in place, you're going to limit the opportunity for all the parties. I just hope we can talk more, and maybe some of what I'm saying makes it into a final product. Those are all my questions. Thank you, Madam Chairman.
Okay. Commissioner, anything to say? Response?
No, anytime Senator Sampson wants to meet with us, open to discussion.
Okay.
Thank you.
I'm going to go a little out of order, and Representative Gonzalez, please.
Thank you, Madam Chair. Nice having you here today.
Thank you.
Always a pleasure. About 1 month security deposit. Is that a federal law that says that after 62 years old, it's only 1 month?
62, state law, right?
That's what? Federal law?
State,
State law.
state law.
Okay. Okay. So that really answered that question. Is that true that me as a tenant, if I cause a lot of damages in the unit, the landlord can go after me, after I move, the landlord can go after me in court as I press charges?
Thank you, Mr. Commissioner. Representative Gonzalez, through the chair. Yes, a tenant is subject to suit by a landlord should they damage the unit beyond the value of the security deposit.
Thank you for that answer. I think that 1 month security deposit, and after that, if I cause more damages, they can go after me in court. So thank you.
That is correct.
Right, thank you. Can you agree, or you think there's will be a good way to go on the 1 month security deposit? Let's say if I go and rent an apartment, and let's say that the landlord want more than 1 month. Let's say that I personally, even though that the law, let's say that we pass the law, 1 month security deposit. But let's say that I want, if I agree with the landlord, they say, well, I want 2 months. If not, it's impossible. I can't rent you the apartment. We know that that's illegal, because if we pass the law, that knows. But can we maybe tweak this bill a little bit and say, if the tenants agree with the landlord, like let's say 2 months security deposit, or maybe pay, make payment to catch up to 2 months, will you be willing to go with that? 2 months. Again, let me explain it again.
No, I understood.
Okay.
I'm just trying to see how that works. Do you wanna go
Certainly.
ahead?
And again, thank you, Commissioner, through the chair. Representative Gonzalez, nothing in the law currently prohibits a tenant from offering to pay more right now than 2 months security deposit. It simply prohibits a landlord from requiring more than 2 months. This would change that requirement down to 1 month. But if a tenant and a landlord at the tenant's initiation wants to give more to the landlord up front, there's nothing in the law preventing them from doing so.
So that means in a way that that covers all the discussion.
That
right.
is correct, Representative.
That covers all the discussion. So if it is an agreement between the landlord and the tenants, I don't think that it should be prohibited, because I think that if I agree and I'm the tenant, I think that should be okay. And you said that it's already in the books for that.
Initiated by the tenant, correct.
Okay. I understand that we having a lot of problems here in the state, and I don't think that it's only the state of Connecticut. I think it's all over, the landlords and the tenants. And I would like to see, if we can fix something out, because the landlords have right and the tenants has right. And we have the good and we have the bad. And I know that you're trying to see how we can work something out to see if we can help the tenants. We also have to look at the way how to can try to fix the problem and compromise, with the tenants and the landlord. And when they talk about, when Senator Sampson talk about buying a property, let's say that I buy a property and I want to raise the rent, and you said that it's 10%. I think that me as a landlord, I'm taking a chance. I'm buying a property, and 10%, I will, 10% increase, it will help a lot. Now, my comment after, I finished, but my comment is saying that a tenant's paying the rent by month is 12 months. And if you cause some damages, like he said, that always the law can go after the tenant. But I want to make this clear. I was a landlord years ago or more, but I was a landlord. But the rent that I used to collect every month, for me, I was saying that it was kind of fair because I don't have a tenant that's going to destroy the apartment every month. So I'm going to be spending my rent in fixing the rent. And if that happened, we have laws in the books that I can always try to evict that tenant. So I think that, yes, we have to see how we can work this out. We have the Fair Rent Commission that also controls that. And I can say, because I was in a meeting not too long ago, and I thought it was kind of fair. I never saw that before. And I was very pleased knowing that we have commissioners in the Fair Rent Control. They're doing a good job. But I think that we have a problem. We have to fix it, but we have to fix the problem, not in the expenses of the tenant all the time. So thank you, Commissioner. Thank you for being here, and thank you for the answers. Thank you.
Thank you.
Representative Roberts.
Good morning, Mr. Commissioner. Good morning, Michael. Thank you for being here today. I just want to let you know that your words are very powerful, especially with these two bills. Just understanding what city I come from, and understand, I think it was a lot of numbers that flew around today, from 2,000, 6,000. In Norwalk, Connecticut, a studio is 3,500. So we gotta be honest and understand, like, no one has $10,000 to put up. So it's not about the average affluent. It's not about the average poor person, low income person. We're talking facts here. So we need to understand, we're not talking about what's affordable, because it's not affordable. So I understand what you're saying today. I do. And when we talk about hedge fund companies or anybody coming in and 10%, it's not a cap, it's coming to the fair. I understand that, because there's a lot of these businesses coming in and buying. And directly for me, New York City is right next door. So I understand what you're saying today. So I do want everybody to understand what's going on today. Wonderful bills. Wonderful bills. So thank you.
Thank you.
Representative Scott.
Thank you, Mr. Chair. Thank you, Commissioner, for coming in today. Great to see you. Same to Mr. Santoro too. So first I want to hit on is 6892, the one about the increase in rental charges upon transfer. I just want to very clearly say, because I'm a little confused. I'll be honest. I'm not trying to question, this is very innocently. I'm trying to question the process of a fair rent commission. So when they're deemed, let's say they want to try to raise it over 10%. Some new owner comes in, tries to raise it over 10% within 12 months. It's deemed excessive. What does the Fair Rent Commission, what does that mean to the Fair Rent Commission at that moment when it's deemed excessive? What is their liability? What are they allowed to do and not allowed to do?
Go ahead, Mike.
Thank you, Commissioner, and through the chair, Representative Scott, thank you for the question. Fair rent commissions are empowered by their municipality, so it will depend on what authority the municipalities have given that local fair rent commission. All it simply does is it removes the requirement for justification by the Fair Rent Commission to say that that particular request is excessive. It's automatically deemed to be excessive. At that point, they work with the landlord under their municipally established authority, their own bylaws, to determine what the next step, if any, is. We are not mandating that the landlord can't do it. What we're saying is the Fair Rent Commission doesn't have to justify beyond that request for more than 10%. It's automatically excessive. It's that simple.
Okay. So if they deem it excessive, there's not major renovations done that qualify under the law, they could still, the commission, the Fair Rent Commission can still say that's okay.
Correct.
If it's 12% increase, they can say 12% increase is okay. Even though they didn't do their major renovations, they can still go ahead and deem it.
That is correct.
Okay. Thank you for that clarification. I appreciate that. I do worry about, and just as more commentary, I do worry about the idea that any threshold, rent cap, this is not a rent cap, whatever you want to call it, like any threshold, let's just call it a threshold, not a cap, is like you will go up to it. You'll go up to 9.9%, right? It could, just because then you don't have to worry about getting flagged. Or if there's a rent cap, which we've talked about in the past in this committee, 4%, you can go to 3.9% every single year and you're never going to get flagged for it. Like that's a worry of mine of how you could manipulate that system by putting a rent cap in there or any kind of threshold. So I do worry about that in general. And then it's something that does bother me because you can actually take advantage of the system that way. But really what I spend most of my time is on 6891. So here's a scenario that we've discussed this bill in the past and that really worries me and should worry everyone in this room, to be honest, and everyone's watching, because those marginal tenants, the ones that don't have the best history, the best credit history, those tenants who are just on the margins, when you're in amongst of maybe 10 or 15 different applicants for this one unit, maybe the landlord would have taken a risk and say, you know what? I met with you. I'm comfortable with it with 2 months deposit. But with 1 month deposit, they might not be willing to take that risk. I worry that this policy will put those marginalized candidates or tenants, when they're up against 10, 15, 20 other people coming for this one unit, they're going to be pushed aside and they're going to constantly get pushed aside. It is a worry of mine that those tenants are actually going to be left out because they don't have the ability to say, trust me, take my word, and oh yeah, here's 2 months security deposit, instead of one that's maybe they're not going to take a risk on that individual candidate. They're going to go with someone else who they think is less of a risk. So we're actually doing a disservice by this bill to those marginalized. And that's my worry for that. I'd definitely love to hear your comments, Commissioner, on that, but that's a worry that I have, that I think with the way the housing market is right now, they're going to be left to the side.
Thank you, Representative.
Thank you, Commissioner. If I may,
Mhm.
Mr. Chairman.
Michael.
Representative Scott, I understand, and as Representative Gonzalez pointed out, there's nothing to prevent a tenant from offering to pay more. All this changes is that a landlord can't require more. So in your particular case, if you have someone who's marginalized, but has the financial wherewithal to be able to offer more, they can. So we not prevent that. Not that we are encouraging that, because to be perfectly frank, that's not what we want to see. We have security deposit programs which can help individuals, particularly low and extremely low income, to make that security deposit payment. The marginalized household who has bad rental history, we'll call it bad credit, they've had problems being a tenant in the past. They have an eviction on their record, or whatever. This would not prevent them from going to the landlord and making their case. Okay. All it would do is prevent a landlord from saying, hey, I'm going to get as much out of you as I can in order to rent to you. Thank you.
So it's my understanding now, I don't know if we have LCO here to confirm this, but my understanding, the current law is 2 months. That you can't accept a security deposit more than 2 months. And if you accept anything more than that, you have to return it. So in this scenario, it's 1 month. If you accept more, theoretically, if it's written the same way as the current bill that it is, that's my understanding of the bill, or it's the current law, sorry, not the current law, is anything more than 2 months, you actually have to return. You can't hold that money. So you don't have that option as legally. Again, could we write this new law to where you can allow more? I guess you can, but currently if you just change the 2 months to 1 month, and that's the only part you're doing, I don't believe, and again, I don't have LCO's acknowledgement of that yet, but from reading the law, I don't believe you have that ability to take more. Do you understand that as the current law states you can't take more than 2 months?
No, Senator. That is not our understanding.
Okay. All right. That's something we're going to have to get flushed out. because clearly reading I have the law in front of me and reading it's clearly it's clearly nebulous at best. So we're gonna have to definitely figure that out, because I do worry that we don't want people breaking the law by taking additional dollars when they're not supposed to. So something we're gonna have to dig into as a committee to get clarity on that for sure. So I thank you both for your time and your answers. Thank you.
Thank you, Representative Scott. Representative Butler.
Thank you, Mr. Chairman. Good morning, Madam Commissioner. It's always good to see you.
Good morning.
I'd like to first thank you for all your great housing initiatives throughout the state of Connecticut over the last few years. So you've done a marvelous job. In terms of the bills we have before us, I only have 20 questions. But I will restrain myself to the customary two that we generally follow in committees. My first question is about House Bill 6892. I could tell you that in the last few years, the number one complaint I've got to my office is from tenants who have faced large increases on their rents. And it was due to the fact that their housing development was bought by another entity. And I don't want to cast aspersions on every developer from New York, but I tell you that 9 out of 10 times it's been somebody from New York coming to Waterbury, Connecticut, buying, housing units and actually increasing, and obscenely increasing their rents. So I welcome you trying to put forward an initiative to work with this. And we have a number of bills that actually address the Fair Rent Commission. So there's going to be probably a few different things that we need to put in place to counter that activity. But I could tell you, okay, if we're looking for a reason to do this, I could tell you in my district, okay, it's the number one complaint. So I welcome this, and whatever we can do to address this, if this is one of the areas, that's great. So my question is, there's fair rent commissions, and we know that they need to be tweaked and made more efficient and need some help, maybe some guidelines. But what happens if this scenario plays out in an area that isn't covered by a fair rent commission?
That's a good question.
My apologies, Representative Butler. Can you repeat the question?
Okay, that's 21 now.
My apologies.
No, no, the question is, the bill speaks to a fair rent commission looking at this scenario and determining how to adjudicate this scenario. My question is, what happens if this plays out in an area where there isn't a fair rent commission?
Essentially, it has no impact. This clearly is intended to simply establish a threshold that can be used by fair rent commissions to determine when a request is excessive. If there's no local fair rent commission, then it's subject to going to the current process, which is that tenant can take the landlord to housing court for an excessive rent increase.
Okay, thank you for the answer. And I was waiting for your testimony to be printed and brought to me, but it did not arrive, Madam Commissioner. So in lieu of that, could you tell me if there's any couple bills that you were in favor of, strongly in favor of the ones that are on our agenda today?
I didn't take a look at all of them because I was worried about my 3 bills. I'm sorry for that.
No, and that's, I understand that. I'm just saying, if I were to read your testimony, with your written testimony, would it show other bills that your department is actually, have strong opinions for or against?
No, we have, the testimony that I was submitted is for the three bills that we have.
Okay, I just want to check. And thank
Thank
you.
you.
And thank you again for coming and your testimony. Thank you, Mr. Chair. 2 questions.
Thank you, Representative Butler. Representative Weir.
Thank you, Mr. Chair, and thank you, Commissioner, for coming, Michael as well. I came from another meeting, so I missed part of the beginning of the meeting, but regarding on 6892, regarding the 10% threshold for for a fair rent commission, how was that 10% arrived at? What's the logic or background on a 10% threshold limitation? Through you, Mr. Chair.
Madam Commissioner or
Um,
Censor?
Michael.
Thank you, Commissioner, and through you, Mr. Chair, thank you. Representative Weir, when we looked at what we are seeing relative to increased market cost in terms of acquisition of properties, we're seeing dramatic changes in increase in real estate values themselves. As the Commissioner pointed out, this is really primarily targeting those large-scale investors who are simply coming in and raising the rent without consideration for the property, its location, its existing residents, et cetera. It's basically an investment for them. What we see is a reasonable return on investment is less than 10%. That was the basis for that as a threshold.
Okay, thank you. Thank you for that answer. And so, all right, so I see where the 10% came from. It seems somewhat, arbitrary. I mean, I guess you're trying to chase, you're trying to come up with some figure, and so as I'm sitting here, in some circumstances, 5% could be excessive.
Okay.
And in other cases, 20% could be perfectly reasonable. And so I'm trying to figure out how we arrived, what drove you to 10%.
That is absolutely correct, Representative. And that's why it is not a cap. It's not intended to be a cap. It's not written to be interpreted as a cap. It's literally establishing a threshold for local fair rent commissions so that they can consider something more than that without having to get into the nitty-gritty, without a landlord providing that backup for why they need more than that 10%. In some cases, as you point out, 5% may be excessive in some markets. It is still up to that local fair rent commission to make that determination.
Thank you for that. I have just some statements to make, no further questions, if I may, and just an overall, because I think, and this is directed to both of you. Others may hear it later on today, but I think because we have you as an audience, part of this is you're driving in your position Connecticut housing policy, outside of what the market is bearing. And so when we're talking about policy coming out of this building and from your perspective, and we want to make sure that it's good, effective, sound policy. And, I'm not a landlord. I'm not a housing provider. I've owned buildings, commercial, and I've had a short stint in residential, but it's a special skill, I think, to one that I don't have. So I would say that, but I've done a lot of work for the housing providers over the past 20 years probably, and seen, worked alongside them in many of these situations. And what I've come to understand is that, they're generally speaking in the business of keeping, obviously keeping their investment, their buildings in good shape and sound and secure, and also keeping the buildings and their keeping their residents housed. Because if they're not taking care of their investment, nobody's going to loan them money to go after the next one if they're not taking care of, if they're not running a good business. So what I want to make sure is in this, in this room that we're considering, when a developer or a housing provider, landlord is looking to make that investment, a lot of times it's not self-funded. You know, you're relying on capital of banks and lending institutions. And so the policies that we make here, we need to make sure that it's attractive to lending institutions. So if we are too punitive, if our regulations are too strict and too heavy-handed, which is what I fear oftentimes when I walk in this building on many different subjects, that we drive away that capital, we drive away the investment, and then you get the people who are willing to take, you know, banks and lending institutions are risk averse. They want a safe investment to return for their investors, and they end up going to the more risky, the people who are more willing to take a risk on a lousier investment. And I think those are the people we don't, you know, we want to attract the people who are looking for a sound investment. So I caution you, as the language on this bill develops more, that we give that consideration that, you know, my colleague, Senator Sampson, pointed out, you know, this is the market is at work in many different things that we buy, many different services that we take advantage of, whether it's landscaping or heating oil or eggs. You know, there's a market force at play in housing as well. And so if we're manipulating that, those forces here by setting, you say it's not a cap, but we're setting regulations, we're setting, you know, boundaries by which people can operate. It can drive down that competition. It can drive down the choice that people have. Banks, you know, you know, this may be anecdotal for you, but I heard firsthand from one of the housing providers I was working for, going back 6 or 7 years ago, when they were, this prior to my time in the legislature, talking about their lending institution, this particular company, had said that they have to diversify their portfolio out of Connecticut, not meaning drop what they're doing in Connecticut, but for further investment, they were not going to lend to them. They wanted them to be in some other states based on some of the proposals that were coming out of this building. And so, you know, that's a firsthand account. At the time, I had no affiliate, you know, no plans to run for office. So this was not like the person was setting me up for some future filibuster here. So I want to make sure that we're aware of that. And I think, you know, I'm a homeowner. I don't rent, but my costs, you know, as the properties around me have gone up, and some of the commercial properties that you're talking about upon a sale, you've got buildings that have been owned for generations, and those property values have risen as well. And so if a person hasn't realized that sale and the rents, you know, are steady or the rents are rising a little bit, they're also, property taxes are assessed, you know, so as this building A is sold over here at a higher amount, building B, which may not have changed hands, they're being assessed at a higher tax rate just because the neighbor sold for higher, and their costs go up, as I've noticed that in my commercial and my residential building. So I want to be aware that when we, you know, those costs affect everyone. Okay. Last, I'd like to touch base on the security deposit. Representative Scott touched on this very well, but that housing providers have a few tools when they're screening a new applicant. And it could be a background check, criminal history, obviously, credit check, security deposit plays into the equation. And so when we here talk about limiting a landlord's ability to use some of those tools, they may rely more heavily on others. And to that point, you could have somebody with a marginal, lousy credit history, somebody who didn't pay, you know, they got an issue with a college loan or a car loan from few years back, things are on track or they're trying to get on track. And we've taken the ability of those two parties to negotiate a higher security deposit, which is in effect what this could do. And I don't see, you know, I understand that a landlord, housing provider landlord, you know, could, sorry, the resident could offer a higher amount. But I think that I'm not sure that that is going to be offered through this, when the landlord could then go back and just say, hey, you know what, it's too risky. I don't, you know, your credit's lousy, criminal history, who knows, right? That there's something on your record that you have a previous eviction. And now I don't have the ability to ask you for something to mitigate my risk. We may have washed those people out. So I just want you to consider that for what it is. These are the what ifs that that I consider. And I think the more attractive we make this environment for people to come and invest, we're going to have more housing. I can't say that the prices are going to go down because the price of lumber, the price of fuel, labor, property taxes, none of that's going down. So I'm not sure how we're going to see the prices go down. But at least, maybe we can stop the rapid rise by having more competition and more availability. And we better darn well in this room be careful about, and at your level, I look at us as a policy-making team, that we need to be inviting people here, setting out the welcome mat for property providers, housing providers, just as we have with manufacturing. Rolled out the red carpet, and we should be considering doing that here. But some of the policies that I'm hearing give me concern. If I were investing in that market, I'd have pause. So thank you, Mr. Chair, and thank you for your time.
Thank you, Representative. And I just want to make the comment, we're here to hear from members of the public. It's, we have 280 more folks coming, and I understand that we have to get off our points, but let's make sure that we're not giving long speeches and asking questions of the folks who come before us. Representative Corpus.
Thank you, Commissioner, and thank you, Mr. Santoro, for being here. I had a question about the data that is supporting these policy recommendations. This is my first term here, but I understand we've been headed this direction towards more pro-tenant legislation for a number of years. So my question is, what is the status of our housing market in terms of have these pro-tenant legislations and policies resulted in more apartments available for rent? It seems like there should be some data available that addresses just the very worries we have about this legislation, which is that it will drive landlords out of the market. Are landlords increasing in our Connecticut housing market? Are they decreasing? What is the data to support our track record thus far, and whether the legislation that we've passed already is working? And a follow-up, one of you mentioned California, and I don't know whether it was 91 or 92, that California has actually embarked on those policies. Has it worked? And does the data show that it's worked?
Madam Commissioner or Mr.
Yeah.
Santoro.
Michael.
Thank you,
Of the data.
Commissioner, Mr. Chair. We can provide some data to you if you're really interested. Obviously, we don't have it in our hands. We certainly can tell you what's happened in the other states and the other cities and counties based on what they have done. We did not go as far as those other areas. They actually have rent caps, as Senator Sampson points out. This is an attempt not to actually implement a cap. As far as new landlords to the marketplace, I don't know that we actually have much in terms of whether the landlord population is growing. We deal with quite a few different landlords. We can try to pull some data from the Department of Consumer Protection on licensures around those issues. Certainly happy to follow up with you.
That's a threshold question for me, because if one of our biggest worries is that we're driving people out of the market, landlords out of the market for rental properties who sort of pack it in and say, this is too hard, I'm not getting a good enough return, I'm going to sell my property, we're decreasing the amount of rental properties available for people who can't afford to buy a home. So it would be very important to know whether that's already happening. Are we already doing that?
Understood. We see a lot of new investors. I'll say it that way. And as the commissioner pointed out, we look at landlords differently than we look at investors. Landlords are your property manager, the guy you deal with on a day-to-day basis. We have a significant number of very good property management companies here in the state of Connecticut and individual landlords. We do and have seen recently a lot of large investors coming in, buying properties, and immediately attempting to raise rents, what would appear to be to empty the properties out and to significantly increase those rents.
Representative, and I don't mean to cut
Thank
you
you,
off. I just want to make sure
Thank you.
that we go through the chair, so we make sure that
My
before
apologies.
folks finish their speeches, that folks aren't jumping in with an answer to a question when I fear that there may have been more to the question.
My apologies.
Through you, Mr. Chair, last question, which is these outside investors that we talk about, and I'm not saying they're good or bad, it doesn't sound like they're very positive overall, What percent of the market are they? And do they add capacity to the market because they have a scale and a backing that allows them to build more units more so than an individual person who owns one property will? What percentage of the market are they? Through you, Mr. Chair.
So again, we'll pull what data we can and get it to you. We're not talking about production here. We're literally talking about existing properties simply changing hands. If you're building new, there's no existing rent would not be affected by this proposed legislation.
Thank you.
Thank you, Representative. Senator Marks.
Thank you, Madam Commissioner and Mr. Santoro. I just want to thank you for being here, and that as the housing chair for 40 years as a nurse, and I'm still a working nurse, my job has been to advocate for my patients. And the people that I advocate for are the people that I think absolutely could not afford more than 1 month rent when they are starting in a rental agreement. I'm 62 years old, have been a nurse for 40 years. If I had to do 2 months rent, guess what? It would be pretty hard for me to do that. I have a very supportive family, lots of people that went into a more lucrative career than nursing, and I know my siblings would help me. But I do think that we really have to think about the people. That's, to me, what government is about. We always talk about the price of eggs. You can live without eggs, right? I'm sure there's lots of us that are living without eggs right now. But you can't, and you could even live without health care. But what can you not live without? You cannot live without food, and you cannot live without shelter. So if you are going into the business of being a landlord, then you need to know that you are going into a business where you are dealing with people and you are dealing with shelter, something you can not live without. Yesterday, I was outside for 20 minutes and I actually thought, how on earth could anybody today with this wind live in their car or live outside? So I just want to say, as the Senate Chair of Housing, when I am considering the legislation brought before us, the people that I will be advocating for and will be thinking of are those that need housing, that need a roof over their head, marginalized. I don't really like that word, but those people that have had bad credit. Many of us sitting here have had something that happened in our life before we had paid sick, right? Thank goodness we have paid sick, paid family now, because there were many times in my life, being the mother of 4 children, where you did have to take off and you did not get paid and life became hard. And I also, it's always the single mom that we hear about. And, for second part of my motherhood life, I was a single mom and the father was very good. And so it's not always the single mom. It's the working couples. It's the people that choose to be single. And it's just those out there working really, really hard. So just my pontification is just that when I am making these decisions, it is because housing is needed. If you become a landlord, you're dealing with people and you're dealing with something that they have to have. If you didn't want to do that, you should have become a car salesman. You should have become a jewelry merchant. I don't know. We are dealing with housing. So I thank you for your really, really hard work. I thank you for these bills that I think truly will help the constituents in Connecticut who really are having a really hard time with housing. So I appreciate you both very much.
Thank you, Madam Chair. Senator McCrory.
Thank you, Chairman and Chairwoman of this committee. I normally don't chime in on committee meetings because I'm very busy, but unfortunately, or fortunately, I got an opportunity to chime in. I missed most of the conversation. So it's for the sake of time, I have one question and a comment. My question is to the Commissioner. Thank you for being here today. Always good to see you. And Michael, thank you for the work you're doing answering these questions by my colleagues. My first question is very simple. Commissioner, do you support 6891 and 6892? House HB 6891 and 6892?
Yes.
Okay, thank you. And I heard some of your commentary on the reasons why. My comment is this. You know, I, I don't. I study history and I look at policies, and I'm listening to my colleagues using the reference of policy making and banks and investors. And I would just say this for the sake of time. I'm not here to debate anyone or any one purpose, but I will educate. And I'll use my time to educate not just this committee, but all those who will listen once this piece of legislation hits the floor. Because I've been and with some tweaks, I'm very supportive of it. But I will educate you and inform you, the members of this committee. I will ask you to go back and read a book called The Color of Law. Because we need to have a larger conversation about housing policy in the state of Connecticut. But we all need to come from the understanding, the knowledge, and information about housing in this country, and specifically how housing has affected our state by using these entities from the federal government, state government, local government, realtors, bankers who created ghettos throughout this country and in our state of Connecticut. So I'm gonna stop right there and ask you all to make sure you read your book, and I give you a good source, The Color of Law, when we talk about policy, because we're policymakers, and be prepared to have this larger conversation about housing and the direction we're going in the state of Connecticut. So thank you. There's no need to respond, Commissioner or Michael. I appreciate you for giving me an opportunity to say a few words. And unfortunately, again, I'm on 3 other committees at this time. I'm not going to be able to stay long, but I will listen as much as I can to the public, because this is a public hearing, and we need to hear from the public who policies that we implement or create affect them. Thank you.
Thank you, Senator.
Thank you, Senator, and thank you, Commissioner, for being here. Thank you, Michael. I just really quickly, I don't want to add on too much to it, but you said a lot, and I am in support of the bills you put before us, especially because people talk a lot about the increase in costs that people have, whether that be for things that the housing provider has to provide, or that be for something that you have to live with in your everyday life. But I think of the 30% increase that the average rent in Connecticut has gone through in the past year. And I can't see how I don't think anybody's average tax bill, I don't think the average cost of your plumbing, your heating, whatever you're going through in terms of fixing your house has kept up to the same rate that a 30% increase in rent has. And you know, you make the comparisons to increase in the price of eggs, right? Eggs have gone from like $6 to $9, almost $10. It's incredibly taxing on folks. But I think of a statistic where I think it's 3 in 5 Americans can't afford a $400 emergency right now, right? The difference between a carton of eggs a couple of weeks ago and a carton of eggs now is about $4. It's not $400, but the difference in 30% of somebody's rent could be $400 or more. It could be a really burdensome thing that people have to deal with. So while I understand both sides of what we talked about, and we will have to tweak some of these policies to make sure that we are living up to some of the promises that we make to these members of the public and folks who really need the help, I commend you for looking to make these changes, looking to do things on behalf of these folks, because the things that people need and the way that we are living, it's not keeping up with that 30%, and that 30% is crushing. So thank you very much, and thank you for your time.
Thank you very much.
Next, we will see Scotacesa Miller. I hope I'm saying that right. Is Scotacesa here?
Hi, I'm here. Hello to everyone.
Oh, the floor is yours.
All right, thank you. I am Scotisa Miller. I'm just here to speak on behalf of myself and my family and my friends who are facing such a difficult time right now in housing crisis. Things have changed over the past decade. And I can say even since the pandemic, it has like significantly impacted us. Finding affordable housing has been so difficult. I'm from New Haven. I'm a part of New Haven Rising. And I know many people who belong to New Haven Rising. We fight for this very issue because we want to see things change. Um, I, I I support landlords and I thank them for providing shelter. But I do want them to remember that we all are people and we all need an opportunity to survive. So for me, I'm from New Haven and the rent has gone up so high. And so I took the alternative to go to Bridgeport to find say more affordable housing, and it worked out for me until my landlord he increased my rent so high that I had to get evicted with my two small children, and there was no difference. All around the country, there's no difference. The rent is so high, and everyone is just trying to survive. So for me, in the process of getting evicted, I said, well, why don't I try to go back to New Haven? But it seems like there's no end out or no way out of this situation at times when we have people who are trying to survive on both ends. But what I will say is I hope that we can be seen as individuals who just need somewhere to live. My kids, to have stability for them, that would mean so much to me, to have stability for them and to be able to afford because I work and I try to provide for them. And I want to be in New Haven. That's where I'm from. But this rent situation has gotten out of hand. And I'm not saying or pointing the finger at anybody specifically, but I just want the people who are responsible to just remember that we all are trying to survive and we need to do something about this because I don't agree with who is the president of our country. Sorry if I, to show any disrespect to anyone, but things are getting worse. And in concerns to housing, shelter is important. It's how we keep our mind, our mental, and our lives like intact so that we're not cold and trying to search for this and that on the streets. But I just want to be heard in a manner of just remember that there are small children who are being affected by this. So if you guys can please hear that part of the of my testimony, it's me and my kids and the people that I'm related to and my friends from New Haven Rising. We're fighting for a better quality of life.
Miss Miller, your 3 minutes have expired. If you could please summarize.
Well, I have said what I wanted to say. Thank you for your time.
Thank you. Thank you for your time. Any questions from members of the committee? Seeing none, we appreciate you for coming to see us today. The next speaker, we're gonna move up the list. It's Mark Champagne. Mark Champagne, are you here? Morning, sir. Floor is yours.
Good morning, Chairman Philippe, Chairman Marks, and ranking members of the committee. I thank you for having me here. My name is Mark Champagne. I'm a Connecticut licensed home inspector. I'm also the president of the Coastal Connecticut chapter of the American Society of Home Inspectors. I'm here at the request of Coastal Connecticut ASHI, as well as with the support of the Connecticut Association of Home Inspectors and hundreds of other home inspectors throughout the state of Connecticut. I appreciate this opportunity to testify in support of HB 6888 AAC, real property tax abatement for certain first-time home buyers. I would also like to use my time here to emphasize the importance of home inspection in the buying process and the need to protect the consumer's right to have a home inspection. A professional home inspection provides vital information to a first-time and other home buyers and the condition of the house, safety conditions, maintenance, and other critical information that they otherwise would not get from a realtor or the seller of the house. Many serious structural, foundation, electrical, roofing, fire safety, and pest issues come to light during a home inspection. Currently in Connecticut, home buyers who are often being advised to bid tens or even hundreds of thousands of dollars over the asking price for the home are then pressured to waive a home inspection as a means to make the offer more competitive. Our concern as home inspectors is that in most cases, buyers do not understand clearly what they're giving up when they waive their inspection. By normalizing this practice and without consumer protections, these buyers are at great risk of financial jeopardy and other damages. We are not asking for a mandate for home inspection, but I kindly ask that you consider adding a provision to HB 6888 to prohibit the waiver clause in the home inspection agreement. Thank you for your time, and I'm welcoming any questions if you have them.
Thank you. Any questions from members of the committee? Representative Scott.
Thank you, Mr. Chair. Mark, thank you for coming in and talking to us today. I'm not a realtor. That's not my world, but I do want to understand what is like the home inspection waiver as part of the process of the buying process. Like, can you explain that a little bit more, what that waiver is and maybe why it's not good, like theoretically for the process?
Sure. Thank you, Representative Scott, for that question. What we're seeing in the industry is that because it is a competitive market, buyers are being encouraged to waive their right to have a home inspection done on the property as a means of making their offer more competitive. So if you had 10 or 15 people bidding on a house, the person who waives their home inspection now automatically bounces to the front of the list. And understanding and being empathetic to the stress that a lot of buyers and even some realtors would be under in the conditions that we have, it just does not make sense to be waiving a home inspection. The risks there are great, and as I said before, I think that in a lot of cases, these buyers are not informed what specifically it is that they're waiving. And the danger is that, you could spend a lot of money, hundreds of thousands of dollars. It's in a lot of cases, it's the biggest expense some people may have in their lives. And then, once you get to closing, you find out that you're looking at hundreds of thousands of dollars in damages to repair things that were overlooked because they were not thoroughly inspected when the house was when they were under contract.
Thank you for that, Mark. One final question I have, Chair, is are other states doing something for this? Like, what's the other states doing? Do we have surrounding neighbors? It's always something we look at to see if something's happened and how it's worked out in the industry. If we're not the first time doing it, the state first time doing it, how it's done and what the reaction has been with other states.
Sure. Again, thank you, Representative Scott, for that question. Currently, Massachusetts had a bill that was passed last fall, and they're currently in the process of moving that forward. In addition to our efforts here in Connecticut, New York and New Jersey are also in the process of implementing similar bills, and we're following their leads closely and trying to do things, as well as we can with their guidance. And again, I want to reiterate that the purpose of this is not to mandate a home inspection for home inspectors in the home inspection industry. It comes purely from a consumer protection standpoint. And we want to make sure that people have the right to at least have the house inspected if that's what they choose to do. That's what the language in Massachusetts stated clearly. New York is also following suit with a similar bill, although I don't think they're as far down the road as we are. Massachusetts is currently the only one I think that was passed.
Thank you, Representative Scott. Representative Butler.
Thank you, Mr. Chairman. And thank you for coming before us today. I think this is a very important bill. For one, I just wanted to get some background in terms of, do you have any idea of how many purchases have gone without an inspection in the last couple of years?
Representative Butler, thank you for your question. I don't have that information. I don't know if those statistics would be even available or published, because I don't know who would be keeping track of that. But what we can say as home inspectors is that we recognize this as a problem because in a lot of cases we're called in after the closing and then ask to do a home inspection. And that's where, we find that in a lot of cases, because the inspection was waived, so that their offer would be accepted, people are finding out that they have hundreds of thousands of dollars in repairs that need to be made urgently. These are not things that can be left, for a year or 2 years. These are things that in a lot of cases need to be repaired immediately. I had one personal experience with something like that, but I've heard other stories from other home inspectors that I've been talking to since we started this effort.
Well, thank you. And we probably need to actually do some investigation on, how many purchases are made without an inspection, just so we know what's going on out there. But I can't imagine anyone buying a house and not having an inspection. There's so many things that could be wrong. You could have termites, you could have crumbling foundations. Okay.
Yep.
The crumbling foundation will probably be more to actually fix that than the value of the house. So I think we really need to look at this seriously, and thank you for bringing this testimony before us today. Thank you, Mr. Chairman.
Thank you, Representative Butler. Senator Sampson.
Thank you, Mr. Chairman. Mark, thanks for being here today. I just, interesting listening to your testimony. I mean, obviously this is an issue that's been bounced around over the years a number of times. And I guess really what I want to get to is certainly sometimes in a competitive market, you will see people, cash buyers move to the head of the line. People that are willing to put less requirements on the seller are trying to do that to put themselves in a more favorable position, including waiving inspections. There's also a lot of people that waive inspections because they're knowledgeable about houses. Maybe they're a contractor themselves or something like that. But what concerns me more than anything about your testimony, and I just want to make sure that this is not actually happening in the world, because I'm a realtor. I've actually worked as a manager of a real estate office and trained people on how to be realtors. And we've always had the policy that you encourage an inspection, but ultimately it's up to the buyer. And you also have to be honest with them about, where they stand. And, there's other offers. There's probably people waiving inspections. You should know that. So it should be their decision. But you said in your testimony, you said that people are being pressured by realtors. You said that it's becoming that it's we're normalizing this behavior. You've said that they're being encouraged to not have a home inspection. I'm just curious. Do you have any actual documentation of that? Even anecdotal, that people have said that they've been pressured into not having a home inspection by a realtor?
Yeah, I think to say and again, Senator Sampson, thank you for your question. I think to say that there's pressure in some cases can be implied, but I think under the current conditions where you've got a buyer who maybe has looked at 20 houses over maybe, a year to 2 years, I think it would be naive to think that they are not feeling pressure when they put that last bid in, and they're worried that whether it's going to be accepted or not. And if then they're approached to say, you know what, and I do have anecdotal evidence of what I'm going to say, if you come to this level on your bid and you waive your home inspections, we will accept your offer. Your offer will, in more likely than not, be accepted. And I have anecdotal evidence of that. I have someone that can actually provide written testimony for that. If you'd like, I could follow up and provide that. I think the other thing that we're seeing happening too is that there's a new standard that's being established where it's, you don't have to do a home inspection, but see if you can get the guy to just come not in uniform and maybe do a walkthrough with you and walk around and point things out. And it's informally referred to as a walk and talk type of inspection. I personally will not do that. I know a lot of other home inspectors who will not do that, but it lowers the standards set by the state of Connecticut for a home inspection that we're bound to follow as home inspectors licensed through the state. I think it lowers that standard greatly, and there's no way doing a 30-minute or 40-minute walkthrough of a house, you're going to be able to get the thoroughness that you would get in what is normally a 2.5 to 3 hour inspection with a written report.
Thank you, Mr. Chairman. I appreciate that commentary. I just, I worry a little bit about folks listening to our conversation and maybe not having a full understanding what happens out in the marketplace. I mean, there are all different types of buyers and sellers, and there are some folks that obviously have much greater risk tolerance than others. You know, somebody who's a real estate investor or somebody who flips houses, you know, they don't typically get an inspection. They're going to go through the whole house top to bottom. You know, so I mean, there are certainly circumstances where people are educated and making that decision. My only concern would be if there is a rash of realtors pressuring people to not get home inspections. I really got to say, I don't think that's happening. In order to be a member of the National Association of Realtors, you have to sign up on the Code of Ethics, and the Code of Ethics basically certainly would frown on that. You could end up, you know, losing your affiliation if you were actually pressuring people to act like that. I appreciate your testimony. It's certainly a topic worth digging into. For me, it's a fine line between people being informed of what their rights are and to make their own decision, and also being advised of the value of a home inspection. And if you're doing your job correctly as a realtor, you're doing both. So at any rate, thank you very much. And I appreciate the opportunity, Mr. Chairman.
Thank you, Senator Sampson. Any other questions? Seeing none, Mark, we thank you for your time and thank you for being with us this morning. Or this afternoon now.
Thank you very much.
We're going to move on to number 4, John Guskowski. I think he's online.
Hello, Mr. Chairman Philippe, Chairman Marks, ranking members.
Just for folks who are online, if you can, sometimes we know that you can't, but if you can, try to turn your cameras on. Thank you, and please continue.
Thank you. I am attempting to turn my camera on. It seems to be disabled. So I apologize. Can you hear me all right?
Yes. The floor is yours.
Okay. Again, I apologize. I'm having problems starting my camera. I will continue to try, but I'll begin my testimony. My name is John Guskowski. I'm a professional planner and government relations officer for the Connecticut chapter of the American Planning Association. We are an association of professional planners and allied professionals, both in public and private sectors, and we are among the top planning and development experts in Connecticut. We appreciate the opportunity to testify today, and we are here to submit testimony on 4 bills before the committee. I'll note 3 of them in brief and spend most of my time on the 4th. We are in support of Senate Bill 1307, which creates a working group on housing and water supply. We support the creation of this working group, and we must ensure that the encouragement of housing growth is done in a way that preserves a safe and sustainable water supply. We are also in support of Senate Bill 1308, creating a working group on starter homes, as this is one key component of Connecticut's housing puzzle. Finding ways to enable and encourage starter homes will be critical to support the overall solving the overall housing crisis in Connecticut. So we need many simultaneous efforts. We are testifying in opposition of House Bill 6940, which creates a uniform standard definition for affordable housing. We would note that Section 8-39A of the Connecticut General Statutes already exists, which does define affordable housing in a comprehensive way. Other sections of the statutes do create nuance, like restricted affordable housing or naturally occurring affordable housing, but the baseline definition already exists, so we don't believe this is necessary. Finally, and most importantly, we're here to support House Bill 6944, requiring certain information of affordable housing plans. This bill basically adds some actual requirements and expectations to the existing requirement for municipal affordable housing plans. That existing statute has no standards, no tracking, and no enforcement. And this bill would set towns on a strong path forward towards making actual progress on fixing their regulations and pointing toward a specific goal of enabling housing developments. This bill still leaves the planning to the municipalities, and it continues to be a locally directed planning effort. And there are many, many paths forward to approaching hitting a specific target or putting the regulations in place to enable housing development. It doesn't require towns to build anything. It just requires towns to make it possible for the market to respond. And for the first time, it actually requires towns to show their work and to make some actual progress with a target and a goal. A couple of minor notes: we would strongly encourage to include some additional support to OPM staff and responsible growth staff who is being asked to review and negotiate
Ms.
these
Kowski,
plans.
Your 3 minutes have expired. If you could please summarize.
Sure, thank you. And we would also request to remove OPM as a potential target for legal action and focus on the towns to ensure that they are the ones making progress. Again, I apologize for my technical difficulty with the camera. And we would be happy to answer any questions as the committee may have.
Thank you, John. Any questions from members of the committee? Seeing none, we thank you for joining us this afternoon. Next, we
Thank you.
have Aaron Boggs. Good afternoon. The floor is yours.
Good afternoon. Thank you to the chairs of the committee and the committee members for being here today. My name is Erin Boggs. I'm the Executive Director of Open Communities Alliance, a civil rights organization and an organization which helps to coordinate a consortium of other organizations called Growing Together Connecticut, which works to ensure that Connecticut families in cities, suburbs, and rural areas can be economically successful with a roof over their heads and money in their pockets. In this time of great uncertainty, there are things we can do here in Connecticut to ensure that our residents, many of whom are already struggling, can weather the storm and grow together, not only to survive, but to thrive. Our 2025 legislative agenda includes 3 pillars: building homes, keeping homes, and supporting families. My written testimony includes support for many other things on the agenda today, but I want to focus my comments on 6944, which we call Towns Take the Lead, and is really focused on creating a more inclusive zoning structure in the state, which actually undergirds some of the other issues we're hearing about. If we can produce more housing, we will see fewer evictions, et cetera. I won't say more about the housing crisis, except to note that Connecticut is one of the most housing constrained states in the nation, and that is having an impact on families across the board. As the prior testifier just commented on, 6944 is really about just adding more structure to the current 8-30J affordable housing plans that all towns have to do. Right now, there are no targets within that. There's nothing that happens if towns don't come up with a sort of realistic plan. What this proposal would do is say every plan, like with anything you do, you want to have a goal. It would set out goals that are tailored to each town of units that they should try to target in and to allow in their local planning, and then a year later change their zoning to match their plan, so it's not a plan that just sits on the shelf. In the course of that process, towns can say, I can't meet that goal, and here's why, but here's what I can do. So there's an opportunity for towns to sort of make sure it's really realistic. And then if towns are able to do that, they are rewarded with priority funding for discretionary funding. So there's a way to add both sort of a carrot and a stick. And we also would encourage that there be an enforcement element to this. So not about whether housing is built, it's just about whether the zoning is changed and the planning has happened. And the reason for that is when you look across the country about what works when it comes to zoning reform, that's an important element. So what's really important here is that with this proposal, towns get a number to work with, which they can also adjust, but ultimately they are planning and zoning. So they really are taking the lead. It will create housing that we have needed here in Connecticut for decades. It will support the environment and encourage transit-oriented development. And ultimately, it will boost our economy and help fill the 77,000 vacant jobs in the state. I have some technical recommendations for the language, which is in my testimony, but apart from that, that's what I want to share, and happy to answer questions.
Thank you, Aaron. Any questions from members of the committee for Ms. Aaron Boggs? Representative Weir.
Thank you for your testimony. I skimmed through the bill. Towards the end of your testimony, you talked about this bill, I'm going to paraphrase because it was a few seconds ago, will support the environment and transit-oriented development. Can you expand more on that? You lost me there.
Sure, absolutely. So what we have right now in many suburban and rural areas of Connecticut is basically suburban sprawl. We have large lots that are generally larger than they need to be, even for septic systems, and it encourages lots of driving and things being separated, not densely developed in walkable communities. And so with this proposal, towns would be planning years in advance to zone for more housing. And that can be done. And I think the incentive structure would be that it would be done in a way that is more compact and allows for that walkability. And that ultimately is much better for the environment. And also the logical way of doing that and having things more densely built together means that it will be much easier to serve through transit. And so it would be very much a transit supportive initiative.
Thank you for that answer. And one more question through you, Mr. Chair. So many of the towns that I represent have limited, some of them, well, I think everyone has some sort of public sewer, but a couple of them are minuscule in terms of what everything's supported by septic. And for those of you who, some people I've met some people in my day who are not aware of what a septic system is. They, the pipe does not, any rate. So we all in the town of Hebron, where I'm from, we have a proposed affordable housing development that the town is very much behind. The townspeople are very much behind. The administration is very much behind. We have a lack of water, public water supply. They've been drilling, testing. To my understanding, there was some possibility there of the water, but it has not borne any fruit. And we're talking 2 years now. So you have a community that's interested in providing more housing, no water. So what happens to a town like mine who has a plan? Somebody else sets the goal for them and they say, that's very nice, but we can't do that. Are we going to be penalized through no fault of our own? Through you,
Yeah,
Mr. Chair.
Well, I think there are a couple of issues there. One is, and there's a really wonderful group of advocates working in Hebron to get more affordable housing built. And I want to just give them a shout out and give them a lot of credit because they're working very hard on that. And they have run into these issues that you talk about with needing to get more access to water. And so a couple of things on that. One is that if in the planning process that arises for any town as a barrier, then that can be stated and that can be a reason why their number would come down. At the same time, the beauty of this is that if you start to see that coming up for many towns, the state of Connecticut can say, okay, here's a big barrier. We should be thinking about investing in this. We should be thinking about maybe whether there's federal infrastructure investment that can happen to help us solve this problem. So one, it can be a reason that the number could come down, and two, will help identify solutions that could come into play later. More generally on water and sewer, there's a lot we can do in Connecticut that's even not on water and sewer in many cases. We all see McMansions going in that are quite large, and in some cases, those are generally on septic, and you probably could put at least 3, maybe 4, maybe 5, kind of missing middle, smaller apartments in those same kinds of developments. So like we need to be, I think, creative while sticking within the confines of what we can do that supports public health to get this housing built. And I think that doing something like this where a town is trying to get to a goal rather than working in a vacuum is going to help that kind of creativity and good planning happen.
Thank you, Representative. Representative Corpus, followed by Representative Roberts.
Thank you so much for your testimony. I'm over here. Thank you. Forgive me for trying to put all these pieces together as a first timer up here. We heard earlier in the Housing Committee the beginning of a fair share study about what allocations of fair housing would go to each municipality. But that's not baked yet. Those allocations are not fully formed. Then this bill, which originally I think came to us, or when we voted to hear about it, was worded in terms of more information in the municipalities reporting on their housing stock. But this seems to sort of leapfrog right into the fair share, dialogue, except that it's now got the onus on towns to provide what the OPM is, or what the OPM is going to ultimately decide is a reasonable share of housing. Are all those dots correct as I've just laid them out?
Not quite. So the number that is relied upon for this proposal is the number that will come out of the 2023 housing needs study. And that first part of that was reported out to the legislature a few weeks ago. And that was the need for affordable housing, a number that is the need. And that number will then be allocated out to different municipalities in a very specific way, depending on what's going on in the ground in that particular municipality, based on a formula. And that formula, the sort of fine-tuned details of that we're waiting on, and those should be out by April. But in terms of the need allocation, my organization worked with a consultant from Princeton University to develop the first run at that. And it turns out that the number that the state consultant came up with 3 different numbers, but the middle number is basically the same as our number. And then we have also done the allocations. So I'm very happy to provide you with our estimate of what those allocations would look like if you're interested in seeing them for your district.
Okay, through you, Mr. Chair, I have one follow-up. I'll take that as yes. Okay, so this is essentially those April numbers. Is that going to be available so that this bill will have 2 questions? We'll have numbers from municipalities. And second question is, if I read this correctly, the bill requires towns and cities in the upper 80% of the state's grand list to develop realistic opportunity plans. So first question is, are the numbers in this list? And second question is, why were the upper 80% of the state's grand list singled out? I personally represent a district a town which would fall in that upper 80%, but which is has very robust affordable housing and a very diverse community.
Yeah. So can you clarify your first question for me?
Will there be numbers associated with this bill that will essentially become a fair share kind of bill?
So under the 2023 housing need allocation statute that was passed, those numbers were supposed to come out last December 2024. There's a delay, but I have every confidence that they will be out in April. So I've been assured that that is the case, and I think there will be information for legislators to base their decision upon at that time.
Okay.
And then your second question was about the
why are requirements based on
for the 80%.
grand list versus actual affordable housing in a community?
Yeah. So what we have seen, and over the last 25 years in Connecticut, is that when there is some level of obligation to do affordable housing or allow it to be built, towns will, and especially suburban, more rural towns, will lean towards doing senior housing that may have 1 bedroom or studios. And that's also because that tends to be, for developers, a place where they can make some money. And that's important housing to have, but we also need housing that is, and maybe even lean towards condos that are home ownership. So we do, we think that housing is important, but we also need housing that's rental. We need housing that's for families with kids. We need housing that might be a little bit more affordable. And so to make sure that that is built, what this proposal would do is take towns that are doing a little better, so in the top 80% of that per capita income, and say, we're asking you to zone for some of this other kind of housing as well. So that's just the distinction with the priority affordable housing plan. And the difference between this and prior fair share proposals, importantly, and this is after listening to lots of people and having lots of conversations, is towns are not judged on whether the housing gets built. that's the way they do it in New Jersey. Not, towns don't ever, even in New Jersey, have to build the housing, but whether they're sort of doing what they're supposed to do is sort of the proof is in the pudding, is the housing getting built? Because there's so many barriers that can be put up at the municipal level. We heard that there were concerns about that, really a misunderstanding about that. So we shifted the proposal to say, it's not about whether the housing gets built, it's about whether the planning has happened and the zoning has been changed. So we were trying to be very responsive, and that was why we made that change.
Thank you.
Thank you, Representative Roberts.
Good morning or good afternoon. Just quick question. There's a lot of different numbers out there when it comes to like the need of affordability of housing. In your terminology, like to your recollection, how much do we really need, and basically at what level of affordability?
The number that the consultant for the state came out with was about 140,000 units. And that is a proxy number based on the number of people in the state who are at 30% of median income and paying more than half of that income towards housing costs. And when I say proxy, what I mean is the assumption is if you allow that number of units to be built, even if they're not as affordable, so even up to 80% of median income, you're still going to infuse the market with enough new units that it will house a lot of people who are housing burdened right now and bring prices down. There are other numbers that are out there that are lower, and those from the same consultant, about 111,000. That assumes that everybody who's in a house right now and they're paying less than a third of their income towards their housing costs, which I am. I've been in my house for 20 years. You may be. That lower number assumes that all of those people suddenly move to a house where they are paying 30% of their income. And so I understand how those numbers were developed, but I don't think that's a realistic number for the state, because I know I'm not moving from my house where I'm not paying 30% of my income. And I think that's true for a lot of other people in Connecticut.
Thank you. Mr.
Representative Zullo online, then Representative Butler.
Thank you, Mr. Chair, and thank you for being here today. Just a couple of follow-ups, and I apologize if this was addressed earlier. With respect to the interested party portion of this proposal, being able to bring an action in Superior Court, my question is it the secretary? I realize the burden of proof is placed on the secretary with respect to whether or not the plan is in conformity with provisions of this proposal. Do you contemplate that the town, for you, Mr. Chair, would not be a party to this action? It would just be the interested party and the secretary?
Representative Zullo, I completely agree that portion of this language is vague, and my recommendation is that it be clarified so that there can be action if needed against either OPM or the municipality. And again, this would only be an action to make sure that the plan is really happening and the zoning is changed. And part of the reason for that is, as you know, with the affordable housing plans that were required through 8-30J, when that deadline hit, I think something like less than half of the towns in the state actually submitted their plans. So I like the idea that you could do this and not have anything that really requires it, no ramifications, but I think this is the request of towns is pretty minimal, and then we want to make sure it happens though. So that's why some kind of enforcement is important.
I appreciate that. So I'm glad that you're open to some types of potential revisions to it. And then with respect to that same portion, my follow-up would be, would you be open to the concept that if a town or the secretary prevails, that the interested party or entity would be responsible for the attorney's fees for the prevailing party?
Yeah, I think that this should work like many statutes that are in the public interest in supporting civil rights, where there's burden shift or fee shifting, but it only goes in one direction. So it would mean that the town would still need to bear the legal costs.
Okay. I would have substantial concerns about developers using this as a shield and as a sword putting towns on their back heels, essentially saying, hey, you know, if you don't approve my application, I'm going to file one of these actions and tie you up, and you're going to have to spend all these fees, and there's not a darn thing you can do about it. That scares me a little bit.
Yeah,
But
I would be really, I hear you. I'd be really happy to sit down with you and think through about ways to head that off and make sure that doesn't happen.
well, the solution is simple. It's to make the prevailing party entitled to attorney's fees. Listen, it could go both ways. I would be open to exploring it going both ways, and I think you'll have good faith on both sides. But I substantially worry about that. I don't want to tie up. Feel free to respond. I just don't want to tie up too much time. I know I'm online and we've got a lot of people today, and I know where to find you offline. So
Okay. Well, my concern about that would just be it would hinder, it would make the suits would not be brought at all. In that case, that would be my concern. But I also think there are probably some, you know, there are probably some strategies that could be used, some language that could be put in that would stop your, you know, would address your concern.
thank you for the indulgence, Mr. Chair. I'll find you offline for anything else. Thank you again.
Thank you, Representative Butler.
Thank you, Mr. Chair. Hello, Aaron. Thanks for coming and sharing with us today. I have a few questions, but I'm only going to ask one in the interest of allowing other people to come to speak before us. My one question that I'm going to ask you is regarding the municipalities that have already met the 10% affordable housing threshold. Would those municipalities already provide enough information to satisfy the requirements here, or would this be for every municipality in the state of Connecticut?
Well, the fair share, the number that is coming out of that study from 2023, the way that works is it does not get handed out. A unit number does not get handed out to any town that has a poverty rate of more than 20%. So many of those towns have already gotten to that 10% number, so they would be not required to do anything under this other than the regular, just plain old affordable housing plan that they already have the obligation to do. There may be, I think there are like a handful of towns that would still have a little bit more to do than the 10%, but a very small handful. And so, you know, that would be, I'd have to go back and look at the numbers given the new numbers that are coming out, but it's fewer than 8 is my recollection.
Okay, thank you for your testimony. If you could provide it to us in an email, I appreciate it. Thank you, Mr. Chairman.
Thank you, Representative, and thank you, Aaron, for being with us. I do want to just note one thing about the proposal that I don't think has been talked about is the giving of a reason for why municipalities can't develop. I think is a super important thing. I think people come before this committee and or to different committees or different working groups in this legislature that we put before folks, and they give us reasons as to why they can't do it. And half of the time, I'll be honest with you, I look at them as excuses half of the time. But when you have it stated clearly somewhere, it gives us an opportunity to look at those things, to address those things for those municipalities and make it easier for them to develop. So I just want to thank you for that piece of it. Thank you for your testimony and have a good rest of your day.
All right. Thank you very much.
Next, we have Travis Woodward online. Good afternoon.
Good afternoon, Senator Marks, Representative Felipe, Senator Sampson, Representative Scott, and members of the Housing Committee. My name is Travis Woodward. I'm a resident of Hamden and an engineer for the Connecticut Department of Transportation. I'm also president of CSEA SEIU Local 2001, a labor union representing 25,000 state, municipal, Board of Ed, active and retired public and private sector workers. For the following testimony on behalf of the members of CSEA in support of HB 6889. Housing insecurity is an issue that too many people in our state and nation face. This includes fellow union members who, even with contracts, are confronted with low wages, expensive rental costs, and lack of residential options. There is no reason why a paraeducator or a school bus worker should have to work multiple jobs to make ends meet. Ensuring that people can live their lives filled with dignity and respect is essential. Having a place to call home is central to that. Everyone needs a safe and stable place to live and a community where they can put down roots. That's how we build prosperous, stable families and communities in a thriving state. In a state as wealthy as Connecticut, we could be leaders in ensuring that everyone can afford a stable, healthy place to live. Rent hikes and no-fault evictions are displacing families from their homes and communities, fueling gentrification, driving evictions and homelessness, and mostly impact Black and brown working class renters and immigrant communities. Yet, current law puts no limit on how much landlords can raise rents and only protects senior and disabled tenants in larger apartment buildings from no-fault evictions. For over 40 years, Connecticut has a law providing just cause eviction protections for tenants who are 62 and over or who have a disability and live in a building with 5 or more units. This law has no unintended consequences and has effectively prevented these tenants from arbitrary displacement. Connecticut should join with the 7 other states and over 24 cities that have universal just cause policies. Expanding just cause eviction protection will effectively result in at least a 10% reduction to evictions overnight. That is a low cost and effective policy solution to, in part, mitigate the worst effects of the housing crisis. I strongly urge you to support HB 6889. Thank you.
Thank you for your testimony. Do we have any questions from any members? Nope. Thank you, sir. Much appreciated. Next, oops, where's my list? Here it is Representative Jamie Foster here? I don't see her. Jose Benitez. Welcome.
Got it. I thank you, Chair of the Housing Committee, Republican Phillip and Senator Marks, for the opportunity to speak. I'm here to support the HB 6892, limiting the rent increases. My name is Jose Benitez, and I live in New Britain. I just want to share a little bit of the story. I live in a complex, which is a housing complex, and it was bought out. And myself and a lot of tenants there, well, so a lot of the tenants had to leave just because the flipping, the rent increases that are happening. They're like between 40% to like 70%, depending on if they want to work something out with you and they want to leave you there. If not, then you would have to mind you, I'm a little nervous. This is the first time I'm speaking in front of a lot of people.
You're doing great. You're doing great.
So, so this is my point of view. I lived there for 7 years. I'm a single dad of 2. I've had custody of them for about 8 years. So living in that actual complex helped me a lot. The flipping of what happened, that they actually sold it to somebody else, they're actually coming in and they're changing everything around. Some of the people that are there, they pretty much, it was, like I said, it's housing. So they can't afford that big increase that they're actually giving out. $400, $700, up to $1,000. So if, like I said, if you stay there and they don't do nothing to your apartment, and if they want to work something out with you, depending on how many units you have in terms of bedrooms, it could be an increase between 40% to 70%. That's a lot. So I know that if this bill passes, it's going to help a lot of people. I know because I'm living it now. So hopefully, you guys do pass this, in the near future, it'll help other people as well.
Thank you. Any questions from, okay, Representative Baker? Butler.
Close enough.
Yeah.
Thank you, Madam Chair. I just have one question. I want to know if you or others where you live actually was able to take advantage of going before a Fair Rent Commission to actually present your issue, and if so, what was the outcome?
Okay, so to be honest, I really don't want disclosure on my side if I've done it or not. But I know that was a tenant that did it, and because of what he did, there was retaliation. The new owner say, "Oh, we found out you went over there, so guess what? We're not gonna do your lease, and here's a form for vacant. You got to leave." So it's like, I know that's not proper, and I know somewhere along the line that's has to be against the law, but it's just retaliations that we also face when we try to get some kind of help with the new landlords or the new owners. So sometimes is the best is in hoping that they negotiate something with you, out of the goodness of the heart, because it's morally right to do it. But when it's just because of money, they just want to flip. At the end of the day, they just don't care if you leave or not. So I'm very skeptical going that route because I have to say I'm a little fortunate to still be in the old lease. But just because I'm in the old lease, it doesn't mean that what's happening to the other tenants eventually is going to happen to me. So that's why I'm trying to speak out and, hopefully speaking out also for the tenants that are no longer there, which some tenants were there for decades. So it's unfair for these tenants that it went the way it did.
Well, thank you for sharing, and I could understand exactly what you're talking about. I will say that the bill actually brings into play the Fair Rent Commission, so that issue of retaliation isn't going away. It's just a threshold that 10% that's going to be, a guideline to follow. So, we need to look at this because we don't want the retaliation as well. We just want to make sure this works for both parties. So thank you for your testimony. Thank you, Madam Chair.
Thank you, Representative Butler. Anybody else? I'll just ask you, Mr. Benitez, how many apartments are in the building?
Believe there's about 81 units.
Okay, so
And it's not a
pretty-
building, it's actually a complex. Each building has about 4 units, some of them has maybe 6 units, but it's a complex.
Okay. And do you know you obviously don't know what happened to all of the tenants, but were those that had to leave because of the increase, were they able to find other housing or did any of them become unhoused?
I actually can't tell. I know some of them were able to negotiate something, and I know some of them that were able to negotiate. They are still living there, but they are like really tight on money right now because it's like, okay, you go to the street or you negotiate. So sometimes you got to bite the bullet and just pay because it's like, okay, I can't really afford it, but I have to do it because I got kids and this and this and that. So at the end of the day, I couldn't really give you a specific answer on that, what happened to the other tenants. I know they moved out. I know they have a lot of apartments vacant. Like I said, that's if they're willing to negotiate, because like I said, they need to flip these apartments. So they might negotiate with you for a certain amount of time, but eventually they're going to want you out of the apartment because they want to do some quote unquote remodeling so they can sky it up even more and get more money out of this apartment. But they don't realize that they harming the families that are living there because some of them they just don't got nowhere to go.
It's stressful, right? Like life,
Very
life is
stressful. As my time is ticking, it just becomes even more stress because now you think about it more and more. Okay, it's the uncertainty. You don't know if they're going to do something for you, if they're going to say, oh, you know why? You one of those tenants that we can't negotiate because we need your apartment. We got to flip it. So now it's like, that's my bad luck now. It's not due to being a bad tenant. It's what it is. I get it. It's a money game. Sadly, it's a money game. And I get it that when you invest in something, you want to get something out of it. That's just what it is, investment. But the ridiculousness of actually increasing so much money and off the back, not saying, okay, we're going to do a lease, we're going to increase 15% or 10%. And then for the other lease, we'll increase. That's the way to go about it. But off the back, asking all this money, I just feel like that's just another way just to get everybody out because they know it's a subsidized housing, so it's like a lot of people can't pay it, so they have no choice, they gotta leave.
And it's not just a roof over your head. It's a community there. You said there were people there for decades and they take care, you know, if Miss Marks was living next to you and she was going to be at a public hearing all night at the LOB and her cat needed to be fed, Mr. Benitez would go feed my cat for me.
Correctly.
Yeah.
Just like I give you an example. I don't, you know, they supposedly they have their own contractors to shovel the snow, but when I shovel my area, I shovel my neighbor's area. You know, I just do that. We had that good neighborly. Sadly, now in my building, in the next door building, I only have maybe like 2-3 neighbors left out of the other ones are all vacant because they had to leave.
And when you have children, it's nice to know who your next door neighbor is, isn't it?
Correct.
Yeah.
They can't just put anybody up in there.
Yeah,
But
it's really
unfortunately, when it's
nice.
about money, sometimes they overlook that. It's reality.
Yeah. Well, thank you for your testimony and you were heard and it makes a difference. So thanks for being brave.
Yeah, thanks for listening.
Yep. Bye-bye. Did Rep. Foster come in? No. Okay. Next we have Deborah Tangaroni online. Hi.
Good afternoon, Senator Marks, Representative Felipe, and distinguished members of the Housing Committee. My name is Deborah Tangarone. I'm a resident of Hamden and here to speak on behalf of the Housing Research Team of Congregations Organized for a New Connecticut and our broader Connect membership of 36 congregations representing 30,000 people in New Haven and Fairfield counties. My co-chair, Melanie Lee, and I appreciate this opportunity to submit testimony in favor of House Bill 6889, an act concerning evictions for cause. Our housing research team was convened about a year ago, and we heard dozens of personal challenges in regional gatherings across our multiracial and interfaith membership. After many meetings internally listening to these stories of housing hardships and many meetings with experts, advocates, and allies, we've decided to support the evictions for cause legislation this session. Our member congregations and leaders stretch from Stamford to Branford to Meriden. We've heard stories about renters facing eviction and homelessness. Some worry about retaliation if they report issues to their landlord, in line with what Mr. Benitez was just talking about. I have been a tenant at the same location in Hamden for just under 20 years. Prior to 2021, my annual rent increases remained pretty static at 2%. But after 2021, those rent increases ranged from 5% to 11%. And without the protections of just cause legislation, I've been reluctant to negotiate a more fair and equitable rent increase for fear of my lease not being renewed. In other words, take it or leave it. We at Connect believe all tenants should have just cause eviction protection. We urge you to vote in favor of House Bill 6889. As you know, the bill stalled last year after being approved by this body. We urge you to pass the act and as early as possible. The bill has been thoroughly vetted, has gotten significant buy-in across the state, and is urgently needed to make our communities better. Expanding the existing just cause protections to all renters ensures housing security and allows residents to establish roots without fear of arbitrary displacement. Evictions devastate our communities, and their negative impacts fall hardest on working class, Black, and immigrant tenants. While this legislation alone will not remedy the entire housing crisis we face as a state,
Your 3 minutes have expired. If you could please summarize.
this legislation will be a critical part of the solution to stop the destructive impact of no-fault evictions. Thank you for your time.
Thank you, Ms. Tangerone. We appreciate your advocacy. Any questions from the committee? Seeing no questions, thank you very much. Next, I am going to skip down to Rep. Ann Hughes, please.
Thank you I'm Rep. Ann Hughes. Thank you, Madam Chair and esteemed committee members and colleagues. I feel like in this moment, I'm very, very pleased to see so many bold housing committee bills being raised this legislation. This session, I'm very much in support of. In this moment, I urge my colleagues to do two things: protect our people and fund our services. In this incoming administration's harm, we really need to protect those most vulnerable, most impacted by the harm that's being rained down upon us, those most vulnerable. And therefore, I'm so excited to see right to counsel being funded. We need to fund these services. And I really want to cede my time to people that can amplify the voices of those most harmed. So I'm proud to introduce Hannah Schreier, who is the president of Connecticut Tenants Union, for the remainder of my time. Thank you.
Thank you very much. Good afternoon, members of the Housing Committee, Senator Marks. My name is Hannah Schreier, and I am the president of Connecticut Tenants Union. I'm here today to testify in support of HB 6889, an act concerning concerning evictions for cause. I represent hundreds of members in Connecticut who are renters who come together every day with their neighbors, with their neighborhoods, with their communities, and with other tenant unions across the state to fight for housing security, stability, and dignity every single day. It's my honor to represent them, and I'd like to say a little bit about who they are. We live and work with you every day. We drive the buses you take to work, we fix your cars, we deliver your mail, we are carpenters, we are builders, we are building inspectors, we are CNAs, we are nurses, we lead Bible studies at your church, we do cleanups in the park, we are crossing guards that get your children to school safely, and we are veterans. We are your neighbors, and we represent every corner of this state. And I'm here and we're here today to insist that the needs of tenants matter and are foundational to the future of the state of Connecticut. So why just cause? We're sick and tired of watching out-of-state corporate landlords evict whole neighborhoods, you just heard a story, whole communities, so they can raise the rent for maximum profit. We're sick and tired of investing in where we live, planting gardens, joining community management teams, etc., and then getting a no-fault eviction notice on our door because the landlord wants to rent to someone who can pay more. And we are definitely, our union membership is absolutely sick and tired of getting together to fight for their rights, for timely repairs, preventative maintenance, reasonable rent, only for landlords to retaliate with no-fault eviction or to discriminate against our families who are Black and brown, who have young children. That's why this year, like the year before and the year before, we're backing HB 6889. Although the building size restrictions do leave out a significant portion of renters, expanding just cause is an easy, no-cost step towards solving the record high displacement, insecurity, and instability renters currently face in Connecticut. Again, it does not cost anything. It's simple. It's been proven to work. We've had a version of this law in the state for 40 years and in our surrounding neighboring states in the Northeast. And in those 3 years that we've been pushing this bill, thousands of families have been no-fault evicted, and many of those families are homeless. I have stories of a few. In this rental market, in this year of historic homelessness, let's do the right thing and pass this bill in 2025, and we can reduce evictions by 11% this year. So let's get it done, because I'm tired of allowing corporate landlords to set the conditions that our families live, work, and raise their children in. And I'm tired of these unchecked greed by these corporate landlords like Up Realty, Yoso Properties, and Alpha Capital that continue to run the way that our neighborhoods live and thrive. And I just want to point out,
your 3 minutes have expired. If you could please summarize.
tenant movement is here to stay. We're not raising new problems. We're just making them more visible. let's get this done.
People, please, 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 I just respectfully ask that we not clap at a public hearing. It just, we don't like to have professionalism. Thank you, Hannah. Thank you, Rep. Hughes. Hannah, I often hear about no-fault evictions. Some people say they happen, other people say they don't. Have you seen no-fault eviction in your leadership as with the tenant union? And if so, could you give an example?
Yes, so I'll give two examples. One is when 17 families were given no-fault eviction notices at once in retaliation for negotiating a collectively bargained lease. And it took us 10 days, but we successfully fought those evictions. But that was a very clear instance of no fault of the families in this union that were just trying to negotiate repairs, communication, and fair rent. And then I'll point out another instance of a property that was no cause evicted. So the new owners could do poor renovations and jack up the rent. And I know several of those families struggled to find housing for several months.
Thank you. Any other committee members have any questions? Okay, Representative Weir.
Thank you, Madam Chair. Hannah, this is for you because you just mentioned something and I, towards the end of your answering that question, that the people who received eviction notices collectively bargained for their leases. Now I understand collectively bargaining in like a labor situation or employment situation. How does that, who recognizes, in that case, that's recognized by the NLRB, who recognizes a tenants union on a housing side? How are you recognized? Through you, Madam Chair.
Go right ahead.
Yep, that's a great question. So just like before the NLRB employers recognized unions, it's the same thing that landlords recognize the unions, and often it's in everyone's best interest for that recognition to happen. In this case, tenants were given a really crazy rent increase of up to $300 that they had to start paying in 2 weeks. And so folks got together and negotiated a contract, and that contract is signed and communication is open with that landlord. So it did reach ultimately a good outcome, but in the middle of that campaign, it did go south.
Thank you for that. So in that example, and I'm sure there are more of them, but in the one that you listed, the both parties were able to come to an agreement through, whichever way they got there. But you said it went south, but then they were able to work it out, but didn't need no outside body stepped in and arbitrated it on behalf of one or the other.
No.
Okay, thank you.
Any other members? Yep. Representative Sweet.
Thank you, Chairwoman. Why is passing just cause this session important to the Connecticut Tenants Union and its members?
It's very important because we see the impacts every day of eviction on our families. We know that it's the leading cause of, children not doing well in school, folks needing to find new employment, et cetera. And I think right now we are in a housing crisis, which everyone is going to say that over and over and over and over again. And if I could just like blink my eyes and build 150,000 more units immediately, I would do that. But this is a way that we can safeguard the housing stock that we have, that we can keep communities together. We can keep neighbors being neighbors, which is important for all of us, for the cat to get fed, for our children to know who they're playing with. And so I think it's no cost. It's easy. A form of it already exists. Why not just get it done now? I see it as the easiest possible path forward to get some housing stability quickly.
You all set? Okay. Any other questions? Chair Felipe?
Thank you, Madam Chair. I just want to say thank you for being here. I know this is a big priority for you guys. I guess my question is, we've seen in a couple of places around the state where there have been mass evictions. Can you just talk about a couple of those scenarios where there have been, mass evictions by people who have maybe newly bought a building and then kick tenants out, and what the people are facing through those?
Yes, there's one particular actor, Up Realty, that does this relatively often. For example, they're buying up the quiet corner, and then they're going in and no fault evicting all of the tenants, including those who are currently protected by our just cause law. Thank God some of those folks are union members, so they're able to understand their rights and fight for them. And then clearing out those buildings, doing little to no repairs or doing some repairs that aren't done very well, and then putting those units back on the market for, you know, $300+ that they were being rented for or more prior. I mean, we've seen $1,000 more dollars, right? It's a little bit nuts. And we're seeing this not even in the typical areas that are closer to New York City, but all over the state. And if it's not in your districts, it is coming for your districts. I want to be really clear. And unless we get this passed this session, and then you will be saved from a lot of calls and emails.
No, I can tell you that in my city of Bridgeport, I've seen exactly what you're talking about, where it's been up to $1,000 in a rent increase. You know, for a 2-bedroom apartment that was $1,800, which is obviously at this point unheard of to find a 2-bedroom apartment for $1,800, but that's where they were, and they raised them to over $3,000. So
right.
It's a really, really tough leap for people to make when it's over a certain amount. And I stated this earlier. They say 3 in 5 Americans can't afford a $400 emergency if it happens to them right now. And that's 2.5 $400 emergencies. So thank you.
Thank you.
I too want to thank you. We saw it in East Lyme, Connecticut at Windward Village, where I don't think East Lyme ever thought something like that was going to come and hit them, right? Everybody living happily and living there for decades, and it happened. And East Lyme was quick. We got them help from the Commission on Housing of Equity and Opportunity, which helped East Lyme form a fair housing committee and fair rent commission, and it worked. It worked. But it shouldn't have had to go to that. So we want to thank you for your advocacy.
Thank you very much.
Yep. Yep, Ranking Member Scott.
Thank you. Real quick, one question. You mentioned about one of the mass ones where they did not so great renovations. So I have a question. We heard in a presentation a couple weeks ago about the housing stock. It's getting older, right? We hear that in even the housing stock we have, while it might be limited, it's getting old, right? How does a person who owns a building or whatever rental unit, how do they go about fixing it? Let's just say theoretically fixing it in a good way. How do they go about doing that without getting someone out of it, like really truly renovating that building, renovating that unit, without ultimately just cause getting that tenant out to be able to do it? It might take 2 months or so. Like how's it go? Because if we don't do that, then none of the units will ever theoretically be able to be renovated in a true good way. So how does that work between what you're trying to advocate for, but also trying to fix units that a lot of them are pretty crappy?
I just want to be clear what I'm talking about typically, and how landlords typically use no fault eviction, is that they are speculators. They buy a property and their intent with the property is to do some sort of paint job or shoddy electrical work, and then 3 years of that, and then sell the building at 20%, right? Like higher than what they bought it for. So that's what I'm talking about, is when they're just doing cosmetic repairs that often degrade the housing stock over time, which I think also preventing no fault evictions will actually ensure that that does not happen at the rate that it's happening in the state with such a old housing stock. And I also think that tenants are also the ones who know when the windows are leaky, when the pipes aren't working, when the electrical is faulty. They are the ones who are often alerting their landlords, hey, this is not a safe and habitable living environment. And so what passing an expanded just cause law would do is enable folks who right now fear retaliation for speaking out about repairs to say, hey, guess what? I really, really need you to check out the heating that's happening because I'm afraid that something is going to go wrong, et cetera.
But what happens when those repairs are needed that someone cannot be in the unit to do so? If it's electrical in the walls that needs to be totally redone, what happens then in that scenario? That's not retaliation to get rid of them. It's we need to fix it. You brought up a problem as a tenant. We need to fix that problem. What happens in that scenario? Are you supportive of that person being not renewed so that building unit can be actually repaired in a proper and better way?
Hannah, I don't remember your last name.
Schreier.
Ms. Schreier?
So in that instance, I would say that the tenant needs to be temporarily housed the way that the landlord is responsible for temporarily housing a tenant when, let's say, poor electrical work causes a fire that displaces them. So I would say a reasonable relocation and then moving them back into the unit.
All set. Anybody else? Okay, we thank you both very much.
Thank you.
Next we have Mr. John Kerwin.
Madam Chair, if I may, just before the good man gets started, if folks do want to react to somebody instead of clapping, just wave your hands. Silent, and people can see that you like what they said. Also, there's a box that folks have of t-shirts that are blocking the door. Just make sure that you move it out of the way of the door. Thank you very much.
Welcome, Mr. Kerwin.
Thank you. Senator Marks, Representative Felipe, Vice Chair Roberts, Ranking Member Scott, and other distinguished members of the Housing Committee. My name is John Kerwin. I am the Supervisory Assistant State's Attorney for the Housing Unit of the Office of the Chief State's Attorney. This unit is a statutorily mandated unit comprised of 4 prosecutors responsible for prosecuting health, fire, and building code violations throughout the state of Connecticut. On behalf of the Office of the Chief State's Attorney, I am here to express support for HB number 1303, an act concerning non-resident landlord registration and increasing penalties for repeat building and fire code violations. This proposal is intended to address an ongoing problem faced by code enforcement and housing prosecutors throughout the state in properly identifying and initiating criminal action via arrest warrant against non-resident landlords who have been cited for violations of building, housing, or fire codes. This proposed amendment seeks to modify provision section 47A 6A of the Connecticut General Statutes to mandate that larger municipalities, those with populations exceeding 25,000, require a non-resident owner, project-based housing provider, or agent to register an actual residential address and provide proof of identification by way of government ID to the municipality. This amendment seeks to address the widespread practice among many non-resident landlords who use a commercial mailbox facility such as a UPS mailbox or Dropbox or similar service, or the address of the rental property as their identification form with the municipality. This is occurring with both individual landlords and managing members of LLC landlords. Additionally, many of these non-resident LLC landlords are being organized in states that don't require disclosure of managing members' identifying information. These practices severely limit the enforcement of fire, health, and housing code violations by municipal agencies. When in order to abate or in order to correct a violation is issued to by an agency and it's ignored by the landlord or the principal members of the LLC, these orders are referred to my unit of the housing unit for prosecution. If there is, however, no actual address or date of birth for these violators, these unscrupulous landlords are generally beyond the reach of criminal process because the state is unable to identify the accused landlord to the degree necessary to secure the warrant for arrest. So without a date of birth or an actual town of residence, we can't pursue a warrant and put it into the interstate system to have it served. HB number 1303 provides a solution to this problem by requiring larger municipalities and allowing those smaller municipalities to enact registration ordinances, and importantly, to broaden the required identifying information to include a form of government identification. This act will remove the veil of immunity that these landlords currently enjoy, and it will spread the message that Connecticut is serious about enforcing compliance with housing laws. Additionally, Section 2 of the bill further promotes compliance by expressly including this registration requirement into the specific list of statutorily mandated landlord responsibilities imposed under Connecticut General Statute Section 47A7. Lastly, with regard to sections 3 through 5 of the proposed bill, those provisions for increasing penalties for repeat building and fire code violations, I commend the Housing Committee's members' efforts to strengthen the enforcement of these code violation prosecutions. However, rather than sending the strong intended message that there are significant consequences for repeat violations, these provisions actually reduce the overall penalty, thus sending the wrong message. So I'm available to answer any questions through the chair.
Thank you, Attorney Kerwin. Yep, Representative Butler.
Thank you, Madam Chair, and thank you for your testimony. This has been a problem for an awfully long time, and even going back to the days when I was alderman, this is one of those issues that have plagued municipalities for decades. So to get this information would be crucial in identifying people, to contact the people who actually manage, own, or operate these housing buildings, units, whatever. So I'm glad to see it. And this is something that is much needed for the state because a lot of times a lot of the bad actors actually are operating under this veil. So we need to actually address this. And even if it's just things that we need to address that, to get a hold to some of the people who are operating these properties, just there's an issue that they need to be contacted. We need the information. Now, you mentioned something about the enforcement, that what we have in the bill is probably less than what you would recommend. Could you talk about those parts of the bill and what you would recommend versus what's in the bill?
Yes, through the chair. Thank you, Representative Butler, for that question. So I think your question is specifically addressed to sections 3 through 5. And just a little history. Last year, the Chief State's Attorney's Office had submitted this same proposal through Senate Bill 209, which had the subsequent offender penalties provision, sections 3 through 5. This year, we did not provide that. That was through the initiative of this committee to provide those penalties. We had felt that it would be a distraction away from the more important provisions of the landlord registration. But to address your question specifically, there's some problems in the way that the proposed language is drafted, where in fact a subsequent penalty does not include jail time. So you're making it less of a penalty. The primary penalty for a first offense includes jail and a fine component. The way the language is provided in this proposed bill, that second so a conviction having a prior conviction on your record, which would be an enhancement, actually the way the proposed bill is written, it provides only for a fine. The language doesn't include that jail provision. And I knew that the intent was to just provide enhanced fines. I think it's important, though, that we look at, these are tools that prosecutors use as charging. So these provisions don't come up generally unless a prosecutor chooses to go forward and charge a person as a subsequent offender. So in a criminal trial, you would have a trial on the underlying guilt or innocence, whether the person in this case violated, let's say, a fire safety code. If a jury then convicts that individual, we have what's called a Part B, where the court or the jury then decides whether, when that offense occurred, this individual, this defendant, had a prior conviction. Right? So that requires a lot more charging, a lot more court work. And so prosecutors are forced to say, is the game worth the candle? Is it really worth it? And just to look at your provisions, for example, I believe it's on page 7, which is lines 179 through 181 of the proposed bill. Basically, you increase the penalty only by a minimum fine of 200 to 500. That $1,000 penalty still prevails, and it doesn't provide any additional jail time. So as a prosecutor, am I, if this was enacted, am I going to, spend that extra time with the jury, with the court, to give the court the ability to add a minor, an extra $300 as a, so it really is not anything that the prosecutors would be looking for, the way it's drafted. So again, that was part of the calculus. We have a limited amount of bandwidth, I realize. So I wanted to keep the focus on the landlord registration provision. But again, I commend the committee with coming up with these enhanced penalties. I would just ask that maybe, somebody, that it goes back and those jail provisions are put back in the subsequent offender provision, the same amount, at least so the penalty doesn't get reduced. So it, it remains at least consistent with an additional fine.
Representative Butler.
Thank you, Madam Chair. I'd just like to thank the gentleman for his testimony and taking the time to answer the question thoroughly. Thank you for your testimony, and thank you, Madam Chair.
Thank you. Representative Weir.
Thank you, Madam Chair. I have a question, but I would like to just set a little bit of a history here, if I may, through you. So this is my 3rd year. Thank you, by the way, for your testimony. My 3rd year serving on this committee, and I think the committee members have changed somewhat over the time, but we have identified, I would say, a common theme around this table, or whatever structure you call this here, that we've got, not all the housing providers and landlords are created equally. We've got large providers, large scale providers who do a great job at providing a service, and their residents are very happy. And you've got large scale providers who do a terrible job, the bad actors, as we call them, who are leaving people in terrible conditions. We've heard about roaches and rats and mold and unaddressed building code violations. And so part of the solution to that was, well, let's go after some of the larger scales. But I think we also recognize that there are small scale operators who also run a shabby operation, who have residents living in terrible conditions, who are not being held accountable. And so I like where this bill has gone, because we've struggled in the past. I am a huge opponent to one size fits all. Let's drop a hammer on this industry and scare away people who are providing the services, right? So I like where this is going. I think this is heading in the right direction to grant local authority, local municipalities more authority to, they're closest to where this is happening, right? And so what's happening in Hamden may not be the same as East Lyme. It may, and allow those municipalities. So the question is, after all that, is there any, has any consideration been given in addition to the fire marshal, to expand some of these authorities, maybe to a building official through a similar manner, or a health department, to give more, more people looking at a problem situation? The fire marshal may not be looking at roaches. He or she may be looking at, is any consideration to expanding this to other enforcement agencies within a municipality, and allowing for a more focused approach versus a one size fits all? Through you, Madam Chair.
Attorney Kerwin.
Through the chair. Thank you, Representative Ware. Very good question. And that was specifically the reason why we didn't include the building official, or the building code and fire code officials, with the landlord registration, because the two aren't really related. The landlord registration would apply to any code official. So that would be building, fire, health department, the municipal housing code inspector, should a municipality have ordinances that establish a housing code. The registration provisions would benefit all those agencies and organizations in the city, because it would allow them to identify those bad actors that you talk about. And I agree with you that, there are bad small landlords and bad big landlords. There are also good small landlords and good big landlords. What we're trying to do is really kind of promote uniform enforcement. What's happened is, I hate to, it's not an intentional thing, but if you can't enforce something against an individual because you can't identify them, well, that's going to put more emphasis and more of the resources are available to those in-state, in-house, or not in-state, but those landlords that are known to the, that live in the community. So the purpose behind this was to really make it more uniform, that we, enforce not just those individuals who we can identify that we know that live in this, live in the community, but those that have come from out of the community that have taken efforts to conceal their identity. But the registration provisions benefit all the fire code, the health departments, building officials, probably forgetting a few, and I don't mean to slight any of them. But yeah, it is, that's the whole purpose behind it. Once you can identify them, you can issue those type of orders for compliance. So it would apply to the roach situation that the health departments would investigate, fire code violations that the fire marshals investigate, building deficiencies that the building inspectors investigate. Once they can identify that landlord, then they can go forward with their orders and we can prosecute them.
Representative Weir.
Thank you. And I think a couple of groups that were left out is you may have in-state landlords who are bad actors, and you may have some outstanding out-of-state landlords who are doing right by their residents, and it's just not it's not all uniform. You just have some people who really have they have a profit motive, certainly an investment, but they're also in the course of that taking care of their residents. Everybody's happy. It's what we're talking here today about, the people who may have the profit motive and who are not doing right by the residents. I would love for this committee, Madam Chair, and to my fellow committee members to maybe we can, whether it's this language or we're able to fit language in, to really focus on the enforcement at the municipal level, where it's more of a scalpel approach. I think I've seen in several of my communities, not necessarily related to housing, but I've seen restaurants, we've seen other businesses and shut down by the health department for violations, right? Or the fire code. And I've seen people displaced from a residence, maybe in a hoarding situation where the building official or the health department has stepped in for the safety of the individual in their own home because it's unsuitable to live and they're incapable. So that authority exists. I think if we have to some more of that at the local level to permit that's a route I would love to see to make sure that we're able to hold some of the worst actors accountable. So thank you for your time.
Thank you.
Thank you, Rep. Blair. Thank you, Attorney Kerwin. So thank you for the part about the fines. We'll definitely look to you to make sure that we're not making the bill less significant, to make sure that people have a safe home to live in. When it comes to the registry, it's really, small government is the word out there these days on the streets. And it's really too bad that we have to do this, right? That we have to do the registry. But it is what government has to do to protect our renters. What I fear is that they're just going to find, I support this bill 100%, but looking at it after we support the bill, I just see that they're going to find a loophole. They're going to figure out a way that we're still not going to be able to find them in order to make sure that they're good landlords, or that not good, but that they do their job that they're supposed to do as a landlord. So do you consider any kind of fine or any kind of discipline for them if they do not sign up for the registry, and make sure that they actually do have a phone number and an address where we can get in touch with them?
Yeah, and it's through the chair. Thank you for the question. It's an important concept that you need to actually enforce the regulations that you adopt. And we have taken steps to increase the penalty provision for failing to abide by the registration provision. So a landlord fails to provide that identification, Originally, that violation was an infraction. It was like a parking ticket that you could just pay through CIB. We have changed the language to make it a violation. What's beneficial about that language is then the municipality can go forward through their civil citation provisions, or the state can prosecute it. It's kind of difficult in a, it's circular. If we can't, the purpose of the registration provisions is so the state can prosecute them. Well, they don't register, so we're going to prosecute, it's kind of bootstrapped. But the civil provisions through General Statute 7152C provide the municipalities the more long arm jurisdiction, so they can actually issue the fines. If the fines are not paid, then the defendant doesn't even have to appear. They can pursue those through liens. So it does, and also in including it in specifically those statutory required duties of a landlord that they're required to register, those have certain implications as well on the civil side. So we're hoping that those two provisions actually provide a little bit more teeth to force those bad actors to register. I don't know if that answers your
It
question.
does. I'd like, how many state employees, municipal employees would you say? I mean, and this is just an off the cuff, and you can say I can't answer that, Senator, but goes into enforcing the bad landlords, right? I mean, how much of our of your department does it employees does it take to actually try to get these landlords to do what they're supposed to do?
Through I work for the Division of Criminal Justice, the Office of the Chief State's Attorney. There's 4 attorneys for the entire state of Connecticut. But then throughout the municipalities, I couldn't even venture to guess this. Every municipality is required to have fire marshals. The bigger municipalities have large offices with numerous fire investigators and inspectors. There's building code, health departments that have sanitarians, and then with those sanitarians, housing inspectors. So there are a large, I can't actually come up with a figure, but there are a large amount of employees within a municipality that are devoted to these type of activities. So this is, what we're trying to do is make their job easier.
No, I know. As a visiting nurse, one of the things that drives me crazy is smoking detectors that don't work, right? And they just chirp, 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 chirp. And I'll go into people's apartments for 6 months and I don't know how they live with this chirping smoke detector. And it's because, you can live near a foghorn, you can live next to a fire station, and eventually you get used to the sound. And the landlords just won't get a new smoke detector or get a battery for the smoke detector. And people will say, oh, well, why can't the tenants just get a battery for the smoke detector? Well, because the tenant is 75 years old and they're not going to get up on a ladder to change the battery in the smoke detector. So it really is, I see it all the time and it is so frustrating. And people paying that rent deserve to have a healthy and safe abode. So thank you very much for your testimony.
Thank you.
Okay, we're going to go, I think we're all set. Oh, no, Representative Jensen.
Thank you, Madam Chair, and thank you, Mr. Kerwin. I noticed that this legislation only applies to towns with populations over 25,000. I wonder if you could comment on that. I mean, don't our small towns have the same number of these bad actor landlords as the larger ones?
Thank you, Representative Jensen, through the chair. Yeah, good point. It mandates, so specifically, it requires those larger communities to impose these regulations. We leave it to the smaller communities that might not have the same interaction, the same rental population to adopt. Nothing's stopping them. And the reason why, this comes from Senate Bill 209. I had come up with this provision. I just thought that it would be a little bit easier, a little bit more palatable to enforce that way, or to at least enact that way. And my thinking is that when the smaller towns see how effective it could be with the bigger towns, nothing's stopping them. They can just wholesale adopt their regulations. So I was thinking, it's more of a representative, that experimentation through representation, through different governments that, the municipalities, the bigger municipalities will adopt their provisions, and then hopefully it'll trickle down to the other communities.
All set. All right. Okay, thank you. Much appreciated. We're going to go a little bit out of order now, and we're going to go to Georgina Fuentes. Do you need us? You all set? Thank you, Ms. Fuentes. Just hit the button on the microphone after you sit down so we can hear you.
Good afternoon, everybody. I just want to speak about all this stuff that's going on the other side of the fence of the child in a family being stressed out.
Could you state your name first, please?
My name is Georgina Fuentes, and I'm from Hartford.
Thank you so much.
I want to, like I said, I want to speak on the family side of the things instead of all the landlords and the corporates and the money. I'm talking about the inside, where the children go to school stressed out, not knowing where they're going to go sleep at night, not knowing where they're going to go cook a meal, and then you got senior citizens that are used to being in one apartment for so many years and have to be removed out of the comfortability of their homes and then into an apartment that they're so uncomfortable that the first thing that comes to their mind is depression and mind wandering and not knowing what to do with that, and they can't go out like they used to because they're getting even older. And then I want to speak about the people that are disabled. As far as myself, it's hard. It's hard for us, right? Like right now, I need to move from where I'm living because there's too many mice in my apartment. It's very uncomfortable. I can't even take a shower safely because my shower chair doesn't fit in my bathroom, and I'm still scared to fall. I can't just get up and go and look for an apartment because they're too expensive also. Yeah, I might have government assistance and help with the government helping paying the rent, but it's still not enough, So all I just want to say is that they need to start being a little bit more lenient with us, because there are people out here that do pay their bills and pay their rent and they still want to get removed. Why? Because we're complaining that the landlords has to do what they have to do. Then why get in the business? If you don't want to do what you want to do, don't get in this business. Find a different type of way to make your money. So that's all I have to say. Thank you.
We appreciate 1 minute. I want to yep. Yeah, Chair Felipe.
Sorry. I was waiting for you to ask if anybody had questions, but I just wanted to ask you what bill are you speaking in favor or in for or against today?
Oh snap. I forgot what's the name of the bill. What is
Is this expansion of just cause evictions?
Just cause. Yes.
Understood. Thank you.
Okay, wait, we still have more questions for you. Senator Gaston.
Thank you so much for your testimony today and illuminating so many different facets of what you discussed that resonates. I wanted to just put a pin in a little bit in the area where you talked about there's mice in the apartment, et cetera. Have you tried utilizing the local, health department within your town or municipality to bring that to their attention? Because I do believe that they have some level of enforcement to be able to assist with that, or at least be able to reach out to the landlord to make sure they cure that defect.
Okay, what's the use of doing that when they still don't come out and do it? And I'm not saying that my landlord don't do nothing about it. Yeah, excuse my French, he might be an asshole for a landlord, but when we do call him for this, he does send Terminex out there. The only thing I'm trying to tell these landlords is don't just try to put a Band-Aid on it. Start from the basement. Clean that basement out, sweep it, mop it, throw everything that you got to throw out, and then go send Terminex down here and cover all the hoses because it's not going to stop. It's not going to stop. So.
Thank you.
Okay, thank you so much for your testimony.
You're welcome.
And next we have Imelda Diaz, and I believe that she also has an interpreter with her. So you will get a little bit of some extended time. Is there only one chair up there? Thank you. Please state your name and from the town that you're from.
Turn the microphone on, please.
Buenas tardes a todos. Mi nombre es Imelda Díaz. Soy residente de Hartford, miembro de Defensa contra la Deportación. Yo apoyo la propuesta de ley HB 6889, una ley relacionada con la desalojos por causa justa. Y creo que todos los inquilinos deberían tener protección de desalojo por una causa justa. Yo siempre he vivido en Hartford y lamentablemente he tenido que mudarme varias veces sin una causa justa de desalojo, solo porque mi contrato se termina a pesar que yo cumplía con el pago de la renta y dueño no tenía ninguna queja sobre mí o mi familia. En el 2023 también tuve que mudarme porque la dueña quería rentar a otras familias a más precio. Mis vecinos del primer piso y tercer piso también tuvieron que mudarse. Estuve 3 meses buscando con mucho estrés un lugar para vivir. Tuve que aceptar una renta más alta y vivir en el tercer piso. Yo uso una muleta y en esta casa me resbalé. Estuve 4 meses sin salir de mi casa porque me dolía el pie. Al bajar las escaleras pienso que esto es muy injusto. No importa si pagamos la renta a tiempo y somos buenos inquilinos, nada nos protege de la avaricia de los landlords. Muchas personas de mi comunidad viven sin un contrato y no le deseo a nadie vivir con miedo y reprimir nuestros derechos solo para no ser desalojados. La incertidumbre que pasamos las familias trabajadoras de Connecticut por la inestabilidad de vivienda, porque no existen leyes como la HB 6889 para todos, es indigente. Lamentablemente yo no vivo en un edificio de 5 unidades o más. Esta ley no me protegerá, pero conozco a muchas personas que serán protegidas y tengo la esperanza que en el futuro próximo sea universal. Por estas razones apoyo firmemente la propuesta de ley HB 6889, ampliando protección de desalojo por una causa justa. Gracias.
Representative Felipe, Senator Marks, and the Housing Committee members. My name is Imelda Diaz. I am a Hartford resident and a member of Hartford Deportation Defense. I support HB 6889, an act relative to just cause eviction. And I believe that all tenants should have just cause eviction protection. I have always lived in Hartford, and unfortunately, I have had to move several times without a just cause for eviction. Just because my lease was ending, even though I was paying the rent and the landlord had no complaints about me or my family. In 2023, I also had to move because the landlord wants to rent another family and a higher prices. My neighbors on the first and third floor also have to move. I spent 3 months looking for a place to live with a lot of stress. I have to accept a higher rent and live on the third floor. I use a crutch and I sleep in this house. I spent 4 months without leaving my house because my foot hurt when I went down the stairs. I think this is very unfair. It doesn't matter if we pay the rent on time and we are good tenants. Nothing protects us from the greed of landlords. Many people in my community live without a contract, and I don't wish anybody to live in fear and have a right to repress just to avoid being evicted. The uncertainty that working families in Connecticut go through due to housing instability because there are no law like HB 6889 for everyone is outrageous. Unfortunately, I don't live in a building with 5 or more units. This law won't protect me, but I know many people who will be protected, and I hope that soon it will be universal. For this reason, I strongly support the proposed law HB 6889, expanding eviction protection for just cause. Thank you.
Thank you both so much for your testimony. Any questions? Yep, go right ahead.
Thank you, Madam Chair. And thank you, Ms. Diaz, for testifying today. You mentioned that throughout the last number of years, you've had to move a few times with no cause. And I believe somewhere in there you referenced that you had children. What impact did that have on your children in that process?
Gracias, señora Díaz. Usted mencionó que a través de los años ha tenido que mudarse varias veces y si entendí correctamente, dijo que tenían niños. ¿En qué modo esto le impactó a ellos?
Bueno, creo que les impactó porque, bueno, nos mudábamos una y otras veces y luego, pues, con la condición, ¿verdad? Que estoy, que camino con una muleta. Bueno, me ha costado tanto, ¿verdad? Subir y bajar las gradas. ¿Por qué? Porque siempre en el tercer piso. Y eso, y caminar con una muleta no es fácil. Pero, gracias a Dios, ¿verdad? Mis hijos ahora están más grandes. Ellos ya pueden valerse por ellos solos. Pero sí esto, sí, yo les digo, ¿verdad? Que si pudieran cambiar algo, ¿verdad? En esto de las desalojos o también en los del depósito que es una, bueno, yo veo así que es una injusticia que están haciendo, cobrando doble. Una persona ahorita no puede agarrar una renta si no tiene $5,000. ¿Por qué? Porque tiene que pagar doble depósito. Entonces creo que es demasiado. Porque hay personas que trabajan y trabajan y trabajan solo para pagar la renta, vivir y pues creo que esto es una, bueno, yo veo así que esto es una injusticia. Pero yo no sé cómo se podría cambiar todo esto. Y esta es mi pregunta.
Well, in my case, we were impacted because we moved various times, especially with my condition that I have to walk with a crutch. It did cost me a lot, to go up and down the stairs since I'm now on the 3rd floor. But thank God my children are older at this point, so, they can go up and down the stairs. But in my opinion, if I could change anything in these evictions or just in renting in general, it would be, the deposit, because basically you have to pay double the rent, and that can sometimes be $5,000 or more. And it's just too much. People keep working just to pay for the rent, and I just see that it's very unfair. Yeah, and I'm not sure how this could change.
Thank you, and thank you, Madam Chair.
Okay. Anybody else? Okay, thank you so much. And next we have Reverend Taryn Lepoki. I'm sure I didn't say that correctly. I apologize. Lopke? Lopke.
Lepke,
Lepke, okay,
close.
thanks.
Excuse me. Good afternoon. Dear to you, Senator, Co-Chair Senator Martha Marks, Representative Antonio Felipe, Co-Chair, Ranking Members, Representative Tony Scott, and Senator Rob Sampson, and the rest of the esteemed members of the Housing Committee. I am addressing you today in my capacity as the Executive Director of I'm crossing into my third year as Executive Director of the Collaborative Center for Justice. My name is Taryn Lepke, middle name Edward. So CCFJ, since 1999, the Collaborative Center for Justice, and this is relevant to the testimony, since founding CCFJ in 1999, Connecticut leaders of the 5 global congregations of Catholic women religious have been carrying out the following mission, which I would like to read to you. Rooted in the gospel and committed to Catholic social teaching, the Collaborative Center for Justice advocates for systemic change and educates individuals about social justice in order to make a difference in the lives of people who are poor and alienated. CCFJ is also a member of the Greater Hartford Interfaith Action Alliance, or GIA, which is a broad 52 faith institution based working organization that is also about systemic change toward justice in our region and state. My testimony today is on behalf of the Collaborative Center for Justice in support of expanding just cause eviction protection for all renters, and specifically in support of HB 6889. But my story is personal today and precedes my time in this job. And it is a story that took place in the winter of 2020. And it's a story that's really difficult for me to tell. I still carry a lot of shame and sadness around this story. So I just got done with a year and a half of contract organizing work in universal healthcare. And I was between jobs, and this was the winter of 2020. And I really needed a job. And so someone I know offered me a temp job at a law firm. And I took it because I was worried about, missing a mortgage payment. Our savings were very small. Things were getting kind of nervous, and so I took it. Only thing is that job was in a firm that specialized and almost only does evictions. And I definitely hesitated before taking the job. It was clearly against my values, but I told myself, well, it's only temporary. Someone else would be doing it anyway. And I know this person, and I won't actually be involved in pushing working class people out of their homes. Really, not really. And so now I'm going to tell you how wrong I was. And I'm going to summarize with the system is built. It's a business. Evictions are a business. They are for profit. They are cutthroat. And it's a bomb that hits a person's life. And I know so because I threw those bombs for 3 months. Okay. It's unbelievable. I almost think everybody should go temp in an eviction law firm for a day before even considering not passing this bill. I got a call from a young man whose home I was destroying. As the person at the law firm that was destroying his home, sending the marshal to his home that day, I delivered the paperwork to the marshal. He called the law office asking me for help. He said, we paid. This was 28 days after the filing. You know, they can get, they get extensions. They get a fast track. This is in 2020. If things have changed, fine. In 2020, if no one showed up to the court date on the tenant side, the landlord gets a fast track. That marshal's going to show up at that person's door within a month. And that's a tornado that nobody knew was coming. And I did that. And I know it to be true. And if I could apologize to all the people I hurt in that process, God forbid I know that it was headed into the pandemic. I literally was putting people out on the street, and don't talk to me about a just cause. Choosing between rent and groceries, that's a just cause. I mean, I just feel like, thank you. I'll wrap it up.
Thank you.
I'm going to do more in my written. Please pass this bill.
Okay.
Thank you.
Thank you for your brave testimony. Anybody have any questions? No, very impactful. Thank you so much. Next, I'm going to go to Mr. John O'Connor, and I apologize. I jumped over you.
No problem. No problem. Good afternoon, Representative Felipe, Senator Marks, and all the members of the Housing Committee. My name is John O'Connor. I teach at Central Connecticut State University, and I strongly support House Bill 6889, an act concerning evictions for cause. I'm a member of CSU-AUP, the union that represents faculty members in the 4 state universities in New Haven, New Britain, Willimantic, and Danbury. CSU-AUP is a member of the Connecticut for All Coalition, and we strongly support Connecticut for All's equity agenda. Teaching these days is much more complicated and difficult than it was 20 years ago. For the last couple of years, what happens in a classroom is impacted by what is happening outside of it. Increasingly, in my job, I often hear stories from students talking about their housing insecurity. Although it's difficult for students to admit, I do hear tales of students living in their cars or students surfing on a friend's couch. It is difficult to expect students to do all their coursework when they are struggling to find and maintain stable and secure housing. Given the political lunacy coming down from the federal government, this committee has a responsibility to ensure that we are not enacting insecurity as policy at the state level. This is especially the case when it comes to housing. I think right now is an important moment to expand just cause eviction protections. Many families in Connecticut are struggling to make ends meet. Our residents are paying more and more of their income for services that we all need. HB 6889 does not prohibit landlords from evicting with cause, such as non-payment of rent or lease violations. Yes, landlords have rights, but what the bill does do is to help ensure that tenants are not arbitrarily displaced. We know that in our state that no-fault evictions can be motivated by illegal discrimination. Our Black and Latino renters are 2 to 3 times more likely to be evicted than white renters. Connecticut already has a law that provides just cause protections to those over 62 years of age and to those with disability. Expanding those protections to all renters will reduce our eviction filings and increase housing stability within the state. Given that Connecticut has a homelessness problem that has been difficult to address, expanding just cause eviction protection will help in that struggle. When I was a young boy, my family suffered from an unexpected lapse of time eviction. It was traumatic, life-altering experience. It resulted in a change of school, a loss of community, and a 2-year period of being unsettled. A number of states, New Jersey, Washington, California, and New York, have expanded just cause eviction protections. We should do it in Connecticut. It will benefit families, our communities, and it will make housing in our state a little bit more rational and a little bit more stable. In a moment like this, more rational and more stable is a good thing. Thank you for allowing me to testify in front of you this afternoon.
Thank you, Mr. O'Connor. You were exactly 3 minutes. Very impressive. So you said that Black and brown tenants are more likely to be evicted for no cause. How about the LGBTQ plus population? Is there data on that as well?
Well, I wouldn't know specifically about that protected community, but certainly I think the folks in the room with you today, the Just Cause Coalition most certainly could provide that data. No question about that.
Yeah, thank you. I'll ask again then. Anybody else have any questions? All right, thank you so much for your testimony, sir.
Thank you.
Next, number 14, Mars Rodriguez. Good afternoon. Floor is yours.
Thank you. To Senator Marks, Representative Felipe, and the rest of the dignified members of this committee, thank you for being here. My name is Mars Rodriguez, a resident of Newington, so hello, Gary. And I write this testimony to express my adamant support for HB 6889 and not concerning evictions for a cause. To begin, I consider myself lucky to never have faced the outright cruelty that is expelling a family or individuals from a home for no cause. Moreover, at this point, I'm not even renting. And I make this distinction because I don't believe that someone must have gone through a no-fault eviction or even be a renter to understand that this act is simply common sense. When I first learned that Connecticut did not have universal no-cause eviction protections, I remember being dumbfounded at how such a progressive state did not already do the bare minimum to protect working-class individuals and families. So I'm very glad to see that this bill is up for being passed. It is evident that in this present moment, when average rents are rising, when home ownership is becoming increasingly out of reach for working class Americans, when the price of groceries and basic living needs impose greater financial burdens, and when the federal government is hell-bent on crippling any kind of social safety nets, that no person living in Connecticut should fear losing their housing situation for no cause. Requiring just cause serves in the interests of all working class Connecticut residents, but especially those who are of historically marginalized statuses. And we've already seen testimonies speaking on this, and I'm sure we'll hear more, but it is easy to understand how a no-cause eviction can be used to discriminate against a tenant for being a person of color, for being LGBTQ+, or simply being part of any group that which their landlord holds a bias against in place of any substantive just cause eviction. Furthermore, no-cause evictions open the opportunity for retaliation against a tenant who may have committed some kind of perceived transgression against their so-called feudal lords, such as joining a union or asking about repairs or threatening legal action for lack of the landlord fixing problems. The hardworking people of Connecticut who are simply trying to survive in an increasingly unstable socio-political and economic climate deserve this just cause bill. If you oppose this bill, I implore you to find your humanity and recognize that no tenant should fear facing a basic eviction. That is all I have to say. Thank you.
Thank you, Mars. Do you have any questions or comments from members of the committee? Representative Turco.
Through you, Mr. Chairman. Mars, thank you so much for being here. You said you were from Newington, so I'm always so proud when a constituent of mine comes here to the state capitol to testify in person or on Zoom on a bill they're passionate about. So I really want to thank you for doing that. Just a follow-up question, something you were making me think about in regards to this bill adding protections for different individuals, whether it's gender, race, ethnicity, from discrimination.
Certainly.
Why do you think that the landlord would have, wouldn't the landlord have discriminated against that individual at the time of rental rather than after their lease has expired and then, they have the opportunity to evict them without cause? Any thoughts on that?
Yeah, certainly. So to reaffirm clarity, why would they discriminate afterwards, you're asking?
Right. If they wanted to discriminate someone and not rent to someone because of their race or gender ethnicity, why do you think they wouldn't have done that right up front rather than after the lease expired and now using, no cause to be able to do it?
Certainly. And I can't speak to any specific example, but I will give a hypothetical that I think is very appropriate and very applicable considering the current times that we're in. Speaking as a trans person, there is clearly there's a landlord may rent to someone who is trans and not know that they are trans. And then for some reason, somewhere or another, they find that out eventually during the terms of lease. And for some politically motivated reason, or prejudice. That is prejudice, right? I don't even want to say politically motivated. It is prejudice. They decide not to renew that lease, and because they cannot discriminate on that basis, they can just say that it's a no-fault eviction.
Well, thank you so much for that. And I was thinking the same thing, perhaps for situations where discrimination is the reason why someone may, evict someone. Perhaps like you're saying, they didn't see the person, they couldn't make any kind of
Certainly.
assumptions before the rental process. And then, after the tenant lives there and they meet them, then maybe they have, a reason to discriminate. So, that's unfortunate circumstance if
Certainly.
it ever happens. I pray that it's very rare, but I appreciate you bringing that to this committee's attention and your concern and protecting people from being discriminated. So thank you so much for that.
Thank you for your question.
Thank you, Mr. Chairman.
Thank you, Representative. Any other questions? Seeing none, and enjoy your afternoon. Thank you
Thank
for
you.
being with us. Next, we have Cheryl Rabe.
Good afternoon, and thank you to members of the committee. My name is
Cheryl, if you could just turn up your microphone. We can not hear you very well.
Hold on, let's see. Is that better?
Getting there.
Yes, thank you. Good
Try
afternoon.
one more time.
How's that now? Can you hear me now?
We're having a tough time, but give it a go. Good afternoon.
Let me try. How is that now? Is that better? Closer?
Maybe if you speak closer to your microphone, we're sorry. We're
I have
not
it at
trying to be
100,
difficult.
so I don't know what else I can do with it here, but can you hear me okay now?
Go ahead.
Okay. Good afternoon. My name is Amy Epler Epstein, and thank you to the members of the committee for the opportunity to testify. I'm an attorney at New Haven Legal Assistance, and I'm testifying in support of House Bill 6948. My client, Cheryl Rabe, asked me to speak on her behalf today because she couldn't do so because she's very sick with the flu, but she wanted me to share her story with you because it illustrates why it's so important that the legislature must act this year to pass HB 6948, which is an act concerning the collateral consequences of criminal records on housing opportunities. So last spring, Cheryl Rabe and her partner, Mark Griffin, came to our office for assistance because one of New Haven's largest landlords, Mandy Management, had denied their application for housing. And when they did a background check, everything was perfect. They had no evictions on their record. They had good credit. The only thing that showed up as, quote, not meeting property requirements was Mark Griffin's criminal record. And what did it show? It showed one misdemeanor assault conviction from 34 years earlier. When he was 24 years old, he was now 58. And on that basis, their application was denied. And despite everything that they tried to discuss with the landlord and show that this decades-old conviction had no relationship to how he would be as a tenant, his 10 years successful in his current apartment, they were still denied. And so we helped them file a discrimination complaint at the CHRO, and we claimed that this blanket policy of denying housing based on a criminal conviction constituted race discrimination in violation of the Fair Housing Act. I am happy to report to you today that last week we finalized a settlement of that case, and I'm very happy to say that Mandy Management, which denied the allegations, but rather than fighting about it, they said they would be happy to work with us to negotiate and come up with a criminal history review policy that they thought was fair and reasonable, and they said was good for both landlords and tenants. And that policy has much in common with House Bill 6948. It's founded on the same principles. Number one, it provides reasonable look-back periods for many convictions, and convictions outside of those look-back periods cannot be considered by the landlord. Number two, for those convictions within the look-back period, or convictions that are not limited because they're of a serious nature that they are not limited by a look-back period, the landlord has to give the applicant an opportunity to present information and evidence as to why the conviction should not bar them from housing and why they will still be an excellent tenant. And this is so important because criminal records do not define a person. They don't show who they are and what they have become. Landlords need to be able to look beyond the criminal conviction to consider the applicant as a full person and give their rental application full and fair consideration. So this story shows a few important things. Number one, legislation is crucial. Landlords can and do deny housing based on convictions, even as absurd as a misdemeanor from 34 years ago. And if Connecticut wants to be a second chance society, the legislature must act to put limits on what kinds of convictions landlords can consider and for how long. Number two, the legislation is
Ms. Rabe,
reasonable.
your 3 minutes have expired. If you could please summarize, that would be great.
Will do so. The last two things, this is reasonable if mega landlord Mandy management can agree to a reasonable policy, so can other landlords, and there's no basis to oppose it. And number three, failure to act can cost landlords money. In this case, my clients were paid $20,000 as settlement of the case. Whereas if we pass this legislation, landlords will know what is expected of them, and as long as they follow those rules, they won't face any kind of charges. Finally, I wanted to say that I support House Bill 6889. I've submitted written testimony expanding just cause protection. And if you wanted to give me the time, I could tell you the relationship between that and the Fair Rent Commission that you've been talking about before. Many landlords circumvent Fair Rent Commission complaints by bringing just cause evictions. Instead of raising the rent, they simply start an eviction with no cause, and then the tenant doesn't have the opportunity to challenge the intended rent increase through a Fair Rent Commission. So it's a way to circumvent all the great protections that this legislature has passed for Fair Rent Commissions. So that's one other reason why it's so important that.
Thank you for your testimony.
6889 passed.
Thank you for
so much
your
the
testimony. Any
opportunity.
questions from members of the committee? Seeing that, I could just ask once more for you to repeat your name.
Amy Epler Epstein, an attorney at New Haven Legal Assistance Association.
Thank you.
So much.
We appreciate your time. Thank you for being with us. And I just want to make a note to others when we go forward, because I did not know that wasn't Miss Rabe testifying. That was somebody testifying on her behalf. If you guys aren't able to come in for whatever reason, somebody's sick or whatever, we're not having replacement testimonies. You'll just unfortunately have to miss it unless you can introduce the person. Next, we'll have Senator Jeff Gordon. Is he here? Okay. Tanya Hughes.
Good afternoon, Representative Felipe, Senator Marks, Representative Scott, Senator Sampson, and members of the Housing Committee. Thank you for the opportunity to come before you today to testify regarding House Bill 6948, an act concerning the collateral consequences of criminal records on housing opportunities. I'm Tanya Hughes, and I'm the Executive Director of the Commission on Human Rights and Opportunities. And joining me via Zoom is the Commission's Deputy Director, Attorney Cheryl Sharp. And we're also joined online by Attorney Michelle Dumas-Kuhler. I believe we were 17, 18, and 19, and I believe Attorney Dumas-Kuhler is having some difficulty being admitted as a participant, but we submitted written testimony, and I'll just summarize a few main points. The Commission supports House Bill 6948 as a desperately needed addition to the protected classes the Commission currently enforces, but we'd like to offer some recommendations we believe will help to ensure the bill's provisions are consistent with all the statutes enforced by the Commission. While the ideas in the proposed language may seem new to some, they're not. The language is in parity with Connecticut General Statute Section 46A80, denial of employment based on conviction information. The state has offered protections to persons in the areas of state employment, licensing, trades, etc. for some time. The state recognized that a past criminal conviction should not be an immediate disqualifier for employment, but rather that a balancing test should be used to determine the nature of the crime and its relationship to employment within the state. And when a housing provider learns a potential tenant has a prior criminal conviction, it can often be the end of any further discussion regarding the rental of a unit. Given the well-documented rental housing shortage in Connecticut, it's imperative that tenants who have a prior criminal conviction not continue to carry the weight of that conviction long after their release. A tenant's ability to compete is challenging enough without the additional burden of their prior conviction. Our written testimony includes a few technical revisions to bring the bill's provisions in line with the rest of the state's anti-discrimination statutes. So with those changes, the CHRO is in strong support of HB 6948, and we look forward to working with the committee on the language as the session progresses. And I'm available for questions along with Attorney Sharp and hopefully Attorney Dumas Kuhler, who's done a great deal of work in this area.
Thank you, Madam Executive Director. Are you telling us that you are all testifying at the same time, or am I still calling?
Correct.
colleagues?
Yes, the
Okay,
three of us should be together.
understood. Any questions from members of the committee? Senator Sampson.
Thank you very much, Mr. Chairman, and thank you for being with us today. Am I correct? I haven't really gone through the language that was drafted for the hearing, and I'm thinking that this bill is very similar to the previous one. But my understanding is this bill only deals with felony convictions and not misdemeanors. Am I right about that? Through Mr. Chairman.
Ms. Hughes.
I believe so. I'm going to ask Attorney Sharp if she will unmute. But I believe it is the felony conviction.
She's there. Attorney Sharp. Unmute yourself, please.
You should see a microphone. That's correct, Attorney Sampson. Only felonies. Representative Sampson.
There we go. It's senator, not attorney or representative.
Senator, I'm sorry, sir.
I don't care. I mean, I just, for the record, I'm not an attorney. I just want, through you, Mr. Chairman, I just wanted to follow up on that. And I appreciate your testimony very much. I'm thinking about this, from a real world perspective, and recognizing, as you do, that, people that have, served their time, I believe they've, paid their debt to society and so forth. However, there's still a distinction between someone that has a criminal past versus someone who does not. And, suppose you have a rental applicant who has a felony conviction and that would fall under the circumstances of this bill, and they are up against several other applicants that have no such criminal record. Is it your testimony that the landlord should just ignore that fact entirely, and that no preference should be given to the folks that have no criminal background versus somebody that has a felony conviction in their past? Through you, Mr.
Not at all, but I think my testimony included that there should be a discussion and that there should be some kind of interaction to have some further discussion about where that potential tenant is in their life. Have they been a contributing member to society? Have they held a job? Have they, taken care of their children and participated on other committees? Those are discussions that are often thwarted once someone finds out that they have a criminal conviction.
Hi, this is Attorney Cheryl Sharp with the CHRO. I'm sorry, I was having technical difficulties. Can I just add that this bill is about giving individuals an opportunity as opposed to foreclosing opportunity based on their protected class status. It's worked well in the employment context, and it really is just delaying the presentation of information that would color in a very negative way that individual's opportunity to get housing, which is already very difficult in this state because we don't have enough housing opportunities for people. It is less about preference, who we prefer, and more about giving someone an opportunity to present themselves. Someone who has had a criminal conviction from 34 years ago may be in a better position to afford a rental than someone who has no criminal conviction, but they wouldn't be given that opportunity but for this change in the law. And so we're here to acknowledge the need for this type of opportunity to be given to individuals who have prior criminal conviction.
Absolutely.
Thank you, Mr. Chairman. I appreciate that commentary because I'm in complete agreement with you about how the situation should be handled. And my experience is that is exactly what does happen. I've dealt with a lot of property owners over the years, and I will tell you, they only care about two things, which is, are you going to make your payments on time, and are you not going to damage the property? Beyond that, I don't know that landlords care much about anything else. I mean, we've talked about various forms of discrimination. I'm not saying that it doesn't exist. I just don't think it's a paramount problem. I think most landlords only care about making sure that they preserve their property and they have a reliable source of income. And certainly, if you have somebody who has a criminal past, especially if it's in their distant past, and they are otherwise in excellent financial shape, I'm quite certain that most property owners are going to put them to the head of the list, just based on the two requirements that I laid out, which matter most to them. The issue I had with this bill last time around was not the subject matter of putting aside someone's criminal record or so forth. It's the entire process that was made part of the bill, which basically required that a landlord had to give an opportunity to the person to provide a written argument, and then the landlord had to have a written response if they weren't going to choose them, opening themselves up to being accused of discrimination, and then ultimately coming before you find people at CHRO. I mean, if I'm a landlord, that's the scary part. It's not, do I have to worry about potentially looking at tenants who have criminal past? No, it's do you want to set me up for some sort of liability, even though I'm a perfectly honest person who's trying to choose the best tenant for my property? I just wonder if you have a reaction to that, through you, Mr. Chairman.
We definitely have a reaction. One is that it would be wonderful if there were no more discrimination and if individuals were not being judged because of their membership in a protected class. But that's just not the reality around the nation, and it's not the reality in Connecticut. Every year, we are processing thousands and thousands and thousands of complaints of discrimination. So discrimination is still happening. People are still being judged because of their protected class status. We still get a number of complaints of discrimination filed against landlords all across the state. And while it's true that there are a substantial number of landlords who want to do the right thing, who have as their bottom line the dollar and how much, whether their property is going to remain intact and not be destroyed by individuals, but we also have some landlords who don't believe in the spirit of the law, that individuals should be treated equally, and that individuals should not be discriminated against based on their membership in a protected class. And so any bill that is putting forward opportunity, which is what this bill is about, for individuals to get a fair chance at having housing in a state where there is not enough housing available, is really important for all of us. It's important for those who don't need the opportunity, and important for those who do need the opportunity, because we all have to interact, function, and live with one another. And so for us, we do see complaints of discrimination. We do see landlords behaving badly. We do see also some complainants who are not forthright and are not doing the right thing, either. But it's certainly not a one-off or a rarity or a rare occurrence that, it's not necessary to have legislation to protect individuals. It is necessary, which is why we support the bill with the noted technical changes of changing from 180 days to 300 days to file, because that's the current state of the law right now, to file a housing discrimination complaint. So there are just some minor tweaks, and we are certainly available and willing to work with the committee to make those tweaks. But it is important to note the individual stories, because we're talking about people and their human condition, plight that they're in with their children and their families, just seeking an opportunity to have a place to live. And the difference, and earlier there was this discussion that, maybe a landlord wants someone who doesn't have a criminal record more than they want someone who does have one. And what is the distinction? The distinction really could just be that one person got caught and the other one didn't. And one person was charged and then and found to, have engaged in this felony activity, where the other person might have done the exact same thing and just not been caught. So I think we are saying that as a society, as the state of Connecticut, it is important to give all protected classes an opportunity to have a basic human right, which is a place to live, to raise their families, to have their children in good, school systems. And if we deny those opportunities to any individual based on arbitrary things such as their protected class status, what we're doing is really diminishing our society as a whole.
And if I could add just one thing, that we are willing to work with the committee to streamline the bill and to maybe simplify the process somewhat, and to work on any kind of education and outreach about the bill. We're willing to work with the committee.
Thank you. Just want to make a note. We have many speakers to get through, so if you keep your responses a little bit shorter, but thank you very much. And Senator Sampson, please continue.
Thank you very much, Mr. Chairman. I think I just heard you say that we should have extra consideration for folks with felony convictions because of the fact that there may have been other people who committed felonies who were not caught. Did I get that correct?
With all due respect, no, that isn't what what I'm saying. What we're saying is that to the extent that someone has a conviction or doesn't have a conviction, there should be an opportunity for those who have a criminal record because they are out of hand being denied opportunities to have a place to live. There should be some consideration of balancing tests like we have in terms of employment in 46A80. We're just asking for that same type of consideration here, that if it occurred so many decades ago, and if the person is a good contributing member of society, that they should be given consideration for a housing opportunity. Not that they get any special treatment, but that there's some equity in the process.
Senator Sampson.
Thank you, Mr. Chairman. I appreciate that answer. Would you say that the one of the let me just preface the question by saying that when we have this conversation, sometimes there's something gets lost in about how likely something is or how common something is. And I just want, from your perspective, and especially, folks that deal with these actual complaints and, and actually go through the process and find out how many of the complaints are legitimate and so forth. Is it in your estimation that it's most landlords that are going to discriminate against people, or is it few landlords, or is it a tiny fraction of landlords that are going to discriminate unfairly because of a criminal conviction? Through you, Mr. Chairman.
It is not most landlords, is our position. As stated earlier, I believe there are a lot of really good landlords, but there are some landlords who would tend to discriminate against individuals based on their criminal conviction. And that is what we would like to address and have addressed, because every individual should have an opportunity to be housed. It is a basic human right. And we want to, be able to reduce homelessness. It's really important. It affects our society as a whole. It affects the economics of our state, because then we have to spend more money in other ways. And so if we are being smart economically, we want to make sure that we have this opportunity for individuals who have a prior criminal conviction to be subjected to this balancing test. So we're not trying to overburden landlords, and we're not trying to give a free pass to individuals who've committed felonies and have not changed or have any remorse. But in these instances, we're talking about individuals who have paid their debt to society, that they have reformed their behavior, and that they are trying to be productive citizens. And so I think that that's something that you have to bear in mind as well.
Senator Sampson.
Thank you, Mr. Chairman. I appreciate that answer. So I guess you said some landlords, and not most was the answer. We don't know what the correct answer is. I'm going to suggest that it's probably a relatively small number of people that engage in bad activity. And that's what concerns me about the legislation like this is I think, sometimes we're using a bomb to, solve a relatively small problem. which obviously is a big problem to the people that are directly involved, of course. But when you make blanket policy like this, I think there's a lot of dangerous side effects. I mean, what do we say? And again, these are some questions for you. So what do we say to someone who is a perfectly strong applicant who does not get the opportunity, as you mentioned, for a property because the landlord feels they are being pressured into choosing the person with the criminal background after this law is passed, and creates all of these requirements on the landlord? So, I mean, to me, that's a potential negative consequence, is we're now forcing a change in behavior that might adversely affect other people that are good applicants. Through you, Mr. Chairman.
So that the change in behavior that we're seeking is to ensure that individuals don't make judgments out of hand based on someone's protected class status. And I think that that's a positive change in behavior. We want individuals in our state to be treated fairly, with equality, equitably. And that's, very important. And to just address something you said earlier, in a state as small as Connecticut, our agency receives, like I said earlier, thousands and thousands of complaints of discrimination. And there are many more complaints that we get even, tens of thousands of inquiries, where cases are not ultimately filed, but people are inquiring because they've been subjected to illegal discrimination in housing, as well as in employment or in places of public accommodation. So our state is not immune from the vestiges of our past that lead individuals to make judgments about people because of their protected class status. And I think that that's something that we have to bear in mind. We're not trying to have a sweeping change that's only going to affect a very small population of people. And it is more critical because we have a very small and shrinking housing stock. So there are not many housing opportunities available. And then if we deny those opportunities, even for the individual to be considered because they have their protected class status, then we are really limiting the opportunity for them and creating a society where even when you pay your debt, it's not enough for you to be housed. And that is a very serious and problematic situation. It is more dire than I think is being described.
Thank you, Mr. Chairman. Thank you. You didn't really answer my question, and I don't mean to be disrespectful, but you didn't. I asked you a very specific set of circumstances. I'm going to kind of follow up with that again, and I'm just going to wrap up here for the sake of time. But this is a very critical issue, and your testimony is super important to how this bill proceeds. I wonder why this bill is being done the way it is. In my view, CHRO exists. You guys do good work. When there are folks that make a complaint and they come to you, it's investigated. And if somebody committed some wrongdoing, you follow up and take care of it. And that's great. But this bill is adding a whole range of new things. It's not just saying that among the other things that you should not discriminate for, you shouldn't discriminate against someone based solely on the fact that they have a criminal record, and leave it at that. That's something I could maybe get behind. But what's happening in this bill is it's saying, not only are we saying that, but we're also saying that now there's a whole process that, the landlord has to take a special opportunity for that individual, and they have to have the opportunity to write up a written reason why they'd be a good tenant and so forth. They're basically putting the landlord in a terrible predicament that the landlord now has got it to say, well, if I'm going to deny this person now, how can I do that? I'm going to end up going to CHRO and I'm going to get fined. And what if there were 3 other applicants that might have actually been better? I feel like you're creating a situation that you're going to create another form of discrimination. Because you're now creating a reason for that change in behavior, which I agree with you is laudable. We want to make sure that people are given opportunity. I want to see folks reintegrate back into neighborhoods and be able to succeed, and that's a lot easier if they have housing. We don't want people returning to any type of crime or anything like that. So anyway, I just throw that out there for, a point of discussion and thought as we go on, through this process. And I hope the rest of my committee members are making a note of what part of this might be more valuable than other parts. Thank you, Mr. Chairman.
Can I just say that there is nothing new here. 46A80 is already a statute that was enacted many, many years ago. It applies to employment. It should be extended to housing. We've outlined why we believe it should be extended to housing. I'm sorry that my response isn't one that you accept to your question, but in a nutshell, the discrimination against individuals with criminal convictions does exist. We do get complaints of individuals or inquiries by individuals who believe that they were denied housing because of their criminal background. It is an issue in the state of Connecticut. It is one that we believe needs to be dealt with. And as our executive director so illustriously said in the beginning, we are willing to work with the committee to simplify any aspect of it, any aspect of this bill that it seems cumbersome for landlords, because that is certainly not our intent. Our agency is for business. Civil rights is good for business. Civil rights unites us all. It's good for tenants, it's good for potential tenants, and it's good for business. And so we are open, willing, and able to work on any language with this committee to simplify it so that it is palatable and also has the force and effect that it needs to have in order to protect some of the most vulnerable citizens in our state.
Thank you. Representative Scott.
Thank you, Mr. Chair. I'll leave this open to any one of the three to take this question. I'm not sure who would be best to be able to do so. But one of my worries, and I said this last year when this came up again, and we're bringing it back again this year, is the lack of how is this going to be policed? So you guys are here, and I think would be the police in this scenario. You would be investigating and understanding. So my question specifically is if there are 5 people that are applying for a housing unit, one of them has a background, criminal history, that is, if this bill passes, were to not be looked at, you're not supposed to look at as a landlord. How is it being policed that person did actually look at it and made that decision that they were not giving it to him because of that background, instead of giving it to one of the other 4 people that didn't have a background, but maybe had a better credit score, maybe a million other reasons why they chose those other, they're ready to move in tomorrow, whatever it might be. How are you going to police that? How is that going to be determined that this landlord did something wrong just because they chose somebody else that didn't have the criminal record? Then you think that they chose it because of the criminal record?
Civil rights law is well established, and through civil rights law, we look at 4 kinds of evidence: direct evidence, comparative evidence, pattern, and statistical. And so it is not an arbitrary process. The investigative process considers all those types of evidence, and currently we investigate and prosecute complaints of discrimination in housing based on someone's lawful source of income. And so we have to look at was there any direct evidence, statements of preference. Then we look at comparative data. Is there a pattern here? Is there some statistical evidence that supports that the individual was treated differently based on their protected class status? It would be the same type of inquiry that the United States courts have outlined, that our own state courts have outlined, and that the federal courts have outlined. Like I had indicated earlier, this is not anything new. We already have 46A80, and it has been in effect for many decades, and it relates to employment. We're saying that this is a balancing test that needs to be done. We are not saying that individuals who are unqualified for the opportunity should be given special treatment because they have a felony conviction. That is not what this bill says. And again, to the extent that it is written in a what has been described as a cumbersome way, we will work with the committee to work those things out. We didn't obviously draft the bill, But we support the concepts in the bill, and we can work the language out to, again, make it useful and effective for those who need to be protected, but also make it palatable and understandable for landlords so that there is no confusion about how everything should work.
So is it up to the applicant, the one who is filing the complaint, to provide that evidence, that direct evidence that this person said that they're not giving it to or whatever? Because if not, you have to get into someone's mind, potentially the landlord's mind, of why they didn't do so. It seems like most of it is arbitrary. The only thing I could say, if there's not direct evidence, is if there's a trend, if there's, history of like this happening 100 times, I guess. But all the other all the staff seem to be more arbitrary, instead of this person specifically did not rent to this person because of their criminal background history. I just have a hard time believing that's going to be able to be proven without a direct statement.
So the way that we collect evidence is that the individual person filing the complaint provides us with evidence. We interview witnesses that are identified by them. We also have our investigators look into the matter to determine whether any of those four kinds of evidence are there. That's why they are investigating the various causes of action. It isn't an arbitrary process. Those things have to be considered, whether or not there's direct statements, whether or not there's patterns. And it is, I can just liken it to what has been in place for a long period of time, which is individuals with their lawful source of income who seek out a housing opportunity and are denied. And our Connecticut Supreme Court determined that Section 8 is a lawful source of income. And so what we presented to the Supreme Court there was that in this particular case, Sullivan is the name of the case, in case anyone is interested in looking it up, that there was pattern evidence that for many years that this landlord had not rented to anyone with Section 8. Then there were direct statements of preference, like, I am not going to rent to you because you have Section 8, or you don't qualify because you have Section 8. Those direct statements were made, and we had to investigate, unearth whether or not those things have been said. We don't get into the minds of landlords or anyone else. We look at evidence, we look at data, we look at documents, we look at oral testimony, we look at documentary evidence as well. So it is a quasi-judicial process after the investigation is done and reasonable cause is found. And so it is, an objective process. As much objectivity as can possibly be put in place is in place. And so it isn't an arbitrary situation. And again, it is not new. It isn't new for us because we've been established in 1943 and been enforcing this law ever since its enactment. That would be the housing laws. So it won't be our first rodeo in dealing with, new protected classes added to our statute.
Thank you, Representative. We good? Any other questions? Seeing none, we thank you guys for your time. Appreciate
Thank
it.
you.
Next, we will have Saray Campbell.
Good afternoon. Good afternoon, Commissioner, Senators, Representatives, Tenant Union, Connecticut Tenant Union Presidents, Connecticut Tenant Union, and all individuals here in support of the Just Cause expansion to all tenants. My name is Saray Chappelle. I am an Army veteran, a tenant union block captain, voting delegate, a member of the negotiating team for Victory Gardens Tenant Union, a care manager for Western Connecticut Area Agency on Aging, and a mother of two wonderful, beautiful, and intelligent children who have made it through too much already at the age of 17 and 4. Unfortunately, I have seen the ugly side to what landlords can do when there's no accountability and no protections in place. I have experienced homelessness twice in my life with both my children. I am in support of HB 6889. Housing is a basic human need, and yet too many tenants live with the constant fear of eviction. often through no fault of their own. The Just Cause Bill currently provides critical protections against unjust evictions for seniors, 62 and above, and disabled tenants in buildings with 5 or more units. But the need for housing stability is universal. That's why we must expand just cause protections to all tenants, because no one should lose their home unfairly. Without these protections, landlords can force out tenants for arbitrary reasons, clearing out units for higher rents or displacing long-term residents without due process. Families, workers, and vulnerable individuals who may not have the financial means to relocate are left scrambling, often at risk for homelessness or housing insecurity. By expanding just cause eviction protections, we ensure that all tenants can remain in their homes unless there's a legitimate reason for eviction, such as failure to pay rent, lease violations, or property damage. This law does not prevent landlords from managing their properties or addressing problem tenants, but it does stop unfair, profit-driven evictions that uproot lives and destabilize communities. Without this expansion, more people, working families, students, and low-income renters will be left vulnerable to housing instability. We must stand together to pass this bill and make sure every renter, regardless of age or ability, has the right to housing security and fair treatment. I would like to end my statement with reiterating, I am in support of HB 6889. Housing is a right, not a privilege. Let's make just cause protections the law for all. Thank you.
Thank you, Ms. Chappelle. Anybody have any questions? And I would just ask all those here that we not come inside the circle. I know you want to take a picture, but we just ask that you not to come inside the circle. All right, oh, she's the press. I apologize. I didn't know you were press. Okay. Ranking Member Sampson.
Thank you very much, Madam Chairman. Sarai, thank you very much for being here. I appreciated your testimony, very passionate and very well done. And I certainly am sympathetic to folks that have run into housing providers that are not treating them fairly. There's no question about that. I think we can all agree about that. I guess that there is a disagreement about the extent of how far the protections in this proposed bill should go. I guess was the simplest way I would describe it. And you use some terms in your testimony. You said that people shouldn't be evicted for legitimate, unless there was a legitimate reason. And I don't disagree with you as far as that goes, although I want to just clear up a couple things. First off, I wouldn't classify the end of a lease term as an eviction. And you might disagree with me. I'm going to ask a question. I'd like your reaction to that. But isn't it understood that when you sign an agreement with a landlord, that it's for a period of time and that the property belongs to them? And at the end of that lease, you've got to come up with a new agreement to continue a relationship. Through you, Madam Chairman.
Ms. Chappelle?
Yes, I agree with that. Once the lease is done, when you're done with that specified time, in my experience, it hasn't been at the end of my lease. It's been in the middle, towards the end, and it makes for a really tough Christmas when you get a notice to quit right before Christmas and you have to figure out what you're gonna do when you have your 2 kids counting on you as their sole provider. What do you do? And at that point in time, we were going through COVID. So not only COVID was going on, we got a notice to quit at our door right before Christmas, and it wasn't for a legitimate reason. It was a big housing community. It was a complex. I can't even tell you how many units. There's about 25 in each building, and they have about 40 buildings in the community. So these were people that were looking to remodel and upcharge. And this is for an apartment, a 3-bedroom apartment that I was paying almost $2,000 for.
Ranking Member Sampson.
Thank you, Madam Chairman. Okay, so I'm just a little confused because your opening statement was that you agreed that the end of the term is the end of the term and then you need a new agreement. But you're suggesting that the landlord came to you somewhere in the middle of a term and said that they were going to evict you, or what did they want? They sent you a notice to quit in the middle of a term. They would need a reason. You'd have to break the lease for that to happen. And that's already part of the law. I mean, you have a contract if they break the contract. I'm trying to get to understand. I mean, I'm with you. If somebody comes in the middle of your lease and tries to change the rules on you, you have every right to say, no, they can't change the rules on you. You can't change the rent in the middle of the term. They can't require you to do something new that's part of the lease. So what happened in your case that they sent you a notice to quit?
Ms. Chappelle.
Yes, they were actually raising the rents, and it was way over 10%. They were looking for either relocating to a smaller apartment, but that was an option given to only a select few of the tenants that lived in the community. I just got the notice to quit right before Christmas, and my lease wasn't gonna expire until like February, March timeframe of the following year.
Ranking Member Sampson.
Thank you very much, Madam Chairman. So you were in a lease. They can't raise your rent during the middle of a lease. And if they try, you file a complaint and you win. That's not what this bill is about. I mean, I know, I would assume you know what this bill is about, but this bill is about what happens at the end of a lease term. And certainly I'm in agreement. If a landlord does something to you that violates the agreement that you both signed, both parties have a right to make a complaint, go to housing court and follow up. I'd be the first person standing there with you. Was this a question about they were saying that they were going to raise the rent at the end of the lease for the new term? Through you?
Ms. Chappelle.
Yes, of course. Thank you for your question. I would just like to, without getting into more specifics, considering the time constraints that we have here, the property management team understood and knew very well that I didn't have resources to get lawyered up, as he referred it to, and he was looking for a way to force me out. Took the security deposit, which I couldn't fight. I couldn't try to get it because that meant time away from work, which means less money coming in when you're the sole person paying for all the bills and taking care of business at home. It was either leave or leave, pretty much. But I think that it's important to expand this just cause eviction protections to everyone as tenants, because landlords know that they can get away with things if the tenant doesn't have financial resources to acquire a good lawyer or, go through that whole process. And honestly, as a parent, that's one of the last things that I would like to do is go through court process and try to fight, which I fight on a daily basis. So, but if you'd like to join me in that fight, I more than welcome you. Yes. Okay.
Ranking Member Sampson.
Thank you, Madam Chairman. I gladly would. If they're violating the lease, then you have every right to fight them. I have I understand we got time constraints, but you're an important spokesperson on this issue, and I would really like to get to the bottom of it. And I'm going to try and be very quick about it, and maybe you'll help me. But the thing I want to really ask you is, so your concern is that the landlords are able to, in some cases, if they're bad actors and they want to, they want you out, they can put you through a lot of hell to make that happen, knowing that you don't have the means to go and get a lawyer and stuff like that. I understand all that. If that's the case, then I'm curious how this bill is going to help, because this bill is not going to do anything to provide you a lawyer or prevent them from, still doing exactly what they did. This bill doesn't do anything except for put more words on the paper that are not going to protect you. But what it also does is it creates a lot of problems for other people who are not doing anything wrong. And that's the issue I have with it. So would we be better served by having legislation that makes sure that your rights are protected and that you have your day in court to be able to defend yourself when a landlord breaks the contract, versus coming up with some rules that are not really, the point in your case? Through you, Madam Chairman.
Ms. Chappelle?
Yes, thank you, Senator Sampson, for your question. So to answer your question as brief and as quickly as possible, I think a good start is expanding the just cause eviction protections to every tenant and going from there, because you're talking about providing legal services and all the other additional things that come with having to take a landlord to court. I think expanding the just cause eviction protections to everyone, to all tenants, would be a good start. Now, can we count on you to support this?
Ranking Member Sampson?
Please don't ask questions back to the.
Thank you, Madam Chairman. I can take care of myself, Madam and Mr. Chairman. I can defend myself. I frankly, no. And the reason why I would say no is because you haven't given me a good reason to support this legislation. I agree with you that there are bad folks in this world, and we need to do something to stand up to them. And I think everybody on this committee, Republican, Democrat, whatever, nobody wants anyone taken advantage of, and we have to push back on those things. The problem is when we empower the government to decide who's good and who's bad, and they use a bomb to hammer in a nail. I would much rather solve the actual problem. Let me just get to this. The bill is all about determining who owns the property. Would you agree that when you rent a property from someone, that it's their property?
Ms. Chappelle?
Yes, are you asking for the tenant or the landlord? Is it their property? I think it's the tenant's property if they're renting it out, if they're paying their rent, they're taking care of the property, then it's their home. Because I rent out in Victory Gardens community, and I consider that townhouse my home. I treat it as my own. I clean it as my own. I maintain it as my own, and it's our safe haven. So I would say that it's the tenant's home.
Thank you, Member Simpson.
Yep. Thank you very much, Madam Chairman. Well, I appreciate that. But what about the person who actually paid for that property and owns it? Now, I know you're paying rent and it is your home, and I would never say it's not your home, but is it your property? Or is your name on the town record? Do you have the ability to turn around and sell it to someone else? Did you save up your money to purchase it versus the landlord? What about that person? Isn't it their property?
Ms. Chappelle?
Yes, of course. Thank you, Senator Sampson, for the question. Yes, I whoever owns the property is the owner. Whoever owns the deed realistically is who owns the property. Whose responsibility is it to, if it's a tenant's home, it's their home, because otherwise, to say otherwise would be saying that tenants don't have a place, whether or not they pay their rent, which most cases, in my experiences, most of the tenants I come across do pay their rent. So they consider their places of where they live is their home, and they take care of their home as their own.
Thank you very much, Madam Chairman. Thank you for that answer. Again, I mean, I think we're going kind of around in circles a little bit, but you acknowledge that the person who bought the property, they own it. They're the owner. They're the person on the deed. And, the way we determine, what both parties' rights are, because that's what we're here talking about, is making sure that when you're a tenant, you get to protect your home and you have a right to use it in the way you see fit, et cetera. But the landlord also has rights too. And the way we determine all that is by drafting a document called a lease. Now, sometimes that lease can be oral instead of in writing. And I would advise anyone in this room not to do an oral lease. It just will get you in trouble because people have a way of forgetting what they said. But when you put something in writing, isn't that the agreement between the parties?
Ms. Chappelle.
Yes, of course. Thank you. Yes, the lease is the written agreement, and like you said, verbal agreements really carry no weight. It leaves room for deviation. So, in that sense, whether it's a contract with a property management team, the lease, updating the lease, it leaves room for error, leaves room for deviation. And it's important to have a written lease because then everybody knows their expectation. So circling back, just getting back to what we were just discussing a minute ago, the importance of making sure that everybody's on the same page. So we want to continue to push forward to expand the protections under the just cause for tenants, and we want to make sure that it's not something that landlords can trick their way out of in a sense, because I have experienced myself that there's been landlords that say one thing, do another, or switch things up, or decide that oh, they're gonna charge $900 more, so we're just gonna set new mirrors in the bathrooms and we're gonna upcharge $900 a month, and that's what's gonna happen. So yeah, having everybody on the same page is very crucial and important to keep this process moving. Thank you.
Ranking Member Sampson.
Thank you, Madam Chairman. Yeah, so we agree the lease is the contract. We also, and I'll agree with you once again that if the landlord came along in the middle of your lease term that said something else and said, I'm going to install mirrors in the room and charge you additional rent, they can't do that. They shouldn't be allowed to do that. I will go to court with you to make sure that they don't do that to you. Okay. But the question is, so at the end of that lease, we agree that that's the terms that both the landlord and the tenant agree to, and that's what's in writing, and that's the agreement. You recognize that this bill changes that agreement by saying that certain things no longer are between you and the landlord. You guys don't decide anymore. Now the government will decide because we put it into a law. I'm just curious whether or not that actually is something that you guys have pondered as part of this, because I will just point out that every time we make a law about what can be in a contract, both parties lose freedom. Both parties, because that thing can no longer be negotiated. Now it's not a matter of what's you or I or the landlord or the tenant feel is legitimate. It's what the government thinks is legitimate. And that's subject to change all the time. So I'm just want to ask a general question about how you feel about a situation where a private contract where you negotiate the terms versus the government suggesting that they have the right to interfere in that contract. Now, maybe In some cases, they might interfere in a contract to benefit the tenant. But very often what happens is there is a rebound, and the landlords come back to the legislature and they write a new law that benefits the landlords. I watch this in the insurance committee all the time, where we write a law to say we have to do this to punish the insurance company, but the insurance company comes back and
Senator Sampson,
punishes the
please.
hospital, et cetera.
Please. I mean, Ranking Member Sampson, please. Please. Thank you.
Yeah. Thank you, Madam Chairman. I was asking whether or not how you respond to changing a contract by law instead of allowing it to be negotiated between the parties. Through you,
And
Madam Chairman.
Ms. Chappelle, I ask that you just answer that question and hopefully we can wrap this up. You're doing a phenomenal, impressive job. Thank you.
Thank you. Yes, of course, Senator Sampson, thank you for the question. I think that if the landlords are doing their part and they're doing the right thing, they really have nothing to worry about. The overwhelming amount of testimonies you guys are going to hear today, everyone here, as we've heard up to this point, the experiences that tenants have had with landlords and things that have already occurred need to be considered and brought to the table, and that this is part of the negotiating process right now, because right now it's not expanded. So we want to make sure it is expanded for all tenants. So that way there, we could go take the next step. And I just wanted to wrap up my statement with, that's ultimately why we're all here. That's what we're trying to support. We're trying to push this forward and get a written document so we don't have verbal agreements which both parties can deviate from.
Ranking Member Sampson.
Thank you very much, Madam Chairman. And just respectfully, I mean, I know there will be a lot of people testifying today, but you are a spokesperson. You announced a litany of credentials and your title when you came up before us to suggest that you're speaking on behalf of many people and the tenants union, et cetera. So that's why I feel like you're a valuable person to ask these questions of. And I appreciate the chairs giving me a little bit of leeway, recognizing I'm not going to ask everybody in the room all these questions. I just wanted to get to the bottom of, you have some expertise, and I just have two more topics that I'd like to get through very quickly if we can. And, the first one is the notion of what's legitimate. You mentioned, that there's different things that you consider to be legitimate reasons for a landlord not to renew a lease. And I'm just curious to know whether or not you believe that it should be one side of the agreement. Remember, it's a free agreement both parties get into. One side of the equation should be able to dictate to the other side what is actually legitimate. Now, you mentioned that you don't believe it's legitimate for someone to non-renew a lease so that they can make renovations and then charge more rent to the next person. Is that correct through you, Madam Chairman?
Ms. Chappelle?
I'm not sure I understand your question, Senator Sampson. There was a lot there to unpack, so I'm not too sure what you're asking me.
Maybe just ask the question. Ranking Member Sampson.
Yeah, thank you, Madam Chairman. I'll do my best to reframe the question, but I'll handle that. Thank you. Through you, Madam Chairman, I'm asking whether or not you believe that a landlord should be able to, and I don't mean cancel a lease in the middle. I mean, you have a year lease that you signed for a certain amount. It's nearing the end, and the landlord comes to you and says, look, it's December, February 1st, your lease is up, but I'm going to want to renovate this building so that I can improve it and charge more rent to a future tenant. And I'd want to give you warning so that you understand that I'm not going to renew the lease, or that if I do, we're going to have to make arrangements and the lease is going to be for more money in the future. Do you believe that it's acceptable for a landlord to do that?
Ms. Chappelle.
Thank you for the question. To shorten this up, I think that there is a certain time constraint where you have to have a certain, some leases are 60 days notice, some are 30-day notice, some are 3 months notice, depending on, it's a case by case, depending on what kind of agreement that tenant and that landlord have. If those discussions are had within that time limit, then, you know, I guess it would be a case by case situation. But if a landlord decides that he's going to renovate his place, his unit for his or her unit for a future tenant, then that right there is just, you're already giving that person information that you're not renewing the lease. That renewing of the lease has to be, that has to be a conversation that needs to be had before that decision is made. Because if it's I'm considering it as your example, as it's somebody that's paying their rent, that is taking care of the apartment, like someone like myself. I take care of my townhouse. I keep it clean. If there's any issues, I report it immediately to the property management. I do everything in my power to upkeep. So it depends.
Ranking Member Sampson.
Thank you, Madam Chairman. Isn't the fact that it's a 1-year lease notice to both parties? And doesn't the tenant have the same right? I mean, you don't, you know, by signing a 1-year lease, you're not promising that you're going to stay for 13 months. You're promising only to stay for 12 months, and you can leave. You don't ever have to say anything to the landlord. You can just leave on the last day of that lease. So since you have that right in the contract, and I thank you for acknowledging that it is an agreement between the landlord and the tenant. So I guess that's the question isn't that already notice?
Ms. Chappelle.
Yes, noted, but it's the leases that I've had is you have a lease term for 12 months and then some required an extending the lease, whether it's 6 months or another 12 months. Some have the options of, okay, once your 12 months is up, you're on a month-to-month basis. So that means that my responsibility as a tenant is that I have to give 30 days notice to the landlord and letting them know that I'm going to be vacating the property and giving them the 30-day notice. So it's really situational depending on what type of leases you're talking about. I hope that answers your question.
Ranking Member Sampson, I respectfully ask that we kind of wrap this up. She's number 20 out of 281. And I can pull an all-nighter, but I'd like to.
Well, thank you, Madam Chairman. I mean, I will ask one more question, but since this is going to continue to go like this, I just want to state for the record, these are all your bills. You put them on the agenda. They're not mine. And I believe the public has a right to hear this testimony. I'm asking important questions of somebody who is a key proponent of this bill. And we're actually getting somewhere. I think the people in the room are appreciating this conversation because we're actually getting to understand
Okay,
what the bill is
Representative
about.
Sampson, I've heard a lot of moans and groans, and Ms. Chappelle is a mother of a 4-year-old and a 17-year-old, and she is the head of a tenants union. She's not a lawyer, an attorney, and she's been incredibly patient and incredibly wise with her answers. I respect you very much, ma'am. It's getting to sound a little it's not it's just, can we just ask one more question without a lot of
Madam Chairman, are you I mean, I'm not a lawyer either. I'm asking very straightforward questions.
we read the law every day. Could you go ahead? One more question. I appreciate that.
Yeah, no,
Thank you so
honestly,
much.
this is no way to treat your colleagues, Madam Chairman. It really isn't. And certainly if you want to have this conversation, it should be done offline, period.
Okay, one more question, please. Respectfully, Ranking Member Sampson.
I have no more questions. Just, I'm going to note for the record, Madam Chairman, that you are preventing the public from actually getting to the full bottom of this policy
Okay, I
discussion.
will take full responsibility for that. Ms. Chappelle, I appreciate you very much. Your 4-year-old and your 17-year-old are very fortunate to have you as their mother.
Thank you.
Next, we will go to Ms. Annie Harper. She is online.
Hello, it's a real pleasure to be here, and I just enormous respect for the previous person who testified. So my name is Annie Harper, Dr. Annie Harper. I live in New Haven. Senator Marks, Representative Felipe, Ranking Member Sampson and Scott, and members of the Housing Committee, thank you for the opportunity to give testimony in support of HB 6889. My testimony is also relevant to, excuse me, and in support of HB 6948. I'm an assistant professor at the Yale School of Medicine in the Department of Psychiatry, but the views I express here are solely my own and do not represent those of any organization or agency with which I'm currently or have previously been affiliated. So in my research, I studied the associations between finances, poverty, and mental health, and that includes seeking to understand how housing insecurity and homelessness affect people's mental health, including among people who've been incarcerated. So we know from our and others' research that if a person is evicted, their financial situation worsens, and they often enter a cycle of poverty, homelessness, and ill health. They often incur significant costs associated with moving, storage, and staying in temporary accommodation. Those costs make it even more difficult to find a new place to live. And when people are homeless, their ability to remain healthy and to effectively support their families is deeply compromised. They're stressed and anxious, they have limited bandwidth as their focus is on finding a place to sleep in the short term. It's difficult to maintain social relationships, and it's much harder to find a job, and much more besides. Just last week, I spent an afternoon interviewing a couple who recently found an apartment after almost 6 years cycling in and out of shelters and sleeping on the streets. Thankfully, a combination of a Section 8 voucher and a landlord willing to provide an apartment at a rent that the voucher could cover means that the couple is no longer homeless. But the stories they told me of the years they spent homeless reminded me of just how difficult it can be for people to find housing again once they've been evicted, given the challenges, and this is not an exhaustive list, of not being able to get a good sleep, constantly feeling unsafe, being cold and wet, having to carry their belongings around, not being able to access regular healthcare appointments, losing medications and other essentials, and feeling humiliated and in despair. Getting a job and finding a new place to stay under these circumstances is extremely difficult. Now that they're housed, I will call him R, he has a job, and his wife is making huge progress in improving her mental health, keeping their home clean and tidy, having her grandchildren to stay, and getting the therapy she needs. No-fault evictions are an incredibly important protection that reduce eviction rates, helping people like R and his wife avoid homelessness. People need to feel secure in their homes to make connections with neighbors, local businesses, and community services. Everyone needs to know their home is a place they can be sure of, that when they arrive home at the end of the day, they can relax. This is true for anyone, regardless of their past. Just cause eviction protections or reduce barriers for people with incarceration histories alone will absolutely not solve Connecticut's housing problem. Others with more expertise than I have know more about what kind of housing systems would work for everyone. But I'm sure of one thing, that a housing system that can't accommodate just cause protections for tenants is a housing system that doesn't work. Thank you for the opportunity to testify and for your consideration of my comments. Just again, the legislature must, in my opinion, pass both bills, House Bill 6889 and 6948.
Thank you so much, Ms. Harper. Anybody on the committee? I see no questions. Thank you for your testimony. Next, we have Representative Doug Dubitsky, who I believe I saw him online. Representative Dubitsky?
I am here. Are you
Go
able
right
to hear
ahead,
me?
sir. Yep, go right ahead.
Thank you. Thank you. I appreciate it. I'm Doug Dubitsky, state representative. I represent and I appreciate the Housing Committee chairs, vice chairs, ranking members, and the committee members letting me testify today. I'm here to testify about HB 6940. I represent some very small towns in Eastern Connecticut. I represent the towns of Brooklyn, Canterbury, Chaplin, Lisbon, Norwich, Plainfield, Scotland, and Sprague. Many of you probably have not heard of many of those towns. They're some of the smallest towns in the state. And they're towns that are often ignored when discussing housing policy. at the legislature in Hartford. As I'm sure you recognize, many of the people who testified today, and many of the people, if not most of the people, that are sitting on the Housing Committee are from towns that are very much larger than the towns I represent. When creating housing policy, we need to recognize that Connecticut is a little unique in this country, and that we have 169 very, very different types of municipalities. And they have different problems. Connecticut does have a housing problem, but it doesn't have the same housing problem in every part of the state. It has very different housing problems. In some areas, like the areas that most of you represent, you have growing populations, you have businesses that are forming and growing and moving into the area. You have schools in some instances that are overcrowded, with lots of children either being born or moving into the area. And there are developers that want to build housing there. You have relatively good transportation, public transportation, roads and bridges. You have water and sewer service. You have police departments, police services. You generally, the towns that you're from have full-time staffs. You have a land use department with people that work there every day. In those places, perhaps you have a problem with corporate landlords and those problems that you've heard all day. But in other areas, like the areas I represent, we have aging populations. We have very few businesses and very few jobs, very few businesses moving into the area. We have shrinking student populations. The high school that the kids in my town go to is a regional school built for over 600 kids with 3 towns, and it's got just over close to 200 people, kids in it, and that's grades 7 through 12. We have no public transportation, no water, no sewer, no police, no full-time building staff. You know, our zoning enforcement officer works less than 1 day a week, basically 4 hours. So
Representative, we just asked that you please summarize. Thank you.
Sure. Putting together a group to look at the definition of affordable housing, I think, is an important thing. But putting that group together, the only way it's going to be effective is to bring in people from all diverse viewpoints, parts of the state, sizes of towns. If you just staff that group with people who agree with you, it's going to be useless. It's going to be worse than useless. You need to put together a group of people who disagree, because that's the only way you're going to take into account the diverse viewpoints and the diverse circumstances of the people throughout this state. Thank you.
Thank you, Representative. Any questions from members? Representative Weir.
Thank you, Doug. Thank you for your testimony. Obviously, we represent areas that are very similar. I'm a little bit west of where you are. Can you talk about when was this population decline noticed? I mean, I know that the census, recent census of 2020, 2021 with the redistricting, we saw a big shift in population from east to west. How is that, how long, over what time frame have you been seeing this decline in population through you, Mr. Chair?
Well, the decrease in population in Eastern Connecticut's been going on for at least 10 years, I would say probably 20 years. It's an aging population. While I hear that there are a lot of areas where lots of people are being stuffed into small apartments and they need their own apartments. Here we have the opposite problem. We have aging people who live in big, historic, old houses who very often can't afford to maintain them and would like to move into a different type of housing, perhaps senior housing or assisted living or something like that. But they need the money that they would get from renting out their house. They'd love to rent it out to a young family or something like that for a reasonable amount of money. But none of that, under the current definition of affordable housing, would count, because they're certainly not going to deed restrict their property for 40 years. Many of these houses are too old to be considered affordable housing. So even if you were to rent out a beautiful historic 4-bedroom, 2-bath house at $300 a month, it wouldn't be considered affordable housing, even though it's obviously affordable, even in our area. So the definition of affordable housing is different in different areas. And when putting together a group to consider making a new definition, you really need to bring in people who understand the various areas and the various needs. For example, in my town, we are the town and many of my towns are very poor. We're considered environmental justice towns. We're considered, essentially poor towns. And the average income is very low compared to much of the rest of the state. Everybody says Connecticut's a very rich state. Well, there are places in Connecticut that are not very rich. And if you tie the definition of affordable housing to the average income of the people in the area, you create a very, very big problem, because that average income can change. During a recession, it can drop. And if you've got a landlord who is making making the rent, and he's able to pay the mortgage, he's able to maintain the property based on the average income of the people in the area, and suddenly we have a recession, suddenly his expenses don't go down. But if you tie the maximum rent to the average income in a poor area and that goes down, the landlord is suddenly not able to maintain the property anymore. That's the bigger problem we have. We don't have the greedy corporate landlord problem here, but there is a problem. And when creating a definition of affordable housing, that needs to be taken into consideration.
Thank you, Representative. Any other questions? Seeing none, we appreciate you joining us today. We know you're busy as we all are.
Thank you. I appreciate your work.
Next, we're going to move on to number 24, Catherine Freeman with Connecticut Legal Services.
Good afternoon, distinguished Chair, Representative Felipe, Representative Senator Marks, distinguished ranking members, and other distinguished members of the Housing Committee. My name is Catherine Freeman. I'm a staff attorney with Connecticut Legal Services. I do apologize in advance if I have connectivity issues. I may go off screen. But I am here in support of Senate Bill 1302, House Bill 6943, House Bill 6892, House Bill 6889, and I'm also here in opposition to House Bill 6949. As I mentioned, I am a legal services attorney. That means I work directly with tenant communities throughout Connecticut. Over the last 4 years, I've worked in the towns of Waterbury. Well, I know there's representatives here from Waterbury. We currently do not have a staff attorney working in Waterbury at all in defensive housing. So it's very important that we have laws in place where tenants are able to represent themselves and get access to venues such as the Fair Rent Commission to get the services they need, particularly when they don't have an attorney. I worked in Hartford last year in 2023, and now I'm currently working in New Britain for the year of 2024. And I know there's representatives on the days today also covering the town of New Britain, where I've had quite a time representing tenants there and seeing what the housing stock is. And I point out all of those towns of Waterbury, Hartford, and New Britain for a reason. It's because we do have aged housing stock in all of those towns and municipalities. And I'm seeing firsthand from the tenants that come in, the conditions of the properties, and also the situations that they confront by the time they actually reach me through the Right to Counsel program. You may have seen that the Right to Counsel program over the last 2 years has actually saved the state of Connecticut over $36 million and other resources and aid by not having to relocate families, not having to involve children in DCF systems and other systems that they would have to call on if they were displaced. However, Connecticut Legal Services and other legal services organizations around the state are only capable of reaching about 10% of families in the entire state when it comes to services that they need. There's been some questions today about, well, can't tenants go elsewhere if things bad happen to them? No, they can't always go somewhere when something bad happens to them, actually, unless they have a lot of money and they want to file an affirmative lawsuit, which they cannot afford to do because they're taking care of their family and raising their family. So yes, when price gouging new landlords do come into the state, like they did in Waterbury in 2020 up to 2023 and beyond, and doubled and attempted to double rent and serve individuals also with notice to quit for lapse of time when they were in places that are already protected by just cause, they can't just run off and get assistance somewhere or make a legal claim. The avenue's not there. And what do they end up facing? They end up facing notice to quit and the summary process cases. And as you probably know from the data, every year in Connecticut, nearly 20,000 people actually go through the eviction process. Those are the people who actually made it to court. That's not all the people who actually were served with paperwork to actually get out of where they live. That is actually just people who made it to court.
Expired. If you could please summarize.
Yes, I just want to summarize by saying that tenants do need rights and they do need protections in place to support them because they're not always going to have an attorney. And that includes access to the Fair Rent Commission so that they can have notice as is requested under the tenants bill, which is 6943. That includes protecting tenants where they live in buildings of 5 or more, where they can have just cause protections to not have to move when the basis is a lapse of time or other termination of right or privilege, which really is just a tool that others have explained and will explain today as a tool to actually discriminate and abuse tenants. And finally, we are in opposition to a provision that would allow a tenant just to go into a landlord to go into a tenant's unit after 6 days because they haven't arranged the proper time to actually go into tenant's unit to either make a repair or to inspect. Because a family could be saving up all year to try and go on a family vacation. And while they're on a 7-day family vacation, they've been saving up for all year, they could actually face a landlord or whoever their agent is going and rifling through their things while they're away. Thank you.
Thank you, Attorney Freeman. Any questions from members of the committee? Seeing none, we thank you for your time. Next, we have Rhonda Backen. I hope I said that right. No Rhonda? All right. We're going to go to Candace Merriam. Candace here? No?
No.
Okay. Tara Romulo? No Tara? Oh. Have they not been admitted? Okay. All right, Tara, the floor is yours. Please, if you can, try to turn your camera on as well.
Unmute.
There you go.
Can you see me or no?
No, I cannot see you.
Yeah. Hold on. Let's see.
Go ahead. Sarah.
Start my video.
Yeah.
Oh, there we go. Good afternoon, everyone. Can you hear me?
Yes. Floor is yours.
Okay. I have a few oppositions here. I'm opposing Bill 6889, 6948, 6891, 6892, 6949, 6939, 6943, and SB 1303. So the first one would be 6889, lapse of time eviction, spike from the courts being closed during COVID. Many tenants from hell were allowed to live without housing providers' ability to remove them. The eviction spikes were also a lot of voucher tenants from New York that people are not talking about. New York paid 1 to 2 years upfront rent via voucher. New York got rid of their bad actors, and now it's Connecticut's problem. New York gave people vouchers who don't have jobs. And what do you think is going to happen? Is that we're going to have a high increase of evictions, non-payment. Stop rewarding bad behavior. This committee keeps coming up with dangerous bills to put good tenants and owners in jeopardy. Why? All of you serve on different committees that need more attention, like education, infrastructure, housing committee that needs more pro good tenant and landlord bills. And I think we're looking at housing from we need to look at it from a completely different lens and perspective, because the landlords are not the problem. We're not the one that caused a housing shortage. There has been a shortage for the past 20 to 25 years in Connecticut alone because there weren't developments. We have a huge influx of people coming from New York here on top of the regular, people that we have living here in the entire state. So this added also to the increase in regards to evictions, the shortage of housing, but I'll go on further. So lapse of time eviction only accounts for 10% of all evictions to focus on. And 90% of the cases where landlords were suffering from non-payment of rent. We need protections for landlords in Connecticut, payment in escrow that works. Where are my protections for my good tenants, my property owners? We don't have anything. These tenants need to be held accountable. They're the reason why rent is so high. They were told not to pay their rent during COVID. Now you have the unintended consequences of these poor bills. We are the boots on the ground. Please ask us for advice on these bills before they're put into committee. It doesn't cost you anything. You will find a lot of landlords willing to help out every year when these committees come up. This bill also removes other reasons to bring in eviction actions, such as no right or privilege to occupy, making it impossible to remove a squatter from a building. Removing no right to privilege is just irresponsible for both owners as well as banks who become landlords upon foreclosures. This would eliminate the bank's ability to empty out a building, assuming the risk.
Have expired. If you could please summarize.
Sure. So also the other one is that's highly, highly concerning is 6948, the concern for concealing criminal records. Now, I'm a female property owner, and a lot of my tenants are single mothers. They have children, they have daughters. I think this is probably the most dangerous bill this committee has ever come out with, because you are putting women, children, females at risk when we are going into these properties, and we don't know who are in these properties, who we are renting to, who we're putting into these properties, with vulnerable, there's a vulnerable community here. And the thing is that you're rewarding bad behavior. These bills that you guys put in here, I mean, I don't understand why rewarding capital felonies, why that's okay, and why you think, that I'm going to reward these guys for, there's a child molester, there's a rapist, there's somebody who committed murder. Why is that okay to put this person into a property like this? Give that owner that right. If, okay, they want to rent to that person, give them the right to do that. But don't seal that record. That's unfair, because now we're going to have more unintended consequences of lawsuits. Who's going to be held accountable for that? Is the committee going to be held accountable for that because you passed this particular bill? That's so dangerous in regards to a look back time. I mean, common sense has to prevail at a certain point in regards to what's dangerous and what's going to harm the community of good tenants, good property owners, female realtors, that are going to show these properties, we have a huge slew that if we open up a can of worms, we're going to have a lot of problems here. And who's going to fix that when there's a problem? Can
Thank
they
you.
file a lawsuit against the state?
Thank you. You've exceeded your time. Maybe somebody will ask you to expound, but are there any questions from members of the committee? Senator Sampson.
Thank you, Mr. Chairman. Tara, thank you for being here today. I want to go back to the beginning of your testimony about the so-called just cause evictions. Let me just, you said a lot of stuff, and I found myself wanting to talk about each one of those items. I'm sorry to go back and remember them all. You mentioned the vouchers from New York. You mentioned the COVID, lockdowns and, the governor of Connecticut's advice to tenants to hold off paying their landlords. And then you mentioned protections for good tenants and good landlords. I just, maybe you could expand on that for me, like what you mean, and also what your concern is with the state dictating what a legitimate reason is for someone to fail to renew a lease. Through you, Mr. Chairman.
So with the you're asking a question about the vouchers, correct? From New York. So that added to the increase in evictions. So what they were doing is that they were giving vouchers, for 1 to 2 years, depending on the person's situation. And a lot of these people were not working. Now, after 2 years, what are you going to have if someone didn't have a job? And I'm from Waterbury, by the way. So we've seen a lot of this, and the majority of evictions are for non-payment of rent here in Waterbury specifically. And I do own property here as well. And I know a lot of females too that own property as well. And a lot of these things are huge concerns, for all of us. So the thing is, like with the voucher, it just added to the eviction moratorium. It added that we had an influx of people coming in from out of state. Now, why do we have to pay for all of that when we're good landlords and I have good tenants? Now, my good tenants, I want to protect them as well. And the majority, like I said, the majority of my tenants, they're really good people. I've raised these bills with them. I told them about all of this. A lot of them are working. They couldn't come, they couldn't testify, but I told them how dangerous this is. I said, I don't want to raise your rent. There's no landlord that says, I want to go into an eviction because it costs a lot of money. I recently went and I did an eviction recently. It was around $10,000 to $11,000. So the average eviction is about $10,000 to $55,000 and upwards per apartment. That's a lot of money for a landlord to be out of. Now, you add that to every single unit that someone owns. Now, you're going to put us, you're going to bankrupt us. What's going to happen to these properties? They're going to be dilapidated. Waterbury I don't know if you guys, a lot of you guys know, the status of a lot of the properties here in Waterbury. They're very dilapidated 15 years ago. We have a lot of people that are coming into Waterbury that are investing into the city, but we also have people that live here. We have small mom and pops. The majority of people that own property in Connecticut are small mom and pops. It's not BlackRock. We don't have BlackRock here in Connecticut. And I think you were talking about the government putting this big bomb on a nail. That's very true, because the thing is that this is not what this should be about. We don't have these big, huge corporate landlords here in Connecticut. It's small mom and pop. This is who you guys are coming after. And we're providing good, clean housing. We're providing safe housing for my great tenants. And they're afraid of this. They're afraid that, hey, Tara, I know you did your background check on all these tenants, but if one of my tenants is going to leave, they're so afraid of who's going to come in now. What protections do I have to protect them?
Well, thank you very much, Tara. I appreciate your testimony today. I'll turn it back over to the chairman. Thank you.
Thank you. Senator Mark.
Thank you very much for your testimony. You talked about vouchers from New York. Do you have proof? Do you have data and any of that information that you just shared with us?
I can look it up. It's public knowledge on New York's website about the voucher program. And actually, I've had real realtors and real estate agents for my units post-COVID. They said, hey, we've got a ton of vouchers that these, we don't know how this is going to work. And I said, well, where are the vouchers from? They said it's the state of New York that they are paying their rent, up front. So there's a lot of realtors that can actually attest to that. So I've seen it myself firsthand. So I can attest to, I've seen the vouchers. I've interviewed tenants that did have these vouchers as well. And they were all from New York. And these were from NYCHA, mostly NYCHA buildings that were rent controlled because New York couldn't take care of their rent control buildings because it was infested with rats, mice, lead, you name it, everything. That's what rent control looks like.
Okay. I mean, I take it as innuendo then that you don't have actual data from New York City.
I can get you
testimony. I
data.
appreciate your testimony very much, ma'am. Thank you.
Representative Butler.
Thank you, Mr. Chair, and thank you, Tara, for your testimony. I'm from Waterbury too, and I know some landlords who can actually attest to some of the New York information that you're talking about now. And New York actually dumping their problem tenants here in Connecticut has been something that's a practice that has happened going back to COVID for sure. Any rate, I just wanted to talk about one of the bills that you mentioned, 6948, in terms of the criminal records. Now, I know there's a issue about the look back period for criminal records of people with felonies. What would you find acceptable for a look back for people with non-violent convictions?
I would say maybe 7 to 10 years, nonviolent. I've rented to tenants that have nonviolent things on their record. I mean, DUI, somebody was smoking weed, disturbance of peace. We rent to people, that are like that. That's not, our main focus. Like, I want to get a good tenant, make sure that they can afford the place, make sure they can take care of it. My biggest concern is being a female, being a landlord, having a lot of female tenants that have children, property managers that are females, realtors that are females, and we don't have that capacity to have that look back in regards to who they're showing a property to or who I'm interviewing. That's pretty scary when you think about it. I mean, you guys all have children, you have mothers, you have daughters. Would you want to put them in a situation like that where possibly something can happen to them? Who's going to be held accountable for that? Because I see lawsuits happening.
And a follow-up, if I can, Mr. Chair. And another part of that bill is in terms of the landlord property owner having to write, rationale for not renting. If that's a part of this, is that something that, how do you feel about that?
Word that again, I'm sorry.
When considering somebody with a criminal background, if you have to actually explain the rationale for why you didn't rent to them, how do you feel about that clause being a part of legislation?
I don't feel 100% comfortable. Again, being a female, being in this particular industry, people are pretty retaliatory. And, that can cause a lot of, they know where your office is, they know where your rental property is. Now, if I have some guy coming in there and I'm like, hey, I can't give you this apartment because you're a registered sex offender, like, who's protecting me?
All right.
I don't want to be put in that position.
All right. Thank you for your testimony. Thank you, Mr. Chair.
Thank you, Representative Butler. Any other questions? I have one of my own. And thank you, Tara, for coming before us. I just wanted to ask you about specifically collateral consequences of a criminal record. The bill that you're looking at, is this year's version or last year's version of the bill? Because you named rape, molestation, and murder as 3 things that that would have some sort of erasure, and those are three things we've actually excluded and given a permanent look back period in the current bill. Did you know that?
I wasn't 100% aware of the changes that you guys made, but the scary part is that once something like this passes, you guys can change that again next year. So it opens up a can of worms where if you start this look back period or you try to seal, you try to say, okay, we're gonna exclude particular types of crimes. Now, next year, you guys can come back, or 2 years from now, you can say, you know what, we have these particular groups that are now complaining, saying that, rapists, murderers, child molesters feel offended that they can't get an apartment where they're supposed to go. So I'm looking at it in general. Once you start a bill and you put it into play and you make it law, it's much harder to take it away, and it's easier for you to add to it. So that's where my concern is about that. You can say that right now, but you can also add those into these bills because, like we've seen post COVID, a lot of these bills that have come out of this committee has been pro-tenant and anti-landlord when we're not the bad people. This is what I want to put out there. We're not the bad people. Nobody wants to do an eviction. It costs way too much money to do an eviction. And everyone's saying you guys are bad guys. We're not the bad guys. We're providing a service. We're providing, housing for people. And I think that we all need to get on the same page. We need to protect landlords as well, because we have so many bills that are protecting tenants. And it's like, when is it going to, end? Because now what are you going to force people to do? They're going to turn their rental property now into short-term rental property, or I'm going to rent out to nurses. You're going to create a situation where people are going to want to get out of this business and pivot and go somewhere else. It's causing chaos is what's happening. And it needs to stop, because I don't think that anyone is talking to landlords. They're not talking to property owners, and we're the boots on the ground. So we're all available. I will, provide you my services for free. If you want to talk to me about this, be on a committee, to help you guys with these bills, because I'm a very good landlord. I take care of my tenants. None of my tenants want to leave. A lot of them are looking for, a 3-bedroom apartment. Some of my apartments are 2. They won't leave until a tenant leaves. Like, that's how I take care of my tenants. And I'm in Waterbury. I'm here. My boots are, on the ground with these people, taking care of my tenants. And do you have, your 1 or 2 landlords, from New York, that are not taking care of their property, or they're not the best? Yeah, you do. I have one particular property where it is a New York landlord, and I have made complaints because it's a blighted property. He doesn't take care of it. So I see, that side of it as well.
Ma'am, thank you. I think we're getting a little bit off topic. I would just like to say that, myself as chair of this committee and many other members, I don't think that it is our intent to be people who treat landlords as bad actors across the board. That is a statement that's been made by you and a few others. I don't think that most landlords are bad landlords. I don't think that many landlords are bad landlords, but enough have done things around this state that need addressing, and maybe the way that we're addressing it, people may feel is a little bit far ahead, but we're doing our best as we're having these conversations to make sure that we get to a place that is reasonable. And when it comes to having legislation like collateral consequences, I'll be frank with you. I respect the fact that people think that once we open up something that we can get to a point where we will make it what they think in their estimation is worse. However, we are struggling just to get it to a place that it's passable. So I don't think you have anything to worry about opening this up to somebody who has committed some heinous capital offense such as rape, murder, molestation. Those are things that I don't believe we should be able to carte blanche take away from people's ability to look at or know about, the same way that we don't do that in clean slate legislation. So I understand where you're coming from, but respectfully, I have to disagree, and I thank you for your time coming before this committee today. Next is number 28, Raphael Podolsky. Yes.
Thank you very much, Mr. Chairman and members of the committee. My name is Raphael Podolsky. I'm a lawyer with Connecticut Legal Services, and I'm here on behalf of legal aid programs. I've submitted written testimony on a number of bills. I'm going to try and say something about 4 bills, but I don't know if I can get it in 3 minutes. So we'll see what happens. We support the just cause eviction bill. I want to just make a couple comments on things you've heard. The starting point for just cause eviction is the reality that ordinarily landlords keep tenants. And when landlords don't keep tenants, there's a reason for it. People aren't irrational. The question of just cause eviction is under what circumstances do you need to disclose what that reason is and prove it. That's really what just cause eviction is about in that sense. It's not, as Senator Sampson has pointed out, if you may consider the end of the lease itself being the reason or not, but there's a reason. There's some reason though that goes beyond the fact that the lease is ended. Otherwise, you'd have tenants changing apartments every year or even every month with month-to-month leases. So what I'd like you to, I guess the point I want to make is this is not a radical bill. And however you look at it, you should not look at it as a radical bill. First of all, the underlying law has been the law since 1980. It applies only to buildings with 5 or more units. It applies right now only to seniors and elderly. The bill expands it to pick up the other tenants in the same buildings. So that's an important factor because it means every building that would be picked up in this bill is already covered by the existing law. It doesn't pick up even one landlord who's not already covered by the existing law for their elderly and disabled tenants. So it's important to keep this in context in that sense. Any kind of housing that in Connecticut that has a direct federal subsidy is already covered by just cause eviction because it's a due process issue. So I mean, there's a federal constitutional aspect to it. There are a number of other states that already have just cause eviction. New Jersey has it since 1974, New Hampshire since 1985, Washington, Oregon, California, Colorado, those places have just cause eviction already. And for New Jersey, for example, there is no exception for smaller buildings. Smaller buildings are covered. And in addition, this year's bill has this enormous compromise in it, which goes directly to concerns that were expressed last year by landlords, which is it has a 1-year probation period for the new added class of tenants. In reality, most landlords will know during the first year whether they want to keep a tenant or not. For someone who doesn't want to have to explain why, for that first year, they're going to be able to do that. The second bill I want to mention is the bill on tenant protections, number 6943. There are a list of things, I think all relatively small. I'd ask you to take a look at them. 3 that I want to mention specifically is the right for a tenant to get a copy of their payment record, their ledger. So if they're being charged all these collateral charges, they can find out what they are. You'd be amazed, but people can't always get that from the landlord.
Rachel, your 3 minutes have expired. If you can please summarize.
All right. So, well, I would say then, Senate, I just want to add Senate Bill 1304 we're concerned about because it deals with retaliation against people who file rent complaints. Looks like it's meant to help tenants. It actually takes away rights tenants have. I'm happy to answer any questions I can. Thank you. Thank you for the opportunity to testify. I knew I couldn't get through this.
Senator Marks.
Thank you, Attorney Podolsky. I am going to try to be a good role model on how to ask a concise question, and I'm going to ask you with your seasoned, at being a very seasoned testifier, to show how to give a concise answer. So as we all know that our housing crisis, right? We're the worst in the country, and we want to build more affordable housing. We want to preserve the affordable housing that we have. How will passing this just cause legislation affect the housing crisis, preserving our affordable housing and the ability to build more affordable housing?
I'm not, I guess you said concise. This is hard. The most obvious thing is that it promotes residential stability. A lot of the bad impact we've had is people buying up submarket rent buildings, older buildings, getting rid of everybody in the building, whether by raising the rents radically or by simply lapsing leases, which is where just cause eviction comes into play. And then typically with very little modifications, re-renting them out at much higher prices. Just cause eviction, I think, does have some impact on that process.
Building more affordable, like affecting the building of more affordable housing.
I don't, well, just cause eviction applies to people who are already in buildings. It's as best I can determine, it doesn't have much impact on that at all. You see a lot of senior housing, multiple family senior housing being built. In fact, towns are much more willing to build senior housing or to zone for senior housing than they are for family housing. And that seems to be going on quite aggressively, notwithstanding the fact that those are the very buildings that are covered by the existing just cause eviction law. So it doesn't, I can't, I don't have data on that, but that's my impression.
Okay, and I will ask this question of some of the landlords that come, but we've had the just cause legislation for 40 years now, protecting seniors and those are disabled. Has there been any problem with that decades now of having this law on the books? Have there been negative effects that you know of?
Well, in fairness to the landlords, that's a question they have to answer. And within our experience, it certainly has never stopped the landlords from evicting seniors and disabled people from multifamily buildings that are covered by the just cause law. I understand the argument that says you're going to be a lot more of our tenants are going to be covered. Therefore, it's a bigger deal for us. That I certainly understand that. But 90% of evictions, as a previous speaker said, are based on cause. Now, you've got roughly 10%, in which lapse of time or equivalent is the only reason cited. We have represented people who, in cases where the landlord has alleged cause, and it turns out the case isn't a valid case. So, I don't think it's been a substantial problem. And I don't see it being a substantial problem now. One of the things that the tenants lose when you do a lapse of time eviction, but when you really are doing it because of a cause, but you don't want to talk about it, is the tenant loses the right to cure. Under statute, except for non-payment of rent and for serious nuisance, tenants have the right to cure once they get a notice. They have 15 days. You lose that in a lapse of time eviction because there's no cause being cited.
Thank you. I appreciate your advocacy and thank you for being here.
Thank you.
Thank you, Senator. Senator Sampson.
Thank you, Mr. Chairman. Counselor, thank you for being here today. I appreciate the way you handle yourself, by the way. You're always very fair. I will I come back to my argument that we should stop referring to this particular practice as an eviction. But I want to ask you a question before we get there. I promise to come back. The earlier today, we heard testimony from the commissioner of the Department of Housing and the gentleman that was with her. I can't remember the name of the sub agency.
Michael Santoro.
Michael Santoro. That's right. But he's I'm trying to remember the name of his agency within the Department of Housing. It's a long name, but at any rate, he mentioned that there's nothing in our current laws that would prevent a tenant from offering a greater security deposit than the current 2-month provision. And I don't believe that's accurate. And you're somebody who practices in that arena. I just for the record, and I'm taking a chance because you're probably on the other side of this issue from me. But I don't think that a landlord can take more than a 2-month security deposit lawfully in Connecticut. Is that correct?
That's correct.
Thank you.
Actually, I just want to say, I'm glad you asked me the question because the fourth item I was going to get to, which I did not get to, was to say exactly what you just said. And I'm in agreement with you. It's a maximum. So yes.
I just wanted to make sure that we had somebody who's an authority who serves in that arena on a day-to-day basis. And we get that on the record so that there's no question about it going forward. Okay, so I want to just talk about the notion of lapse of time evictions. For me, an eviction is a situation where a landlord is having to remove a tenant by force. I don't mean physical force, but by force, by contacting a court and requiring someone to leave the premises. That's an eviction. That's in. I'll give you a chance to respond.
Okay.
Yeah. So can you tell me how we equate the simple expiration of a previously agreed to term of occupancy, which is a lease? It has a start date. It has an expiration date. Everyone knows at the time they sign it that that's the end of that term. How are we calling that an eviction? Through you, Mr. Chairman.
Okay, we're not calling it an eviction. An eviction is a judicial process. The landlord needs to bring the eviction to court. There has to be a reason of some sort. If you call lapse of time a reason, then there has to be some basis. You have to serve the tenant with a notice to quit, which only gives them 3 days, but it's a mandatory preliminary step in bringing an eviction. What's interesting is the eviction ultimately leads to a judgment. But the tenant is still there at that point. The tenant must be physically removed if the tenant doesn't move voluntarily. A marshal carries that out. Do you know what the piece of paper is called that the marshal brings that gives him the authority, him or her, the authority to remove the tenant? It is called an execution. Now, there's a reason for that, because what the marshal is doing is executing on the judgment, executing in the sense of carrying it out. But when you asked about the term eviction, I wanted to say, no, the actual removal is not called an eviction, it's called an execution. The just cause eviction basically deals with the fact that you cannot use as a ground for the eviction. If a tenant doesn't move, you have to go to court. Lockouts have been illegal in Connecticut for, I don't know, 300 years or something like that, 200 years. You have to go to court. What just cause eviction says is, here's the list of reasons that you can use as a grounds to be able to get something from the court, ultimately the order to put the tenant out. And it says, in effect, lapse of time is not one of those. And the reason behind it is because it's not a real reason. It's because there is some other reason. We all know there is some other reason behind it. So that's the difference. For tenants who are protected by just cause eviction, then the landlord is going to have to give the reason. It does, when there is a for cause eviction, for example, breach of the lease, tenant doesn't pay the rent, or tenant's committing a nuisance, or tenant's doing something else, you don't have to wait for the lease to expire. Those are violations of the lease. And you can bring those evictions at any point during the term of the lease, but you cannot bring a lapse of time eviction until the lease is expired. If it's a month to month, you can start it after any month. If it's an annual, you can start it after the year's over. That's, I don't know. Does that answer the question? I'm not sure where you're going with this.
Senator Sampson.
Thank you very much, Counselor. Yeah, no, you said a lot. I don't know that you got to where I was going for, but you covered a lot of territory, which is important, which is to make it very clear that all of the just causes already work. You don't need a new law for that. Every one of those things already applies, just like any other deviation from the lease. No, in other words, I see people shaking their heads, but you can evict someone for non-payment of rent for all the items that are listed in this bill. You don't need a new bill for that. You can already evict people for all that.
Right.
Right.
That's
The
right.
only thing this bill does is it says that a landlord at the end of a lease, when it's ended, we said I'm gonna have 12 months. You're gonna stay here. You're gonna pay $1,500 a month from January 1st to December 31st. When December 31st comes, that means that the tenant gets to stay unless the landlord can cite one of the reasons that we say in this bill is legitimate.
Yeah, that's right. That is what just cause is. One of the reasons.
I understand. Okay, let me finish there, Counselor. You can have all the time you need. But that is, in my view, and why I keep saying it, not an eviction, because the lease has ended. An eviction would be to ask someone to leave for violation of a lease in the middle of the term. When the term of the lease is ended, you're not evicting anyone anymore. And I suppose we shouldn't debate that topic because it's a matter of semantics and an opinion, but I think it's important to get it on the record that, an eviction is when you have to have somebody removed because they broke the lease. but the lease ends on a certain day. At that point, they're not breaking the lease and neither is the landlord. That lease is just ended as of that moment. So the question is, why is it so necessary to put restrictions on the property owner that they can only finalize that lease term based on the things that this body would deem to be legitimate? Through you, Mr. Chairman.
Well, the reason is what you've heard from other witnesses, basically. The reason we got a statute in 1980 was because older people who'd been in buildings for a long time, it was during the condo conversion crisis, and their units were being turned into condos, and they were being told they couldn't stay, and if they tried to stay anyway, they were being evicted, and without disclosing a reason, although everybody knew what the reason was. That's why we have it. We have it because when you don't disclose a reason, when you know there's a reason, the reason may not even be lawful. It may be, it can be completely arbitrary, and it has an incredibly intimidating effect on tenants. I mean, and you heard that from some of the earlier witnesses who said, it's like, something's wrong. The landlord doesn't fix anything. Why don't you complain? And the tenant says, maybe they won't say it to the landlord, they say it to their friends, I can't complain, I'm going to get evicted. I need the place. It's not, and that's not even retaliation. There's no motive there. It's because it's built into the relationship. People are scared about losing the housing. Just cause eviction helps minimize that. Doesn't eliminate it, doesn't stop it, but it helps minimize it. That's why, as a policy matter, the legislature has chosen to provide this protection. And I will say, it's not an eviction to tell somebody that you're not going to rent to them anymore. The eviction is the remedy. Eviction's a landlord's remedy when they don't want the tenant anymore. But even if the tenant breaches the lease, you can just work with the tenant and say, you got to fix up this brief. You got to stop this behavior. There's no eviction. The eviction comes when the landlord says, tenant, I want you to move, and the tenant doesn't move. Then you need to go to court through a process, which is called eviction, and get an order from the court. It's not a shootout or anything. It's you have a managed, judicially controlled process that ultimately ends with a marshal who's a state judicial official physically carrying out the eviction if the tenant's still there, if the tenant hasn't moved yet. But everybody had a chance to present their side before that happened.
Thank you, Mr. Chairman. Counselor, I'm the last person to tell you to try and make your answers more concise. I really am. I want you to be able to say whatever you want to say.
Okay, I'll try harder.
But I'm going to get cut off, and I have a bunch of things I want to ask you, and I want to stick to the point as much as we can so that we can get through it. So the issue is, I'm just trying to wrap my head around this. So why is this different than renting a car? You know, if I go down to Enterprise and I rent a car for a week and I say, and again, I can understand somebody might say housing's more important, et cetera. But if I make an agreement in writing with the other person, we both sign it, we both agree, I'm going to rent this car for 1 week. If I don't bring that car back in a week, I'm stealing that car, right?
Well, no, you're not stealing the car. You're breaking the agreement. I mean, stealing the car would mean you intend never to bring it back. But the answer to your question, you gave the answer, which is because shelter is such a fundamental right. The legislature has decided to treat it differently than owning a car. It could, I mean, if the legislature wanted to apply this to cars, they could, but there's a reason they apply it to shelter and they don't apply it to other things.
I appreciate that. Thank you for that answer. Okay. So that's the only real distinction in your mind, why the contract that is time-based should be discounted in the case of a landlord-tenant relationship. Can I just ask, you know, based on this, does it even make sense to have a lease that has an expiration date on it any longer through you?
Yeah, no, it makes sense. Just cause eviction only comes into play though when the landlord wants the property back. So, and in fact, there are plenty of landlords who start a tenant off on a 1-year lease, and the lease itself says at the end of the lease it'll roll over into a month-to-month lease. It's not unusual at all to see that kind of arrangement, which means the landlord that's typically a benefit to the landlord, because once it's month to month, the landlord has no obligation to wait a year for doing something. Not just cause eviction provides some protection for the tenant under those circumstances.
I understand.
Thank you, Mr. Chairman. So in effect, the provision that you just mentioned about month-to-month leases will become null and void if this
No.
bill becomes into effect. And the reason why is because effectively, you just said that the landlord wouldn't have to wait till the expiration of the lease to do something. Well, guess what? The landlord no longer can do anything. They're going to be limited by what is considered to be legitimate reasons by this body as for terminating the but not even just, it's not even, if it's not evicting, it's not terminating, it's just recognizing the actual end of the agreement as was already agreed to by the parties.
That's,
Go ahead.
no, that's what we've had for seniors and disabled in larger buildings since 1980. Yeah, that is correct. One of the things just cause eviction has, and it has to have, is normally failure to agree to a reasonable rent increase would not be a ground for an eviction, because you would simply lapse the lease. You wouldn't renew the lease if the tenant didn't want to pay a higher rent. But because of the just cause protection, if you look at the list of grounds that you can use as the landlord, you have to have a ground related to refusing to agree to a rent increase. Otherwise the tenant would have the same rent for the rest of their life, and you can't do that. So that's actually an extra ground that exists in the just cause statute, because it needs to be there in order for just cause to work. And the landlord has to have a means that they can raise the rent over time.
I understand.
Thank you, Mr. Chairman. So, yeah, respectfully, I don't see why they couldn't take the extra step and just say that the landlord can't raise the rent either, because effectively it's almost as onerous as that, by telling the landlord that they no longer have the right to do what they want with their property, even though it's already been agreed to for a specified period of time. I find it hard to believe that anyone would recognize that something that has been agreed to by all the parties in writing with a known date of expiration is now in question as a result of this proposal. And it seems to me, you mentioned that we've heard from a lot of people. The only thing I heard anyone say that I thought was what they considered to be an illegitimate reason for letting the lease lapse. I'm avoiding using the terminology myself, is a case where someone is going to renovate the apartment, where they want someone to vacate at the end of the lease term because they're going to do renovations and maybe charge more rent in the future. Do you feel that that's an illegitimate reason that should not be included as far as just cause goes through you?
I think it depends. It's not a reason under this Connecticut statute now. To my knowledge, that has not been a problem. That it presents, there are ordinarily ways that landlords deal with the issue of upgrading the property in senior, for example, in senior complexes, where you cannot, in the discussion with the previous witness, what was talked about was temporary relocation. So those things are possibilities. That's different from eviction. There are ways around it. And again, time has tested this. This is not proven to be a problem.
I understand.
Thank you, Mr. Chairman. All right, just a final question, really, just to get the flavor of this whole thing. I guess, for me, we've heard a lot today about, different things that have happened to tenants, and I'm certainly sympathetic to those circumstances. But most of the things I've heard are situations where the landlord's already violating the lease. And if that's the case, then the landlord should be held accountable to that, in my view, because no one is above the law and no one should be allowed to break an agreement that they've made a promise to. But if you've only promised to rent the place from January 1st to December 31st, when December 31st rolls around, that's the end. And if you were concerned about that, then you should have attempted to negotiate those terms in advance for a longer term or an option for renewal or things like that. And if you don't have that, then you should be willing to honor the fact that the property belongs to the landlord and that you made that agreement yourself and agreed to it. What I really find puzzling about this is that so many people seem to think that that doesn't matter, that that term of time, it seems to be irrelevant, that because it's someone's home, which I certainly respect, that trumps the property owner's right to their own property. Like even if they, I don't remember what we put in this just cause, but I mean, apparently there's some things we can agree on that the landlord has a right to, like if they want to use the property for themselves, for example. I think that's one of the items that's included. If it's not, I don't know
No,
why.
no, it is.
Okay, so there you go. So we agree then, you know, the people pushing this bill suggest that it's okay. A landlord can take back their property and the lease if they're going to use it personally, but they can't do it if they're going to try and improve the property and rent it for more. That's something they can't do. Is that right?
That's right.
Yeah. Okay. So it sounds to me like it's very subjective about what this body or the proponents of the bill believe the landlord's rights to do with their property. And for me, that's a concern because I think that if you own property, whether it's your clothing or your car, or you own an actual piece of real property, that's yours to do what you want with. And if you have a contract, you know, to loan it out to someone, whether it's a rental car or a house, you should honor those terms and you should be held accountable if you don't. But this is like getting into a new territory where now the property owner doesn't have the right to do what they want with their property. We're going to tell them when it's allowed to take their property back or not. And for me, that's a moral question that I think is problematic, especially when it seems to me the number one concern is whether or not the landlord's doing it for the purpose of making money. And it's funny because I remember last year when we had the similar debate, people in the room seemed very upset with the notion that somebody wanted to make a profit. They should realize that the making profit is why those properties exist to begin with. There would be no rentals if the landlord wasn't making money. So as soon as you remove the profit potential, you're going to have less rentals. Rafi, I know you and I probably disagree philosophically and ideologically on this question, but do you have any concerns about landlords who just say, you know what, I'm not dealing with this. I want to maintain the rights to my property. I'm going to go to another state or choose a different, a vocation because they're concerned that the state is taking liberty with something they own. Through you, Mr. Chairman.
You and I may differ on what we consider reasonable concerns. I am not without concerns, but I think we draw our balances in a different way. I would just point out that landlord-tenant law is a very heavily regulated industry, not just in Connecticut, but throughout the United States. So the notion that a landlord can do whatever he wants with his property was rejected well more than a century ago. And so legislatures, I think as long as they act reasonably, and I think this bill is eminently reasonable, can regulate. And this, I think, is a reasonable regulation. I think it's reasonable that they've applied it to shelter and not to cars. I don't see anything here that is unreasonable, and it works on the assumption that you're using ultimately the power of the state to force people out, and it's reasonable not to generate unnecessary forcible removals if it can be helped. So I don't see this as, I don't see this as, I began by saying this is not a radical bill, in my opinion.
Thank you, Mr. Chairman. Counselor, thank you very much for your testimony. I appreciate your candor. We don't agree. I think it's beyond radical. I think it is enough to tell a lot of property owners not to bother, and that they will, in fact, leave the industry. And I'm concerned that that's going to have a negative impact on the availability of property going forward. And we're going to hear from other landlords today. And I have a feeling we just heard from a woman from Waterbury. She said exactly that. She said, why are you going after me instead of people that are actually causing problems? She's offering property. it's the landlords that are still out there trying to make their units available. They're not the reason why there's a shortage or why the rates are going up. The rates are going up because of competition. And that competition is because there's fewer and fewer available units and more demand for them. Going after the remaining property owners, to me, is a very bad way to try and make rents go down. But I appreciate you very much. And even though we disagree, I respect your views, certainly. Thank you, Mr. Chairman.
Thank you.
Thank you, Senator. Representative Corpus.
Thank you. Thank you for your testimony. I had a question of what happens in the real world in this example we keep citing, that someone has a lease for 12 months, the 12 months is up, the landlord does not have any of the statutorily prescribed reasons to to evict the tenant or to fail to renew the lease. So how do you deal with that standoff? You have a landlord that doesn't want to re-rent to this person for maybe it's a good reason, the tenant that wants to stay, and what happens?
So you're saying if just cause eviction applies in that case?
Correct.
What'll happen is the tenant will stay. They'll essentially stay. De facto, it'll be a month-to-month. De facto, it'll be a month-to-month extension of the lease, and it'll just keep renewing every month. If the landlord, each of them has to make a choice. The tenant's going to have to make a choice. Are they going to stay knowing the landlord wants them to leave? The landlord has to make a choice. Do I want to start an eviction against them? Because now they're on what's essentially a month-to-month basis. If the landlord starts an eviction, the landlord needs to have a legal ground, and just cause eviction limits what the legal grounds are, and that just saying the lease expired excuse me, won't be a sufficient ground. The landlord would have to say more than that. So the tenancy would simply continue. If the landlord wants to raise the rent, and the tenant refuses, then just cause gives the landlord a ground that is called refusal to agree to a fair and equitable rent increase. And so the landlord could bring an eviction on that ground, which is different from lapse of time. Lapse of time is just no reason disclosed. Refusal to agree to a reasonable rent increase is disclosure of reason. The tenant could defend on the basis the rent increase was not reasonable, but the landlord could prevail on the argument that it is reasonable. Tenants refused, and now the court will, in due course, issue an order that the tenant has to vacate.
So through you, Mr. Chair, so that means that if the landlord doesn't want to raise the rent, the tenant could potentially stay there indefinitely because just cause would just keep applying every month.
Right.
But if the landlord just wanted to basically get around this and get the tenant out, they could raise the rent on the next month that's coming up. And if the tenant doesn't agree to it, evict them that way.
They could, or they could evict based on, say, breach of the lease. Let's say the tenant has been they're smoking in the hallways or whatever it might be, that they could evict on that ground. And those continue to be grounds for eviction. The most of the just causes, if you look at the statute, the just cause, the grounds that are there are mostly for fault-based grounds, typically some variation of committing a nuisance or violating the lease. But typically the landlord will put a lot of stuff in the lease, and the leases are more or less form. They're written not from the perspective of the tenant, but from the perspective of the landlord. So there are a lot of, if you want to claim breach of the lease, there's a lot of stuff wrong that the tenant might be doing. And that's a problem. It's an inherent problem that you don't want landlords kind of faking claimed breaches.
But a follow-up question through you, Mr. Chair. So doesn't that just mean that the statute won't work?
No, it'll work.
Because the landlord could just raise the rent and kind of game over at that point.
Well, game's not over at that point, because the ground for eviction based on rent is not the tenant won't pay a rent increase. It's the tenant has refused to pay a reasonable rent. It's a fair and equitable rent increase, I think, is the framing in the statute. So it's not automatic that the landlord could just raise the rent to anything, but a modest increase in the rent, something that could convince a judge that it's fair and equitable. If now the tenant's going to have to agree to that if they want to stay, because if they don't, they've empowered the landlord now to bring an eviction based on, let's call it cause, because that is one of the causes that's listed in the statute that they can use. So that's really for the protection of the landlord, that a tenant can't just say, well, I'm just going to keep, great, I like my rent. I'm going to just stay here forever at that rent. No, that won't work for the tenant.
But through you, Mr. Chair, that just means though that this could go on for years with the landlord raising the rent a reasonable amount, the tenant saying, yes, I'll pay that rent. And if there's no other reason, there's no way that the landlord can ever end this lease.
But that's like a happy ending. That's not a bad thing. That's a good thing.
It's a happy
because-
ending for one side. That is true.
No, right. Because the landlord's willing to keep the tenant. The tenant wants to stay. That the tenant's not breaking the lease or giving the landlord some other grounds they could use. So yes, because part of just cause is about, sometimes they call it security of tenure or neighborhood stabilization. And one of the things that's happened in all the cities with the outsiders coming in is it destabilizes buildings and neighborhoods. It takes the units that are relatively modestly priced and produces higher priced rents that drive people out. So that there are these collateral benefits that come from a system in which you can devise a way to keep people in. If you don't have all the crisis that goes with having to move and relocate, and it's like there's so many policy reasons why this is a good thing that I would hope the committee would think about those in assessing. You know, it's not like it's an evil thing to say that people have to have a reason to force people to move. It's just.
Through you, Mr. Chair, this is my last question. I agree. It sounds like a very happy ending and it does promote more stability, but it also means that if the landlord wants to do that renovation, they can't because the tenant keeps accepting the fair increase in rent. If the landlord has a sibling that just moved here from a different country, which is not covered in this, it's child, grandparent, parent, a sibling that moved here from another country and the person has a building and they want to bring that family into the building, they can't. And not only can they not, they can't indefinitely with a statute as it's currently written.
Well, I think it's more complicated than that. First of all, 1 to 4 family buildings are excluded, continue to be excluded from the statute. So it doesn't affect that at all. I believe that there's, because something that was worked out last year, although the bill didn't pass, there's a provision in there that now that would allow the landlord to include members of the landlord's immediate members of the landlord's family, not just the landlord personally. So I'm not crazy about that provision, but it's there.
But you get the point. It's a cousin, whoever.
Well,
who's someone not
right.
covered.
And the other thing is, and you think about this with buildings of 5 or more units, which might not be true in a 2-family building or something like that. There's turnover. I mean, it may be true that people are able to stay there as long as they agree to rent increases over time. But in fact, there's always turnover. And the bigger the building, the more turnover there is, which means that units are opening up. More will open up in a larger building than in a smaller building. But for someone who's trying to bring someone in, you know, you've got a cousin that you want to be able to move, you own a 10-unit building or a 15 or 20-unit building, and you want to bring someone in, the odds are some of those units are going to turn over within a reasonable period of time. So the problem doesn't actually arise. It's like a theoretical problem, but not I mean, unless you had to move somebody in tomorrow morning, it's likely that you just plan ahead and you say, okay, the next unit that opens up, I'm going to put my niece in there.
I guess it's my final comment. I guess to me, it's not theoretical. Like that's actually what the statute would do. That is actually how the statute would operate. And we don't know if it's going to be solved by, you know, what commonly happens. We don't know if it's going to be solved by someone leaving. But what we know is this whole potential area of rights of the landlord, which are pretty normal rights, are chopped off in that scenario. So thank you for your testimony.
Sure. Thank you.
Thank you, Representative. Representative Butler, followed by Representative Weir.
Thank you, Mr. Chairman, and thank you, Rafi. Thank you for all your advocacy. and your knowledge that you share with us. And I have a question about just cause bill. I'm trying to picture, the eviction types that, are involved in probably this whole landlord tenant relationship. And I'm trying to understand if there is a better way to write this to have that happy ending that you were talking about in terms of being fair to both parties. And right now, I've heard testimony today of tenants that talk about the horror stories about getting into the end of their leases and actually being asked to leave and vacate. And I guess that's lapse of time. And is there any other reasons, like I heard you explain earlier about nuisance causes? Is there any other causes that are in here that that will no longer be a part of this process?
Um, Substantially, the answer is all the reasons you could evict someone for otherwise are pretty much there. I don't want to say it's not exactly the same, but breaches of the lease, breaches of statutory duties, I mean, the kind of things that you would think a landlord might want to evict somebody for cause. I mean, if we take out this category of I have reasons that I don't want to have to say out loud to other people, but I I think the answer is yes. But it may not be identical. I mean, we have to sort of set the things next to each other. I think probably it's a little bit more protective for under just cause eviction than in general. But it's similar. I don't know how to better to answer that without actually setting the statutes next to each other and looking. I don't think it's been a problem. Let me put it this way. When landlords have wanted to evict people who are covered by just cause eviction, they seem to be able to find appropriate reasons. And breach of the lease is probably breach of the lease and nuisance. And well, non-payment of rent. Okay. Non-payment of rent is probably the single most important reason, which is a breach of the lease. Other breaches of the lease and nuisance, which typically is also a breach of the lease because leases incorporate all these things. I mean, that's really what you're talking about is the causes that people use. And those I think are all in the existing just cause statute.
Okay, well, thank you, because in my mind, I'm always trying to reach a balance between the tenant and landlord relationship because they both really rely on each other. And to find that happy ending is elusive, but the best we can do to actually strike that balance, I think the better off everyone would be. So thank you for your testimony. Thank you, Mr. Chair.
Thank you, Representative Weir.
Thank you, Mr. Chair. And through you, Mr. Chair, thank you, Rafi. Good to see you again. And I have a couple questions around the current protections for elderly and disabled. Do we know what percentage that is? Are there any statistics in terms of the total market in Connecticut? What percentage?
Through you, Mr. Chair. I expect the answer is yes somewhere. I don't have that information, but it seems to me it's probably basic census data. I mean, I think it's something we could find out. It's like what percentage of all units, say in buildings of 5 or more, are occupied by people who are either disabled or 62 years or older. So I think it's findable. I don't have, I can try and find it if you'd like me to.
I think that's important for this committee to, whether you find it or we find it, I think it's important information to have. And, the next piece of that is outside of, in those situations, the lapse of time isn't valid. That's at that point, you may end up more likely to end up in court if the landlord and the tenant are going to both hold their position, hold their ground. And I'm curious if you add this to a larger population of people, and again, I don't know if we're talking 10%, 90? If we're talking 20, 80, what percent is elderly versus, you know, everybody else? You know, how is this going to impact the workload of the courts if we're now going to be adjudicating this? There's no more, the lease is up. You know, I feel that we'll be seeing more of these things are going to end up in court.
I think there may be some data on this. I've at least read some of it somewhere, but I don't quite know where, that there's a tendency with just cause, it tends to reduce the total number of evictions because in a sense, it just, but by maximizing this push towards residential stability, that people having a greater opportunity to stay and not having to move, you tend to end up with fewer evictions. I don't know how significant that is. And again, I think there probably is data somewhere that we could try and find more information about. But I think that the impact on the courts tends to be less rather than more, to the extent there's a noticeable impact at all. I think that's the case. But again, I think it's a legitimate question that somebody should try to find an answer
Well,
to.
thank you. Yeah, I appreciate that because we want to get beyond the innuendo. We want to get to, you know, the data. I think it's important for us to have that. And, you know, wherever it leads us, I think it's an important thing to consider, lest we get down the road and say, how come we didn't consider this? So thank you. Thank you, Mr. Chair. Thank
you, Representative. Any other questions? Well, Rafe, I have a few of my own really quickly. In your time, you know, we have had this debate back and forth, and people have talked about renovation, for example, as one of the things that people are losing in this. When folks are renovating, right, especially in a larger building, let's say it's 20 or more units, is it normal in your estimation for people to just move tenants into other units while they renovate theirs?
I think it happens a fair amount. I mean, there may be some. I mean, if you totally and completely gut a building, I suppose it can be difficult to do that. But I think most of the time, you would make use of vacancies basically, and the fact there's almost always tenant turnover, as distinct from say putting somebody up in a hotel or something like that. You would probably try and put somebody in your own apartment. I don't think it is. I'm not aware that it has prevented at least most kinds of renovation from taking place. And over time, typically the whole building will get covered. It's, to my knowledge, it has not been a significant problem, but I can see that, you know, it takes some thought and some planning, maybe more so than a landlord would have done otherwise. But I don't think it creates a real obstacle.
And just continuing on that point, you talked about the intent to maybe fully gut a building, for example. Would that not qualify as somebody, let's say, removing that property from the housing market if they were doing a full renovation?
No, no, it would not.
Okay.
And that goes back to the history of the statute, because it's explicitly says there is a ground for permanently removing the property from the housing market, which means either demolition, which is pretty permanent, or conversion to a commercial use. Okay. But one of the reasons it wouldn't work, say, for example, to say removing it from the rental market or removing it temporarily, is then you actually, that becomes a loophole that becomes the way in which people remove tenants. And we've seen it in a slightly different context with fair rent commissions, because some of the new investors who've come in, again, especially out of state, that if they try to get to empty the building by raising the rent, there is the risk the tenant can file a complaint with the Fair Rent Commission. The Fair Rent Commission may roll some of that rent increase back. So in some sense, the trick becomes just lapse the leases, and you now have got a reason. Why am I lapsing the leases? Well, first, I don't have to disclose, and second of all, it's so I can more easily, make minor improvements for the ultimate purpose of raising the rent. That's the kind of loophole it creates. And so I think from the beginning, the legislature said we can't open up that loophole. It'll be really counterproductive to the statute.
And you mentioned earlier, in your happy ending that everybody's talking about, um, and we were getting there because you were talking about the fair and equitable rent increases, right? Is it your estimation that if you have enough of those fair and equitable rent increases throughout a year, eventually one of two things will happen? Either the landlord will be pretty happy that they're getting paid the amount that they're looking to get paid, or at some point the market will intervene and just say, hey, you can't raise it any further just because nobody else's rent is quite that high, and people will just stop renting from you overall.
Yeah, yeah, sure. That seems a fair statement to me.
All right. Well, thank you. We appreciate your time, and we are finally through our first page, everybody.
Thank you.
Next we have Councilman Josh Michtam from Hartford Online. Good afternoon, sir.
Good afternoon, and thank you for the brief promotion. Senator Marks, Representative Felipe, members of the committee. I am a city councilman here in Hartford, and I am also speaking in support of the Just Cause Bill 60. I don't have my notes in front of me anymore. I had to leave to pick up my daughter. You know the one I mean. I want to jump off from some of the comments that Senator Sampson made, because I think we can really see this bill, in addition to a humanitarian act, as a really good piece of regulation that helps municipalities maintain safe housing, right? Senator Sampson talked a lot about the notion that a contract is sacrosanct, right? The state can't control a contract between two people, or that the use of property is sacrosanct. And that's just not true. And it hasn't been true for at least 100 years. I mean, I own my house, but I can't have a pig farm in my yard, right? There's limits. And by the same token, we can put limits on what people charge for certain commodities. For example, their labor, right? I mean, there's a reason we don't have child labor. And it used to be that our court said, yes, we have to have child labor. We can't have child labor laws because this is a valid contract between a factory owner and a 12-year-old, right? And we put that reasoning behind us for the greater good. And by the same token here, we can step into the landlord-tenant relationship, and it brings a benefit. In addition to all of the stability that other folks have talked about, it brings a benefit, which is that it helps municipalities to discover conditions that need repair. Right. In Hartford, we have 13 housing inspectors. We can't inspect every rental unit. We depend on the residents of the rental units to tell us when something is wrong, when something needs fixing, when something's not safe. And what I know, because my constituents come to me with this all the time, is that tenants are afraid to report because they know, because it has happened to them and it's happened to their neighbors and their friends. They know that if they make a report, if they're on a month to month, they'll be out very soon. And if they have a lease, they'll be out at the end of it. They know that that consequence is coming, and they're afraid to make reports. So what happens? Small problems become big problems. This is how we get house fires. This is how we get dilapidated buildings. This is how we get one mouse becoming many mice, becoming an infestation. This is, the roaches that contribute to our children's asthma spring from this inability of tenants to make reports because they legitimately fear losing their house. Many people have spoken about how scarce and how expensive housing has become. That is, I would say, the most acute in our cities because our cities are poorest. I mean, Hartford's vacancy rate is 4.5%, which is half of the state average. Our vacancy rate for affordable housing is 2.9%. And remember that our median household income is the same as what each of you gets paid for this part-time job at the legislature. And I think you should get paid more, don't get me wrong. But you're talking about families who are getting by on $41,000 a year. So an affordable apartment that their whole family can fit in is an extraordinarily precious commodity. And so they're not going to mess that up by reporting
3 minutes
a small electrical problem.
Please summarize.
I think I've made my point. I'll rely on my written testimony for the rest unless there's any questions.
Thank you, Councilman. Any questions from members of the committee? Seeing none, we appreciate you being with us today. Next.
All right, thanks for all your work.
Thank you. The next is number 30, Miranda Savioli. Savioli. Gotta get one of these names right, man.
Rhymes with ravioli.
Senator Marks, Representative Felipe, and members of the Housing Committee, thank you for the opportunity to speak here today. My name is Miranda Savioli. I am a resident of New Haven, Connecticut. I'm an internal medicine physician, and I support House Bill 6889, an act concerning evictions for cause, and believe all tenants should have just cause eviction protection. A statistic taught to me in medical school and repeated throughout my time in residency is the following. Clinical healthcare only contributes 10% to an individual's overall health and well-being. Genes and biology contribute another 10%. The remaining 80% of a person's health is comprised of social determinants, such as the environment where somebody lives, health behaviors, and other socioeconomic factors such as housing. So I am here today as a primary care physician because housing is healthcare. Evidence shows that just cause eviction laws have positive health outcomes. For example, states that implemented stronger eviction restrictions during COVID-19 pandemic showed improved mental health of renters. Conversely, research also highlights the negative health outcomes associated with evictions. High eviction rates have shown significant associations with all-cause mortality, especially in women and African Americans, thus widening already existing healthcare disparities. Evictions are associated with disrupted continuity of healthcare, such as increased likelihood of losing Medicaid coverage and fewer medication refills. Evictions have been found to increase hospital visits for both physical and mental health concerns. Some believe this could be due to both worse health outcomes for those facing eviction, as well as increased utilization of the hospital as a means of shelter. I and many of my colleagues have cared for individuals presenting to the hospital simply for a meal and a place to sleep. To be sure, there are evictions which are justified. This bill would not restrict evictions for those who damage the property, refuse to pay rent, or engage in criminal activity. Please pass House Bill 6889 so Connecticut can join 7 other states that provide fair protections for renters and promote stable housing. Remember, housing is healthcare. Thank you for your time.
Thank you. Came through in the white coat. Look at that. Any questions from members of the committee? Seeing none, we really appreciate you coming down, especially meeting with us in person. Number 31, Johannes Wetzel.
Thank you. Representative Felipe, Senator Marks, members of the committee. My name is Johannes Wetzel. I'm a staff attorney at Greater Hartford Legal Aid. I've been a tenants attorney for 13, 14 years, mostly in New York, for a few years in Connecticut. I share a lot of the same views as Rafi, so I don't want to just go over it, but I want to share a little bit of my experience. And I was particularly concerned when a member of the committee seemed shocked to hear that a tenant would receive a notice to quit during the lease term. It really does happen. And to me as an attorney, it's kind of amusing or chagrining, but to a tenant who doesn't know what's going on, I think it happens and it's very frightening, and no doubt it leads to people leaving their apartments when they shouldn't. It's too onerous to go to court. There's no affirmative remedy that a tenant has in getting served an improper notice to quit. And the same thing happens with the good cause protection that we currently have. I have a client in East Hartford who got a notice to vacate, notice of non-renewal at the end of last year, although he's a senior and he's protected. And he called me several times in fear, and I said, "Don't worry, you're protected." And nonetheless, he was in fear and anxiety about this. How many people get those and just leave out of their fear? And I think that if there is a the member also said, well, how does this law protect people from those things? And I think that it is the case that if there is a universal, parsimonious law about good cause, more people will know it and people will be protected, and they won't voluntarily leave apartments when they shouldn't. I have 2 other points about some testimony I've heard, and I want to go over these things and add my experience, because these arguments kind of irk me. And the first is what about the quality of the housing stock? What about renovations? in all these years, it really has never played out in my experience that landlords move tenants out and do quality, substantive renovations that should entitle them to the rent increase. The landlord's project is to remove tenants, do slapdash renovations, and then re-rent at the maximum. And the argument, well, if a landlord owns a property, then they're going to protect their long-term asset. It just doesn't play out like that. And landlords want a return now. They want to maximize their rent roll so that they can refinance and get as much cash out as they can as soon as possible. And it's just not the case that the housing stock is preserved by a system of landlords doing renovations at will. The other argument that I saw a lot in the written testimony that I was reviewing is landlords saying, well, what about the nightmare tenants? And I think Rafi made this clear that the landlord's remedies remain. Non-payment will be the primary grounds of eviction.
Attorney Wetzel, your 3 minutes have expired. If you could please summarize.
Thank you. Just want to say that the causes of action remain to get out nightmare tenants. There's no nightmare tenant who is immune to a breach of lease case or a serious nuisance case. And I might know what that person was talking about the vouchers from New York, but we can maybe let that go. Thank you.
Thank you. Any questions from members of the committee? Seeing none, Attorney Wetzel, we really appreciate your time.
Thank you.
Mr. Chair, I did have my hand raised. I apologize.
Oh, Representative Zullo, I apologize.
Thank you for the indulgence. I'll try to be quick. Good afternoon, Counselor. Just very quickly, I forget how long you indicated that you've been practicing, but are you telling me that in your career of practice, you have never seen a situation where a landlord has tried to vacate a premise or vacated a premise for the purpose of performing substantive renovations? Never once in your career?
It is my experience that landlords will get tenants out, do a minimum amount of superficial repairs, and try to re-rent at a maximum. I don't think I've ever seen a landlord who got someone out so they could do a fantastic job and turn a premises into some kind of high luxury, exquisitely finished apartment. That I don't think that happens. I think that only happens when apartments get demolished and either so-called luxury buildings get built in their place, or maybe actually well-built luxury buildings get built occasionally.
Well, I don't think it would necessarily be reasonable to expect a landlord to purchase, let's say, a dilapidated property, right, and then spend $500,000 renovating a property that maybe cost $100,000 or $150,000. I think we could both agree that that's probably not going to happen. But I don't. Again, I forget how long you indicated you've practiced. I've also practiced, and I've seen plenty of landlords, people who purchased property and performed renovations that I would consider quality. And that substantially improved properties, including the health and safety of the properties and the aesthetics of the properties, obviously with an eye towards doing it economically so that they can continue to profit from the property, because I think we can both also agree that profit is also the point of purchasing the property. But getting to that issue of never seeing it, I was stunned by that. But so it's your experience, though, that landlords generally do not perform substantive changes or renovations to properties.
I think it's definitely my experience that landlords do a minimum and superficial renovations in order to make something look flashy that they can, rent out to the first tenant at the market maximum. I think landlords see the beginning of the first tenancy as the moneymaker, and I think they also want to maximize rent roll so they can refinance. It's a common situation, and it's a tragic situation when a premises is really dilapidated and it's occupied often by a long-term tenant. And some other people have mentioned that the solution to that is to temporarily relocate the tenant and do repairs and put them back. And that almost never happens. And landlords, I don't think are incentivized to do that because the returning tenant isn't going to be able to afford the rent that the landlord wants. It's a tough situation. I do think that a landlord ought to temporarily relocate and put an original tenant back, but it rarely happens.
And then finally, I just want to make sure we're speaking the same language. When you talk about superficial improvements, I'm thinking paint, maybe sanding floors, replacing necessary, like a door. I mean, I've seen plenty of times where the door isn't functional. I'm thinking that is superficial. When you're talking about substantive, are you talking about replacing electrical, replacing plumbing, performing mechanical upgrades like HVAC, things like that, things for air quality?
Yeah, I am talking about that. And I think back to the tenant who testified quite a while ago about mice. And she said, well, they send Terminex to do a visit, but what about dealing with a root cause in the basement? And I see a ton of that. I see, especially with exterminators. The exterminator comes and I've had tenants even tell me that they've spoken with the exterminator. The exterminator said, listen, if your landlord really wanted this solved, they could do it if they would pay me for the proper treatment, but they're not paying me for it. So maybe what I mean by substantive work is addressing the root cause of the mice in the basement and sealing it up, renovating it, and removing water incursion, whatever it is. And yeah, mechanical work as well.
Okay. Again, I won't tie up any more time. I talked even longer than I thought. Thank you very much. I appreciate the clarification. And thank you, Mr. Chair, for the indulgence.
Thank you, Representative. And now, thank you, Johannes, for joining us. We appreciate your time. Next is Kim McLaughlin from Bridgeport. Nice to see you online.
Unmute, start video. There we go.
There we go.
There we go. Great. Well, good afternoon, Co-Chair Representative Felipe, Senator Marks, and members of the Housing Committee. My name's Kim McLaughlin. I am a resident of Bridgeport, and I'm here with the All In Alliances in support of House Bill 6889, an act concerning evictions for cause. There's already a just cause law that protects senior citizens 62 years of age and older. I know you know that, and/or disabled individuals in Connecticut. It was passed in 1980 at the height of the condominium conversion frenzy in our state to respond to the affordable housing emergency that was created as real estate investors were buying apartment buildings, converting the units from affordable rental apartments to pricier condominiums. I remember it well in Bridgeport. Thousands of affordable housing apartments were lost during that time, while thousands of low-income and working families, seniors, and disabled people were displaced in the process. The 1980 Just Cause Law was the Connecticut legislature's attempt to assist those disabled residents with the greatest need at that time. According to a record of debate on the floor of the Senate, in consideration of the proposed legislation at that time, Senator Joseph, I'm going to butcher his name, but Feliso stated that State Deputy Housing Commissioner Michael Sharp said that last year, which was 1979, the condominium conversion rate was 10,000 units, and it's not expected to abate, meaning 10,000 apartments were changed and converted to condominiums. And he finished by saying, if that isn't an emergency, I don't know what is. Well, leaders and members of the Housing Committee, we're now in the midst of another full-blown housing emergency, a crisis by everybody's definition throughout the state. Members of the 1980 legislature responded boldly to their housing crisis, and we need the 2025 Housing Committee now, and to be followed by the legislature's House and Senate, hopefully led by members of this committee, to respond boldly to the housing crisis of our day and time. Corporate real estate companies and private investors are buying up multi-unit properties in Connecticut with the goal of earning above average profit from their investments. We are not talking about small landlords who we know in our neighborhoods and in our cities who own properties of 4 units or less. Just cause does not apply the property owners of 4 units or less. Longtime tenants, my neighbors in my neighborhood, my neighbors who are the parents of children in my grandchildren's school, who I talk to all the time. They go to the community improvement meetings that I go to.
Your 3 minutes is up and your time has expired. Can you please summarize?
Sure, I want to just say that currently there's a need for 100,000 affordable units, and that's a crisis also. So we ask that you boldly pass out of committee House Bill 6889 and move it on to the House and Senate. Thanks very much.
Thank you very much. Any questions from members of the committee? Seeing none, I just want to personally thank you for coming before us. I know you've been doing this kind of work for a very long time.
Thank you. Yep.
Next is number 33, William Roberts.
Hello to Senator Marks and Representative Felipe and all the members of the Housing Committee. My name is William Roberts. I am a resident of Hartford and a Smart Justice Leader with the ACLU of Connecticut. I am here in support of HB 6889, an act concerning evictions for cause, and HB 6849, an act concerning the collateral consequences of criminal records on housing opportunities. I'm going to direct most of my testimony to HB 6889. First off, I would like to say that housing is not just a basic need, but a human right. As of right now, the list of requirements just to get access to housing has increased over the years with very little oversight on the impact it is causing. From extreme rent increases forcing out low-wage, hardworking people, to people forking over hundreds of dollars a month in credit background checks and criminal histories. In some of these cases, charges that show no disposition, even if those charges were dismissed. A study done from 2016 to 2019 showed that at the time, over 50% of homeless people living in shelters had a criminal history. Last year, my neighbors received an eviction letter with no explanation as to what they did to break their lease. Confused and angry, they asked me to help them navigate their legal options. They thought it had to be some type of error. Our landlord had previously tried to raise their rent, but the legal protection they had under the Fair Rent Commission had expired. I had high hopes that a just cause eviction bill was going to pass, so I told them to sit tight and wait it out. Unfortunately, a common sense bill protecting thousands of renters across the state did not pass. After buying my first home last summer, I felt a huge weight off my shoulders. I no longer had to wait for numerous rent increase slips under my door that would eliminate any wage increases for me, or pay credit check fees that would suck up my savings. Even after all that, I still had to take getting my security deposit back to court because the burden has always been on renters. It took me 3 months to get back what was already mine to begin with. For people fortunate to have an apartment who have paid their rent and been responsible tenants, their landlord should not have the power to evict them without cause. Evictions devastate and destabilize our communities. Just cause eviction protection is a tool that Connecticut must implement to stop the destructive impact of no-fault evictions. I urge the members of the Housing Committee to support HB 6889 and HB 6948 and put people over business interests. Thank you for listening to my testimony. I'll take any questions if you want.
Thank you, Will. Any questions from members? Seeing none, we appreciate you taking the time. Next is online, Rivera Sharon.
I'm here.
Nice to see you, Rivera. The floor is yours.
Thank you. Good afternoon, co-chairs, ranking members, and members of the Housing Committee. My name is Rivera. I work at Universal Healthcare Foundation, and I thank you for the opportunity to submit testimony in support of HB 6948, and I will also be supporting HB 6948. Sorry, my apologies. HB 6889. I'll talk more about HB 6948, and my coworker will be speaking on 689. People involved in our criminal legal system who finish their sentences have pay their debt to society and deserve an opportunity to live their lives in communities without barriers to being safe, productive, law-abiding citizens. Homelessness has been on a steady rise in Connecticut since 2023, with a continued rise in cost of living impacting people's ability to access affordable housing. And we agree that housing is a human right. People with a criminal record in the state face over 550 legal barriers to meeting their basic needs, like accessing to housing, making it more difficult to reintegrate into society and support themselves and their families. People with criminal convictions are 10 to 13 times more likely to experience homelessness than the people who have not been incarcerated. At the same time, policies that criminalize homelessness, like laws against loitering and panhandling, increase the likelihood that people with a criminal record will encounter the system yet again. Stable housing is critical to a successful reentry for someone that is coming out of incarceration, but by creating collateral consequences related to housing, the state sets up people who are reentering society for failure, which increases their chances of reincarceration. America is the land of opportunity and second chances. We believe in redemption and someone's capability to change and be a contributing member of society. We have to invest in programs and policies that improve reentry, reduce reoffending, and make our communities safer. And one of those policies is removing collateral consequences of a criminal record on housing opportunities. And that's it. That's all I have. Thank you.
Thank you, Rivera. Any questions from members of the committee? Seeing none, we really thank you for your time. Next is Meg Smith. Oh, there you are. Floor is yours. Welcome.
Can everybody hear me? Alrighty, well, good afternoon or good evening to everyone who's joined us here, either in person or online, to Senator Marks, Representative Felipe, everyone else who's here on the Housing Committee. My name is Meg Smith. I am currently a tenant living in Hartford, and I support HB 6889, an act concerning evictions for cause, and I believe that all tenants should have just cause eviction protections. I first moved to Connecticut in 2017 for college. I went to Trinity, and upon graduation in 2021, I decided to make Hartford my full-time home because I love this city, I love this community, and I really love living in Connecticut. I support this bill because I have personal experience with the harms of no-fault evictions. In June of 2024, I was forced to move out of my apartment suddenly and unexpectedly due to a no-fault termination of lease. The situation was confusing, stressful, and disempowering because of the poor communication from my absentee, out-of-state corporate landlord, PMC Property Group. The first notice I received of my no-fault termination was an email I received from PMC on June 3rd asking why I hadn't turned in my keys. I promptly called them, and after several voicemails, they told me that I was supposed to move out on May 31st. When I asked for proof, they sent me a letter backdated to February 20th that neither I nor the cosigner of my lease had ever received, either physically or by email. It was an incredible struggle to get in contact with them. I waited days between emails and phone calls. I never once got to speak with the property manager, and they never gave me a reason why they were terminating my lease. I rushed to move out because I knew how hard it would be for me to find a new apartment with an eviction notice on my record. I chose not to fight it because I didn't have the time, money, energy, or legal knowledge to enter into a legal struggle with this corporate landlord. I was fortunate and frankly privileged enough that I had enough money saved up to find a new apartment with less than a month's notice and the community support to make the move. It burned through all of my hard-earned savings. If I hadn't had these resources and these supports, I would currently be destitute, and I would have had to leave my career, this wonderful community, and this great state. I had been a model tenant. I paid my rent on time, I obeyed the terms of the lease, and I got to know my neighbors, their kids, and their dogs. In fact, I put up with horrific water damage. I lived on the top floor of my building, and a few months after I moved in 2021, every time it rained, water would leak through my ceiling, my walls, and my windows. I woke up multiple times to streams of rainwater on my face. Each time, I reported it to the management, but the repairs were often too little too late. Every time it rained, for 3 years, I would submit a work
Your
order
3
to my
minutes are up and your time has expired.
Alrighty, well, I guess I will gloss over some of the finer details, but I just have to say that nothing compares to the distress caused by not knowing if you're going to be able to stay in your home even if you've done everything right. Just cause legislation, such as the kind that exists in my home state of Oregon, would have prevented this from happening to me and tenants like me. Housing is a human right. Everyone deserves a safe, warm, dry, affordable environment that they can call home. Renters deserve to know that if they abide by the legal agreements they enter with their landlords, they can continue staying in their homes. I implore you to pass HB 6889. We will all be better off with just cause protections. I'm happy to answer any questions you may have, and thank you for your time.
Thank you, Ms. Smith. Any questions from members of the committee? Seeing none, thank you for sharing your personal story with us. We really appreciate it.
Thank you, take care, and have a good evening. I recommend getting up and stretching. It's been a long night.
Next, we will have Chelsea Infinity Gonzalez.
Thank you so much. Good evening, Senator Marks, Representative Felipe, Representative Scott, Senator Sampson, and esteemed members of the Housing Committee. My name is Chelsea Infinity Gonzalez, and I am the Public Policy and Advocacy Director at the American Civil Liberties Union of Connecticut. I stand before you today in strong support of House Bill 6948, an act concerning the collateral consequences of criminal records on housing opportunities. Imagine serving your sentence, doing everything right, and then discovering that you're 10 times more likely to end up homeless than anyone else, simply because of your record. This isn't speculation. This is the reality for Connecticut residents who have been involved with the criminal legal system. Our state has written over 550 barriers in a law that block people from rebuilding their lives, many specifically targeting housing. The cruel irony is that once someone becomes homeless, our laws criminalizing loitering and panhandling, amongst others, push them back into the system. Think about that cycle. We punish people by denying them housing, then punish them again for experiencing homelessness. This trap doesn't just hurt individuals, it devastates entire communities. Without stable housing, finding and keeping a job becomes even more difficult, pushing people further away from economic self-sufficiency. Further, more than half of incarcerated people in Connecticut are parents. When we deny someone housing because of their record, we're not just punishing them, we're punishing their children too, as they are directly experiencing the harm of these systemic barriers. If the system were fair and equitable, this would be an entirely different testimony. But the criminal legal system has always been designed to disproportionately target Black and Brown communities, and the numbers reflect that. In Connecticut, more than 42% of people in prison are Black, a ratio that has remained unchanged even as the overall prison population has declined over the past decade. Latina men in Connecticut are 3.9 times more likely to be incarcerated than white men. Allowing blanket housing denials based on criminal records would only extend this racial inequity beyond prison walls, keeping entire communities trapped in cycles of instability. House Bill 6948 offers a practical way forward. Instead of allowing blanket denials that perpetuate this cycle, it requires housing providers to look at each person as an individual. Criminal background checks would only happen after a conditional offer, and the bill thoughtfully considers both sentence length and age at offense. It also provides landlords with clarity, protection, and resources, including civil immunity, training, model forms, and clear guidelines on documentation to ensure fair, transparent decision-making while reducing legal uncertainty. This approach recognizes two crucial facts. First, that this legislature itself has already classified crimes by severity through sentencing ranges, and second, that brain development, particularly in areas related to impulse control and decision-making, continues into the mid-20s. Our courts, parole boards, and other justice system actors already recognize that young people
and your time has expired. Can you please
should be treated differently when considering accountability and rehabilitation. In essence, this bill is about basic fairness. It's about whether we believe in redemption and second chances, and the idea that no one should be defined forever by their worst moment. And so I urge this committee to pass House Bill 6948 and ensure that Connecticut is a place where people can rebuild their lives, support their families, and contribute meaningfully to their communities without unnecessary and harmful barriers. Thank you.
Thank you, Chelsea. Any questions from members of the committee? Seeing none, I have one of my own. I just wanted to ask, when considering this bill, can you go a little bit further into the brain development piece that you talked about? Why is it so important that we look at people who are under 26 years of age a little bit differently than we're looking at anybody else when it comes to these lookbacks and these criminal records?
Absolutely. Thank you so much for your question, Representative Felipe. This provision in particular, the under 24 years old provision, is based on research about brain development, rehabilitation, and reentry challenges specifically for young people. So we've rooted this in scientific studies that show that brain development, as I said, particularly in areas related to impulse control, decision-making, your prefrontal cortex is still in development well into your mid-20s. And so we are just recognizing that young people, in the same way that courts, parole boards, and other justice system actors in Connecticut, but also beyond Connecticut, we are simply trying to recognize that young people should be treated differently than older adults when considering accountability and rehabilitation. Young people released from incarceration in particular face especially high barriers to stable housing. And without it, they are at greater risk of homelessness, unemployment, and re-involvement with the legal system. And so this is one way that, we believe will help young people in particular successfully transition into adulthood and reduce long-term instability.
Yeah, I want to thank you. This is something that we've spoken about at length. It's something that's very near and dear to me. People that are young are really starting out their lives, and when they have a criminal record so early, people tend to have a view at points that a criminal record is a criminal record is a criminal record, and that's just not the case. Sometimes people have made a petty mistake, got caught doing something, and they especially when they're younger and their brain isn't fully developed, need the opportunity to be able to grow, be able to build and build a life the way that other people have. So thank you very much. We appreciate you coming out. And I'm now going to turn it over to my co-chair. But before I do, I just want to say welcome back, Austin. We have our former clerk here doing a little bit of work for us. So thank you, Madam Chair.
Okay. Next, we have Xiomara Fugan. I hope I said it right. Fugan. Go right ahead.
Muy buenas tardes, mi nombre es Xiomara Fugón, representativo Felipe, senadora Marx y los miembros del Comité de Vivienda. Mi nombre es Xiomara Fugón, soy residente de Bridgeport y miembro de Make It the Road Connecticut. Yo apoyo la propuesta de ley HB 6889, una ley relacionada al desalojo por causas justas, y creo que todos los inquilinos deberíamos de tener protección de desalojo por una causa justa. Durante los últimos años ha sido casi imposible encontrar una renta accesible. Durante los últimos años ha sido casi imposible encontrar una renta accesible para vivir en buenas condiciones. Y con renteros justos que se aprovechan de las leyes vagas que protegen al dueño y solo alquilan vivienda para ganar más dinero, más no les importa si nosotros tenemos otras necesidades como seres humanos o los que vivimos realmente en un apartamento. Hace ya 3 años tuve mi propia experiencia de desalojo, que anduve sin hogar con mis 3 hijos. Fue por un mes que anduve viviendo de casa en casa, personas que ni siquiera conocía, personas de buen corazón, para yo poder, nunca había vivido un diciembre de esa manera, para yo poder vivir una Navidad así, sin hogar, de 20 años que tengo de vivir en Estados Unidos. Pero eso pasó a causa de renteros que no se tocan el corazón para ponernos en contra de nuestros propios derechos. La renta justa no existía hace 3 años atrás. Tuve que ir a la Corte de Vivienda y hablar con un mediador, donde me hicieron firmar un papel en inglés en el cual yo aceptaba un desalojo, aunque yo pedí 1.000 millones de veces y repetía constantemente de que me gustaría haber tenido una audiencia porque tenía pruebas suficientes que mi desalojo era injusto. Aún así, la mediadora no se tocó el corazón con tan solamente decirme, no importa, el juez no te va a ayudar nada a ti, porque recuerda una cosa, los jueces siempre van a estar a favor del arrendador, no de ustedes. A los inquilinos no tienen derechos. Entonces me pregunté, ¿hasta cuándo van a seguir violando los derechos de nuestras maneras? Porque incluso los mediadores, a veces uno trata de hablar, de ser diferente, pero todo siempre está en contra de nosotros. Entonces sería una forma de cómo ayudar y protegernos a nosotros. No solamente hay propietarios que se hacen pasar por buenas personas, pero cuando a ellos les toca, no se tocan el corazón con uno. No sé por qué razón, no sé por qué. ¿Será que los del consejo, los senadores o los miembros del comité de vivienda no pelean nuestros derechos como inquilinos? Siempre van a tener la razón los dueños de casa, los dueños de apartamentos. Muchas veces creemos que los arrendadores son personas buenas, pero luego nos damos cuenta que no nos anduvieran robando electricidad por meses, porque fue una de las razones que me pasó. No nos damos la oportunidad probablemente porque nos dicen que como inquilinos siempre saldremos perdiendo. Siempre, y no soy la primera persona ni la última persona que todo el tiempo tenemos que perder ante una audiencia sobre vivienda. También nos damos cuenta de que no son tan buenos cuando venden las viviendas sin avisarnos y nos dejan sin contrato para que los propietarios nuevos nos echen cuando se les da la gana por nuestros contratos de renta, porque nuestro contrato de renta expiró. ¿Cómo les ha pasado a mucha gente de comunidad? No es justo que vivamos sin miedo permanentemente de perder nuestro
Time
techo.
has expired.
Lamentablemente.
Can you please summarize?
Sorry.
Interpreter, could you please?
¿Podría resumir, por favor?
Ok, bueno, resumiendo el caso es que yo apoyo la ley HB 6889, una ley relativa a los desalojos por una causa justa y que por favor realmente se pongan la mano en la conciencia y en el corazón que no todo se lo den a los propietarios. Solamente estoy abogando por nosotros los inquilinos, nuestra comunidad. Gracias.
Hi, good afternoon. My name is Xiomara Fugon, Representative Felipe Marth and the Housing Committee. I live in Bridgeport, part of the Making the Road Connecticut. I'm here in favor of the Bill 6889 about just cause for evictions. I think that renters should have protections for this. Recently, in the past years, it's been impossible to find accessible rents and to be able to live in good conditions. Renters really lay upon the laws and they only do want to earn money. They don't really care about our needs. And I had an experience that I was evicted. I was with my 3 children without a home, and I had to rely on good-hearted people to live with them. I had never lived a December alone with no home in my 20 years in the US. Basically, landlords don't have any empathy. They can't reach their hearts when it comes to our rights. I did go to court a few years ago to basically accept my eviction because back then there was no just eviction. And I asked many times that I would like an audience because I had proof that this eviction was not a fair eviction. However, that wasn't the case. The judge doesn't really care because at the end of the day, they're in favor of the landlords. And so until when are landlords going to stop violating our rights? Because, you know, I try to speak, but everything in reality is against us. These property owners pass as good people, but really they don't touch their heart and have empathy for us when we do need it. I don't know why. You know, we do have a council, we have senators, we have a housing committee. Are they not defending our rights? Are landlords going to be always right?
Thank you. Is
And
that, oh, okay.
I
Continue.
apologize. And so to resume, I do support this bill HB 6889 because we really want the landlords to have some more empathy towards renters. Thank you.
Thank you. Housing committee members? Oops, we appreciate your testimony. And next we have Rachel Merva. I see you online.
Thank you. Good evening, Co-Chair Representative Felipe, Co-Chair Senator Marks, and members of the Housing Committee. My name is Rachel Merva. I am a resident of Milford and a member of All In for Milford, Missions Chair of and Church Council member at Mary Taylor Memorial United Methodist Church, and board member at Bethel Center Incorporated. I support House Bill 6889, an act concerning evictions for cause. We are continuing to lose affordable housing in Milford as units and buildings are vacated and sold. Projects that were built with deed restrictions for affordable housing are expiring. Although some new projects are being built with a set aside for affordable housing, our percentage of affordable units continues to decline. One way to protect affordable housing is to enact just cause eviction protections for tenants. Today, those with disabilities and seniors in the state of Connecticut have just cause eviction protection, but these rights are not extended to other tenants in buildings of 5 or more units. Just Cause has been enacted in 7 states and 23 communities around the country, and there is growing momentum. Expanding these protections for tenants prevents displacement, decreases evictions, and increases housing stability. I'm a landlord and a homeowner in Milford. I am grateful that I have tenants that continue to grow roots in the community they are living in, first as a married couple and now with children. But I've seen countless friends move out of Milford as rents skyrocket and their housing burden just becomes too high. As a homeowner, I recognize that we need a diversity of housing options for residents and that adequate income-based and other rental housing is an essential part of our ecosystem. We must all work together to ensure our residents have what they need to thrive, and Just Cause provides critical protection for our tenants. For these reasons, I strongly support House Bill 6889, an act concerning evictions for cause. Thank you.
Thank you, Ms. Merva. Any questions from, okay, we appreciate your testimony. Thank you. Next, Chelsea Connery. Is your microphone on?
Yes, it is now because it's red. Good evening, members of the Housing Committee. My name is Dr. Chelsea Connery. I'm a resident of New Haven, a tenant in a 2-family home, and a staff attorney at the Connecticut Fair Housing Center. I submitted written testimony detailing my support of HB 6889, HB 6892, HB 6948, and HB 6943, my opposition to SB 1304, and comments on SB 1264. I'll focus my testimony here today on HB 6889, an act concerning evictions for cause. As a tenant, I have personal experience with the painful and uniquely disempowering process of being threatened with a lapse of time, no-fault eviction. And I know through my work as a staff attorney, supporting on eviction defense, conditions issues, and tenant organizing, that my situation is not unique. Given some of the prior conversation, it seems important to be very clear about what HB 6889 does and does not do. Currently, the majority of tenants who are on month-to-month leases or whose lease is up can be asked to move out or can be evicted for no reason through the use of no-fault grounds of eviction, of which there are 2 primary ones. At the most basic level, all this bill does is eliminate only no-fault grounds for eviction and require that landlords provide a justification for lease non-renewal and eviction. This idea is not new, as you've heard, and no, we have had this law in the book for subpopulation of renters for over 40 years, and thousands of our Connecticut renters with federally subsidized housing are similarly protected. So all this law is doing is expanding the population of covered renters. So just cause under this bill would apply to tenants who have lived in complexes of 5 or more units for at least 12 months. That is, prior to the protection kicking in, there's a probationary period of 1 year during which time a landlord could in fact use no-fault grounds. The bounding of protections to tenants in complexes of 5 or more units means that our smaller landlords will also not be impacted by this bill. So what it means for tenants is that protected tenants, those who have been living in their complex of 5 or more units for at least 12 months, can't be asked to move out or evicted without a landlord citing one of the grounds listed in law. We've heard arguments that this is going to hurt good tenants, which, like, setting aside the problematic nature of that divisive language, it's just not true. The probationary period gives landlords more than enough time to suss out possible concerns. If a tenant is harming or endangering their neighbors, that is just cause for eviction and non-renewal. More importantly, however, something like this, like just cause protections, helps prevent a revolving door of tenancies that often decreases trust and safety among neighbors. Other examples that have been cited today and in written testimony of opponents are tenants doing things in violation of their lease. Those two are cause for
Your
eviction
3
and
minutes are up,
non-renewal.
and your time has expired. Please summarize.
Sure. I also have responses to some questions that were asked earlier regarding development and populations of tenants who are currently protected, and I'm happy to answer questions on that.
Okay, if you could answer those questions that were answered before about the population, that would be much appreciated.
Sure. So, so the current just cause law applies to 11% of Connecticut renters. That is around 115,000 individuals. 36% of Connecticut renters, it's about 360,000 individuals, live in properties of 5 or more units, which are covered properties under just cause. Of those living in covered properties, 22% are 62 or older, and that population is with or without a disability. And then 12% are under 62 of age and have a disability. So that is the population of people who are currently covered, and I'll provide that in my written testimony as well, so you can look back on it. So then it would just be expanding to the rest of those populations in those covered properties who are not elderly or disabled. Do you want me to say anything about development?
Yes, please.
Okay. So there is research, and I have included links to like everything that I'm citing in the written testimony. Evidence from states with universal just cause, research indicates that it does not impact the housing development market. In New Jersey, where just cause protection has been on the books since the mid-70s, development rates have been surpassing Connecticut's. There's also been a very recent study where researchers conducted like the first real empirical analysis of the impact on just cause and development, and there is no evidence that universal just cause protection in California, Oregon, and New Hampshire, which all passed their laws at different times, have resulted in a decline of new construction. So there really is no impact on what we are aiming to do with like, this is a short-term, immediate policy that can be, impact people's lives now, and it's not going to impact our long-term goals of building more affordable housing.
Thank you for that. Those were my questions, so I appreciate it. Anybody else? Okay. Oh, yep, go right. Yep, Rep. Turco, go right
Through
ahead.
you, Madam Chair. I've been in and out of this room at different events and meetings today, so I haven't been able to ask too many questions on this bill. So appreciate the opportunity. That's okay, Madam Chair, because you seem very knowledgeable, and I really appreciate the way you explained the merits of this bill and the details of it. My first question is just, in your experience, for when an individual's lease expires, they're in that month, and they're evicted, what, in your experience, are usually the reasons that a landlord might tell a tenant that they're evicted?
Mm-hmm. So in the cases that I have been personally involved in and that I experienced myself, oftentimes it is, the goal, you can always get more money from a new tenant than you can from an existing tenant. So a lot of times it's used to push people out in order to raise rents. We've had one large landlord in the state that has been buying up property that has been publicly cited as stating they engage in tenant replacement strategies. You can deduce from that what you may. We've also seen no-fault eviction used as a discriminatory tool, especially against our immigrant populations, Black populations, and our LGBTQ tenants. Again, this is, I think someone brought this up earlier, is that it's very difficult for tenants to prove when we have an option like a no-fault eviction where there is no justification required to be provided. That is a very easy tool to abuse in situations where you are looking to push someone out for discriminatory purposes. And then finally, no-fault evictions are also used to retaliate against tenants, right? The retaliation statute that we currently have only protects tenants for 6 months, following the assertion of certain rights. And we've seen landlords wait that time period out and then use that no-fault eviction ground. And, on top of when it's being used, there's also the fact that it can be used. So tenants are modifying their behavior because they fear, right? They don't want to shake the boat. They don't want to be the squeaky wheel because they're like, I need to stay here. So they might not, and this is also a personal experience of mine, they might, for example, live with an oven that when you use it, it sets off all the carbon monoxide detectors in your apartment because you tried to get it fixed, 2 or 3 different times and it wasn't working out. And you don't want to be the squeaky wheel because you need somewhere to stay.
Thank you. And through you, Madam Chair, and we heard someone earlier talk about they have a bed mice issue. So that could be a tenant that's complaining about the mice problem that they have, and the landlord says, I'm just tired of this, right? And that's a case where it could be used.
Yes, yeah, there are some retaliation protections that currently exist, but it is, yes.
So what would you say? I'll often hear from landlords, and I'm sure there was testimony on this earlier today I missed, or there will be. And you sort of alluded to it, the situation where there's an individual that is a problem tenant. They're causing a disturbance. They're a nuisance to the other tenants. It's a benefit for everyone else in that building if this tenant was removed because of the harm they're causing to quality of life. But if you have to go through having a cause and going through the court system, it could be extremely lengthy amount of time, costly, and sometimes just impossible to actually remove that tenant. This is what I hear. I'm not a landlord myself. I haven't experienced this. I know when I've rented, I've complained to landlords before because of tenants who caused disturbances, and they weren't dealt with in a timely manner. And maybe it's because they couldn't go through the court system. So what can you tell me about that?
Sure. So first, to be very clear, is a no-fault eviction is an eviction. It is currently in the statute as lapse of time, right? That means like that your time here has lapsed, but really what there's no justification that needs to be provided. So that is going through the court system, right? If you ask a tenant to move out at the end of their lease, oftentimes they will, but if they, are feeling insecure, they can't find a new place to live, you have to engage in that eviction process. So the no-fault eviction is an eviction process that goes through the court. So what you're saying, for any number of reasons, you're talking about fault-based grounds, right? Which we have several, right? And Attorney Podolsky had mentioned these before, but they are, violation of your lease or rules and regulations that you and your landlord have agreed to after the lease contract, violation of your duties as a tenant under state law, serious nuisance as that is described separately in state law, nuisance as that is described separately in state law. So there are these fault-based grounds that landlords can turn to, especially, I will mention that lease violations, you write the lease. You can write whatever you want into that lease, right, in terms of those rules and regulations. So there is a lot of fear mongering about the difficulties of proving wrongdoing and using fault-based grounds for eviction. In reality, we at the Connecticut Fair Housing Center did an analysis of judicial data, which shows that the timeline from filing that eviction to judgment in that eviction case for lapse of time as a no fault ground versus fault-based evictions is not statistically significant. Between 2017 and 2023, the median case processing time for all evictions was 31 days. Again, that's from filing to judgment. And the median case processing time for no fault evictions was actually 35 days. So in some cases, it actually takes a little bit longer.
I really appreciate that. And last question through you, Madam Chair. I really appreciate you giving those dates, 31 versus 35. That gives me a lot more clarity on the court process. Maybe this isn't a good idea, just curious. Couldn't one way to solve this be not allowing month-to-month leases anymore? When a lease ends in another year, a new lease has to be signed. It's year to year. The landlord, the tenant, both at the end of each year have an opportunity to renew or walk away. Has anything like that been done in any other states or?
No, that
Ms.
hasn't.
Connery?
Oh, sorry.
I'm just, yeah.
That has not been a policy provision that other states or municipalities have looked at in response to this issue. I think that, that type of lease can be beneficial for some population of our renters. The problem is when renters are forced onto a month-to-month lease, which we often do see with some of our more vulnerable populations, because for them, like the month-to-month lease gives the landlord a lot more control over that person's life. And so I don't think that that is the route to go to mediate some of these issues, because it can be beneficial for both parties at some point in time to have that option. The problem is when that option is abused, and this is a way, I think, the best way to kind of navigate that. Mm-hmm.
Thank you so much. Thank you so much, Madam Chair.
Yep. Any other questions? Okay, we appreciate you very much. Thank you.
Thank you.
Next, we have Sarah Mervine. I believe I saw her online. Yes. Hi, welcome.
Hi, Senator Marks, Representative Felipe, and members of the Housing Committee. Thank you for allowing me to give testimony. My name is Sarah Mervine, and I am from the Center for Children's Advocacy. I'm an attorney and also the director of our Yale New Haven Health Medical Legal Partnership, which is a pediatric program. And I'm speaking in support of 6889, and very much like some of the other lawyers who spoke today, I want to just focus on the kinds of cases that I actually see, which is a byproduct of no-cause evictions. And we've already talked about it today, but I just want to give you some of the real case examples that I've seen. I receive cases from pediatricians when the children are sick. I get these cases and I work on housing and education and other issues. And what I can tell you is that I have lots of housing conditions cases. I've seen with my own eyes lots of homes where they're infested with mice and roaches and bed bugs, with leaks and mold, with chipped paint, broken doors and windows, and no heat. And in each of these cases, I can help. That's what I do. I can get the person to the inspector in the town. I can file a fair rent. And the best part of it all is I am free. So if you're lucky enough to get to me, I am free representation. And still, many of my clients do not go forward and assert their rights because they are afraid that at the end of the day, they are going to get this no non-renewal of lease or no fault eviction, which it is an eviction, make no mistake, and it goes on their record and keeps them from renting other houses. So as somebody who's defended these no lapse of time, no fault evictions, I will tell you they're very tricky to defend because your client is blameless and therefore it's very hard to raise a defense. I still try to convince people that it is, they should stand up and talk about their rental issues. I had a client recently, these are just some recent cases, a client who had no heat. She had several children and a newborn baby, and she was using her stove to heat the place. And the landlord said, I'm going to fix it. I'm going to fix it. And I told her, let me do something. And she said, I just went through a no-cause eviction at my last place. I cannot do it again. I've also had clients where I've brought fair rent and we've gotten the landlords to fix things after getting the rent reduced. And as soon as the conditions are fixed, the landlord brings a no-fault eviction. So it's something I have to warn my clients about. Conversely, I've seen clients who've had just cause protection, those disabled individuals or seniors who are in 5 or more units, and I have been able to vigorously defend them against these housing conditions. These families deserve it. All of our families deserve the same. I welcome any of your questions. Thank you.
Thank you, Attorney Mervine. Any questions? Yep, Representative Weir.
Thank you, Madam Chair. I'm trying to get to the bottom of this. I'm not clear in my own head, so I'll just leave it that way on this subject. You stated that this is absolutely an eviction, and I'm trying to comprehend how do we get from a failure to renew a lease? The lease ends, the property owner fails to renew, decides not to renew the lease. At what point does this turn into an eviction? That's something is missing in that connection for me, through you, Madam Chair.
Attorney Mervine.
I really appreciate the question and the ability to explain this for those of you who haven't been in eviction court. And if you haven't been in eviction court and you're on the housing committee, I welcome you to go to eviction court and see how fast things actually go. So how does this become an eviction? We just heard the last attorney explain how many of our clients live month to month. And what happens is they sign a year lease and then they're left to go month to month. And the landlord leaves them sort of hanging there on this month to month case, right? So if you're one of my clients and you come and you complain about conditions, you can get a lapse of time eviction for the end of that month within a week. You can have to be out. And if you're like most of my clients who happen to mostly be women who are caring for children, many of whom have disabled children, if you are that person, you don't have another place to move. So if you don't move once the notice to quit runs, then what happens is you get served with an eviction. Once you get served with that eviction and your name goes on the court website, you are done in most of Connecticut for getting a place to live. You have now an eviction filed. When landlords look up Sarah Mervine, they see the eviction. They don't care that it's lapse of time. Lapse of time tells them you didn't move when that landlord wanted you to move because you couldn't. Lapse of time might even tell them you complained about conditions. They don't want that person either. And that's how it becomes not just an eviction, but a record and a threat that is so big that as a good lawyer, I have to warn all of my clients of what they're up against. I warn all these people, this may happen. I warn them. I tell them I will defend them if this happens, but ultimately this may happen. I hope that answers your question, and I'd be happy to talk more about an eviction record. It is something that is, studies have been done that is worse than a conviction record in terms of caring for your family and getting money and how you're going to care for your kids. And we see it all the time.
Representative Weir.
Thank you. I think you made the connection. I mean, I guess the answer to my question is it turns from a lapse of time failure, a failure to renew the lease. It turns into an eviction when the resident refuses to move and the courts become involved. That's the clarification. Thank you.
May I answer that? Not when the resident refuses to move. I've never had a client refuse to move. Most of my clients want to move, especially the ones who are dealing with lead paint and chipped housing, and certainly the ones with no heat. They are looking for a place to move. Most of them don't have the security deposit together and the first and last month's rent to move, but they want to move, and they are given about a week to move. And I don't know how many children you have. I have 3. And if I had to pack up my whole household and move within a week, even if I had somewhere to go, it would not happen. So it's not when they refuse to move. At least that's not my answer. My answer is when they cannot move. They've been given this week to move. And also they had no warning because they didn't even know, because they didn't do anything wrong. They weren't misbehaving. They were paying their rent. They're surprised by this notice to quit. And if they don't get out within the week, yes, they're facing an eviction.
Representative Weir.
Yeah, I thought I heard you say doesn't move or refuse. Bottom line is the resident doesn't move and it ends up in the courts. So yes, that's the clarification I was looking for. Thank you.
Ranking Member Sampson.
Thank you, Madam Chairman. Counselor, thank you very much for your testimony. You're very good at your job. And you do make a very strong case for this bill. But I think you take some liberty with the language in some respects. When someone has a written lease, they know at the moment that they sign that lease, the date that it terminates, do they not, through you?
Attorney Mervine.
When somebody has a written lease, I think they sometimes know when it ends. We're living in a fictional world, so I want to tell you what I actually see on a day-to-day basis. I see clients who don't speak English, who don't read the lease, who don't understand the lease, whose landlords haven't given them the lease. But to answer your question, if I'm given a lease and it has an end date, yes, I know when it ends. I do also want to add, and I think it's important to add, that so many of our clients get that 1-year lease. They know when that 1 year is up, but then they're on a month to month, and then they really don't know, and they want to keep that lease going. I also want to tell you that these are children who are in school, many of whom who are disabled, and they have special programs at their school. So yes, the client knows this is the end date, but of course the client who's making this their home is hoping to stay there, especially if the landlord's staying in the business of renting and they're just going to rent to somebody else who didn't complain about the mice. They feel that they would like to stay there. But to answer your question, 100%, yes, if leases should have an end date for a year. Sometimes my clients have seen them, sometimes they haven't. I would say 90% of my clients come into my office and they do not have a written lease.
Ranking Member Sampson.
Thank you, Madam Chairman. Okay, I appreciate that. And I appreciate you sharing, what happens in reality. And that to me sounds like a communication issue more than a contract dispute, which is what I think we're delving into when trying to write this policy, this legislation to change the state policy. I'll just note, by the way, that you mentioned a couple of times that you're referring to folks that have a disability, and I believe they're already covered. So they're really not part of this equation. We're sticking more with people that are not seniors and they are not disabled. They fit into the other category that is not currently covered. So I guess what I'm trying to determine is, and just following up on Representative Weir, which is how do we get from somebody's understanding that the lease term, the period that has been previously agreed to for the time that they'll have the ability to occupy and use a property, does have an end date, to referring to the landlord as somebody who's evicting their tenant without a reason? I mean, to me, those are two wildly different characterizations of the same thing. Through you, Madam Chairman.
Attorney Mervine.
So there's a few questions there. I'm going to try to take all of them, but if I miss them, I'd like you to just tell me again, because you sort of give a lot of questions, but forgive me, not so much time to respond. So let me respond to the first one. Absolutely, I'm talking about people with disabilities as part of it. Obviously, this bill will cover 5 or more units and will cover people who do not have disabilities and aren't elderly. That's true. But what I'm seeing, I would like just cause to be expanded. Obviously, that's not what's in front of this body right now, but certainly people who have children who are disabled, who live in 4 units or less, they are under this kind of scrutiny that I was talking about. So that's number one. We absolutely are talking about those people. We're just not talking about protecting them tonight, much to my dismay. Your second question was, is this really a contract question? And I just want to give you a thought experiment for one quick second. If you are running a bakery and people are coming and you're passing out coffee and they're paying for that coffee, and then a person comes and says, I'd like another cup of coffee, and the business owner says, no, I'm not giving a reason, but I'm no longer paying. I'm not letting you pay, even though you're paying, and all these other customers here, I'm ready to serve. I'm not ready to serve you. We would recognize that something's wrong. So when you're talking about the landlord and their expectation of getting this property back, if they want the property back so that they can move themselves in, so that they can do certain things with their property, they're welcome to do it under this bill. If they want it back because you weren't the kind of tenant they wanted, not because you broke any lease, but because you actually followed the law and you complained about your rental conditions, you went to fair rent and you beat them at fair rent, that says to me that they shouldn't have the right to kick you out at the end. But how does it get to the eviction? It gets to the eviction because these things move quickly and because we know how tight our rental market is and people just don't have the luxury of moving. So if people don't know where to go, if people aren't able to move, then they're going to be there past the date, and that landlord now has the right to go to eviction court. It doesn't have to get to eviction. It's the landlord who takes it to eviction. After all, this is a rent-paying person. They could just keep them paying the rent. This is a law-abiding person. They haven't done anything wrong. Had they done something wrong, they would have a for-cause eviction.
Ranking Member Sampson.
Thank you, Madam Chairman. I appreciate the analogy, although I don't agree that it's a good one. I don't think a business that is offering coffee to any consumer that walks in the door is the same thing as a property owner that retains ownership of their property and should be able to reclaim it for their own or a different use at some point in the future, especially when it's negotiated in a contract with a specific set of terms and an end date. And I also would point out that that's not against the law. You can refuse to give somebody a coffee. What we're talking about here is a little bit different. The question I asked, you gave me an answer, but it wasn't really to the exact question I asked. I was asking how we go from characterizing the end of a contractual agreement that everyone understands the terms of to characterizing it as, in your terms, kicking someone out or an eviction, etc. That's what I'm wondering, because, you know, the landlord, when he offers the property for rent, is offering to make terms with the tenant, and that those terms can be, you know, negotiated, whether it's the amount of rent or, you know, whether or not you have use of the driveway or the garage, or, you know, what the length of the lease is going to be, etc. So if those terms are all agreed to, and we're going to just evaporate the expiration date as one of those terms, as far as this law goes, like doesn't matter anymore, then what else in the lease doesn't matter anymore then, is really my question. Because I just see it as if you don't have to honor the expiration date as a tenant, then why do you have to honor whether or not you had access to the garage? Or why do you have to honor any other aspect of the lease? Through you, Madam Chairman.
Attorney Mervine.
Okay, you've again asked me a lot of questions, and one by one, I really would love to take them. So let's try here. You said a landlord reclaiming their property. So I want to be clear about what what just cause is and what it isn't, right? If a landlord wants to reclaim their property, they want to say, I don't want to be in this business anymore of renting. They can do it. They say, my family wants to move in. They can do it. They say, I want a reasonable rental increase. They can do it. So it is putting limits on things, but it's not keeping them from their property. They're the ones who have decided to be a landlord. That's number one. The coffee analogy is sound in that you cannot just refuse service to people with no cause. That will lead to a problem. We, as we put on public policy, we decide that the landlord is in the business of serving people and giving them a place to rent, right? And so I want to talk about what really is happening when just cause happens, is that if you said, well, why don't we just erase the other terms? That was your other question. Why not throw out all the other terms? Well, the other terms will lead you to a lease violation. If you start parking in the driveway, and the driveway is not yours, first of all, the landlord can just have you towed if you do that. But we aren't asking for you, if you violate any of the other leases, that's for the clauses, that's for cause. What we're saying is that if you've been a good tenant and you've paid your rent and you're paying the rent that the landlord wants, and you haven't breached anything in your lease, why should you have to leave that property so the landlord can rent to somebody else? as a matter of good public policy. It's just not a matter of good public policy. If the landlord's staying in that business and you're paying the rent, why not let that tenant just stay?
Ranking Member Sampson.
Thank you, Madam Chairman. A couple of things. First off, you said when the landlord decided to become a landlord and rent out their property, and I don't disagree with that, except there is a distinction that the landlord agreed and decided to rent out their property for the term specified. You know, this is the thing that keeps being glossed over as not a matter of fact and importance. You know, we respect private contracts in every other aspect of our society and the way our system works in America. This is a case where we're basically undoing a contract. We're not even talking about changing the law so that these types of contracts can't exist anymore. We're still going to have landlords and tenants signing leases that have a 1-year expiration date. And then we're going to say, well, that doesn't matter. It's like the Twilight Zone, to be frank, counselor. I don't understand how we can still be allowing leases with a 1-year term if we're going to say that 1-year term doesn't mean anything, because in your words, the landlord is still a landlord because they chose that. So they must have to offer their property out forever without any change whatsoever. They can't change their mind. I'd also like to.
Well, may I answer that before? May I answer?
Can you please wait, Attorney Mervine, until Senator Sampson's done? I thought he was done. It was my error.
Oh, sorry.
I apologize. I'm trying to wrap up here, and I'm trying to finagle a question here. I've been trying to get the same answer a few times, and I guess we just disagree is the bottom line. But I'm trying to understand how we can justify a key point in the contract. You said that, you know, other points will get you in trouble if you use the garage when you're not supposed to or something like that. Well, going past the expiration date to me is a key point of the contract, and going past it should get you in trouble. You know, it's like the negotiation happens in the beginning. The terms are predetermined, and the contract normally states what happens at the end, whether the person has the option to renew, whether that both parties have to agree, whether there is a month-to-month situation, but it's in writing and it's already predetermined. This bill will effectively ignore what both parties have agreed to, and in fact, saying that even though both parties agreed to it, only one of them is obligated to honor it. And that's a concern I have. Again, I guess there's no question there, so I'll just leave it right there. Thank you, Madam Chairman.
I'm so sorry, but I believe there was a question, and I would like to answer it if I'm allowed to.
Attorney Mervine, I'm sorry. He didn't have a question, so just to stay with process, we are all set, and there's no other questions. We appreciate your testimony today.
Thank you.
Next, we have Peter Kiernan.
Senator Marks, Representative Felipe, members of the Housing Committee. I am Peter Kiernan, a resident of Burlington and an admitted student at UConn School of Medicine, where next fall I will begin studying to become a doctor. Right now, I work as a nurse aide at a skilled nursing facility in our state. As a current and future healthcare provider, I am supporting HB 6889 and the expansion of Just Cause, not only to more tenants, but to more patients in our state. While I shadowed a doctor at Hartford Hospital last year, he paused between palpating a patient's liver and assessing their jugular to ask them about their housing situation. While shadowing an internist at the skilled nursing facility where I work, I learned each patient's chart includes a social history. Forgive me, I'm recovering from flu. In which housing insecurity and eviction are all too common findings. Physicians in our state ask such questions and record this information because housing instability and eviction in particular disrupts the treatment of disease. At the skilled nursing facility, I help patients with exacerbations of chronic diseases, those recovering from surgery, and others receiving rehab after injuries. These patients enter our care with an interim problem. Once it is resolved, they are supposed to leave. You'd be shocked how many of our patients recover, yet continue occupying beds in skilled nursing homes because they have no home of their own to be discharged to. I know patients for whom eviction is the direct reason they cannot leave. This is not without risk. More time in a healthcare facility means greater exposure to antibiotic-resistant infections, which can complicate future surgery, worsen existing conditions, and lead to death. This is not without cost. When our patients stay in a skilled nursing home because they have no home to return to, Medicaid usually foots the bill. This is not without cruelty. Imagine having to navigate an eviction at the same time as a cancer diagnosis, dialysis, or injury. Connecticut patients are dealing with this right now. Maybe some patients drowning in medical care costs would still be evicted under HB 6889 for failure to pay their rent. That injustice is discussion for another time. The point today is that, given the serious health implications of any eviction, we at the very least should require a good reason before subjecting any tenant, any patient, to eviction. In a sense, your committee will be putting on your doctor's hats as you weigh this bill's risks and benefits for Connecticut constituents. My advice is to consider what health professionals already know. As a perspective shared in the New England Journal of Medicine puts it, housing is not simply a commodity or a business. Housing security and a fair eviction process are determinants of health. Thank you.
Thank you. Seeing no questions, I'm going to put on my nursing hat and say you will be a much better physician because you are a nurse's aide. So thank you. Next, Grace Brangwyn. Oh, okay. And next we have Senator Gordon.
Thank you, Chair Marks and Chair Felipe, Ranking Member Sampson and Scott, and members of the Housing Committee. I'm State Senator Jeff Gordon, proud to represent 13 towns in Northeast and part of North Central Connecticut. I'm speaking in opposition to House Bill 6944. And to quickly preface my remarks, not only am I speaking as a state senator, but I have 16 years having served on my town's Planning and Zoning Commission, 15 of those as chair. So I do have real world ground level experience dealing with housing decisions and affordable housing. And I do support efforts in general that are reasonable and realistic to address housing issues. And it's just not affordable housing. It's also housing affordability, dealing with the high cost of living in this state. And that has huge impacts on what people can afford when it comes to overall about their housing needs for themselves, their families, or if they're retired and want to stay in Connecticut and live in Connecticut for their remaining years. So it's a much bigger topic than just when we talk about affordable housing. There's a lot of concerns I have about HB 6944. I did submit 6 pages of testimony. I won't read through it all because I know you have a long night, but please read through what I've detailed with regards to some of my major concerns. One of my concerns is that this really is getting to fair share, which we know there's a study ongoing. I was at the presentation by Eco Northwest, and it's a preliminary study that's issued some results, but we don't yet even know much of the detailed recommendations that will later come out. And now we have a bill here that is actually going to tag affordable housing plans more and more to fair share recommendations we don't even fully have yet. And to me, that's putting the cart before the horse. When you talk about making good decisions for our towns from a planning point of view for land use, you always want to plan first and then create regulations after. And this is the other way around. We don't even have all the information we need to be able to tag new affordable housing plans to what is extremely prescriptive for all 169 municipalities. And that gets to one of my next points, which is each of our towns and cities is unique. We know that, and we do respect that. And it's people in their towns that know best what's best for their towns. And they make local decisions. They're elected local officials. They work with state officials and others to make decisions that they know work well for their town. We can't do this cookie cutter. You can't do it one size fits all. This is almost like pounding a square peg into a round hole. We know that doesn't work. And if it was easy to do, 830G, the affordable housing laws, would have worked decades ago, and they really have not. And we need to move in a different direction. For example, as you know, I submitted many bills for creative ways for towns to be incentivized to earn additional housing unit equivalency points, things that many towns can choose from a menu of options and not more mandates that don't work. And the mandates set up many towns, including small rural towns I represent, to fail because they don't have infrastructure, they don't have enough funding and resources to be able to expand housing the way the state says that, quote unquote, they should expand it. And they don't even have public transportation or the number of jobs to even allow opportunities for people who might want to move to the town for affordable housing.
Senator Gordon, your 3 minutes have expired. If you could please summarize. Thank you.
Sure, thank you. And one other point I want to make is that this is going to deprioritize a number of municipalities for discretionary funding. And in fact, OPM submitted testimony to the Planning and Development Committee that I serve on, basically saying they're not in favor of deprioritizing towns or even how to administer that when we were talking about work, live, ride legislation. So that's something that's of a key concern when you're talking about deprioritizing steep grants, for example, for many towns of no fault of their own who want to do what's right. The best thing is for the state to partner and provide more resources and opportunities, town level and regional, to really be of help. And then you set a good foundation to be able to move things forward. Thank you for letting me testify today.
Thank you, Senator Gordon. Ranking Member Sampson.
Thank you, Madam Chairman. Senator, good afternoon. Great to see you. Actually, it's getting to be good evening, I guess. I know that some of my colleagues have more specific questions for you, but I just thought I would ask you a couple of general questions, maybe. Just reading through your testimony, it seems like a lot of it is about this, push and pull between home rule and local control versus the state dictating terms as far as planning and zoning and what type of housing is going to be required and so forth. And I'll note that Senator Looney was before this committee a few days ago for a public hearing. And I had asked him a question and he said that, towns don't have those rights. They're incorporated by the state of Connecticut, and the state should, when they feel it's a important role, they should interject. Now, I've always been I'm more on the side of defending local control. I guess that's kind of the way I see our political system, which is that the individual should have maximum power and maximum rights, and then government is best when it's closest. So you have local and then state and then federal. But I just looking forward to your assessment of this particular proposal and how that interaction between state and municipal control should work in your eyes. Through you, Madam Chairman.
Senator Gordon.
Thank you, Madam Chair. And thank you, Senator, for the question. I've always operated when I was a planning and zoning commissioner that it's the people who decide. They elect local officials. I happen to have been one. And then we work with people to work out what's best, being mindful that local decision-making is a fundamental principle in our country. And one could parse whatever about, various laws and legalities about the federal and the state enabling acts. But there is a basic right that I believe for people to decide what's best for their communities, just as I believe there's a right for citizens to decide that in Connecticut and citizens in our country to decide for our country. This is why we elect officials. This is why we encourage public hearings, why we encourage town meetings, for example. We encourage people to attend municipal agencies and state agencies for their meetings, to know what's going on and be involved. And I do firmly believe, and I've seen this through many years of experience as a town official and now as a state official, as a state senator, that the people of Connecticut know best what's best for the towns in which they live. We have laws, federal and state, to deal with discrimination, and we should, and those laws are used. But I've never seen people using zoning regulations for best decision-making to keep people out. Decisions are made. Sometimes they're tough decisions where you have to sometimes say no to a land use development. But many, many times things are done at the local level for the best interests of people who live there, people who work there, people who travel there, and people who might want to move there. And the one thing we really have to keep in mind about why that's important right for people in their towns is each one of our 169 municipalities is different from each other. That's a fact, that's a reality. And even within each one of those municipalities, there are different parts. My town of Woodstock, the second largest geographically sized town in Connecticut, even though it's around 8,000 people, I can think of at least 12 different distinct parts of that town that are not identical to each other. And we take that into account with regards to local decision making. And that, again, is a fundamental right. I've always viewed it that way. And that's the way that I believe my constituents and the people of Connecticut view it. And that's why you hear a lot about local decision making, but also because it's the right way to be making decisions. We don't really want the state making decisions about parts of the state they don't know anything about and haven't even been out to. That's how you have unintended consequences, bad decision making, and then you spend more time fixing those decisions than you do actually working to make good decisions that just not benefit one town, but a region, and then the entire state. And that's how I've always viewed it and continue to view it.
Ranking Member Sampson.
Thank you, Madam Chairman. Appreciate those comments, Senator Gordon. I wanted to just also ask you one other thing, which is that in your testimony, you refer often to housing affordability, and you make a distinction between that and affordable housing, which is more of a term that is used in legislative chatter up here and maybe as a legal term. But maybe tell us what you feel is the difference and why housing affordability should be the thing we're talking about. Through you, Madam Chairman.
Senator Gordon.
Thank you, Madam Chair, and thank you for the question, Senator. I do see a really major real-world distinction between affordable housing and housing affordability. I sometimes call it housing attainability. The reason is that affordable housing can be a very strict definition if you use 830G. Very, very strict. And because it's that strict, many small towns can never meet the 10% threshold because they just will have no way of really meeting those goals when they have no public infrastructure such as public water, public sewer, minimal, if any, public transportation, not enough jobs, limited budgets, limited resources. Housing affordability is a term that I like to use because when I helped create in my town several affordable housing plans that we were mandated by the state to do, we really looked at and engaged people in my town each time who could really benefit from making housing more affordable, just not 830G affordable. And that's a bigger population of people. For example, if you look at the United Way ALICE data, that's a much bigger population of people who could benefit from housing affordability than very strict state criteria for affordable housing. And in fact, there's many ways you can achieve housing affordability that towns do get zero credit from the state. And that's why I submitted a number of bills this session to show that we can actually create a menu of options instead of mandates that towns can be incentivized to do if they choose, if it works for their town, and that can better help people such as a young working family who doesn't meet the income criteria to be considered low income, for example, yet they're still financially struggling. What can we do to help them? For example, in my town, I helped streamline regulations and cut costs and time that really save money. We helped better allow certain flexible land uses that would better help people use land with regards to less costs and less of a burden on them if they say wanted a starter home or wanted to build accessory dwelling units or other things that can be done. But also incentivizing developers and contractors who might want to build certain degrees of housing affordability, such as for veterans or for seniors who may not qualify for low-income housing assistance. And there's ways to incentivize to be able to have a win-win situation to be of help for a community. Those are things the state can do if it chooses to do it. And as a legislature, we can do that. And so for housing affordability, the other aspect is the high cost of living in the state, taxes, energy costs we certainly know about, workforce development, career advancement opportunities for people. These are all things that factor into affordability in this state. And that does factor into how much money people then have for housing. And the more we can work on all of these issues, including what we do in a creative way with housing in each of our towns, every little bit adds up. And before you know it, you've really helped affordability in general and expanded affordability options for housing, just not very strict 830G criteria that may benefit a limited number of people, but we shouldn't ignore the larger number of people who we also should be helping at the same time.
Thank you, Senator Gordon. Representative Weir.
Thank you, Senator Gordon, for that. And through you, Madam Chair, Senator, do you see a burden placed on the towns? I mean, looking at the reporting requirements and, not just once, but, every 5 years, what can you say about the burdens placed on the towns from a monetary standpoint or otherwise? Through you, Madam Chair.
Senator Gordon?
Madam Chair, thank you. And thank you, Representative, for the question. Yes, it is a burden. There is a cost burden. Having gone through affordable housing plans, it takes a lot of time, takes a lot of resources. It does take money. You do hire sometimes additional staff. You do have to do various things in order to do it correctly. So it is an additional burden. At the same time, the town is still administering its subdivision and zoning regulations, still working to do what it can for proper land use, upholding the key principles of zoning, which is upholding public safety, public welfare, and public health. So yes, there is a burden, but at the same time, what the state causes the towns and cities to go through this process at set intervals, the state doesn't fully take into account that almost every year, things are being looked at with regards to housing affordability when you're attending to town regulations that deal with land use. You just don't sit and wait 5-10 years and say, oh, now I have to look at housing affordability. That's an ongoing process. And that should be better recognized as far as it being, just not bouncing from 5 years to 5 years or 10 years to 10 years, but all the time, that's a continuum that towns and cities are undergoing. Again, this is more of the creative ways that our state laws can better match what towns and cities are already doing. And when you're talking about small rural towns, and I represent a lot of them in my district, these expenses add up. And where do these expenses have to come from? They come from property taxes. There's limited amount that people can pay in property taxes. And then you have to make a decision where else in the budget of a town you're going to pull things from. Heaven forbid you pull it from a DPW or from the schools. So it is a burden, and that does need to be recognized. And that's why we need to unburden the process, but not lessen the work that towns and cities are doing and should be doing to make certain their regulations are meeting what needs to be realistically the needs for the people in their towns and the people who might want to move to their towns.
Thank you, Senator Gordon. We all set, Rep. Weir? Okay, I think we're all set. Thank you, Senator Gordon.
Thank you very much, Chair.
I'm not seeing, okay, so now we have William Love Jr. I see you online. If you could please turn on your camera if possible.
Hello, I'm coming.
Hi, we see you and we hear you. Please go on. Oh, and I think you're frozen. Okay, you're frozen, Mr. Love Jr., so we are going to come back to you because we have a long night. So I will ask you again next. Maybe you should turn off your camera next. Oops, there you are. And if you turn off your camera, maybe you won't lose us again.
Okay, I think it was, I moved to the back of my office, so I
Okay.
switched from Wi-Fi to, at any rate, sorry to keep you all waiting. My name is William Love Jr. I am a resident of Danbury, Connecticut. And thank you to Senator Marks, Representative Felipe, and the members of the Housing Committee. I am the leader of the Danbury Area Justice Network and founder of Danbury Pride. And I am a tenant, and I am here in support of HB 6889, an act concerning evictions for just cause. I am speaking out in favor of this bill because I'm a tenant who has dealt with incredible rent increases. I haven't gone to the Fair Labor Commission or the Fair Rent Commission because it's still under fair market rent. So I'm worried that there will be retaliation from my landlord, which is why I haven't gone that route. My rent went from $760 to $990 to $1,200. And I constantly live with anxiety about whether I'm going to come home and see a notice from my landlord saying that I'm being kicked out or the rent's going up again for no reason. So this legislation would help give me some security, make me feel not quite as anxious knowing that I do have the support of the government, because housing is a human right, contrary to what some people might think. Housing is a human right. Being a landlord is not a job. Being a landlord is providing housing. If your only job as a landlord and your only way of making money is just by living off of the working people, then you need to get a different job, because that is just not acceptable. I don't really know what else to say. I'm a little anxious in case you couldn't hear in my voice, but I support this bill wholeheartedly and hope that the committee does as well. Thank you for your time, and I'll take any questions.
Appreciated. Any questions? Seeing none, thank you very much.
Thank you.
Next, we have Dega Senberga. Okay, and next we have Jacob Pudin. I don't see. Oh, there you are. Hi, Jacob.
Yep. Hi. Thank you, chairs and members of the Housing Committee. My name is Jacob Pudlin. I'm from New Britain, and I'm strongly in support of HB 6889, as well as HB 6892. I think we've all heard from some pretty fantastic lawyers, doctors, and tenant organizers today who know a lot more about the details and logistics of this bills than I do. So that between that and my voice dying, I'm going to keep this pretty brief and just thank the people who wrote the bill for sponsoring such an important piece of legislation, and remind everyone that what we're fighting for here is to treat housing as a human right. And you have the tools more than most to create a society that reflects that prioritizes housing as a right over as a source of profit. Thank you very much for your time.
Thank you. And seeing no questions, we will go next to Brian Lemire and Norma Martinez Hosang. I do not see. Luke Melanakos Harrison. Oh, Luke Harrison. Hi, welcome.
You nailed the pronunciation. Great job. Thank you, Senator Marks. And to the members of the Housing Committee, thank you for sticking with all of us in this long hearing. I know we have a lot to go. My name is Luke Melanakos Harrison. I'm the Vice President and Political Director for Connecticut Tenants Union, one of the key organizations pushing for HB 6899, an act concerning evictions for cause. I'm so honored to be here representing my members, many of whom are working, whether on the clock or at home, and not able to show up to things like this, although so many have. But it's an honor to be able to represent them and speak to their interests in this building. I'm going to use my time to just hit a couple high-level points of themes that have come up throughout the day. The first is I want to just set the context for where this bill came from, it came from originally in recent years, 2022, Representative Q Williams, former co-chair of this committee, pushed for a version of just cause in response to the mass evictions that Up Realty perpetrated at the Stonegate apartment complex in Middletown, which is one of our chapters of the Connecticut Tenants Union. That story of Up Realty and similar deep pocket corporate investment firms coming into the state, buying up properties and clearing out dozens, sometimes hundreds of tenants at a time is the core story that has motivated our push for just cause this year. Up Realty and similar companies have perpetrated those actions against the residents of this state in many of your districts, not just in Middletown, but across the state. And just cause is a crucial intervention to interrupt that highly predatory business plan. So I want to just remind everyone of the context here and the history behind this bill. The second thing I want to speak to is the question around leases, the tenant-landlord relationship, and negotiations. As the tenant union, we are very interested in negotiating with our landlords to reach fair agreements that can work for both parties. The problem with lacking just cause eviction protection is that the tenant essentially has a gun to their head at the end of their lease and extremely minimal or non-existent ability to negotiate anything in that lease or the rent, because all the landlord has to say is, well, I'm not going to renew you and you're going to be out of here. Take it or leave it. There's no negotiation between two parties when one party can threaten the other with homelessness if they don't agree to the first party's term. What we're interested in is fairness and balance and genuine negotiation between both parties to reach an agreement that works, which is not possible without just cause protections. The third thing I want to real quickly point out is that anyone who's claiming that tenant protections are doing more to discourage housing supply than restrictive zoning is doing to curb housing supply is giving themselves away as not arguing in good faith. And I'll just leave that there. Finally, I want to say
Luke,
that
your
the
3 minutes
argument
have expired. If you could please summarize.
Absolutely. The argument that when, the poor, the working class, the have-nots are asking for a policy that will benefit them, the argument is that, is made that, well, it's actually going to hurt them in the long run. They don't know what they need. We know better. That argument has been made not just for decades, but for centuries. And I just want to urge the members of this committee to question whether that argument is being made in good faith and to look at the data, which is firmly on the side of just cause, reducing evictions, increasing housing stability, having no detrimental impact on housing supply, and being a fair, smart, common sense policy that's going to help the state of Connecticut at a time when we really, really need it. Thank you.
Thank you. So I saw Hamilton this weekend, and I'm really trying to talk less, smile more, and not let them know what you're against or what you're for. But that's a song. But I am going to, this has been for 8 hours, we've been hearing this. And so I'm going to ask you this question. It's almost like we're talking about contract law, right? That there's opponents are saying your lease is up after a year, and that's it. You had a year lease, and so we're going to say goodbye to you. And then the proponents are saying, but if you're renting to Martha, and maybe you don't like Martha because she has curly hair, so now you're going to rent to Luke because he has a beard and you prefer beards. So that's not a reason to stop that lease, to stop that rent, and to end that lease. And that housing is not renting a car or renting clothes. You can rent clothes now, right? Or renting a lawnmower. Housing is what you absolutely need. Probably one of two things: housing and food. And I heard somebody say that when you become a landlord, really you're just worrying about getting the lease and getting the money. And I think if you're a landlord, you shouldn't go into being a landlord. Like you shouldn't go into be a doctor or be a nurse or be a teacher if you don't care about people and you don't care about their basic needs. So if you can just explain this kind of contract law, and when a person after the year or after each month, because you have a verbal agreement, that does if the landlord comes up to you and politely says, hi, don't like your curly hair. Well, maybe they don't tell you. They don't have to tell you why they don't like you, right? I don't want you to live here anymore. You need to leave in a week. Is it said like that, or is a piece of paper given, like an eviction notice given? Because I heard that saying, what is the difference between coming to the end of the lease and then having an eviction? And I believe that is what happens, that when they don't want you there for no reason, and you have lived there and you have done everything you're supposed to do, and there are many reasons, there are many biases, and they don't like people because of their sexuality. They don't like people because they're single moms, because of their religion, because they're fat, because there's so many reasons why people don't like people. And I've said too much, and I wasn't going to do this, but it's been 8 hours. So if you can just explain this contract law and what happens at that moment when that landlord does not want that tenant there anymore.
I'll try to speak to the most common situations that we see on the ground that hopefully will address your question. One is in cases where a new owner comes in and has built in mass evictions into their plan. They buy the property with the intent of clearing everyone out. Typically, they buy it and then simply no one can reach them. You call the number, you never get a call back. You send an email, you never get an email back. And people are trying to renew their leases. And the new owner is allowing all the leases to expire and not contacting anyone about what's happening next, so that they can then start issuing lapse of time evictions. And it's like you never hear from the Ocean Management or the Up Realty or the Alpha Capital, et cetera, et cetera. Your lease expires and then you get that notice to quit, the first legal piece of documentation that starts the eviction process. On the other hand, and that's often when it's groups, they're clearing out buildings. On the other hand, the other really common scenario that we see is tenants get notified that their lease is not being renewed, and it happens to coincide with they were calling about the stove that was setting off the carbon monoxide detector, or they were the tenant who got people together to have meetings to talk about how the sewage is perpetually leaking in the basement or whatever it is. And it just happens to be the person who was outspoken, or the person who was organizing other people, or who was, using their legal recourse. That is the person who gets a non-renewal. And then that can turn into a no-fault eviction if it runs its course. And that mostly depends on whether the tenant has the means to pick up and move, which most of us don't in 2025. But those are the two most common types of scenarios we see: the non-renewal to target an individual as a form of retaliation for advocating for themselves and their neighbors, or simply allowing all of the leases to expire and being impossible to contact, so that then all of the tenants are month to month and vulnerable to an immediate lapse of time eviction. What Just Cause would do would, again, give tenants a little bit more leverage and negotiating power, so that wouldn't be such an easy tool of either retaliation or gentrification. But the landlord would have to negotiate with the tenants who are there. It doesn't say what has to go in the contract. It just has to say they have to deal with the tenants who are there unless there's a justifiable reason for them to use the eviction process. So that then the tenants who are, again, the people who live there and know what's going on with the building and have a real stake in the property. Of course, the landlord has a stake in the property as an asset and an investment, but the tenants have a stake in the property as their home and want to see it be cared for and want to see a long-term future there. People don't want to pick up and move every 12 months. And it's absurd to think that people are planning on doing that. and it would be severely detrimental to the state of Connecticut if it was an expectation that the third of us who rent would be picking up and moving every 12 months. I mean, I don't need to rant about the detrimental impacts that would have. But the point is that it gives tenants an opportunity to actually negotiate what is in the contract. The government is not saying what's in the contract. It's just saying that tenants should have a seat at the table. And I think that's more than fair.
It is more fair. And you said it's their home. And I think that's a really, really, really big piece of this that we can't forget. So I'm going to smile more and talk less now. And anybody else? No, thank you. Oh, Representative Weir.
Thank you for your testimony. I think we've been together the past couple of years during these long night sessions. Through you, Madam Chair, what are some of the things that you're looking to negotiate on behalf of the group, collectively? What are you negotiating that would be outside of what, because the leases are with the individual unit residents. So what is the collective looking to negotiate that's outside of that?
Yeah,
Madam Chair.
Thank you for the question, for the interest in collective bargaining. Love to talk about it. Some of the big repeat categories that our unions are interested in negotiating are maintenance standards, things like pest control, snow removal, the gutters getting cleaned in a timely manner. How long can you expect before you send an email to property management before you hear back? Communication. Stronger protections against retaliation. That's come up again and again, and I hope it's clear to this committee just how real that fear and anxiety is for so many tenants. So putting that in the lease that tenants will not be retaliated against for speaking up about housing conditions or organizing a union, et cetera. And of course, what we try to do is negotiate for rent stability that lasts longer than 12 months, because not knowing if, the rent is the biggest bill that most of us pay every single month. And not knowing if that biggest monthly bill is going to skyrocket every 12 months leaves people in a perpetual state of economic precarity. So, one of our unions that was able to win a collective bargaining agreement negotiated 2.5 years with scheduled rent increases that were predictable and manageable for people. It wasn't a rent freeze, which is what the tenants would have wanted, but through a negotiation process with the landlord, they got better maintenance, better communication, fairer terms around how the parking was managed and what the snow removal timeline was going to be, et cetera. And they got manageable rent increases spread out over time. And that kept people housed. People who would have otherwise become homeless from lapse of time evictions, we were able to prevent that. And of course, when that agreement is up, it's going to be time to negotiate again. And both parties are going to come to the table. But thankfully, it's not going to be, hopefully, the same, again, gun to the head situation where tenants are being basically told, accept whatever terms or get out, which is the unilateral power situation that tenants are currently facing if they don't have a union and they don't have just cause. Does that answer your question?
Through you, Madam Chair. Yes, you asked that. I mean, towards the end, I don't see this. And again, I've had a history of doing work inside of a lot of apartment units, and I recognize, I've said it today a dozen times, that there are different standards for different landlords in terms of, some hold themselves to a high standard. Those are the ones who I chose to work with. And some of the ones you mentioned, I've been a subcontractor for. That relationship didn't last very long. So I understand. But I want to make, my observation in working with the quality people is that they're caring for their unit, their residents. The residents are staying. If they're choosing to leave, it's because they have had a new opportunity or this isn't working out for me. I haven't seen, some cases I have, but generally speaking, it hasn't been the level of acrimony that's coming in here because the relationship has been damaged. So when I sit here talking on this, it's from this perspective, is that we need to be careful. And the caution is, I don't want to lump people who care for their residents and put a burden on them that they didn't earn based on the people that some of the actors that you're dealing with. So that it's not a personal thing. It's not you know, it's philosophical. I don't want to lump everybody together. I'm trying to figure out in my own head how to do that. So the questions that we ask, it's not from a perspective of being adversarial. It's more from, hey, I want to understand if there's a solution. We want to find it, but I don't want to come down on the people that are doing things right as a result of the people who are doing things wrong. So thank you.
Understood.
Okay, any other questions? Seeing none, thank you for waiting and thank you for testifying.
Thank you.
I'm going to go back to Brian Lemire online. Go right ahead, Mr. Lemire.
Good evening. Sorry about that. Having a little technical difficulties this evening. I'm here to express my opposition to HB 6889 and to share an important real-world example of the critical role that eviction for cause plays in the responsible management of rental communities. My name is Brian Lemire. I'm the Senior Director of Operations for Paradigm Communities. I'm also the Treasurer for the Connecticut Apartment Association, who represents 70,000 apartment units of the good landlords that Representative Weir just mentioned. I've been in the business for providing quality housing to Connecticut residents for over 25
Can
years.
you just state your
In my
municipality,
extensive
Mr.
experience,
Lemire? Where you live?
yes, I'm in Hebron, Connecticut, Talon County.
Thank you. Go right ahead.
In my extensive experience, eviction for cause, specifically lapse of time, is an option we resort to only when absolutely necessary. It is a last resort used in circumstances where all reasonable efforts to resolve the situation amicably have been exhausted. We are facing a situation that perfectly illustrates why such an option is vital. Our apartment community, one that we own and manage, which consists over 100 homes, is in the process of upgrading its HVAC systems across the entire property to improve the living conditions for all tenants. We have invested significant time, money, and resources into this project. Unfortunately, one resident has repeatedly refused to allow us into her unit to complete the required HVAC upgrade. Despite our efforts to accommodate her by offering flexible access times, cash incentives, and even the option to stay in a hotel during the work, she has continued to deny us entry. This has not only delayed an upgrade, but it also has cost us tens of thousands of dollars in lost utility rebates and forced us to continue to run an outdated and inefficient boiler just to provide heat to this one unit. In this case, our only option moving forward was to serve the tenant with a notice to quit for lapse of time. This decision was not made out of malice because it is crucial for us to continue maintaining the property, protecting the investment in the community, and ensuring that all our tenants, especially the ones who are abiding by the rules, can enjoy a peaceful and well-maintained living environment. Restricting the ability of landlords to utilize eviction for cause would make it significantly more difficult to operate properties efficiently and fairly. It would also place an undue burden on other residents who could suffer from delays in important property improvements and maintenance of their safety. Ultimately, it would compromise the quality of life for all tenants. I strongly urge you to consider the practical realities that landlords face in managing apartment communities and the need to maintain tools like eviction for cause to ensure that all residents can benefit from a well-maintained and safe living environment. Thank you for your time and your consideration this evening.
Thank you. Representative Weir?
Thank you, Brian, for your testimony. And in full disclosure, Brian's a constituent and a neighbor down the road in Hebron, and I'm familiar with his company. And I know that, again, Brian, the work I've seen you guys do is different than some of the what we've seen and heard stories of. And so thank you for giving that example. And we look forward to further testimony and listening more tonight.
You're welcome. Thank you for having me.
Anybody else? Okay, thank you, Mr. Lemire. Next, we have Norma Martinez Hosang.
Hi, can you hear me?
Yes, we can.
Thank you. Sorry, I'm pulled over. Um, Good afternoon, co-chairs Rep. Antonio, Felipe, co-chair Senator Marks, and members of the Housing Committee. My name is Norma Martinez Hosang. I live in Hamden, and I'm the director of the Connecticut for All Coalition. It's a coalition of about 60 community labor, advocacy, and faith organizations, and we're united and working towards a Connecticut where all families can live and thrive. Housing, we think, is a human right, and without secure housing, families cannot prosper. And that's why I'm here to speak in support of House Bill 6889, an act concerning evictions for just cause. Our coalition's long-term goal is for every person who lives in Connecticut to live a life with dignity. Dignity in the workplace and dignity in their community. Dignity means access to affordable health care, public education, a good job, and a place to call home. And one thing is clear to the members of our coalition: people can't get ahead in any area of their lives if they don't have a safe, stable, affordable place to live. Our coalition represents hundreds of thousands of families from across the state. These are teachers, college professors, and staff. They're healthcare workers, they're paraprofessionals, they're youth leaders in communities, and children. And no matter what organization they are part of, or what issue their organization is focusing on, one thing we do know is that nothing is possible for our families if we don't have a home. This bill is a very small intervention to a bigger problem in Connecticut, which is just access to affordable and safe housing. We don't have to guess whether something like this would work, because for over 40 years, Connecticut has had this law that's providing just cause eviction for tenants who are 62 and over, and who have a disability, and live in a building with 5 units or more. This law has effectively prevented tenants from arbitrarily being displaced, from arbitrarily being displaced. And we can also look at 5 other states and 12 cities that have just cause eviction protection, including studies in California that in my written testimony, I've linked that study, where we see that the just cause eviction protection has for over a decade now, in some of these cities have shown that displacement has dropped for as much as 80%. And also let's not forget that there's still grounds for eviction for non-payment of rent, for lease violations, or for refusal to agree to reasonable rent increases. And that the landlord's permanent removal of the unit from the housing market, that's also another reason why tenants could be asked to leave. Evictions and the threat of eviction impacts whole families' mental health day to day. It affects children's education. It affects people's employment opportunities. And I also believe it affects the fabric of all of our communities. We all want to be in communities where our neighbors thrive and are safe. We know that this is a very complicated
Your
landscape.
time was up. If you could please summarize.
Yes, I'm almost done. We know that this is a complicated issue, housing as a whole, and we think that this is a very small first step, and we urge you to support this bill 6889. Thank you.
Thank you. Seeing no questions, thank you for your testimony.
Thank you.
Catherine Whitney online. Hi.
Good evening, Senator Marks, Representative Felipe, Vice Chairs Roberts and Herron, Ranking Members Scott and Sampson, and distinguished members of the Housing Committee. My name is Catherine Whitney, a homeowner in Willimantic and a program manager at the Connecticut Coalition to End Homelessness. I'm here today in support of HB 6889 and 6948 because these bills will improve housing stability for Connecticut residents and contribute to preventing and solving homelessness. I support HB 6889 because we should be trying to avoid turning people out of their homes, especially in a time when there are so few truly affordable options. As a homeowner, I'm incredibly fortunate to be able to pay my mortgage without much worry, and my bank cannot force me out of my home as long as I continue to pay. I want this level of stability for my neighbors who rent and for their families and others who depend on them. For people who are evicted, national data show that Connecticut does not have enough truly affordable housing. Rent has increased 26.2% since 2021, while income has only increased 9.4%. It would take someone making minimum wage 71 hours a week at FMR to make enough to afford a modest one bedroom. And our housing and transit infrastructure does not always allow people to find affordable housing close enough to where they work. All of this evidence is borne out in the stories our team hears from providers across the state. The bottom line for all Connecticut residents is that the best way to prevent homelessness is to keep people in the housing they already have. From my perspective, looking at the already overburdened, short-staffed, and underfunded homeless response system, lapse of time is just not a good enough reason to risk that stability and add more strain to our system. It is also not a good enough reason for me as a member of my community, knowing that my neighbors are always at some risk of eviction, even if they are model tenants. I support HB 6948 because Connecticut residents with a criminal record face over 550 legal barriers to meeting their basic needs, including housing. We also know that people of color are disproportionately incarcerated, and that exclusion from housing based on criminal record compounds that effect. 79% of formerly incarcerated people have been denied housing due to criminal conviction, and they are 10 to 13 times more likely to experience homelessness than people who have not been incarcerated. Those who serve people experiencing homelessness know that one barrier can be the difference between successful reentry after incarceration or weeks, months, or years struggling to find stable housing. That is time that people could be spending on building families, energy that could be put towards contributing to communities and economies in Connecticut, or yes, rent paid to a landlord. Our communities and your constituents know this too. According to one ACLU survey, 74% of Connecticut voters support passage of a law prohibiting formerly incarcerated people from being discriminated against due to their criminal record when it comes to housing. The same poll shows that 82% of people agreed that people who've been convicted of a crime can turn their lives around and become productive members of our community if they can just get the right kind of help. I put it to this committee that the right kind of help is equal access to stable housing. Thank you for considering my testimony today.
Thank you for your testimony. I see no questions. Thank you very much. Jessica Stamp.
Good evening, members of the Housing Committee. My name is Jessica Stamp. I live in New Haven. I'm a teacher and the steward of the Blake Street Tenants Union. I'm here to testify in support of HB 6889, an act concerning evictions for cause, because I experienced a no-fault eviction. About 2 years ago, after being on a month-to-month lease for a year and a half, my landlord gave me and 15 of my neighbors notices to quit for time lapsed, which is a no-fault eviction. He gave us 12 days to move out or face eviction. I always paid my rent on time and I was a good tenant, but my whole world was destabilized when I faced homelessness. I didn't have enough savings to move. I needed housing application fees, first month's rent, 2 months of security, right? And then I had to move. I had to find a place and move in 12 days, right? And there are moving expenses. Moving is a huge financial burden. What I didn't know was that this notice to quit was illegal. Shmuel Eisenberg, my landlord, was trying to raise rents up to $300 a month. Shmuel agreed to negotiate with our tenants union in good faith. And at the beginning of the meeting, we presented our starting place for negotiations. And instead of responding, Shmuel had his lawyer draw up notices to quit in retaliation. And it's illegal to evict for retaliation. The landlords hold all the power, right? When you talk to them, they play the victim and complain about bad tenants. But in a 2-year span, the right to counsel represented 5,500 households in eviction court. That's 13,000 individuals, mostly children. And that doesn't count people who were representing themselves in eviction court, right? That's a huge number of attempted evictions. And I don't believe that 5,500 evictions were all bad tenants. A number like that speaks to systemic issues like how rents are too high and a medical emergency or losing a job can quickly destabilize a family or cause a missed rent payment. Or how landlords evict people so they can turn around and increase the rent for a new tenant by $300+ while doing minimum renovations, which was happening in our complex. And also don't forget the people who just ask their landlord to fix something and then they get evicted. My tenant union prevented those 16 households from being evicted. But right now, we have 20 more households on month-to-month leases who have all asked to renew their leases multiple times, but they've gotten no response from SHMUL. And they are one step away from a no-fault eviction. So HB 6889 will expand just cause and will protect my neighbors from being evicted without cause. It will reduce the stress and the fear that people live with when they're on a month-to-month lease, right? Children don't have to switch schools, adults can better plan out their future finances, and communities remain whole. And we have a very strong community in my complex of 70 units. But landlords, they can still evict bad tenants with cause if they choose, right? But we're just in a housing crisis and tenants need protection. All we want is stability, and I don't think that's too much to ask for. Thank you for your time.
Thank you so much for your testimony. Yep, Representative Brown.
Thank you, Madam Chair. And through you, Jessica, thank you for your testimony tonight. You referenced that you're a teacher, as am I.
Yes.
So thank you for the work you do there. And clearly, this situation that you've been in has impacted you. I'm wondering if you could speak to how that impacted your ability to do your job in the classroom, because we're seeing situations where teachers aren't able to afford to live in the communities where they work, where they teach. And so that eventually is going to have an impact on the students that we're serving in those communities. So in the situation where you had this no-fault eviction, how did that impact your ability to do your job?
Well, the funny thing is I was given 12 days notice, and that was the end of August. So we were about to go back for a new school year. And there's another teacher in my complex who was so overwhelmed because she is a single mother. She has a daughter who is like high placing in gymnastics in the state. So she's constantly doing things after school. She couldn't wait to negotiate with us. She just had to sign the lease for the higher rent amount because she was so afraid that we would lose that she just couldn't risk it. And for me, it was really hard because like our first day of school, we had a march where we had over 400 to 500 people show up, right? Senator Blumenthal was there, Chris Murphy's office was there, Rosa DeLaura's office was there, the entire New Haven delegation, and the mayor of New Haven was there. Like everybody showed up for us because we were, we were scared and we were going to fight back. Like we weren't going to sit down and take this. But like I had to get through my first day of school, getting to meet all of the adorable freshmen because I teach freshmen, and try to get through my day. And then I had to go home and I had to go through a march at home just to try to save my housing. And then we had court cases and we were in like professional development, and I was running in and out trying to get updates on our court hearing and to find out like what's the situation, like what's happening now, because we fought this in the streets with the media, but we also fought this in court. So it was just so much going on at once. And I'm so lucky that I have a very strong support system at home and a strong support system at school. And if this had gone on for like longer than a month, I would have been, I would have gotten knocked out because I also battle severe mental illness. And so it's very difficult. Like as long as everything's structured and stable, I am good. But like if things get thrown off, like I can run into problems. And so it's definitely one of those things that like if we didn't have this union, and most people don't have a union like this, right? But like we had this really strong union. We had been fighting together for a year prior, and we all were able to stand together. We were all able to like support each other and like help out when people needed help, and like sit together and cry if we needed to. And like we had all these great planning meetings, and we were all on the same page, and we all knew we were going to stand and fight together, except for just two people who just couldn't take the risk. And as we started to win, we felt better. But like, I can't emphasize this enough, like, because we had the support system, we were able to get through this. If it was just me, all on my own, I would have no idea how to fight this eviction. I I wouldn't even know where to start. Like, I don't know anything about the legal system. I'm not eligible for right to counsel. I make too much money. Like, I make too much money for right to counsel, but not enough money to really be stable, right? So it's like, that scares me. And right now I'm in a 2.5-year lease, as Luke was talking about. But now I have all of these neighbors who are paying over $1,700, $1,800 a month in these quote unquote renovated apartments. And they're all month to month, and they're all scared right now. And I don't know. I think it's hard for anyone who's in this position right now, knowing that in the state of Connecticut, like, none of us make enough money to pay the rent.
People in the audience, please just remember you go like that. Thank you for that. Yep, Rep. Brown.
Well, thank you, Jessica. Thank you for your advocacy, and thank you for the work that you do with your children. And having taught freshmen myself, adorable is one way to put freshmen. But no, thank you, and appreciate it. Thanks.
Thank you, Jessica, for telling us your personal story and for being so strong to be here. It was very impactful.
Thank you.
Next, we have Maria Weingarten online.
Good evening. Thank you so much for letting me speak to you. I'm writing testimony, which I've not submitted yet, on HB 6944, which is the Fair Share Open Communities Alliance bill to, I guess, the act requiring a municipality to include certain information in its affordable housing plan. I would like to put out 3 reasons why this bill is concerning. Number one, it takes really the locally, you have to create your plans locally, which has been happening already. But now these have to be deemed approved by a bureaucrat in Hartford that may not know all of the circumstances and conditions that are impacting a local community. And we have 169 different towns that have different infrastructure constraints, whether it's sewer, water access, wetlands, all of those different things. And these are all concerns that are best handled locally. And we know that in the state of Connecticut, we have 80% of the water resources, wetlands resources of all water is privately held, and that is managed by our local land use commissions. So it's really important that we take these protections seriously to ensure that we have adequate natural resources for our communities. Second thing is that interested parties in this bill, which include nonprofits and developers, can sue the Secretary of OPM and actually lock into that as well, municipalities, in lawsuits to try to, if they deem that a town has not created a realistic opportunity for the development of their affordable units of housing. And so this just creates a cottage industry of litigation. This we've seen in Fair Share in New Jersey, which currently has the #1 highest local property taxes, that this has become a litigation quagmire in New Jersey, and we do not want to follow that path. And the third thing I'll say is that we, as was mentioned by Aaron Boggs earlier today, do not know what the fair share allocations are going to be to every municipality. When they were disclosed, they were so onerous that it would have required most municipalities to double their entire housing stock by allowing market value development, doubling their housing stock in order to develop have the private sector develop their 10 to 20% affordable units that would be required. So there's a lot of empty, when Fair Share Phase 1 passed, the thought was that there would be a bill. We would see what the numbers were. We don't have numbers. We don't know what these numbers are. And now we're going through and looking at creating a bill here, and we're hearing a bill where we don't know any of these numbers. And I recommend that as a founder of CT 169 Strong, we've looked at those numbers, and Erin Boggs referred to her numbers, and we've evaluated those numbers. And I think everyone should take a very close look at those numbers again, because they will be
expired. If you can please summarize.
Thank you. And so I could just recommend that everybody take a look at those numbers and understand what's in those numbers, and we would be more than happy to discuss this further. Thank you very much.
Thank you, Ms. Weingarten. Yep, Representative Corpus.
Thank you for your testimony, Maria. I really value the work you all do, and how you really dig in and explain some of these more complicated bills. So if you don't mind, I have a few questions. Is it the case that in this bill, you said that the municipalities are already doing their own housing plans, but this bill now requires that those plans be reviewed by the state. And in order to be deemed reasonable and appropriate for the purposes of this bill, the plans have to have 20% of new units constructed affordable, 50% rental, 75 not age restricted, 50% non-age restricted, and 2 bedrooms or more. Is that right?
Ms.
And
Wein-
and 80% at two bedrooms or more. And again, this is part of the issue. Is it's when you have a highly prescriptive plan, you're not giving municipalities an opportunity to build what's needed. Now, I'm in New Canaan and I'm on the Affordable Housing Committee, and I think about these things a great deal. And I think about being able to have older residents being able to downsize into senior housing. And there have been a lot of people who've been negatively talking about having senior housing as a way that it's done to avoid having families or anything like that. Well, all we've done is built because of the way the HUE points are allocated to get toward moratoriums. We've not built the senior housing that we really need. I think when you have a prescriptive plan, it eliminates the flexibility that's needed to build what's needed within your community and really look at it holistically and understand what's best for a community in terms of meeting all the needs that exist in the municipality.
Representative Corpus.
Thank you, Madam Chair. So through you, Ms. Weingartner, is it then the case that there doesn't have to be any substantiation? The municipality, whether or not they need that housing, whether or not they have room for or need restricted, non-age restricted 2 bedrooms, whether or not they have the population to support 75% not age restricted, those prescriptions apply regardless of what the characteristics of the municipality are? Through you, Madam Chair.
Ms. Weingarten?
Yes, that's true. And the reality is that you can suggest that you don't that you should have 2+ bedroom units. 80% have to be 2+ bedroom units, but maybe a municipality might want to have 1 bedroom units, because those are, if we really want to create affordability, in some instances you might want to have smaller units of housing. So because the cost to develop is obviously less, and that's common sense here. So we have to sort of allow flexibility to create what's actually needed. And if we're trying to get to more affordable, especially in areas like Lower Fairfield County that tend to be more expensive, sometimes your size constraint can help reduce the cost of what a unit is. So these are all different things that are best looked at in a local way, and this bill does not allow that.
Representative Corpus.
Thank you. One last question. So if the municipality creates a plan under this statute, and the statute is deemed to be unreasonable from the Department of Housing at the state level, that, or if it's not, an interested party can bring an action. That means, as you said before, a developer or a nonprofit can bring an action and prevail, in your opinion, on that action, even if the municipality does not need the kind of housing that's prescribed here, just because it deviates from the state plan?
Ms.
Yeah.
Weingarten?
Yes, and actually it's not even a reasonable opportunity, it's a realistic opportunity. That is not a defined legal term. And so there's so much vague language in here. There's a lack of recourse for municipalities. There's a lot of detail that's not included in this bill that makes it problematic. And again, the last thing we need is more litigation. What we really need, and we don't want to follow in New Jersey's footsteps here, what we really need is to find more collaborative solutions. And especially in Fairfield County, where housing values are higher. I'm also a realtor, so I track this very closely. we have to find ways, and Fairfield County in particular, there are different methodologies that have been used by Westport, by Greenwich, by Darien, and New Canaan, where we've come up with different ways to create more affordability within our communities. And what we should be doing is reaching out and maybe bringing everyone together and have meetings where we discuss some of these best practices and ideas, because we are now seeing that all of these 830Gs and are popping up all over the state, and there's got to be a better way forward where we can find opportunities for development and to get better processes together when we work collaboratively. But this is more of the same, and we've seen some version and iteration of these bills over the last 3 or 4 years. And it's time for a new approach. And I hope that that's something that will be considered by the leadership to see if there are better opportunities here than to just rehash what we've already seen before.
Thank you. Thank you.
Okay. Thank you for your testimony. Seeing no other questions, I will move on to Kenny Morris.
Have a good night.
Hello, good evening. Thank you so much for bearing with us today.
Yep.
Good. Test. Great. Thank you so much. And thank you so much for your time today. My name is Kenny Morris. I'm the Community Engagement and Outreach Coordinator for the University Network for Human Rights. We exist between Yale and Wesleyan University, and I'm also a Middletown resident. And so I am here to speak in support of the implementation of just cause eviction protections through HB 6889. And so I'm very thankful that I've never had to face an eviction myself, but a neighbor of mine, Mr. J, has not been so lucky. Mr. J has lived in Middletown for decades, where he and his wife has raised their kids. They planted their wonderful garden that has more herbs than you can imagine and vegetable plants that I believe are older than me. And they made a home there. And they've rented there the whole time. And so they found out that their landlord is actually foreclosing, and this is through no fault of Mr. J. And the property is being sold as is, with Mr. J, his family, and his vegetable garden inside of it. And so his family has been notified that they will be evicted when this is sold. Again, this is through no fault of the tenant here. And he's over 63 years old. You'd think that he'd be protected by the existing protections, but unfortunately he has a single family home that he's renting. And so he's not covered under the current law. So this foreclosure of his landlord is forcing him out of the home that he's lived in for decades. So now you might remember the story from last time I sat here a year ago, explaining the situation. And unfortunately, he's still being forced through this process with the sword of eviction hanging over his head. And I understand that the single family home would not be covered under the proposed law, but it is still my hope that this could be expanded universally. And this is why just cause is needed for everybody. And I'm not really sure how people are able to put down roots when powers that be can just sweep it all away. I'm not sure how we can feel secure when we have to look for housing 1/4 to 1/3 of the year to find an adequate, affordable housing. It's been referenced. We've talked about stability a lot today. And I've really admired the community in Middletown, and not having these protections erodes that away. And so I work for Human Rights Org as well. It's very clear in human rights standards and law that housing is a recognized right. Everybody deserves housing, dignified housing. And the norms around what forced eviction are very clear too. Eviction should only occur as a last resort and after a full exploration of alternative means to resolve outstanding debt, such as emergency housing benefits, which has been mentioned, debt rescheduling, or if required, relocation to more affordable units meeting adequate standards. And so what people face when their landlord evict them at no fault of their own are in direct violation of these international standards. And the passage of just cause protections would be a good first step towards bringing Connecticut law in line with these standards and keeping our neighbors like Mr. J housed. Thank you so much.
Thank you, Mr. Morris. Seeing no questions, we appreciate the testimony. Next, we have Cindy Prizio. They're not here. Okay. And the next, Matthew Blinn Strubus. I saw you online. Hi, sir.
Hello, Senator. Senator Marks, Representative Felipe, and distinguished members of the Housing Committee. My name is Matthew Blindstrubis, and I'm the Executive Director of Equality Connecticut, an organization dedicated to advancing the rights, health, history, and culture of Connecticut's LGBTQ community. And I'm testifying in support of HB 6889, an act concerning evictions for cause. This bill will provide needed protections and security for the many tenants across the state, including LGBTQ plus people. It's vital to the well-being and safety of LGBTQ tenants that this legislation be enacted as soon as possible. Housing is a huge issue for the LGBTQ community. A report by the Williams Institute at UCLA's School of Law estimated that 17% of LGBTQ people had experienced homelessness in their lifetimes compared to 6% of the general population. This bill would prevent discrimination against LGBTQ tenants. Eviction without cause is one of the last vestiges of potential legal discrimination against our community in the state. Because landlords do not have to provide justification for no-fault eviction, it is very difficult for tenants to prove discrimination. Additionally, because of this difficulty, many tenants leave their homes before a no-fault eviction is even filed to avoid permanently damaging their record, even if the eviction may have been discriminatory or retaliatory. So while no-fault eviction makes up around 11% of filings in 2023 and 2024, they account for an even more unreported displacement. Right now, Connecticut protects those over 62 and people with disabilities, but leaves everyone else out. An LGBTQ tenant would never know or be able to prove that their identity was the reason for that their lease was not renewed because the landlord doesn't like them and doesn't have to give a reason for not renewing their lease. This is a perfect example of the ease at which a landlord can get around a current non-discrimination law, as it would be almost impossible for the tenant to prove that discrimination happened. To put it simply, what it means for a queer or trans person to feel safe and secure in their neighborhood is immeasurable. The sense of safety, stability, and belonging is vital to our mental health and physical security, and in many cases, it's very hard to find and can take years, even decades to cultivate. Despite the rising tide of intolerance we're seeing sweep the country, we are seeing families with trans and gender diverse children migrating to Connecticut from across the country in greater numbers. These families see Connecticut's history as a leader on LGBTQ rights as a beacon of safety. Ending no-fault evictions ensures Connecticut is living up to its reputation as a place that is safe for all LGBTQ people. Equality Connecticut thanks the members of the committee for its consideration and calls on you for your support. And we also call on members of the entire LGBTQ community to stand up in every corner of our state to support this bill. Thank you so much for your consideration.
Thank you for your powerful testimony. I see no questions. So now we will go to Megan Scherer.
Hello, can you hear me?
Yes, we can. Go right ahead.
Hi, Senator Marks, Representative Felipe, and members of the Housing Committee. My name is Megan Scherer, and I'm a resident of Hartford and the Policy Advocacy Manager of the Hispanic Health Council. As well, I am a renter myself, and I support HB 6889, an act concerning evictions for cause, and believe all tenants should have just cause eviction protection. The mission of the Hispanic Health Council is to promote equity and address health disparities for Hispanics, Latinos, and other vulnerable communities through research, advocacy, and culturally resonant services. Our ultimate goal is to ensure everyone can reach their highest level of health. Health equity is more than just healthcare. It is access to resources that support your well-being. One pillar of health equity is access to safe, quality housing, a place where someone can go home to every day and not have fear of being kicked out for no reason. Many of the clients that the Hispanic Health Council serves, though, do not have access to safe, quality housing. Many are on month-to-month leases. They have fear that their landlord will not give a reason and decide not to renew their lease. The Hispanic Health Council clients are good tenants. They pay their rent on time and do everything expected from them by the landlord. Even though they are good tenants, the landlord still has the power not to renew the lease or file an eviction for no reason. This power the landlord has to evict the tenant for no reason causes vulnerable communities to be fearful of speaking up when something is wrong with their apartment because they fear of a retaliation eviction. Evictions and sudden loss of housing detrimentally impacts employment, mental and physical health, and education, worsening housing insecurity, increase homelessness, and make communities less stable and safe. When evictions and a lease are not being renewed, happens, our clients are put in a place of crisis, which ultimately impacts both their physical and mental health. The Hispanic Health Council service providers go above and beyond trying to help these individuals and find housing for themselves and their families if their lease is not renewed or they are evicted. But housing that our community can afford is limited. As well, there are only so many resources our community can access due to availability and immigration status. So our community may end up homeless in an unsafe apartment or in an apartment that is past the capacity of people allowed to stay, which once again impacts their health. This is why the Hispanic Health Council is advocating for just cause eviction. Just cause eviction prevents displacement and strengthens communities by significantly decreasing arbitrary evictions while reducing overall eviction filings by 11%. Finally, it protects rights to safe housing by allowing tenants to assert their rights to safe living conditions and form a tenant union without retaliatory eviction. Just Cause allows people like clients at the Hispanic Health Council to not worry about losing the roof that is over their head and having a home that is safe. At the Hispanic Health Council, we strive to ensure that vulnerable communities can reach their highest level of health. Stable housing helps our community reach their highest level of health. The Hispanic Health Council strongly urges the Housing Committee to vote in favor of HB 6889 and act concerning evictions for cause so that tenants have protection and Connecticut can be a healthier and more equitable state. Thank you.
Thank you, Ms. Scher. Seeing no questions, I'm going to turn the public hearing over to Co-Chair Felipe.
Thank you, Madam Chair. Next, we have Nicolina Giuliani. Is she here or online?
Online.
Oh, awesome. It is your turn, Nicolina. If you can turn on your microphone and hopefully your camera. And the floor is yours. Yeah. All right, I see her on. Oh,
Okay. Hi.
there you go. You can try to turn your camera on, but if not, we're ready for you.
Okay. There we go. Hi. I don't remember the HB. I'm unprepared. I'm sorry. I forgot that this was happening tonight, so I'm happy to send in my comments.
Go ahead. What bill? You can say the name if you want. I can tell you what number it is.
Oh, it was the one where they take away the rights for the fair share. They're taking away the town's rights.
Exactly how I would qualify that, but that is House Bill 6944.
That's it. I'll send in my comments. I'm really not prepared. I'm sorry.
Oh, no problem. Thank you very much. We look forward to reading your testimony. Number 58, Alexander Kalakatranis. Oh, did I get that right?
Oh, sort of, yeah.
Well, state it for the record so I can get it right next time.
Sounds good. Hi, my name's Alexander Kolakatranis.
Kolakatranis.
I live in New Haven.
Floor is yours.
Great. My name is Alexander Kolakatranis. I live in New Haven. I'm director of the Naugatuck Valley Project. I've been organizing tenants since 2019. Back then, through last year, I would have tenants ask me, "Why do you do this?" You know, like this random person, right? Coming to your complex and talking about these issues. And I'd say, well, in part, it's also to protect me. And then guess what? It ended up actually happening to me. Someone bought my building and kicked out everybody in the building. So I now live somewhere else after living in a hotel for 7 months. I got 2 different notices to quit. And at our Fair Rent Commission hearing, when we filed a retaliatory action complaint, it was asked to the new landlord if the tenants would have a right of first refusal to come back, and the response was, well, the tenants can certainly apply, but it's going to be market rate. Well, market rate means if we go by the building across the street for an equivalent 2-bedroom apartment, $3,800, $4,000. So nobody in this building, I mean, this is like 2.5, 3 times more the amount. Nobody can afford this. So I'm here to say that, you know, as much as I'm speaking as a tenant, in part, I'm also speaking here to say that this is even bigger than think of this as strictly a tenant issue. This is more broadly an affordable housing issue. I've heard a lot about supply. Not having just cause is what curbs supply. Not having just cause means that we actually have the amount of our current stock of affordable housing units under threat, either by way of private equity coming in and buying up buildings, or by way of what happened in my building, which is units deteriorating, people too afraid to report. As you've heard in other testimony, smaller problems becoming bigger problems and bigger problems and bigger problems, and then the units are gone. And so, you know, we see a press release, for example, from the city saying, hey, we built 8 new affordable units. And myself and my former neighbors see that, and we think, 8 new units, but we just lost 19. So I think the truth is we don't really know what's going on in the state in terms of housing supply. We're talking about housing supply as if it's static and here, and we can just keep growing it and growing it. But what's really happening is that we're losing a ton in all of these different ways, and our new construction framings are almost a moot point. It's not even clear if we're even remaining static in that way. So I'm here as someone, again, who lived in a hotel for 7 months, but I mean, I can run through the statistics for you if we just talk about aging housing stock. In the Naugatuck Valley, this is going by the COG set of towns, 22% of renter-occupied units, which is 26,000 units, were built before 1950. Now imagine a renter in that apartment, one of those apartments, being afraid of being retaliated against for even raising an issue.
Mr. Colacotronis, your time is expired. If you could please summarize.
No problem. So add that together with 28%, 1950 to 1969. So we're talking about 50% of units being built before 56 years ago. That's a lot of units that need a lot of care. And tenants cannot be partners in taking care of our aging housing stock if they're too afraid to report it, and validly so, because they might face retaliatory action, as I've seen and potentially even have experienced in my own ways.
Thank you, Mr. Colacotronis. Any questions from members of the committee? Representative Sweet.
Thank you, Chairman. I know you talked about the broader affordable housing issue, but I'm wondering if you could speak to just cause as it relates to our fair rent commissions and also code enforcement.
Yes. So a number of years ago, I testified here concerning rent caps. I've testified concerning right to counsel. One of the arguments has been advanced as well, we need to rely on our fair rent commissions. Our fair rent commissions need to be allowed to do their job. Or you'll hear locally, you know, why don't you just file a fair rent commission complaint? Well, in my day-to-day life, I have people call me and say, hey, I got a $600 rent increase. What do I do? I say, well, you know, they'll ask, is there a law against this? I say, no, well, but you can't go to the Fair Rent Commission. And the first question I'll get is, well, will I be retaliated against? I'll say, you know, truthfully, I don't know. In some cases, I haven't seen people retaliate against, and it's worked out fine. In some cases, and I can tell you my own story, you know, there might be an argument there that you will be. And if we really want to see fair rent commissions work, as we've been talking about, as has been talked about, even I think in a bipartisan manner, then you need just cause. It's extremely reasonable to think you'll be retaliated against, because the current retaliation protections on the books say that you have 6 months of protection after forming a tenants union, filing a complaint, and a few other criteria. So even if you abide by the existing retaliation laws, all you have to do is wait 6 months, and then after that, it's retaliatory. So just cause is absolutely essential if we want people to actually file fair rent commission complaints. And more to the point, if we want people to actually be able to raise concerns that would go up to a fair rent commission, because sometimes you can't get adequate code enforcement. I'm speaking as someone who's gone through the code enforcement process until you go to the fair rent commission, which then orders actual code enforcement to be carried out. None of that can happen really again, or people will not feel safe or really be safe in doing so unless there's just cause.
Thank you, Representative Sweet. Any other questions from members of the committee? Seeing none. Oh, Representative Zullo, I'm sorry, I missed you again.
No, thank you, Mr. Chair. You didn't miss me. It was a last minute or a last second hand raise. So thank you for your diligence in looking. Just very quickly, and thank you for your testimony. Do you differentiate at all? So the proposal that we're looking at sets a number at 5 units. Do you differentiate at all between a housing provider that owns maybe like between 5 and 15 and 5 and 20 or more than 20? Are you saying that this universally should be for every housing provider?
I will say, I mean, so I support the bill HB 6889. I don't think I said it outright. However, I frankly, I think the threshold should be universal. And one reason why I say that is I get the spirit of saying 5 units or not below 5 units, or 1 to 4 units being exempt. But if we go by also what's the trend across this country, what we have is private equity buying up single family, 2-family, 3-family homes. So the spirit of the bill is, I think, very much about tackling these big corporate landlords, out of state landlords, some in-state corporate landlords as well. But that I think the way it plays out in practice is that it is precisely single family homes, 2-family homes that are the ones that are being targeted by major investors. And that's happening across the country. And my fear is that this is something that, and we're beginning to see it, is something that's going to start happening more and more in the Naugatuck Valley. And the Naugatuck Valley is already a place that has experienced a form of this, I mean, what is corporate raiding? I mean, it's coming in, it's buying up a property or buying up an asset, stripping that asset of its value by selling it off or letting it fall and deteriorate, and then finding value in maybe the land itself. That's something the Valley experienced in terms of brass manufacturing and all of the 50,000 jobs that were lost over the course of 30, 40 years. Now we're seeing that move from factories into housing. So in spirit, I think this makes sense. I think in practice, actually universal just cause would be what would really be maximally impactful. And a lot of our aging housing stock is not just these 5+ unit buildings, but it's our single and 2-family homes. Yeah.
I appreciate that. And just one follow-up, Mr. Chair. So then, if I may, I'm not saying that it's something that I would support, but would it be more interesting then to propose it as, maybe some type of landlord registration, and then you count the number of units they own, right? And then if it exceeds, whether it's 5 single families or 3 duplexes, but if you own more than a certain number of units, whether it's individually or through subsidiaries, et cetera, then you become subject to this. It might be a little bit difficult to track, but it might be more interesting if it plays out that way, because then you'd truly be protecting those, we like to call them mom and pops or small housing providers, but you might be getting more at the issue of tackling some of these larger landlords that we seem to be hearing today a little bit may not be living up to their obligations.
Yes, I think a landlord registry would be very, very important in this way. And adjusting accordingly, I think this would make a ton of more sense. So it's something I think we're finally seeing play out better in a number of ways in New Haven over the last few months with the landlord registry program. And it's great to see that there's some other towns across the state that are starting to really pick up on this idea. But I think at the state level, that would be phenomenal to have something like that. I mean, I know when I look at the Secretary of the State's website, it's just a maze in order to navigate that, and to have something like a landlord registry program would be very helpful, especially in terms of, again, not even just in terms of tenant protections, but again, we're talking about actually protecting our existing housing supply. Because if someone who's a corporate landlord, an out-of-state landlord, can see that there is in some way a way to get around the law in practice, or again in the spirit of it, we're continuing to still enable these very extractive managerial practices that involve less actually housing residents and more about someone else from not even here extracting the financial value of a place, and then people no longer have a place to stay. So I think a landlord registry in general would go a long way in terms of setting the groundwork for beginning to tackle that.
All right. Well, I appreciate the insights. Thank you very much. Thank you, Mr. Chair.
Thank you, Representative. And seeing no other questions, thank you very much, Mr. Clark. Collateral.
Yes, got it. Thank you.
Next we have Ian Skogard online. Floor is yours, sir. Good evening. He's on. Just unmute yourself.
Yep. Okay.
There you go.
Yeah. Thank you. Good evening. Chairs and distinguished members of the Housing Committee. My name is Ian Skogard. I am a homeowner and living in New Haven, Connecticut. I'm testifying tonight in support of House Bill 6889, an act concerning evictions for a cause. When I first moved to New Haven, my family rented a house for 5 years before buying a home in the same neighborhood that we had come to love. As a renter, I had no problems with my landlord, nor he with us. Our rent did not change, and we kept the property in good order. As a member of both congregations organized for New Connecticut and New Haven Rising, I have had a long-standing interest and concern for the community and city I live in. I have worked hard as a volunteer to help even the playing field and ensure opportunities for people in my city to get a leg up in the world, which in turn has helped to revitalize and stabilize their neighborhoods. It has been a win-win situation for everyone. New Haven has a high number of rental units, proportionately, which gives landlords extraordinary power over the welfare of the city. While small local landlords might share the same concerns as me about stable neighborhoods and households, I fear that large corporate landlords may not. For them, housing is a business to maximize profits. I have a story of 2 interns where I work. One intern had a benevolent landlord who lived in the same building and did not increase her rent. The other intern's landlord was an out-of-state corporation which increased his rent by 20%, which he could not afford and was forced to move. These 2 different outcomes make me realize that we need to distinguish between local property owners and large corporate property owners, which I think it's been made clear in the testimony tonight. The former are generally good actors who care about the community and tenants, whereas the latter can be quote unquote bad actors who act like hedge funds squeezing tenants to what the market will bear. I see this bill, Just Cause Eviction, as protecting the interests of tenants while checking the grosser exploitive behavior of large corporate households. I just want to add, if I have time, that it's a very there's a lot of ambiguity in this issue of housing. There is housing as property, and there's housing as shelter. As property, it is privately owned, and owners are entitled to do whatever they want with their property. However, we do have rights to shelter as well. We are not a nation of nomads that can pick up and leave every year and move to someplace else. If I had my way, I would argue for longer lease times for renters to give them that stability. Right now, the playing field is very uneven in favor of landlords. So I think this Housing Bill 6889 will go a long way toward making it more fair for tenants. Thank you for your time and opportunity to testify.
Thank you. Any questions from members of the committee? Seeing none and none on Zoom, Mr. Skogard, we appreciate you and thank you for coming out. Next, we have Esther Bissell. I know I didn't say that right, but I'm trying. Is Esther here? Seeing no Esther, We have Annette Diaz. Annette Diaz is also not here. Peter Wesk. All right, moving through. I've seen this person online, and excuse me if I get this wrong. Alunid Lee.
Yep, thank you so much.
Yes, can you just state your name for the record and so I can get it right the next time I say it?
Oh, yeah, my name is Luna Lee.
Ah, I got it. Perfect.
Just as you said it. Yeah, perfect. Thank you so much. Should I go now?
Yes, floor is yours.
Oh, sorry. Distinguished chairs, Representative Felipe, Senator Marks, and honorable members of the committee, thank you so much for this opportunity today. My name is Aluna Lee. I live in New Haven. I'm here today as a member of C3M, a statewide organization dedicated to protecting future generations from the consequences of a changing climate. As a member of New Haven Rising and as a renter in New Haven, there is nothing I can say about HB 6889 that other people haven't already said much, much better. I have no expertise to share, but if what I say can function to add emphasis to what other people have already put so clearly and so well, then I'll try. HB 6889 is a desperately needed measure to offer protection to every resident of New Haven hoping to invest in our city and build a family here. Every renting member of my community who I've spoken to, whatever their income, experiences at some level a very grounded fear of being trapped in an inescapable cycle of housing insecurity. At a memorial service recently for unhoused New Haveners who have lost their lives this past year, our city had to grieve a list of names of beloved community members that would take my full allotted time today to get through. If it is a key objective of the government to protect lives, then it also must be a key objective to keep people housed. We cannot give landlords unfettered protections while tenants are forced to bear the burden of fearing lost access to a safe home, on top of the many other intersecting harms of living with housing insecurity that have been brought up today and will come up again and again. Forced homelessness is not a necessary evil of a thriving economic system, in my opinion. It signifies that we are not living up to our obligations to one another. Another consideration is that renters and households with low incomes are disproportionately exposed to and harmed by disasters like floods, hurricanes, and wildfires, and face the steepest rent increases after a disaster strikes. According to an MIT study from April of last year, severe floods are associated with significant increases in rents for households renting units priced at the bottom of the rent distribution, but not the middle or the top. Protecting renters from predatory practices is one of the most important choices we can make to protect people from climate-fueled disasters that they did not contribute to, but that they will suffer from disproportionately. We are also putting on the front lines renters who may be trying to improve their living conditions, complain about, dangerous conditions, or encourage their landlords to invest in reducing emissions in their buildings. We cannot ask people to choose between advocating for safer conditions and facing potential retaliation or discrimination, taking on the risk of losing housing and having to struggle desperately to find new accommodations. We cannot leave the fate of these families at the mercy of another individual's discretion. Housing is not a commodity that a person can plan around intermittently accessing. It is a basic need, and its absence has lasting consequences. It is both incredibly difficult to live through, and further still, its absence is criminalized. Profiting from and evicting without cause, without common sense regulation like HB 6889, in my opinion, will hurt the people of Connecticut who are already hurting. It is for these reasons that I came here today to add my voice to the chorus of much better voices to support HB 6889. Thank you so much for your patience, consideration, and time. Thank you.
Thank you, Ms. Lee. Any questions from members of the committee? Seeing none, we appreciate you taking the time to see us tonight. Next, we have number 64, John Lee. John here? I know he's on the line. All right. Number 65, Peter Huzik. And please say your last name for me so I get it right the next time.
Indeed. The U is silent. It's Fosek.
Fosek, got it.
But you got closer than most.
Floor is yours.
Senator Marks, Representative Felipe, and members of the Housing Committee. My name is Peter Fosek. I'm a resident of New Haven, and I have the privilege of serving as the Secretary-Treasurer of the Connecticut Tenants Union. I'm here in support of House Bill 6889, an act concerning evictions for cause. I believe that all tenants in our state deserve the basic security, dignity, and due process that just cause provides. I believe that those rights are worth more than the ability of investors to displace entire neighborhoods
or the ability of slumlords to quietly push tenants out for speaking up. Just cause, which simply mandates that a landlord provide a legally valid justification when terminating a tenant's occupancy, are not only in place in other states, from New Jersey, New Hampshire, New York, to Washington, Oregon, California, Colorado, and DC, but in fact, we have already had just cause in Connecticut for decades as a protection for elderly or disabled tenants. Those protections, proofs of concept, have been implemented effectively. They have had nothing but positive impact. That would likewise be the case for the humble expansion we're advocating for today, limited to buildings of 5 units or more and to tenants who have occupied their homes for at least a year. This is a compromise born of an overabundance of caution, if anything, meant to ensure that universal just cause protection's broad-based positive impact is not marred by unwanted side effects. We make this compromise so that we can win this bill for our thousands of members and the million-plus renters across our state. Just cause is urgently needed in a state facing a several 100,000 unit deficit in housing stock, particularly our affordable housing. If we want to meet that substantial need, we must preserve the affordable housing that we have. Otherwise, we will never be able to build enough. That means providing tenants the right to organize with our neighbors. It means ensuring that renters can speak out about our conditions, about poor maintenance and mismanagement and mistreatment, without fearing a traumatic eviction process and subsequent displacement. But those fears are justified in the absence of universal just cause protections, when tenants can face an unjustified eviction at the end of any month or year without possibility of recourse. Those fears are justified as homelessness is criminalized on the federal level, as rents continue to rise while wages remain stagnant and the cost of living stays unsustainably high. The rule of law, the right to due process, these are fundamental keystones of a free and democratic society. So too is the right to organize, the right to advocate for one's interests, the right to seek safety, and to hold your counterparty accountable to a bilateral contract. These are not outlandish demands, they are basic moral decency and economic common sense in the face of a devastatingly deficient housing market. As households are displaced and lives uprooted for no cause but the profit of investors, they begin to search for rentals and other housing solutions. When that happens, demand will increase even further, and with limited supply, rents will likely surge and cause further displacement across the region's housing market, which will cause broad-based economic strain and entirely avoidable suffering.
Mr. Fusek, your 3 minutes have expired. If you can please summarize.
That's all I've got for you tonight. Thank you very much.
Thank you, Mr. Fosek. Any questions from members of the committee? Seeing, Representative Scott.
To be commentary time. I appreciate your passion. Just don't move to my 112th district, because the way you speak and your passion, I don't want to have to face you at any point in an election. You seem very passionate, and congratulations, you did a great job speaking today.
Appreciate it, Rep. Scott. Perhaps I'll have to move.
Thank you. Next, we'll have Wilfredo Laboy. Wilfredo here. Perfect. Beth Hines. Arjun Jackson.
Hello.
There you go. Floor is yours.
Thank you. Good evening, Chairman, Felipe and Madam Senator Marks and other members of the Housing Committee. My name is Arjun Jackson and my town of residence is Stamford, Connecticut. I am a tenant and graduate social worker student, and I support HB 6889, an act concerning evictions for just cause, and believe all tenants should have just cause eviction protection. While I have not yet personally experienced the heavy burden and tumultuous process of eviction without just cause, I have spoken with many residents who have, specifically the residents and tenants of Bridgeport during my time interning with the City of Bridgeport Social Services Department in 2024. It was through this opportunity and privilege of serving the community and speaking with residents over the phone that I learned firsthand the reality and consequences that many families have to face, either when they have the eviction on their record or they're given the notice. And while I'll note that I and my fellow testimony givers, constituents, have 3 minutes to testify, residents may feel like they only have 3 minutes to call social services and fellow nonprofit organizations that are designed to help with them, as well as facing long queues and having to be perceived as lacking resolve, resiliency, or not having the self-determination to fight systemic issues alone. While the cost of living continues to grow and compensation remains stagnant across vast sectors of labor, the pressures of having one's rent raised beyond equitable measures reflective of the economy has unfortunately shifted blame on residents and tenants as a moral failure. And as Representative Antonio Felipe, sorry, has stated, there's been up to an increase of 30% in rent and 13% rate in homelessness. Now, during my time interning with the Bridgeport Social Services, I had the pleasure of speaking with the Fair Rent coordinator at the time and was able to learn a couple key points that I will briefly talk about here in the spoken testimony. The rest is written in the full. But ultimately, their goal is to lower the amount that's spent on the income from 50% to 30%. Goals for the future were discussed to be capped at 20%. 10% when it comes to rent. There's a lack of educational resources for both tenants and landlords, and there's too much focus on resources being provided online versus in person and consistently something that is mutually collaborative. Lastly, during the interview with the Fair Rent coordinator at the time, there's a newly scheduled program with the commission and whatnot. There was over $50,000 saved in the span of 6 months. So, and this was with one coordinator in that department. So this effort alone speaks volumes to the disparity being faced by renters all over Connecticut. And it also begs the question of how burdened tenants and renters are in municipalities who have yet to recognize the importance of such programs, such as expanding Just Cause or even having a Fair Rent Commission in the first place. For these reasons, I strongly support expanding Just Cause eviction protections, and thank you.
Thank you, Ms. Jackson. And I just want to say it must have been a time being part of Bridgeport Social Services at that moment, especially in 2024. I've spoken about this publicly many times. That is the time where we had mass evictions in Bridgeport on East Main Street. Those are probably the people that were giving you a call, the people you were hearing from, and it was something that was eye-opening to me. As I was already going through this, I had only been chair of the housing committee for a few months at that time, but thank you, and I know that you went through a lot. Any questions from members of the committee? Seeing none, have a wonderful night. Next, we're going to number 69, Julian Castro. Julian here? All right. I see you chomping at the bit there, Mr. DeCosmo. We'll get to you. Number 70, Jalen Daniels. No? Well, I do see Lori Ladon, number 71. Floor is yours.
Hello, Senator Marks, Representative Felipe, Ranking Members, Senator Sampson, and Representative Scott, and all the distinguished members of the Housing Committee. My name is Lori L., as people call me, Ladon. I'm a resident of Shelton. I'm a musician and medical delivery driver and a Smart Justice leader with the ACLU of Connecticut. And I'm here to testify in support of HB 6948, an act concerning collateral consequences of criminal records on housing opportunities. I'm addressing the committee from my own experience. I'm formerly incarcerated, and when I was released in 2020, I consider myself really fortunate that my mom, upon her passing, left me a small condo to move into when I was released. And my family didn't want to lose the property due to my incarceration, so the title was actually in someone else's name. And to be frank, this became an opportunity for them to become very manipulative and have control and power over me at their whim. I would get angry, drunk calls at night from a family member to get out, I'm done with you. And my home, it became it became a reason for someone else to reach out and blame me and to take out their frustrations. So I got really scared, and it left me frantic. It left me scrambling for alternatives, knowing how unpredictable my family could be. So I searched for a way to secure a safe place. I searched every place I could reentry. I called so many of the people that I knew that were involved. I'm in the system. I know the resources that are there, and I could not find anything for myself. It was my first realization of what a dire state homelessness is for people who are reentering society and need a roof over their heads, a safe place to build a foundation for their best chance of success. Because if there's no home, there's nowhere to find hope. And I knew firsthand how having a background check could ruin your life after having the hardest time securing a job. I was hired and fired the same day more than once after the hiring manager ran my background check, thus deeming me unhireable, even though my resume proved I was overqualified. How was I going to afford a place? These practices have to stop. Housing is a human right. And if I had such difficulties as a privileged person, all these privileges that I had, I cannot even begin to imagine what it must feel like for those who do not. I urge the members of this committee to please support HB 6948. And thank you for listening to me this evening. You know how to find me.
Thank you, Ms. Lindana. Anybody have any question? Seeing none, have a wonderful night and thank you for coming before us. And we know we'll see.
Thank you.
Number 72, Juan Fonseca. This one here. No? All right. Adam Bonoff. No, Adam. Sarah Bromley. No, Sarah. All right. Mr. Bob DeCosmo, you're up. Floor is yours, sir. Nice to see you.
Good evening, Representative Felipe, committee members. Thank you for your hearing today. It's going to be a long one. I thought I was going to testify around 3:30. So anyways, there's an awful lot to unpack. You had a 24-item agenda. My first comment, though, is we talk about the need to build more housing in Connecticut. The majority of this legislation you would consider to be pro-tenant. I don't think there's anything here that's going to encourage private capital to come into the state and construct new units. I emailed the committee members a recent study from University of California. It was May of last year. Tenant rights, evictions, and rent affordability. And I'll just read briefly from the conclusion. But strict landlord regulation, often championed by advocates of tenant rights, is proposed as a means to prevent evictions and address the significant social and economic costs associated with evictions. They went on to list their methodology, and their overall findings highlight an important trade-off between tenant protections and rent affordability. Imposing strict landlord regulations may protect tenants from potential hardships associated with evictions, but at the cost of lower affordability, higher rents, vacancies, less units on the market, and increased homelessness. So I asked the committee to be cautious when it's considering the legislation that is proposed. There was a lot of talk today about 6889, just cause. That's not about just cause. That's a radical rewrite of the Connecticut eviction statutes. It eliminates 5 of the current legitimate reasons to evict a tenant, including nuisance, serious nuisance, no right or privilege to occupy, or no right or privilege to occupy but once having someone. You will no longer be able to get rid of a squatter that broke into an apartment illegally because you're taking out the no right or privilege to occupy. Nuisance and serious nuisance, my goodness, you're putting good tenants at extreme risk from the bad element that does get into these properties from time to time. And again, landlords do not evict without a reason. It's not something that they look to do. It just, quite honestly, takes too much money, takes too long, and by the time you really go through the process, your good tenants may leave your property, leaving you with the troublemaker. Also, I'd like to just mention this to the committee. We need to start to look at the multifamilies as an opportunity. Here today in Connecticut, who can afford a $300,000 or $400,000 single-family home as a starter home? The true affordable entry-level housing is a multifamily, where you can live in one unit and collect income from the other two. So again, we have to be careful when we're thinking about things like security deposits, limiting them to 1 month. Because again, I think we really got to go into these multifamilies again, like our grandparents did.
Your time
And
has expired. If you could please summarize.
yes, and use the multifamily as the model for entry-level affordable housing. Thank you for your time this evening. I appreciate it.
Thank you, Mr. Cosmo. Representative Scott.
Hey, Bob, thanks for coming in. Appreciate your commentary every public hearing that we have. We know you come in with some information that is helpful to us to consider. I do like your idea about the duplex. I'd like to hear a little bit more. Like, is there incentives or something that we can do around these duplexes? Like, is there something that we can do as a state? Do that. I remember as a kid, my grandparents owned one, and they did exactly that. They rented the other side out, and that's how they helped pay their own mortgage, but also try to build wealth a little bit, right? And it's super interesting that kind of has curtailed, I guess, from a generation to generation. But is there a way to come back to it? Was there incentives or something from a landlord perspective, excuse me, or from a perspective of investment that could maybe bring that back, maybe a little bit to the forefront? Any opinions you have on that?
Sure. Actually, it's probably 12 years ago, but we were running legislation for an act concerning urban homesteading, and we were looking at creating it was actually creating long-term residency at the same address, using the multifamily as the model for entry-level affordable. We're actually looking at a lease-to-own model where people will get into the multifamilies. There was going to be ongoing post-purchase wraparound support, so there'd be training in case there was a problem. We thought about mediating between disputes. There's an extensive volume of information that's available about those programs. It needed some funding, and again, CHFA provides funding available for first-time home ownership. It's just, I think multifamily has just gotten a bad rap over the years with with all the talk about the slumlords and people not take care of properties. But again, looking at the multis, in my opinion, that really is affordable entry-level housing. And again, we have tons of information. Representative Butler spearheaded a lot of the legislation back then. Terrific idea, and I think it really works in today's environment. Because again, who could afford, to purchase a single family starter home at $300,000 if you're just a young married couple just starting out? It's just out of reach economically.
Thank you. Representative Weir.
Thank you, Bob. And real brief, you mentioned that this legislation going to be potentially taking away 5 of the reasons that are often in evictions. If those options are taken away from you, what kind of what recourse do you have? Then what do you use to lean on instead? Through you, Mr. Chair.
Well, I think you're really tying the hands of the housing provider. There really is no recourse with a squatter. Especially today, because I guess you had a hearing last week on how to remove squatters. It's a problem. Squatters are not tenants. Squatters are occupants. 6889 deals with landlord tenants. But squatters are occupant and owner. It's 2 different classifications. So you would never be able to remove a squatter if this bill goes through. Banks who do foreclosures, they're not in the business to manage rental properties. They'll buy out a tenant's lease, or if the tenant doesn't want to move, then they use an eviction for no right or time no right or privilege to occupy the unit but once having one. So pretty much just saying, you used to be a tenant, we now took over the property, we don't want you here. Banks won't be able to get rid of that occupant. So now what does the bank think about investing its money into the state of Connecticut, where under worst case scenario, it's got to take a property back? I think it passes on the market and moves into someplace else that's less regulated. And again, those are the things that are buried in that bill that, none of the speakers today spoke of. And I double checked. I looked at the existing statute and I went back to the proposed legislation, and they're gone. They're just not in there for reasons to bring an eviction under 6889. There's just some tools you just can't replace.
Thank you, Representative. I just want to make one point in terms of the example of banks owning property. If a bank buys a property, especially without the with the intent, which I don't think they would have the intent to use it as a dwelling or as a housing unit, that is the removal of that unit from the housing market, which is a cause under just cause eviction, just so people are clear. I wanted to ask a question, Mr. DeCosmo. And the question is related to the study that you sent us. I actually did look through the study.
Okay.
Do you happen to know where on the index amongst the states Connecticut is in that study?
Let me send you the complete study.
Yeah.
Yeah, it was a little bit above my pay grade to get into all the analysis that they did to determine the results. But I do have the original study. I'd be more than happy to send it down to you.
Yeah, for the record, I think we were somewhere around 28th or in between like Iowa and Kansas in
Okay.
terms of how many renter protections we have compared to the rest of the country. We're close to the middle and actually further from the top half than we might think we are. So I just want to say while that study is comprehensive, I think there's a couple of things that I would look at, and one is the numbers are a bit arbitrary when it comes to things like they looked at notice of rent increases was one of the things that they had put in the study as one of the policies they looked at. It's an arbitrary one, and it's also one that we don't really enforce very well in the state of Connecticut. It's not like people are getting fined up the wazoo because they're not giving notices for rent increases. So while I think that the study is important to look at, especially the premise as you put it, where more renter protections that squeeze landlords end up putting a little bit of a squeeze on the market, we need to look at where Connecticut is, and we can afford to do a little bit more because of where we are. But regardless, I just wanted to make sure we address
No, I
this stuff.
appreciate that. And Representative Felipe, I mean, I get a lot of calls from very concerned housing providers, and and I guess the consensus is the more that we're trying to change the policies, you're forcing the property owner, the housing providers, to step up their requirements to gain entry. So if we make evictions more difficult, the next thing that's going to fall, next domino that falls, is when you're applying for an apartment, I'm raising my credit requirements. So it's not 625. Now I need 700 on your credit, or you're not coming in. And I think it's a matter of literally trying to mitigate risk or anticipating risk and then trying to mitigate it before it occurs. So, and again, the thing with the 1 month security deposit, I mean, I hope that doesn't get out of committee. That doesn't hurt landlords. It hurts marginal tenants that are looking for an apartment. Instead of saying, here's the keys, you're going to say, next, see you, because you've got a marginal record and I don't want to take a chance. So I think that's, and again, landlords and tenants, in my history, 95% of the time they get along great. They go together. They need each other. So, again, just caution, because some of this stuff is really causing the community of housing providers to react, and they're very defensive right now. I mean, there hasn't really been much legislation that benefited the housing providers in a long time in coming out of Connecticut. So again, so this, the stuff that was on the agenda today, it scared a lot of these guys.
Understood. One question about the security deposits as they were.
Yes.
If we were to kind of open up the conversation about the security deposits, do you think that it would be a benefit where maybe we have to leave it at 2 months, or even if it got to a month, if we allowed for that opposite side of the coin? Because we talked about it earlier, where the tenant could offer to pay more I'm not saying that we change our requirements in the state of Connecticut and allow a landlord to require more than
Right.
2 months, but maybe to allow tenants to make that offer to sweeten the pot. Do you think that that makes a bit of a difference?
You know, I think in certain cases, that may be the recipe that gets that person into the door. As you say, you know, it's not a requirement, but right now it's prohibited. So if you do accept the money, you're breaking the law. But yeah, because again, it's risk mitigation and looking at somebody's holistic background. There may be some issues there. They say, hey, you know what? We're willing to give you a shot, but you know, most tenants use the security deposit as last month's rent. So, you know, the second month really goes to guard against any damage. Because again, and what happens at the street levels, most tenants go, I'm moving, take my deposit as my last month's rent. So there really is no security deposit if it's just 1 month. So, you know, that would be an interesting idea to say, you know, if as long as we don't require more, but say it can be, and I think that would be interesting. Oh, and one other bill that really, this is something that I think everybody could agree on. Nobody's going to defend a bad landlord.
1 second, Mr. DeCosmo.
Yes.
Just to make this official, and then hopefully we can end it right after this. What is your one bill?
The landlord
ask the
registry,
question for you.
the out-of-state registry. But the problem there is Connecticut cannot prosecute an out-of-state landlord for failure to maintain a property. And we've got to get an agreement with the New York Attorney General to allow our arrest warrants to be served across the border. Because all of this legislation is not going to bring an absentee landlord from New York that doesn't take care of their property into our criminal justice system where they belong. So literally, we got to work on getting the papers served across the borders because nobody wants those guys in the business. You know, so I mean, your registry is kind of it's you're trying to address the problem, but you're not going to solve it. You know, the real solution is to let these guys be handcuffed and brought in front of the judge for failure to maintain. And I know that I talked to the fire marshals in Waterbury, and they got a stack of returned unopened certified mail. Can't touch these guys.
Got it. I appreciate that, and I'm glad that we can end on something that we both can absolutely agree on.
Looking forward.
So, wanted to make sure we asked you a few questions. You got your time in, Mr. DeCosmo. We know you're a wealth of knowledge, and we want to thank you for joining us.
Appreciate that so much. Thank you.
Got it. Next is number 70. Or sorry, we're gonna go back for a second. Juan Fonseca is here. Want to give you your time. Good evening, and the floor is yours.
Good evening, Senator Marks, Representative Felipe, and members of the Housing Committee. My name is Juan Fonseca Tapia. I live in Danbury, and I am a tenant. I am testifying in support of HB 6889, an act concerning evictions for cause, because I believe all tenants should have just cause evictions protections. It's been 28 days since Trump and his administration entered the White House for his second term. Hundreds of executive orders have come out of the presidency, creating chaos, fear, instability, and uncertainty across the country, including here in Connecticut. Many elected officials have sounded the alarm about the long-term ramifications and the urgent need to take action against unchecked power. Why am I mentioning this? I want you to know that the unchecked power we see in Washington is not so different from the unchecked power tenants face every day at the hands of some landlords. We need this law to ensure checks and balances between landlords and all tenants in the state. I am an immigrant, I am gay, and I have served in the United States Air Force for 9 years. I have seen firsthand how landlords exploit tenants, how housing insecurity devastates lives, and how this imbalance of power weakens our communities. In 2021, the Connecticut LGBTQ Network conducted a statewide needs assessment, and 1,100 out of 3,048 participants identified housing insecurity as one of their primary concerns. LGBTQIA rights organizations consistently cite that LGBTQI people are at higher risk of eviction, homelessness, and housing insecurity. As a military member, I also know that veterans face similar disparities. They make up about 7% of all homeless adults in the US, even though they only represent around 6% of the total US population. A 2023 HUD study reported that 165 Connecticut veterans experienced homelessness. On Veterans Days, politicians post on social media thanking us for our service. I want you to know most veterans don't care about performative posts. We care about policies that actually protect us, like HB 6889. As an immigrant, I can also tell you that landlords weaponize immigration status to exploit and intimidate immigrant families. Immigrants have always been fearful of reporting abuse, negligence, and uninhabitable housing conditions due to the fear of retaliation and the threat of deportation. Now, more than ever, these fears are justified. This committee knows that working class people of Connecticut are struggling. You know that working families' needs will only be exacerbated by the Trump presidency. As I ask you to use your moral compass and your power to pass HB 6889. This committee has the opportunity to show the people of this state that you are, in fact, accountable to us, the people that elected you, not the ultra-rich mega landlords in the state. Thank you for your time. And I'm here for any questions that you may have.
Thank you, Mr. Fonseca. Any questions from members of the committee? Seeing none, we really appreciate your time and making it out here, especially in person.
Thank you so much.
Next online, we have Adam Bana, number 73. The floor is yours, and if you can, please try to turn your camera on. Just unmute yourself and the floor is yours. Still muted. We're gonna see if we can unmute you from here. Can you try to unmute him? All right, we're gonna move on, but Adam, keep trying and we'll see if we can get back to you. Number 76, Rosalina Rojano. She here? She in the waiting room? What's going on? Oh. Okay, Sarah, it's on you, number 74. Floor is yours.
Thank you. So, good day, Co-Chair Representative Felipe, Co-Chair Senator Marks, and members of the Housing Committee. My name is Sarah Aaron Bromley. I live in Milford, Connecticut. I'm a proud member of the All In for Milford Alliance, and I'm here to speak in support of HB 6889, an act concerning eviction for cause. I am a homeowner here to say it's not just renters who care about this legislation. It's not just city dwellers. We need this legislation for the suburbs too. My reasons for caring about this are both professional and personal. As a Connecticut early childhood educator for over 40 years, I'm really worried about how evictions impact our infants, toddlers, preschoolers. I'm willing to bet that not that many people realize that children under the age of 5 are considered the most at-risk group for evictions in the United States. Connecticut's no different. Another group I lose sleep over are our older children. You know, those thousands of young adults who are doing absolutely everything right, but have just about given up on trying to attain those benchmarks of independent adulthood that came so easily to our older generations. And my personal story is about my 26-year-old daughter. She's lived in Milford all her life, and when she graduated from high school, she received a special superintendent's award for her record-breaking number of community service hours. It's a record that still stands today, and I share this not just to brag, but to demonstrate her commitment to her community. It's a community she'd like to be able to stay in. So after graduating Mount Holyoke College, another brag there, a degree in biology, she landed a job in Darien. Now, she makes $35 an hour, and that's way more than I make as a preschool teacher, even after 40 years. So she still doesn't make enough money to afford to rent her own apartment in Milford. And so she lives with us, right, in her childhood bedroom. That American dream of home ownership, it's just a cruel joke now. It's a joke for her generation. The new American dream is simply to rent, and even that seems unattainable. My daughter has honestly stopped thinking of a future where she could move out because she knows even if she did somehow pay off her student loans, save enough money for a large security deposit, and find an apartment she could afford, she would still live with the threat of arbitrary eviction over her head. So, in Milford, we see that her story is all too common. Almost 50% of her peers aged 18 to 29 and even older, even with good jobs, they're still living at home in their childhood bedrooms. Now, hopefully they have updated posters at the very least, but every time I ask my peers, how many of them have adult children living at home, almost all the hands go up. This is a problem in the suburbs too. This new norm of nests that never empty, they're not full of failure to launch individuals. Rather, there are generations that we have failed. So I implore you to begin to fix this, like to swiftly plug one of those holes in the leaky bucket that's our state housing crisis by passing HB 6889, an act concerning evictions for cause. And, really swiftly, because my 21-year-old is coming home from UConn soon, and my nest's getting even fuller. So thank you so much for your time. And obviously, any questions?
Thank you. Any questions from members of the committee? I will just say as probably one of the only people that can say that they're under the age of 30 here in this legislature. Part of that generation, I understand what folks are going through, and while I am fortunate enough to live by myself, I do know that the specter of having to save mountains and mountains of money just to buy a standalone home one day and raise a family, it's a really tough thing. So I thank you for calling light to that. And we appreciate your time.
Thank you for your time.
Oh, sorry. Come right back really quickly. We have Senator Anwar on Zoom who has a question for you. I apologize, Senator.
Thank you so much, Mr. Chair. Thank you, Sarah, for your testimony, and thank you for the work that you do, and we appreciate all that you're doing. And I think you make a very strong point. I just wanted to appreciate your work and being here.
Thank you, Senator.
Thank you, Senator, and thank you, Sarah, very much. We're gonna try Adam one more time. If you can unmute, my friend. We'll get back to you. I know Rosalina wasn't here. What about Joan Eiley Cologne? Josh Pollock? Johnny Shively, I see you.
I see you too. Thank you. Great. Well, good evening, members of the Housing Committee. My name is Johnny Shively, and I am the Housing Policy Manager at Elm City Communities in New Haven. I'm here to testify tonight in support of HB 6889, an act concerning evictions for cause. And specifically, I'd like to discuss the empirical research showing that just cause is not likely to impact the rate of housing production in Connecticut. One of the questions that has come up repeatedly around just cause is how it might impact our state's housing supply. The concern that has been stated by opponents of the bill is that if it becomes harder to be a landlord in Connecticut, then there will be fewer units developed and fewer owners interested in managing existing units. Obviously, this outcome would run counter to the housing goals outlined by state leaders who know that increasing housing supply is a key strategy for easing Connecticut's housing crisis. However, the existing research does not back up the narrative that this will happen. Last month, senior researchers at the University of Maryland and the University of Minnesota analyzed the impacts of just cause on housing supply in 3 states where just cause has already been enacted: California, Oregon, and New Hampshire. Specifically, these researchers looked at the rate of housing production in each of these states before and after just cause legislation was implemented. The researchers also observed counties bordering these three states to try and control for factors outside of just cause that might also impact housing production. Ultimately, the researchers found no evidence to suggest that just cause protections negatively impacted housing production in any of these states. In fact, in California and Oregon, the number of development permits issued actually continued to rise steadily following the passage of just cause. This research suggests that passing just cause will not create a significant barrier to housing development in our states. These findings have been endorsed by faculty at UC Berkeley, Harvard, Columbia, Rutgers, UCLA, and a host of other academic institutions. For me, this finding is important for helping us understand the balance between how this legislation stands to impact tenants and how it stands to impact landlords and developers. Although the existing research tells us that just cause will not significantly impact housing production, we know from a much more extensive body of research that it will improve the lives of renters throughout the state of Connecticut through reduced rates of evictions and reduced displacement. Thank you all for hearing my testimony. I would be happy to answer any questions you have and to share this research with you if that's of interest.
Thank you, Johnny. Any questions from members of the committee? Seeing none, we thank you and appreciate bringing data. Anybody who brings data is always appreciated. Adam, I see you trying. I think it's your daughter trying to help you over there. Any luck? Still trying to get Adam. All right, we'll get back to you. All right, we're gonna go back one to Josh Pollock. Floor is yours, sir.
Hi, good evening. I'm assuming you can hear me.
Yes.
All right. Well, greetings, chairs Marks and Felipe. I can't tell who's in the room. Ranking members Sampson and Scott and members of the Housing Committee. Thank you for this opportunity to testify in support of HB 6889 and act concerning evictions for cause. My name is Josh Pollock. I'm the minister at the Unitarian Universalist Society East in Manchester. I'm a leader with the Greater Hartford Interfaith Action Alliance, and I'm a member of the Connecticut for All Steering Committee. I'm a resident of Glastonbury. I vote in the 31st House District and the 4th Senate District. And in addition to owning a home, my wife and I also own a 2-bedroom rental property in Glastonbury. For me, just cause is a matter of faith. Unitarian Universalists gather our congregations around a set of principles and values that guide us in living faithful lives. Our principles and values are very simple, but they speak volumes about how we ought to treat people. And by implication, they tell us what it takes to build and sustain healthy, cohesive neighborhoods, towns, and cities. As a Unitarian Universalist pastor who has been serving congregations in Connecticut since 1999, it is abundantly clear to me that reliable, stable housing for families and individuals is an essential component of building healthy, cohesive communities. Reliable, stable housing enables people to build rich local connections with neighbors, schools and teachers, healthcare providers, social services, employment, elected officials, and more. And when housing is unreliable and unstable, when it can vanish in the blink of an eye, not only are the lives of those who lose it upended in often irreparable ways, but those rich local connections are lost and the health and cohesion of neighborhoods is damaged. So in my view, Connecticut's current eviction statutes are not just, they are not equitable or compassionate. They make it far too easy for landlords to force tenants from their homes without cause. I'm especially concerned about large out-of-state landlords who force tenants out with impunity and with no commitment to sustaining healthy, cohesive communities in Connecticut. HB 6889 would appropriately limit landlords' ability to force tenants from their homes. I'm satisfied that HB 6889 adequately identifies those circumstances under which landlords should be able to remove tenants, so non-payment of rent, violations of the lease, removal of the unit from the rental market, or the landlord's desire to occupy the unit. But with successful passage of HB 6889, stable, reliable housing will be protected. Rates of housing disruption and homelessness will decline for individuals and families, and the health and cohesion of Connecticut's neighborhoods, towns, and cities would rise. I say please support HB 6889. Thank you.
Thank you for your testimony. Any questions from members of the committee? I see Senator Anwar.
Thank you, Mr. Chair. Reverend Pollack, thank you so much for your testimony. Reverend Pollack, have you come across situations where private equity from out of state has been buying condominiums and then raising the prices to the point that people cannot live there and have to move? Have you heard of those situations?
Yeah, I mean, I've encountered people. I can't give you an actual number, but it would be, 5, 6, 7 over the last year where I hear that story. And then obviously listening today, I keep hearing that story a lot. I'm really concerned about private equity. And I've also noticed not just the situations where they'll remove tenants and then raise the rent, but just getting into some of these places, all the hidden fees that just make renting more and more difficult. I'm concerned about that too, although I know this bill isn't addressing that.
Well, thank you so much. You brought it up, so I wanted to make sure we highlight that as well. Thank you.
Thank you. You're welcome.
Thank you, Senator. And thank you. Is it Reverend?
Yes.
Thank you, Reverend Pollack. I see Senator Sampson online with the aquarium in the background.
Thank you very much, Madam Chairman. Or Mr. Chairman, I apologize. I never know who's running the show moment to moment. But Reverend, thank you very much for being here. I was listening to your testimony intently. I'm confused about a few things. The first thing I want to ask you is just in reference to Senator Anwar's question, which is, I mean, do you make a distinction between who the owner of a property is to determine whether or not they're a bad actor? Through you, Mr. Chairman?
You're asking, I can't tell, you're asking the chairman or you're asking me?
You.
No. I don't make a distinction necessarily, but what I'm aware of is that a lot of the challenges that renters face are in these situations where private equity has big complexes, and in my experience just doesn't care about the quality of our communities or the experience of the renter, or whether or not they stay or go. I mean, I think with a tight housing market, they know that they're not going to have trouble filling their units, and that to me is problematic. I see that again with the large owners, not so much the local mom and pops or the small owners. But that doesn't mean, and I think this goes to your question, Senator, it doesn't mean that I'm not saying that all big venture capital firms that own properties are bad actors, or that all small owners are good actors. I'm not saying that.
Thank you, and I appreciate that answer, Reverend, and I appreciate you clearing it up too, because that concerns me a lot, because that's some kind of rhetoric we hear very often, and I don't think it's appropriate to lump any group into a category, whether it's by race or their method of purchasing property. I mean, it's just there's good people in the world and maybe not such good people, but that we can't distinguish that based on superficial characteristics necessarily. Although I can understand that a corporate landlord that is from out of state may have less ties to the community than a local landlord, but that doesn't necessarily mean that they're going to be bad at it either. Some of them I'm familiar with are actually quite good. Just another question too, which is, I mean, I got to tell you, I mean, the fact that you brought the morality question up right from the start of your testimony is a little frustrating for someone who is opposed to this policy, because I don't see that this policy is going to achieve the goal that you are looking for, which is what we're all looking for, which is to have more plentiful, affordable housing in the state of Connecticut. I believe that this will be an impediment to even good landlords, and as a result, cause many of them to leave the marketplace, maybe give us more bad landlords. So I would just leave you with that. And I don't really have a question. I wanted to at least offer another, perspective with regard to that, because we are all on the same side here. We want to see, thriving communities, people that are able to afford their rent, live in clean, quality places. I've been talking to folks all day long who have expressed all their different concerns to me. And I find that a lot of it has to do with the, lack of municipal enforcement for health violations. A lot of those things have very little to do with this bill. This bill is really about ignoring the fact that a landlord is renting their place for a period of time, and that time is finite. And to ignore that contractual agreement to me is problematic. But I appreciate your commentary and your thoughtful remarks. And thank you, Mr. Chairman, for the indulgence.
Thank you, Senator.
Almost call me Madam Chairman again. I'll give you the first two. Thank you.
Just don't call me attorney again. That's all.
I didn't call you attorney.
I'm just making a joke, Mr. Chairman, and I apologize for the misspeaking.
Understood. Thank you, Reverend Pollock. We appreciate your time.
Thank you. I appreciate it.
Very quickly, we're gonna go to Adam. I think his audio issues have been solved.
Okay. Can you hear me?
Yes, I can hear you, and the floor is yours, sir.
Okay. Thank you, honorable members of the Housing Committee. I appreciate all your efforts, and this is not an easy topic, but I want to stay on the same one, HB 6889. I want to just shine a light on really the angle of this is somebody's property. This is, and you're taking away the ability for somebody to be able to maneuver on an asset that they own. They have put in all their blood, sweat, and tears to make this investment, to own this property, and they have all the risk. And you want to turn over this to somebody who has no skin in the game other than that they happen to live there now, but they have no financial risk. I mean, and let's look at the difficulty that the difficulty that it is to get rid of your wife. If you want to divorce, you can do that in this country. You can get rid of a spouse, a family member you can get rid of. If you elected officials, you want to stay in power, you want to keep your seat, you want to get a higher office, you need to run again. You need to be you need to be elected again. But if we pass a bill like this, what we're doing is we're basically saying a tenant has more rights than any of these other people, trumps everything. This is a forever thing. And let me put it this way. I've been a landlord for 25 years. And if it's not the people that I have a great relationship with that are going to be forcing me to keep them in that position. It's going to be somebody that you have an adverse relationship with. It's going to be somebody that's causing you a headache. It's going to be somebody who is possibly a drug dealer. It could be somebody who's intimidating other people on the property. It could be sexual predators on the property. I mean, why would you want to subject good tenants? I understand there's problems, people buying up properties that have low rent costs and evicting them to make more money. I get that, but we're throwing the baby out with the bathwater. You really, I can't understand the true connotations, because you're really, you've no longer given somebody the opportunity to control their property. A landlord's hands will be tied. I mean, I had one time had a guy shoot his son in a unit, and I mean, I was powerless. I couldn't get him out, and I tried everything I could to get him out. But the point is, the landlord was even powerless in a situation like that, where this guy was able to get back into the building because he had gotten bail. And I tried everything to get rid of the guy. And our laws are so skewed to the tenant's ability to control and manipulate everything. I just don't get it, and I don't buy it. I hear these arguments about the high rent and everything else, and I get that, but
Your 3 minutes are over. If you could please summarize.
Okay. Bottom line, this is an un-American, anti-capitalist proposal that's on the table, and we shouldn't be doing it. It's not right. We're crossing a line. And this is somebody else's property. You don't own it, and you don't have a right to give these rights away. Thank you.
Thank you, Mr. Bonoff. Any questions from members of the committee? Senator Sampson online, I see you.
Mr. Chairman, thank you. So Adam, welcome. Thank you for your testimony. Glad you got your audio working.
Yeah, me too.
Yeah. You're obviously very passionate testimony and so forth. I just want to ask you maybe one or two general questions about being a property owner and housing provider, which is, I mean, I'm sure you're noticing, obviously rents is the big issue, the cost of rent, but are you noticing your expenses going up also? And do you feel like that is a factor in what's driving up the cost of rents? Through you, Mr. Chairman.
Yes. Senator Sampson, I appreciate the question. Every single thing under the sun that you have, that everybody else has to pay for every, in their normal life has gone up, and everything has gone up for landlords. I mean, the cost of labor, my insurance, my taxes, every single thing. They're giving me no breaks anywhere. My costs are not going down, and they've already got rent control with the rent commissions now. So it's not, I mean, they've already got you tied up. So it's not, I think they've done enough. I really do.
This bill has to do with really just people that are up for renewal, and I don't know. It's very difficult to talk about. I've had this conversation so many times, and many people, I think, who are listening, and even some folks who testified, I don't want to, say anything insulting to them, but I don't think everyone understands the true extent and ramifications of this bill, because it really is far reaching. And you're one of the few people that actually came out and said that you believe that this is a violation of the rights of the property owner. And I concur. And so if there's anything you want to add on that subject, I mean, you made it pretty clear that as a property owner,
it was never easy to buy a property. When I started, I didn't have any money, and all this impossibility that you can't buy a $300,000 property, it's really not true. And I know people are going to balk. Oh my God, how can you say that? You can get an FHA loan. Put 3% down, you need $10,000. You can't get $10,000. I mean, I'm not trying to be an idiot and be mean-spirited and everything else, but it's the truth. So if you want something, you can do it. And it's not right to take everybody else's property rights.
Yeah, through you, Mr. Chairman. Yeah, thank you very much. I appreciate that. While I have you, Adam, let me ask you another question. We have another bill on the agenda about security deposits. That would limit the amount of security deposit you could hold from 2 months to 1. And I'm just curious your reaction to that.
Well, again, it's like if we scored all of these bills that are on the table, and I didn't feel like I had enough time to really address, and I really wanted to address this big, what I consider to be a bombshell bill on this call. If you, again, limit, you're going to just, the people that are on the bubble that are going to be trying to get a rental apartment, if, again, you're making it that much harder for them to get in, because if that guy has a minus 600 credit score, it's not happening with me. It's not happening. I'm not giving that person a chance. I mean, there's just no reason to do it. It's just far too much risk. And they need to look at these proposals and score them and say, hey, what is this going to do? What's the downside? I mean, let's look at the last 20 years of what's happened in Connecticut. We have all these laws and bills and everything we've piled on top of landlords. And what do we have? 98,000 units that we need to fill. I mean, there could be an inverse relationship. Maybe I'm stupid. Maybe I just don't get it. Maybe, but I'm trying to tell it like it is. It's the truth. We are causing our own problems. If you take your foot off the gas, I would love to see the study of, let's take a look at a state where you can evict somebody and get them out in 30, 60 days. Okay. And compare that to a state like mine. I just went through it took 7 months to get rid of somebody who wasn't paying, and, they paid sporadically, and I lost, I don't know, 4 months and legal and everything else. And there's no reason for it. There's no need for it. It doesn't help that tenant in the long run. That tenant is still out. And what did we accomplish by doing that? All we did was now price the market higher, because now my risk is higher and everybody else's risk is higher. We didn't do anything. We didn't do any favors to anybody by doing this. We made every other renter pay more because they did that to me. And I'm just putting it out there. It's the truth.
Yeah, last question, Mr. Chairman. So Adam, just a comment is, I think there's precious few people that are actually taking the side of being opposed to this bill, certainly testifying today. And so if you're looking for the study or the information, you're it. You need to be as compelling as you can to make the argument. I've been trying to do it throughout the day.
To me, it's common sense, and it's supply and demand. It's like, if you have you have a retail store, you're selling red dresses, blue dresses, green dresses. The red dresses sell like hotcakes. You get rid of them. The green dresses just don't sell. So what do? You cut the price of the green dress. I mean, it's so simple. But we don't look at it that way at all, because this is somebody's home. Instead of it being a supply and demand and it being a commodity, we don't look at it.
Yep. One final thing, and that is that, based on everything you said, this is what I was leading up to, actually, which is, based on what you're saying, I guess the conclusion is, if we make it harder to operate as a housing provider in the state by imposing these new restrictions, it's going to tighten up the requirements to become a suitable tenant, because the housing providers are obviously going to be much more interested in scrutinizing applicants, knowing that you may be stuck with someone well beyond the ability to remove them as of the end of a lease. Am I right about that?
You absolutely are. If I knew I could get rid of a bad tenant in 30, 60 days in Connecticut, I would buy more properties. I wouldn't think about exiting the state. There would be no reason to do it. It would be a much better place to I want to do the right thing by tenants. Somebody calls me, there's a problem on the property, their heating is off. I get someone out there immediately. If there is a hot water problem, I get someone there immediately. A leak, whatever it is, there's pests on the property. Do the right thing by people. I'm not saying don't do that. But everybody's in business, whatever they happen to do to make money, and it should be understood that you're gonna get poorly run. Take the incentive away. You're gonna get people that are willing to that are gonna look for greener pastures. I mean, there's just no reason. There's no reason if you can't succeed in this business, because they hamstring you the whole way.
Thank you very much, Adam. I wish I could spend more time with you, but obviously there's a lot of people that are, signed up to testify, and we want to get to everybody. So thank you.
Thank you, Senator. Appreciate your time.
Thank you, Senator. Any other questions from members of the committee? Seeing none, Adam, we thank you for your time, and glad you got unmuted.
Have a great night, everybody. I hope you're glad that I got on. All right, take care.
Next, we'll go to Rosalina Rojano. Is she online? Well, she was. Last one.
I got to go. How about that?
Now Adam can't unmute.
Hola.
Rosalina.
Yes. Hola. Hola,
We
buenas noches. Representante Felipe, senador Marx y los miembros del Comité de Vivienda. Mi nombre es Rosalina Rojano. Soy residente de Hartford. de Haciendo Camino en Connecticut. Yo apoyo a la propuesta de ley HB 6889, una ley relacionada con los desalojos por causa justa. Y creo que todos los inquilinos deberían tener protección de desalojo por una causa justa. Vivir sin un contrato de renta nos vuelve frente a los arrendatarios abusivos. Hace ya 4 años que vivo en mis domicilio. Nunca he faltado en mi renta y he mantenido la vivienda en buenas condiciones. Pero durante 3 años, el dueño me aumentó la renta cuando quería. Lo peor es que nunca se encarga del mantenimiento de la vivienda, ni el invierno ni ni en el verano. Yo gasto mucho dinero para mantener una casa que no es mía. Yo le pago una renta y encima tengo que cargar el mantenimiento de su propiedad. Como inquilino también tengo mis derechos y por eso estoy aquí, porque causa, porque cuando pregunté por mi mantenimiento, él me dijo que me tenía que hacer cargo yo. Creo que es injusto para muchas familias que pagamos nuestra renta tener que hacernos cargo de las responsabilidades del arrendador. Usualmente uno recibe esta clase de amenaza indirectas o también nos asfixian con los gastos de mantenimiento para que renunciemos y nos salgamos de las viviendas, porque lo único que quieren es hacer más dinero con nuestras necesidades básicas, aunque seamos buenos inquilinos, que pagamos a tiempo. Lamentablemente, esta ley no me incluiría porque vivo en una vivienda de una familia, pero tengo familias, amigos y miembros de mi comunidad que sí se
Señora,
benefician.
señora Rosalina, su tiempo ya terminó.
Sorry.
Ok, gracias.
Hi, good night, Representative Felipe, Senator Marks, and members of the Housing Committee. My name is Rosalina Rojano. I'm a resident at Hartford, and I'm a member of Making Road here in CT. I do support the HB 6689 bill and act supporting eviction for cause. I do believe that a renter should have protections. I lived without a contract, without a lease, and this puts me in front of an abusive landlord. It's been 4 years since I've lived in my home. I've never missed a payment for my rent, and I'm the one that has maintained the property in good conditions. In the past 3 years, the owner would charge the rent up whenever he would like. The worst thing is that he doesn't take charge of the maintenance of the home, not in winter, not in the summer. I do spend a lot of money to maintain a home that is not mine. I do pay a rent, and on top, I I have to do the maintenance of the property. As a renter, I do have rights, and that is why I'm here. Because when I asked for the landlord to fix any maintenance, he said that I have to do that myself. This is unfair for many families. We do pay rent, and unfortunately, we have to be responsible for these duties. Usually, we may receive an indirect threat, or we have to keep paying for the expensive maintenance costs so that we can give back the property and so that we leave. Because at the end of the day, all that the landlords want is money out of our basic necessities that we need, even though we do pay on time. Unfortunately, this bill does not include me because I live a unit of one family, but I have friends, families, and community members that would be helped by this bill.
Thank you. Any questions from members of the committee? Seeing none, we appreciate your time. Señora, gracias por tu testimonio. Un placer. We're gonna go now to, we're gonna skip around just to get to some people on Zoom, but also to some people who have been in the room with us all day. So now I'm gonna call on Regina Coviello, if she can come up and testify in the room, and then we'll get to somebody on Zoom and then get back to somebody in the room afterwards. Take your time, and when you're ready, just make sure to press the button in front of you. There you go. Good evening. The floor is yours.
My name is Regina Coviello, and I am a resident of Southington, Connecticut. I am also on our local Fair Rent Commission. I am in support of HB 6889 AAC Eviction for Cause. I am currently a homeowner struggling to keep my home due to disabilities. I am very concerned that if I need to rent, that I could unjustly be evicted. Recently, my friend, whose apartment complex was taken over by an out-of-state company, was given a notice of eviction and had 30 days to vacate. She had been a great tenant for years. She even offered to pay more money, but they said they were going to renovate and turn them into luxury apartments. She had to stay with family until she could find a place. She finally did, but she is now sharing expenses with a family member because the cost was so high. Others, and the costs were so high, sorry. Others in the building were not as lucky, and they actually became homeless. Hopefully, some of them have found homes by now. I'm hoping. Another friend of mine is losing her home to foreclosure. She is disabled. She has a 17-year-old son, and her dad is 90. They're having a problem just finding an apartment. This state is in an affordable housing, and I say housing, not houses, crisis. Then, if you are lucky enough to have an apartment and are a good tenant, you could lose it for no reason. I don't want to hear about the free market that my own town representative, State Senator Rob Sampson, keeps bringing up. If you are a landlord and collecting money from tenants, it is a business. Businesses have to follow rules and regulations, such as a reason for eviction and at least a 90-day notice to work on finding housing. That is why you here as state representatives must do something to help people from becoming homeless. You have the obligation to the residents of this state. Landlords need to state a reason for eviction, which this bill will accomplish. Thank you, and please do the right thing.
Thank you. Any questions from members of the committee? Senator Sampson.
Thank you, Mr. Chairman. And Regina, welcome. I appreciate your comments on social media sometimes. You're very entertaining, and I know that you're extremely well read, and I'm delighted that you're here today to testify. But I have a question for you, which is that you made it clear you think that landlords need to provide a reason to evict someone, and so do I. Obviously, we need to protect the rights of tenants and make sure that people are not mistreated. I know that there are some folks out there attempting to mischaracterize my views and the views of landlords and people opposed to this bill. We all want the best for the people of the state of Connecticut. We just believe that we need to make good policy. But one thing that I noticed about your testimony is that you're equating this bill to kicking people out of their homes without a reason. But this bill has specifically to do with people that are at the end of their lease term. In other words, they rented a house from January 1st to December 31st. And traditionally, that's when the end of the lease is, and both parties are aware of that. And what this bill would do would be to allow people to stay beyond that day unless the landlord had one of the reasons that are stipulated by this committee. And of course, there's probably many, many reasons beyond those reasons, and that's the concern and why people like me are opposed to it. So do you recognize that when you purchase a rental, that it is for a period of time, and that if it was going to be extended beyond that, you'd have to negotiate the terms with the landlord? Through you, Mr. Chairman.
Yes, they do. And that's where, in my town, I get into a little bit of trouble because I see a little bit of both sides, and I class myself as purple. Let me tell you, I think I get myself in more trouble than either side does. But we have to work together. And when it comes to my friend who is in an apartment and, affordable, there for a decade, a New York company, as we've heard numerous times here, comes in, and it's 2 buildings, and I don't even know how many tenants, but just hand a notice, sorry, we're not renewing. We're turning these into luxury apartments. Now they're out there looking for something. First of all, I believe all landlords should give at least 90 days, because we know damn well that no one is going to find an apartment in 30 days. Okay, we know this. And just since I'm talking to you, Senator Sampson, I found it very rude of you earlier here today. You asked a question of somebody who was on YouTube, and then as he's answering you, you left the room. Yes, you came back after, but I think that's kind of disrespectful as a representative. Anything else?
Thank you very much. Through you, Mr. Chairman, I'll just state, Regina, that did not happen. You can go back and watch the tape.
Yes, it did.
No,
yes,
it didn't. It didn't. Well, you're very good on social media, so I suggest you
Yeah,
go
I
and
know,
find
you're a
that.
liar. You're a liar, sweetheart.
Okay. Well, thank you for your very cooperative testimony. I was going to ask you another question that was going to help you enlighten us with your
For
testimony.
2 years, I've been asking you to meet you locally, so.
No, I've never heard from you, Regina. Don't use this as an opportunity to tell a story. Okay, please don't. I'm trying to engage you right now. You have your opportunity to have a conversation with me. Please be polite
And
like I am.
You're not. You're lying, so.
I'm not lying. You've never asked to meet with me. You've never even had a conversation with me
Really? So
before
on
now.
social media, I did not.
I don't.
ask to
Yes,
meet
no,
with
it's
you.
never happened.
Okay. Same
I'd
with
like
your
to get back to
counterpart.
your
You know what?
testimony.
You're not worth
we
this.
stop speaking over
You're
each other,
not worth this. You're not worth this. You and your counterpart, Susan Zipahansky, can have a great time. I'm done. I don't.
If you don't want to answer the question, that is fine. Have a good night, Regina.
You know what? You're home. I waited till everybody was here, so.
Thank you, Regina.
Next we have Robert Van Egan.
Okay. Good evening, Co-Chair Representative Felipe, Co-Chair Senator Marks, and members of the Housing Committee. My name is Robert Van Egan. I live in Oxford, Connecticut, part of the Naugatuck Valley. I'm a member of the All-In Alliance, and I'm here to speak in support of House Bill number 6889, an act concerning eviction for cause. I was raised in a tiny village between Guilford and Bradford, consisting primarily of blue-collar families. As the children of these families grew up and ventured out, they started their own families, rented apartments nearby, saved money, and in a few years had enough for a down payment on a home of their own. This was the story of my parents and essentially my story. But that was then, and things are radically different now. When it was time for my daughter and son to strike out on their own, housing prices had risen to a level that made owning out of reach. Renting, as their parents and grandparents had done, seemed the only viable option. But rentflation had kicked in. The rental market was, and now is, out of control. The rental vacancy rate in Connecticut has reached unprecedented levels, and arguably the tightest in the nation. Rents are rising at a rate that outpaces the exorbitant rise in the cost of home ownership. It has become more costly to pay a monthly rent than it is to make a mortgage payment. The results, landlords are able to ride roughshod over tenants. Not all landlords, but there are some that do. You ask what happened. Low supply and high demand happened. Unbridled capitalism happened. Lack of control, laws and statutes which would prevent abuse happened. The landlords are able to do whatever they want, such as raise rents year after year without just cause. And I do accept fair and reasonable rate increases. Evict a renter if they balk at a rent increase without just cause. Evict a tenant at the end of a lease without just cause, then simply rent the apartment at a much higher cost to the new tenant. Evict a tenant without just cause if they bring to the attention of the property owner a need for repair, as I believe was related by Alex a few people ago. This is allowed to occur because there are no laws, no oversight to prevent it. The rights of tenants have been eroding over the past decades. It's time for meaningful, comprehensive laws restoring some of those rights. While this just cause legislation is not a panacea and will not address all the inequities in the system, it is a meaningful and much overdue good start. Because fairness, equity, and empathy are many times lacking, the basic fabric of our society is unraveling. When basic human values fade, the greater society must step in. You, the members of this housing committee, are representatives of that greater society. Until human decency once again takes precedence over profits, we must rely on laws and statutes to ensure everyone is afforded fair and equitable treatment. I ask you to please vote in support of this bill before you. Thank you.
Thank you, Mr. Egan. Any questions from members of the committee?
Van Egan, sir.
Seeing none. Thank you very much for your time this evening.
Okay, thank you.
I don't have your number in front of me, but the young man in front of me has been sitting here since 10:30 this morning, almost 11 hours. We're going to give you your opportunity now. Please come up and speak to us.
Yeah, that sounds right. Yeah. I know it was like in the hundreds. So.
Well, give us your name and we'll find you.
My name is Joshua Caskey, and I'm from East Lyme, Connecticut.
124.
Got it right. Floor is yours.
So I'm here today to urge you to support HB 6889 to protect our tenants and community from unjust evictions, which are harmful to our tenants and our communities. I have firsthand experience seeing how Just Cause can improve our towns after working with tenants of Windward Village in East Lyme in their fight to have a stable home and protect them from these unjust lapse of time evictions. They are not bad tenants. They have paid rent, tried to communicate with their landlord unsuccessfully, and they have maintained their units unlike their landlord currently. Just Cause does not prevent landlords from evicting bad tenants, as has been repeatedly discussed today. They still have cause. They just have to state a reason for it. It protects good tenants from those landlords who try to exploit tenants solely for their profit, for the landlord's profit. Just Cause has been shown to be effective not only in its limited implementation in Connecticut through those of 62 years old and older, but also around the country. In California, where it has reduced eviction rates substantially. Many of the tenants at Windward are covered by the Just Cause protections, and they have been protected from being forced onto the streets. If this protection did not exist, they would be on the streets right now, and they would be homeless. So East Lyme would have more homeless people today without Just Cause. Even so, there are still many tenants at Windward Village who are not protected by Just Cause. And when their leases are up, they will become homeless or have to find non-existent affordable housing, or go into friends and family who are already stressed with affordability. Having a stable home also allows people to not have to worry about their home next month. It provides stability to our communities, allows them to fully participate in our community and economy. And despite what you may hear tonight, this issue is not uncommon. There are thousands of lapse of time evictions in Connecticut every year, and these force people onto the streets. They harm our communities, and it is unconscionable to me to know that we have not done anything to prevent thousands of these unjust evictions. Secondly, I also want to support some other bills. HB 6939, which is a right to counsel. Right to counsel will give more funding to right to counsel, which will protect tenants. It will save the state money from having to pay increased hospitalization and homeless response services. I also support HB 6945, which will improve the current methods of health and safety violations. As was discussed earlier, many tenants are retaliated against.
Mr. Caskey, your 3 minutes have expired.
I'll just go summarizing. When I first met the tenants of the Windward Village, I saw determination and their determination to defend their right to live in a stable home. I also saw their disappointment with local and state leaders' lack of action to protect them. Today, I am here to urge you to support HB 6889 so everyone who is struggling with exploitative landlords and the housing crisis can be confident that their state representatives are supporting them and their communities. Thank you for your time today. I'm welcome.
Thank you for your testimony. Any questions from members of the committee? Senator Marks.
Thank you for being here. And from my district. So were you there in the beginning when all of it first started to happen?
I was there when you called Elizabeth Sibilia. I was in her office working on the spreadsheet of the local decision makers, and I could hear what was going on. It was I recently got involved directly with the tenants that summer.
Oh, that's wonderful. Yeah, I have a loud voice when I talk. Most people hear me. So that's what I wanted to say is I wasn't the chair of housing yet, and they called me, and what do you do? And then how important it was for the Center of Housing of Equity and Opportunity to be able to be there. If you don't have a tenants union, right? How much you need attorneys, people with wisdom and that know the law, they're behind you. So if you just want to tell super quick, like how that all happened. And then what just happened a couple weeks ago in East Lyme?
So like just kind of like a short history of what happened at Windward Village.
Real quick, because it's a
Okay,
really great
yeah,
story.
So basically, Windward Village, to my knowledge, was originally held by a small landlord. It got bought out by Alpha Capital, out of town landlord, and they tried to raise the rents and also have lapse of time evictions. So after that happened, the tenants, they got together with Elizabeth Sibilia, Connecticut Legal Services, and CT Fair Housing to work to establish a fair rent commission, which was a great step in the right direction. It does not solve the underlying issue of the affordability crisis caused by exclusionary zoning, but that is a discussion for another day. And just a couple of weeks ago, they had their first deliberations and hearings at the Fair Rent Commission to reduce their rents to what is reasonable and equitable for those people. And just for clarification, their rents were Alpha Capital was trying to raise their rents by 92%, $900. These are people that were on Social Security. They simply would not have been able to do that.
Yeah, it had a pretty good and happy ending, but we need to make it happier for next time they try to raise the rents. So thank you for all your good work, and thank you for sticking it out, and drive home safely.
Thank you. Thank you for your question.
Any other questions? Seeing none, thank you for your time, and thank you for sitting here all day. You were in the room more than some of us were, and it takes dedication. We appreciate it. Next, we have number 81, Ken Burkamp, if they're online. Then I'll go to Zach Postle.
Hi, can you hear me?
Yes, sir. Floor is
All
yours.
right. Perfect. Hi, everybody. My name is Zach Postle, and I want to thank the committee for holding today's hearing. I'm a resident of New Haven, and I work in public health as a life sciences consultant. I'm also a member of the 1455 State Street Union and the Connecticut Tenants Union. I testify today in support of HB 6889, an act supporting evictions without cause. So personally, I've lived in Connecticut since 2018. I really think it's a special place. My partner's from here. Despite my feelings, though, I know that Connecticut is incredibly difficult for renters. And I say this, both, experientially having lived in other neighboring states like Massachusetts and New York for most of my life, but also as a statement of fact. I know that Connecticut is, by some measures, considered to be the most difficult state in the U.S. to rent in. So with that in mind, let me paint like a typical scenario that's happened to me. And with this in mind as well, I have had great, mom and pop landlords in the past before, but this is something that's happened to me personally. So imagine this. After spending months finding an apartment that fits your needs, you realize things are broken. And now, I bet if you had a broken household with broken appliances and items and foundations, you as homeowners, which probably a lot of you are, you'd probably take care of them pretty quickly, because not only would this threaten your health and your safety, but this would cost you a lot of money down the line. This is your money and this is your equity, I assume, right? As a renter, the logical equivalent of all this would be to simply get in touch with your landlord, right? Well, what happens if your landlord simply opts out, right? In which they won't respond to your maintenance request whatsoever. This happened to me, and this happens all the time across the state. If you're informed, you might respond by escalating with your town's housing enforcement agency, and it might prompt your landlord to finally make these long overdue fixes. And it sounds like progress, right? Wrong. Instead, do you really think that the same people who ducked you for 6 straight months are going to be thrilled about offering you a lease renewal, especially after you forced them to make necessary fixes? No. And especially not without some hefty rent increases involved as well. So, hypothetically, how does an $800 increase in rent sound with short notice on an unmaintenance apartment that hasn't been fixed in years, right? It definitely hasn't even been renovated, right? I'm sure that 30% rent increase is surely necessary to match inflation, right? No. So here's the worst part. Let's say you've been given an almost no notice of rent increases whatsoever, again, because your landlord doesn't have lines of communication with you, but you simply can't pay, again, because rent costs more than mortgages these days in Connecticut. And you can't find equivalent, safe, reliable, and affordable housing anywhere in Connecticut, because Connecticut has some of the lowest vacancy rates in the country. You will get evicted, and no-fault evictions stay on your rental history record. That's a death sentence. So good luck getting another rental, much less qualifying for a mortgage, right? This is only accelerating as a trend, though. So back in 2019, we saw that only 9% of evictions were without cause, whereas by 2022, this skyrocketed to 35%. What could possibly explain this figure? It's not like people became horrible tenants all at once since the pandemic. We're people, we're the public, right? We should be protected. We haven't changed. So let's be clear. Yeah, noted. This is driven by profit and artificial scarcity. So, in summary, if we had healthy housing stock and laws preventing unjustified double-digit rent increases, then sure, we wouldn't even need something like just cause eviction protections, but we do, and we don't have the housing stock to protect people. We need this law passed. We've had other neighboring states, competitors like New Jersey and New Hampshire, that already have expanded just cause eviction protection laws on the book. We have this in place for, protected classes in Connecticut. This should be a no-brainer in our state, in my opinion. And in my opinion, people shouldn't have to stress about leaving their community, changing their child's school, or having a longer commute due to landlords seeking higher profits at their expense. Renters deserve peace of mind, and I think landlords need to take action to make this happen. So that's sort of my take on that.
Thank you. Any questions? Okay, seeing no questions, thank you for your testimony. So I'm going to start going back and forth a little with people remote and people in person because it's public safety, public health. I want people to drive home and be safe. So next I'm going to go, I'm going to go back and forth, and if I get confused, I'm sure somebody will correct me. Number 84, Wilfreda Pera, are you here? Okay. And then we have 85, Angela Schlingheid. I know, I want to go to a person in the room is what I just said. So what is? Oh, that's the next one. Okay. You did my work for me. Thank you. Number 118 is Joseph Young. If you could please come testify, and thank you for your patience.
Thank you. So yes, I'm testifying in favor of House Bill 6889 for the just cause evictions. And part of what I do every day in Hartford is I service the homeless population. We give out food and blankets, and we put them in touch with the right resources to find jobs and things like that. And I think that that bill would be good to end evictions in this state. And I think that it would protect people with disabilities and the elderly from being evicted as well. And I also wanted to speak on the retaliation and on the out-of-state landlords, because there was somebody a few hours ago that testified about PMC Property Group, and I also used to live in PMC Property Group right across the street, actually, at 26 Rush Street, and there was a leaking ceiling, like the same problems that they had, and there was rats, and I tried to call the super of the building, and they weren't picking up, and I actually had to call the fire department, and they sent the super. It was like late at night, and then after that, they refused to renew my lease, and I had been there for 2 years, and they're from New Jersey, so I think that there should be a bill that says that landlords should be from the state of Connecticut, and I also support a rent cap, and there should be a bill for that too. And that's really all I got. So if you have any questions.
Thank you so much for your testimony, and seeing no questions, drive carefully, get home safe.
Thank you.
And for all those that are still in the room and who plan to testify in person, if you could just go to our clerk, Ariana Sakaitis, and let her know your name and number, and then she will share them with me and we will start alternating. Okay, thank you. And so next we have 83, Peter Benner, online.
Thank you, Madam Chair. Members of the committee, I appreciate the opportunity. My name is Peter Benner. I'm from West Hartford. I'm a member of the Greater Hartford Interfaith Action Alliance. And it also indicates on the list that I'm from the Connecticut Bar Foundation, which is true, but I'm not testifying on their behalf. I'm really testifying more as an individual citizen of the state with very strong opinions about the leveling of the playing field between tenants and landlords. We've heard, and I've been on the call since the beginning today, and we've heard some extraordinarily powerful and articulate, very well-reasoned testimony on behalf of the bill, which I support, 6889. And it seems to me that passing this bill in Connecticut, where the balance, the equilibrium between tenants and landlords is just so imbalanced that passing the bill is long overdue. Eviction, as we well know, is a trauma that turns people's lives upside down. Landlords, good landlords in particular, know how to run their businesses. They know how to run their businesses profitably. They know how to be good landlords if they are so inclined. And that really means operating in good faith and recognizing the interests of the tenants while you seek to pursue the ownership of the property as you would for your own interests. Bad landlords don't act that way and will be constrained by this bill in a way that is appropriate under the law. And it's not going to have an adverse effect on being a responsible landlord in Connecticut. It's going to be good for the economy by providing more stable and secure housing. And we can reduce the incidence of homelessness simply by virtue of reducing the risk of eviction. And now getting back to the Connecticut Bar Foundation, the primary reason that I'm here is because I serve on the committee of the foundation that administers something called the Pels Fund, which is a fund that provides limited but significant resources to tenants who are going through the process of eviction, represented by very able members of legal aid organizations, and simply need some extra funding to help avoid evictions. And what I see is predatory landlord behavior. I see landlords who are taking advantage of very vulnerable individuals, and I see landlords who really don't need to behave that way. And with this kind of limitation under which they would be operating through this bill, they would be much less likely to be able to, and the individuals who would be subject to evictions without cause would not have to go through the trauma and the difficulty that they do simply to maintain the right that they have to being in a stable home. So it's really time for Connecticut to make the right call to protect that human right, to level the playing field between tenants and landlords, help avoid homelessness, and promote stable housing and economic development. So I urge you once and for all to pass this bill as something that's really going to make a difference for a lot of people who are going to be much better off for it. I thank you for your time.
Thank you. And seeing no questions, we,
Senator-
oh, I apologize. Ranking Member Sampson?
Thank you for the recognition, Madam Chairman. Peter, thanks for being with us. I kind of told myself earlier that anyone who continues to refer to this bill as or the activity in this bill as an eviction, I'm gonna question them, just because it's a frustration of mine watching all day to see this bill and what it actually covers being described as an eviction, when, as you know, and because I can tell you're very clearly read on the subject, this bill only affects the end of a tenancy when the actual lease is over. And it only becomes an eviction if the tenant actually refuses to leave at that point. My question for you is, how long should a landlord be required to continue to rent a home beyond the intended lease period and expiration date, in your estimation? Through you, Madam Chairman.
I don't know that the question can be answered, and I don't mean to dodge your question, but I don't think it can be answered with how long. I think it's a matter of process and removing the ability, as we've heard so often today, the ability of landlords, simply because they want to replace the tenant with another tenant without reason, and thereby creating instability of the possession of the unit, is an overriding public policy. But there is a process. If the landlord truly wants to pursue the removal of that tenant, the landlord has the opportunity to do so. But we are weighing some public policy issues here. I mean, you look at it from one perspective. Those of us who have testified in favor of the bill look at it from another perspective, and we really are engaging in a weighing of policy. And I think I come out, and I know many of the people who have testified today come out in favor of making sure that people do not fear losing their tenancy because they've complained about something that's been wrong with the apartment during the course of the tenancy, and therefore are subject to this lapse of tenancy at the end of the term, or simply don't want, or the landlord doesn't want to keep them. And I understand your concern. I understand that perhaps that puts landlords in a position that doesn't cause them to be as powerful as they would have been in the past. But that's, from my perspective, good tenants are going, good landlords are going to be able to deal with that, are going to be able to live with that. And I don't see that as an overly restrictive imposition on the landlord's ownership of the property.
Thank you for that. Yeah. Thank you, Mr. Is that you, Mr. Chairman, or is it Madam Chairman?
It is Madam Chairman.
I didn't know who was running
Right
the show. I
ahead,
hear other
Ranking
voices.
Member Sampson.
Yeah, thank you, Madam Chairman, and thank you for that answer, Peter. I find it interesting. You repeated a lot of the things that other people said throughout the day, and none of that has anything to do with this bill. I mean, this bill basically says that at the end of a lease, no longer is that the end of the lease. It's not the end of the lease anymore. Now the tenant can stay beyond the end of the lease. And the only way that the landlord can actually begin an eviction, which is a totally expensive and crazy process involving court and getting all kinds of paperwork and fees and marshals and all kinds of stuff, is if they can choose from the short list of reasons that are going to be provided in this bill for why they can actually go through the ridiculously expensive process of evicting someone for overstaying the period of time that they agreed to rent. It seems like an insane bill from a common sense standpoint. And I'm not here on behalf of landlords. I mean, that's been implied many, many times today. I'm here on the side of good policy. That's what I'm here for. That's why I wanted to talk to you, because you mentioned good policy. And good policy is not arbitrarily harming people that are providing the limited amount of housing that is remaining in the state. If you want to go after bad landlords, I'm your guy. I'll help you write all the laws in the world to punish bad actors and people who are doing things that they shouldn't. But this bill, just as an example, Peter, would say that at the end of a lease, after the landlord had rented to someone for a few years, they and planned all the time that at the end of the year 3, they were going to reclaim the property so that they could put their family member in there as a tenant. This bill would say that's impossible. The landlord can't do that. The landlord cannot actually evict that person. They would have to leave that tenant there no matter what. They have no right to use their property for that purpose. I'm just curious. I mean, what's your position on it? Do you think that's a just way to write policy, that the person who took the risk and bought and paid for the house and honored the lease agreement with the tenant for several years, did everything they were supposed to, maintained the property, took care of them, and honored the lease in every way, even provided notice to the tenant, maybe 3 years in advance? They still could not reclaim their own property to put their own family member in the unit.
I understand and respect your position, because it is a difference in policy, and we always can disagree on policy. What we're really talking about here is big picture, and the fact that those of us who have testified in support of the bill, who believe in the bill, see the need for rental stability and the stability of remaining in a property to supersede in certain cases. Now, that doesn't mean that if a landlord wants to get a tenant out of the property, they cannot do it at the expiration of the lease. Doesn't mean that. There's still a process, as you say, of eviction, and they can
I don't mean to interrupt you, Peter, and through the chair, forgive me, but I just want to correct you. There is no process, not unless
Excuse me,
you meet
Ranking
one
Member
of those
Sampson,
5 items.
Ranking Member Sampson, excuse me. You did interrupt, so I'm going to let Peter Benner finish his thought, and then I will go to you.
The tenant does not have an enduring right to occupy that unit at the expiration of the lease if the landlord wants the property back and goes through the proper procedures of eviction. It's the landlord's property. It's just a matter of not being able to go through it without establishing a basis upon which the landlord needs the property back or wants the property back.
Ranking Member Sampson.
Thank you, Madam Chairman. And respectfully, Peter, you're just incorrect, factually incorrect. That's not what the bill says. The bill is quite clear that you at the tenant's occupancy does endure the expiration of the lease. The only exception is that you can evict them for one of the few reasons stated in the bill. But the reason I gave you is not one of the reasons stated in the bill. So presumably, if I attempted to evict my tenant for overstaying their visit beyond the expiration of the lease, and I went to court and said, well, I would like my property back. It's my property. I warned this person 3 years ago I was going to have a family member move in after they finished their 3rd year. The court would have to say, no, I'm sorry, that is not one of the reasons allowed by law. So now this law effectively takes the place of the property owner's rights. I've heard all day about tenants' rights, and I care about tenants' rights, but both parties have rights, and some of the rights that are important. What's fascinating to me is that the argument for rights all day ignores the rights to have a contract upheld and ignores the rights of people who actually have gone through the process of paying for and obtaining property as their own. So it's a little frustrating. I didn't mean to pick you out of a crowd, Peter, but you did bring up a couple
No.
of things that.
No. I mean, as I say, I think it does get back, as we've heard literally all day, to the question of policy, and we've heard very strong advocates for the policy that is behind the bill, and I understand your concerns about the bill, but at the same time, I don't believe they should prevail.
No, well, through you,
Ranking Member Sampson, do you have a question for Mr. Benner?
I was just going to thank him for his time, and I'm sorry I didn't mean to jump in there. I was just waited for a second, and you didn't say anything, so I went. But Peter, thank you very much.
No, I appreciate the opportunity.
Yeah, and I appreciate the conversation, and we certainly can respectfully disagree. I just think that is a kind of a bridge too far to suggest that the property owner is so limited on the reasons they can go ahead and re-obtain their own property. And I'll continue to talk to people about it. Thank you.
Appreciate it.
Thank you both. So next we're going to go online with Angela Schlingheid, and then after that we will have in person Sarah White. So we're going to start having people prepare themselves and trying to move this on. Go right ahead, Ms. Schlingheid. I hope I said that correctly.
Very close. Thank you. Good evening, Senator Marks, Representative Felipe, and members of the Housing Committee. My name is Angela Schlingheid, and I am the Executive Director of the Connecticut Bar Foundation, which is the primary funder of civil legal aid in Connecticut. I am testifying tonight in support of HB 6939, an act authorizing state funding for the Right to Counsel program, which has been a vital program in stabilizing families and upholding access to justice in Connecticut. In 2016, the Judiciary's Committee's Task Force on Access to Legal Counsel provided a series of legislative recommendations recognizing eviction defense as a key area where the social and financial costs of injustice far outweigh the cost of legal representation. Without counsel, tenants, especially vulnerable groups like families, seniors, and survivors of domestic violence, are severely disadvantaged in eviction proceedings. The Right to Counsel program serves as a crucial safety net for low-income tenants, ensuring that all available resources to keep them housed are fully utilized. Attorneys help guarantee procedural fairness and ensure tenants don't lose their homes due to lack of awareness or access to vital resources like housing benefits for veterans or crime victims. This comprehensive approach not only prevents evictions, but also strengthens housing stability across Connecticut. Since its inception, the program has served over 6,000 tenants, preventing evictions or reducing disruptive displacements. Independent evaluations show that Connecticut has saved at least $36.6 million through this program by reducing reliance on emergency shelters, preserving jobs, and preventing disruptions to education and healthcare. For every dollar invested, the state sees a significant return in both economic and social benefits. Connecticut was a leader in enacting this Right to Counsel program in 2021, becoming only the second state in the nation to do so. Now, 24 jurisdictions have similar programs. If we fail to provide adequate funding, we risk denying justice to thousands of vulnerable residents who would be forced to navigate a complex legal system alone, undermining our state's commitment to equal justice. We urge the General Assembly to allocate $1.75 million in fiscal year 26 and $5 million in fiscal year 27 to ensure the continuation of this vital program. Housing stability is the foundation of economic and social well-being. Without it, maintaining a job, keeping children in school, or staying healthy becomes nearly impossible. Connecticut has shown leadership in establishing Right to Counsel, and we now ask that you ensure this program is fully funded. Thank you for your time and your commitment to justice, and I'm happy to answer any questions the committee members might have.
Thank you, Ms. Schlingheid. I see questions online. I'm not sure who raised their hand first. Rep. Butler?
Thank you, Madam Chair. And thank you so much for your testimony. I will just say Angela because I don't want to even struggle mispronouncing your last name. I'm sorry
That's
about
fine.
that.
No problem. Thank you.
But I understand the figures you gave about, the return on investment that we got pretty much by having this program in place to actually help represent tenants. Now, and I understand your request for the next couple of years. My question is relative to the availability of lawyers. I know over the last couple of years, I heard that there was, a shortage of lawyers or the assignment of them for tenants. Could you just speak a little bit about that?
Yes, absolutely. So when the program was rolled out initially after the passage of the legislation, they started by using a zip code model to roll the program out. So we were rolling out a statewide program, and we'd never done this before. Almost no state in the country had ever done this before, so we didn't have a lot of models to choose from. So initially, they looked at the areas where they felt there was the most evictions happening, and they decided to roll out the program in those zip codes. Since that time, over the last year, we have removed the majority of the zip code restrictions from the program. So where you live is not going to be a barrier to accessing the program. Having said that, even with this program, legal aid, as you know, has never been able to provide an attorney for every single person who needs one, unfortunately. And, it will be a long time and a lot more money before every single person who ever needs a legal aid attorney, who's income qualified, will be able to access one. But the program has moved forward by removing those zip code restrictions. And since that has happened, we have seen more people being able to access the program in all different parts of the state.
Okay, thank you. I only have one other question. In terms of the fiscal request you gave, the 1.75 and the $5 million, what kind of percentage of lawyers you think you'll be able to bring to bear to actually represent tenants during those fiscal years?
So the money that we've requested for the next 2 years is really to keep the program currently at what it is. We understand the incredible burden that is on the General Assembly this year, especially, and we really looked at our budget to try and ensure that we were only asking for the bare bones that we would need to make sure that this program could continue on as it is. So currently in the state, there are 24 attorneys and 8 paralegals and professionals being supported by this program. So with the money that we've requested, we would be able to maintain that those numbers throughout the 5 organizations that are funded through this program.
Okay, thank you for your testimony and for your detail. Thank you, Madam Chair.
Thank you. And now we have Representative Corpus.
Thank you, Madam Chair, and thank you for your testimony. I had a question about this program. As I understand it, was originally a COVID era program, which was funded by ARPA funds to the tune of 20 million. And I was wondering if you saw it differently now. I can get my head around the need for a program like this, or the acute and emergency need for a program like this, when people are losing their jobs and people can't afford to pay their rent and people can't afford to hire a lawyer to defend them to pay their rent. Do you see it differently now that we're in the post-COVID era?
So I'm incredibly happy, Representative, that you asked me that question, because I don't believe that this program is a COVID era program. It was funded initially with ARPA funds because the crisis eviction was certainly exacerbated by the conditions of the pandemic, as everyone here knows. knows. But from my testimony, and it's, as you heard, and if you look at my written testimony that was submitted, you can actually see the report that is linked. But in 2016, December of 2016, the Judiciary Task Force on Access to Legal Counsel made legislative recommendations to create right to counsel programs for specific areas of law. One of them being eviction defense, the other being restraining order hearings. And then I can't think of what the third one is without the report in front of me at the moment. But that was back in 2016 that it was identified that the social and financial costs of injustice far outweighed the cost of legal representation. It was, again, when the state had access to the relief funds from the federal government and the spotlight that was being shined on this crisis by the pandemic, that the legislature moved forward with that recommendation. But my belief is that this is not a pandemic related problem. And this is an access to justice issue. People are going to go through the eviction process if they're going through the eviction process. And what this program does, it is enables everyone, hopefully, to have access to an attorney so that there is fairness, that they have access to system and that they're fairly able to navigate that system. It doesn't mean that they get, a get out of jail free card. It just means that they have someone advocating for them, letting them know what their rights are and helping them advocate through the process. I think that that is essential for our state when we talk about equal justice, and that a person's access to their financial resources shouldn't determine whether or not they have the same access to justice in our state as someone who might have more financial resources.
Rep. Corpus?
One follow-up question. You had mentioned, I think that 20-some states embarked, we were a leader in this, but 20-some states, I think it was 24, embarked on a program such as this. Do you have any idea how many of those have continued it post-COVID?
So the 24 jurisdictions I talked about and that are linked in my written report, I actually linked it to the website where you can look up the different jurisdictions and what their programs look like in those areas. But those are currently the 24 programs that are currently active in this state, in this country, excuse me.
Representative Corpus.
So I guess I would imagine that other state legislatures are facing what we are this year, which is that everyone's ARPA money has run out. So I guess if you look at us, this program exists for us too. I'd be curious to see, and I'm not saying we shouldn't continue it, but I would be curious to see how many continue it after that those federal funds are no longer available. But thank you very much for your testimony.
Thank you.
Thank you both. I see no further questions. So next we will have Sarah White in person. Then we will have Mary Elizabeth Smith online. And then we will have Robert Chesson in person. And I hope those online show us grace and understand why we're doing it this way.
Senator Marks, members of the Housing Committee, thank you so much for the opportunity to testify today. My name is Sarah White, and I'm an attorney at the Connecticut Fair Housing Center, and I'm testifying in support of the Just Cause Bill, HB 6889. And I'm just going to address some of the things I heard today listening to testimony here. So we did hear a landlord testify that they would need no-fault evictions for tenants who refused access to the unit for repairs and renovations. This is not the case, and this scenario is already covered under Connecticut law. We have a statute 47A-16 that says a tenant cannot unreasonably withhold consent for the landlord's entry for necessary repairs or improvements. Refusing entry for improvements like to HVAC is also almost certainly a lease violation and a ground for eviction under expanded just cause. Landlords can and do evict tenants covered by state and federal just cause protections. They just have to provide a permissible reason. Serious nuisance and nuisance will continue to be a permissible reason, as is a violation of a lease, a document that the landlord almost always writes. Under expanded just cause, the landlord would also be able to evict someone to move in an immediate family member. So just to emphasize again, all landlords that would be subject to expanded just cause are already subject to just cause requirements for elderly and disabled renters and have been for 45 years. This is not a new framework at all. It's just expanding something that we already have and already works. It does not apply to 1 to 4 families, which are the properties with residential mortgages that banks are most likely to foreclose on. It also does not change the grounds for eviction other than removing the no-fault grounds for larger complexes of 5 or more units, where the landlord should already be familiar with these protections for elderly and disabled tenants. Expanding just cause is also a racial justice issue. It would especially benefit our Black and Latinx renters and women who are both disproportionately likely to rent in our state and 2 to 3 more times more likely to be subject to eviction compared to white renters. An eviction is not just a one-time event. It has ripple effects on education, jobs, mental and physical health, future housing stability, and it's incredibly important that we take steps to reduce evictions. The number of no-fault evictions are also increasing in Connecticut. In 2023, we determined that 10.7% of summary process filings, over 2,000, were for no fault. This is an approximate 19% increase in the rate of no-fault evictions since 2018, which swelled early in the pandemic to nearly 35% of total eviction filings. In some municipalities, the rate of no-fault eviction filings are even higher than the state average. In New Haven, it's 13.6%, 14.4% in Windsor, and 20.7% in East Haven.
Attorney White, your 3 minutes have expired. If you can please summarize.
Just to summarize, we're seeing so many more no-fault evictions because of the incursion of out-of-state landlords who are using them to clear out buildings, happening all over. We're also seeing the rise of no-fault evictions coincide with renewed organizing by tenants and tenants who understand their right to safe and healthy housing. And as we've heard, no-fault evictions are a tool to punish tenants who ask for repairs and discourage other tenants from speaking up, which unfortunately works. So I urge the passage and I'm happy to answer any questions.
Thank you, Attorney White. I see no questions from those here online. So thank you. Drive safely. And next we will have Mary Elizabeth Smith online, followed by Robert Chesson.
Good evening, everybody. Good evening, Senator Marks, Representative Felipe, members of the Housing Committee. My name is Mary Elizabeth. I'm a resident of New Haven, Connecticut. I work at Make the Road, which is an organization that builds power in immigrant, Latinx, and working class communities in Bridgeport and Hartford. I'm a homeowner and I support HB 6889 and act concerning evictions for cause. I've had the flu, so I hope I can get through this without coughing, but forgive me and I hope you can hear me clearly. I was lucky enough to purchase a home in 2017, and even though there are some months when it's hard for me to make ends meet, I know that I have the security in my home to get my kids what they need and that they'll have a place to stay month to month. However, that's not the case for so many people in the state of Connecticut. And today I'm going to lift up just a few stories that demonstrate some of the issues people have been speaking to over the past few hours. One story is that of my dad, who I talked about in detail last year. In the last few months of his life in 2023, he started cleaning out his apartment that he had been living in for over 30 years, that he had raised us in, he had built his community in. And he did that because he was receiving letters that his rent would be going up by about 20% at the end of his lease, and he wasn't going to be able to afford it. My dad's apartment was full of black mold, mildew, and had rotting floorboards and peeling paint. He used to bail the water out of the hallway with shovels and a bucket on a very regular basis, and would do so without complaining ever. And when I asked him why he wouldn't complain, he would say, oh, you know, Mary Elizabeth, that's when they're going to get me out of this place. Which may or may not have been his case, but it certainly speaks to the fear that a lot of people have of speaking up about the conditions that they are living in. Another story is that of one of my co-parents and my stepdaughter, who have been in eviction proceedings for months after complaining about the rotting and uneven stairs in their apartment and other unsafe conditions they are living with. Because when our community members who are undocumented complain about poor conditions in their apartments, generally the next step is a notice to quit or an abrupt end to their month-to-month. I think many of you might remember the story of Imelda Barajas, a champion of just cause and whose testimony I had the honor of translating last year. Last year, Imelda shared with us how she was threatened with eviction as well as calls to ICE because she had dared to complain about the conditions in her apartment. Imelda is no longer with us today, but I know that she would be here if she was, because she knew that Just Cause was about community safety and stability. And lastly, I'm here because of the countless other stories like these that we hear every day at Make the Road of individuals who have been forced out of their homes from 1 month to the next because they dared complain about the unsafe or uninhabitable conditions in their apartments. This is particularly true in the undocumented communities we work in because of the already heightened fear and the ease of threats to those folks who don't necessarily have a safety net.
Holy shit.
This bill is one small way that we can contribute to ensuring more people are not living in fear of losing the homes where they raise their families and put down roots. Just Cause is a low cost and effective policy solution that doesn't take away the power of landlords to evict tenants. It simply forces them to have a justifiable reason to do so. For these reasons, I strongly support Just Cause for eviction, and I will take any questions folks have.
Thank you, Ms. Smith. I see nobody here or online, so I hope you feel better. And thank you
so
for
much,
testifying.
and thank you for being here.
Yep. Next we have Robert Chesson in person, followed by Greta Blois online, followed by Sophia Wang.
Good evening, members of the committee. I appreciate the opportunity to be before each night and appreciate your stamina for enduring as long as you have. Hopefully I don't have to stay with you here for the rest of the night, however. As the last attorney who sat here and spoke did, I feel it compelled to clarify some things that have been brought up earlier today that I think are important for this committee to consider. The first would be the way tenant advocates, tenant landlords. Well, let me first explain. I'm a landlord attorney. I've been doing this for a little over 25 years, and I represent landlords in every housing court in the state. And in every housing court in the state, tenant landlords use lapse of time to their advantage. And here's the advantage. When a landlord brings a serious nuisance eviction, a successful serious nuisance eviction, or perhaps it seems like one, legal aid asks that we convert that to a lapse of time eviction to protect the tenant, to protect their subsidy, protect their future ability to get a new apartment. And landlords do that all the time. As a gracious move to help the tenant, even though they weren't willing to keep them into the future. A little surprised that wasn't brought up, and disappointed that it wasn't recognized and isn't recognized that tenant advocates use lapse of time to their advantage. Second thing I'd like to bring up is how long this process actually takes. Most leases require a 60-day notice that they're not going to be renewed. So 2 months before the lease expires, the tenant is aware that that is the landlord's intention. The tenant doesn't leave, there has to be a notice to quit served. After that expires, and under current rules, that could be as many as 30 days, not the 3 days that was misrepresented earlier. After that expires, the case is brought to court. It then has to get to the courthouse, which is several more weeks. And then after a successful case, judgment enters, the court can issue a 6-month stay. That means the tenant can remain in the premises as long as they pay the previously agreed upon use and occupancy for the next 6 months while they look for another place to live. We're talking 8 months plus before that process actually expires. It's important that you understand that. This doesn't happen overnight. It doesn't happen in 3 days. It takes a long time. And the tenants who are faced with a lapse of time eviction have lots of protections already built into the law. Lastly, I want to make sure that it's brought up tonight that I thought of an analogy today Under our laws in Connecticut, two people can get married. They can enter into the contract of marriage, and under the law in Connecticut, they can get divorced for absolutely no reason. They're required to wait for a period of time, and they can get divorced. This law requires the landlord and the tenant to stay married. Period. I don't think that's fair to anybody. When the landlord can, the tenant can leave whenever they want after that period expires, but the landlord has to keep them on. Thank you for your time. I'm happy to answer any questions you may have.
Representative Weir?
Thank you.